people, welcome to Marathon. So let's try to keep it for around, I would say, within 14 hours, the complete part. Let us try to focus as much as possible. Now, in the marathon, we will be doing, of course, 100% syllabus coverage, definitely. With that, what we will try to do is let us try to take wherever there is possible some tricky questions that has been asked in the past. So if we are completing a particular number of units, let us say, for example, we are completing 6 units today or 7 units today. Tomorrow, the first thing is that let us spend some 1 hour only on looking at the questions for that 7 units. So the task for you today will be, I'll be finishing 7 units. You guys also should go home and read as if tomorrow is your exam. Go letter by letter. And tomorrow, let us solve the questions out of these chapters. Now, you will get the intensity. That's the first thing that you guys have to do. Read as if tomorrow is your exam. So, by Sunday, your target is to complete the CA Inter Law. I'm saying like as if Monday is your exam. In that intensity, you guys have to complete it by Sunday. Yes, do not take it to the end. That is the first thing. The second thing is that I told you, I'll explain you. So now we have passed the stage of reading the content from the material. So if you're starting your journey now, or for people watching on YouTube, so this is the main material. Now the time has passed. Now this definitely cannot do much of a magic now. Now, what we rely upon is your summary books. So, if you guys are having your own notes, if you guys are having your own chart books, whatever you guys are following, follow that. Now, this is a time for revisions. Now, we guys would have made a handwritten notes and all inside the class. Now, this is the time you guys have to flip it through. Now, put that into place. Assuming that a 2-time, 3-time revision, whatever is to be done, is done. You know, sir, we thought this is only our first revision. Okay, a good optimistic people. Yes. So keep that in mind. Yes. And the third thing. Now, as I said, now what is important? Now, what do you say? Now, say for example, what is the target that I am looking at law for all of you? I am looking at anywhere between 65 and above. Achievable, 100% achievable. Now, why I will tell you, what are the difference that you guys have to do? Towards the end, what we will do is let us do one practice question of how to answer your law-based questions inside the exam. That we will do. It will be our last day assignment. Next thing, I'll also write one question. You also write one question live in the class. Let us try to learn how do we decode. Yes, learning agenda. The second thing, what is the reason for someone to score 60 and above? What will be the difference between a person scoring between 40 to 50 and 60 and above? Or, for example, the last attempt, few people said the law was difficult. Was it actually difficult? Answer is no. Was it lengthy? Answer is yes. So, the point number one, go prepared for a lengthy paper. It is going to be lengthy. For you to touch 100 marks will be difficult. Be prepared psychologically. Meaning what? It is a writing paper. You guys have to cover and make your MCQs count. Start inculcating a habit of reading a lengthy MCQs. It is going to be lengthy. Your first question, trust me, if the life is a little unfavorable, just like the God has been on me, yeah, it is going to be lengthy. 2-page minimum will be the length of the first question. First opening on the yaake, I felt bad on the banale. I said no. Yeah, all that you guys will start thinking of. Because it is going to be lengthy. Now, what is the way? See, the first thing that happens with the person scoring 65 and above, they will see and solve more than 5 to, I would say, if you can increase this more than 5, really, really good for you. At least go through some 5 papers. At least 5 papers. Mandatory. The more questions you see, the more perspective you develop. You will know. You tell me, there is some section 19. what are the different ways to test one section? Companies Act 2013. From the last 12 years, that's the section, it's the same. In what and all ways can they test? So don't you think if you go through the past papers, you would have covered everything, every possible way of testing it. The new perception will open on that particular section. Now, what is the mistake we do? We will not read the questions. We will not go through as many questions as required. Go through that. However you want, you go through that. Yeah. No, that is the most important thing. I was getting the point. Because the more questions you go through, you will get the perspective. Okay, this is how they may question this versus how you guys will go prepared. Section 19 means they will ask me exception for a subsidiary company to hold in a holding company. Don't you think it has become school level test now? That's the only thing that is there in section 19. Why should they ask that only? They will ask a different perspective. That is when people will say it is difficult. So the more questions you solve, the better for you. Agenda number one. I getting the point. Now again, you guys will have a question. Sir, how do I get it? How do I get these particular questions? The first thing, people, there is already one video available on YouTube. I have made 5 RTPs, I don't know, 5 or 7, no, 7 RTPs, 7 MTPs. You sit and watch that 150 plus questions are there. Good perception, a different way of looking at 150 plus questions. Isn't it good for you? Definitely good for you. I think the file size is less than 3.5 or 4 hours. Everything put together. 5 RTPs or 7 MTPs. I don't know. 2 hours. That's 2 hours, 30 minutes. Can't we see that? And what is the total number of questions covered? I'm saying the total number of questions will be definitely, I'm telling you, more than 150. Watch it. Easiest way. And don't have high ambitions. What? Sir, morning 8 o'clock, I'll get up. By 10 o'clock, I'll finish up. That's when you will lose interest. Split it and do it. That's why people, I could have done this marathon. You'll not believe. The first marathon I've ever done was done in one day. Morning 8 o'clock till night 10:15. That's the first marathon I did. And that's the first video to clock that 1 lakh views on YouTube. Yeah. Now I know I will do. Now I know the thought all of you have, sir. You don't know the level of how brutal you were on the students that day. You don't know. Unfortunately or fortunately, I don't know. They were the ones who pushed me that day. So do it, we'll sit. And that's how we did it. Yes. And now today, what is that we are doing? Let us take it really slow. I don't mind. What is the intention to pass? Allah, 60 plus. People trust me. If this paper makes the magic for you, it is going to make the magic in your entire group. You know the other subjects are difficult. It is a little difficult to get that mark. Aggregate. We do not want a scenario where operation successful, patient died. Why? Aggregate shouldn't be our problem. So always remember, there should be a paper where you're scoring more than 65 plus. There should be a paper. And I'm not even setting an unreasonable or unrealistic expectation. 65 plus is achievable. 18 the point. Now the second one. Sir, okay, papers, they solve more questions, correct. What is the second one? Interpretation, how to write, writing practice. Do not start writing it everything inside the class. I mean, I'm saying when you go for an exam, that should not be the first time you're writing the paper. Start taking up mock tests wherever, whichever city you guys are in, wherever, whatever, at least write 2 papers. Much required. I don't know if you guys know, the mock tests in Arivu is also coming. Yeah, take it up. For you guys, I am only telling you, it is not money making process. Register for whatever papers you want. Come for all the papers. The entire money will be refunded. It is only to make sure you guys are committed for that particular thing. Take it up before going for the exam. At least write. I'm telling you, if not ours, write somewhere. But write mock test. Required, mandatory. Are you getting the point? Yes. Okay. The third thing, people, is what is the other difference that can happen? Remember, the more closer you go towards 100 marks paper, meaning the paper will be for 100 marks. No, don't write 80 and come out. The more closer you go, the better the result will be for you. Now, if you stay back, now imagine if you only attempt for 65, 75, 80, then whatever result you are getting, it's not on 100, no. It's technically on what? It's on 80, whatever you guys have written. And law will drain you. It will be a writing paper. It will be little lengthy. Go prepared. And remember, make your MCQs count. The more you solve, the better for you. The more you solve, the better for you. That is a fundamental strategy. Are you getting the point? Hello? Yes? Okay. Now, what is the fourth thing, sir? Where can we go right in increasing our marks? Now, that is where I'm coming to you, people, and that is this particular sheet. As I told you, this particular thing, yesterday also, this is what I was working on, night also. Now, this will come to around approximately, even as I'm doing now, it is not complete. I'm still trying to, remove unwanted content and still add, content that is required for you. Now, what will this chart have? Now, three things that you guys all feel confused. One is people section numbers, which one to, remember, which one not to remember. Now, what I've done here, people, the entire section numbers are there. Entire section numbers are there. Everything is there. Now, certain things, now, for example, GDR, I do not want to tell anything there. There are no limits, no forms. If nothing is there, I will not be writing anything here. Why? Because the summary we already made in our class. This will be only for forms. Now, what do I mean by forms? Now, say, for example, private placement. Now, you can see all the timelines, everything, anything with regards to numbers, that will be here. And all the forms, that will be here. Now, that is the intention of this particular chart. What? It will have timelines, it will have forms, it will have section numbers and content in one place. Now, it is left to you. How do you guys do? I will tell you how I did when I was a student. Every day, now you guys have around 30 days for your exam. Every day, no matter which subject you guys are reading, make sure on the first half an hour of your day, go through some, say for example, mark and keep it. You will know what are the most repeated topics. Now mark all those things in this particular thing. Take a highlighter, put a star mark, whatever you want, you guys do. Now at least try to remember 40 sections. Isn't possible, 100% possible. Because remember, I'm trying to address a crowd who has already read something. Yeah, you guys at least know something. Agreed? Yes or no? Huh? I believe, I assume. Correct? Huh? So we at least can take that call. Buyback. In section number 68. Now we know this, no? At least that part is there, no? Now go and highlight and keep it. Now, people, for the next 20 days, wake up in the morning, keep that 40. First day, take some time to highlight. Now, even in the marathon, I'll be telling you which are the important sections. Highlight and keep it. I might give you 80, but you take how much ever you want. Now, your first thing in the morning, keep half an hour to just revise sections and limits and forms. This will be your activity until the day of your exam, irrespective of the subject you guys are reading. Sir, why are you so unfavorable towards other subjects? Allah, I'm telling you, this is the only way you guys can push it. I've told you this on day one only, but we have not done. That's why we are here now. Now, what I'm telling you is it possible now? It is still possible. So what do I do? Now I know 42. Don't you think if I try to remember this much and if I try to remember this for every section there, isn't it sufficient? It will play a huge role. You can at least expect some 15 to 20 marks based on the limits and the sections and the forms. Are you guys understanding? Yes. So that is what this particular thing will try to serve. Are you getting the point? Hello? Okay. So Bartini Amel. Sir, give this. Okay, we'll do. Now, people, as I told you last day, I'll give it to you. Now you are here, you will get it. Why, sir? Yenido locking people strategy? No, I'm working on it. It will be over on the last day only. So you will get it on the last day only, fortunately or unfortunately. So now that is about this part. So keep this in mind and approach the subject. I think the rest of it will always be good for you. Clear? Yes. Now, what and all I'll be covering in this particular marathon, I clearly told you, we'll be focusing on 100% of syllabus coverage. And along with that, wherever it's possible, we'll come and we'll try to remember those limits and all of that. We'll try to practice and whatever is our recent RTP, that we'll take it up. And that will be our agenda for this particular marathon. Clear? Yes. Okay. Online able to see her online on? Okay, wonderful. Huh. The YouTube, this charts cannot be given as a soft copy because of whatever IP issues are. So please, okay. So let us start, people. Let us start with chapter 2, that is incorporation. Definitions, as we always see. Towards that, after the entire company law is done, and then we will start with the definitions part. Okay. Now, people, let us start with the chapter 2. Okay. What are certain basic things that comes in chapter 2? The first thing that starts with is people, okay, incorporation of a company. Chapter 1 will always talks about the preamble and what it covers. Okay. Section 2 we'll see throughout. Section 3, sir, the types of company based on formation. So based on formation, people, we can classify companies into 3 types. For now, that is called as a private company. Now, what do you mean by private company? A company which will have 3 things in it. A company which by its articles of association restricts, limits, prohibits. 3 keywords, remember for your exam. A company which restricts the right to transferability of shares. A company which limits the number of members to 200. In that, there are 2 exceptions. What are the exceptions? If at all there is any joint shareholders, treat them as one. And if at all there are past and present employees, remember, I have given some shares with an employee. He has left the company, but he is still holding the share. Such employees also need not be counted. But remember, they can also ask you, the employee was there with the company. He sold the shares. He left the company and then purchased the shares. You will count him in the limit of 200. Only the person who was there, he left, he is continuing to hold. Only they will be excluded. The third category is called as prohibition. That is nothing but people, you can never go for a public offer. There is one more question that they had asked in the past, people, that is, there is a company called as ABC Limited. There is a company called as ABC Limited. This company in its AOA, it has said the shareholders, before they transfer their shares to any other person, they have to first take the approval from the company. They had introduced such clause in its AOA. They had asked the question, is this condition or a clause valid? Because one of the shareholder transferred his share to an outsider without taking the company's approval. Now they're asking you whether the action done by this person, the shareholder who sold his share to an outsider, is this valid? Is it valid? Valid, invalid? But in its AOA, it says there is a restriction. So remember, this was actually a very, very simple question. Why? The definition, I mean, the question is based upon what do you mean by a public company? A company which is not a private company is a public company. Now, we are so used to a robotic definition of, okay, private company, it's not means it is a public company. But what is the intention? When will you call it a public company? That means whatever the 3 things that we saw in private companies, what are the 3 things we saw? There should not be any restriction or transfer. Second one, there should not be any limit on number of members. Third one, there should not be any prohibition on public offers. If these three things are not there, you will become a public company. Now, because those three things were not there, I will call something as a public company. So in ABC Limited, you cannot restrict the transferability of share. If it's a public company, no approvals required. They should be freely allowed to transfer. That's the answer. Are you getting the point? See, answer is easy. Interpretation is wrong. Are you getting the point? How do I answer now? That's why I say conclusion is easy. You guys have all may have written, may have not written that yes, this is valid or yes, this is not valid. But how is always important. Remember, in your long questions, the maximum weightage will go to people. What? It will go to your provision. If provision is wrong, conclusion has no value. If I write something and I write conclusion as yes or a no, it will not hold value. Your conclusion should be valid. Are you getting the point? Yes. So that is very, very important. Remember. Clear? Okay. So that is your public company and private company. Okay. Now, what is the next type of company, sir? Public company, which is not a private company, provided a subsidiary of a public company will be deemed to be a public company. Third one, sir, is called OPC. Now, what do you mean by OPC? One person company. Tell me what and all are the conditions for OPC. First one, it should be a natural person. So who can start a OPC in India? There are three conditions. What is that? He should be a natural person. So one company cannot start another OPC. Second one, people, this person has to be an Indian citizen. The third condition is people, whether this person is a resident in India or otherwise. Now, what is resident in India or otherwise? There is again a detailed video on YouTube only. I have only made just to search as OBC resident in India or otherwise, you'll get a in detailed explanation. What is that resident in India or otherwise? I've tried to explain that. Okay. Now, sir, there are three conditions I need to satisfy to become a OPC, that's member of an OPC. Now, in an OPC, what if the member dies? What will happen? There is another person called as nominee. Now, this nominee also, is there any conditions or anyone can become a nominee? Even for nominee also there are conditions. Who can become a nominee? Again, people, natural person, again it is an Indian citizen, resident in India or otherwise. When will we call a person as resident in India? The person should have stayed in India for a period of 120 days. When? In the current year or previous year? Remember, people, it is in the immediately preceding financial year. This is very, very important. Oh, we are going to have a tough time then. 7 times. ಅದು ಟಿವಿ ಮತ್ತೆ ಚೇಂಜ್ ಆಗಿದೆ ಇವಾಗ ಅದು ರಿಪೀಟ್ ಆಗ್ತಾನೆ ಅಂತ ನಿನ್ನೆ ಆಲ್ಮೋಸ್ಟ್ ಇಟ್ ಹ್ಯಾಪನ್ ಫಾರ್ ಮೋರ್ ದೆನ್ 8 to 10 times ಇಟ್ಸ್ ಕ್ಯಾನ್ ಯು ಫಿಕ್ಸ್ ಫಾರ್ ಒನ್ ಟೈಮ್ ಓಕೆ ಓಕೆ ಎಸ್ yes sir. The people resident in India or otherwise, what is that? People remember this 120 days condition will come in two places. Even in LLP also, when you're doing designated partner, one at least should be resident in India. For designated partner there, it is again 120 days. But is it in the previous year or current year? There it will be current year. Here it will be previous year. Try to remember. Important, that will have some difference. Yes, sir. Okay. One member can be one person can be a member in how many OPCs? One OPC. One person can be a member in only one OPC. Can I be a nominee in one OPC? So one person can be a member and a nominee in how many OPCs? Remember, one person, say for example, Mr. A can be a member in XYZ OPC He can also be a nominee in A, B, C, OPC. Both are possible. At the same time, same person can be a member also and nominee also. In one OPC, nominee in one OPC. Sir, you guys can have a question. What if wherever I am a nominee, that member dies? Then what will happen? That means I become a member in two OPCs. That is against the law. That means what they're telling me, I will have to leave one company in 180 days. So if I become a member of two OPCs, if I become, it is against the law. So what is that they're telling me? They're telling me I have to leave. I have to choose between these two within 180 days. This part is clear. Okay. Now, OPC is not allowed to do certain activities. What are they? They cannot do NBFC activities. They cannot they cannot carry on Section 8 business also. They cannot get converted to Section 8 company also. Remember, Section 8 company is pure, OPC is pure business driven. Charity, non-profit organizations cannot exist in the OPC form. Hello? Okay. Now, can I change my nominee any given point of time? How? I need to by INC? INC 4. Now, can I nominate any person? Yes, sir. Remember, can a minor be a nominee? Minor? No. Can a minor resign? Sorry, can a nominee resign? Nominee also can resign. Can I only change the nominee? Any particular combination is possible, provided you need to intimate the form you file is called as people INC 4. Is this clear? Can a OPC get converted to a private company? Public company? Is it possible? Yes, people, absolutely possible. Whenever they want, they can convert. Today, they register as a OPC. Tomorrow, if they want to convert, they are free to convert. Hello? Agreed? Okay. And it has nothing to do with limits or time period. They can convert whenever they want. Is this clear? All of you? And one more question that you guys will have is, whoever is a member of OPC, can he also be a member of a private company, a listed company? The answer is no limit. I can be a shareholder in OPC and I can be a shareholder in another 100 listed companies. There is no restriction. Is this part clear? Agreed? Yes. OPC, natural person, 180 days, cannot win an NBC convert. Done. Okay, yeah. Okay, next one, sir. Okay. Now, the next thing is people, with regards to another type of company, let us cover it off here only. The other type of company is called as government company. Now, tell me the definition of government company. What is considered as a government company? When now, my question to you guys, let us take, for example, there is a company called as LIC. There is central government who is holding 55% of shares, having voting power, not some random share, of course, having voting power. Now, is this company called as government company? Yes. There is a company called Company X. There is a state government of Karnataka. There is a state government of Tamil Nadu. There is central government. Karnataka is holding 15% in this company. Tamil Nadu is holding 10% in this company. Central government is holding another 15% this company. And this company is holding how much? 30, 40, another 15% in this company. Yes, I thought. Now they're asking you people, is this company, Company X, a government company? Taka taka. Online, no. Is this a government company? Tricky question again. Fast. It's not a government company. Will not add this. They logically think and answer. Is it a government company? Answer is people. This is not a government company. Why? The definition clearly says, what is the government company? Whenever there is more than 51 percentage, yes, so 51 percentage is held by state government, state governments, or state government and central government or central government. Anyhow, if the number is coming to 51%, now I will call this company as a government company. In that definition, people nowhere a government company holding 10 or 15%, you should add that also. Nowhere it is written in the definition. That's why we will not take this 15%. Understood all of you? Hello? But sir, let us imagine there is LIC. There is another company called Company Y. In Company Y, LIC is holding 55%. What will be the status of Company Y? This will be a deemed government company. Remember, always a subsidiary company of a government company. It's a serious problem, da. We'll change of the class if this is the case. ಅದು ಮತ್ತೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಶೋಕ್. ಇಲ್ಲ ಕ್ಲಾಸ್ ಚೇಂಜ್ ಮಾಡೋಣ. ಅಲ್ಲ ನೀನೊಂದು ಕೆಲಸ ಮಾಡಿ ಇದನ್ನ ಫಿಕ್ಸ್ ಮಾಡು. ಒಂದು ನಿಮಿಷ, ನಂಗೆ ಯಾವ್ದು ಮಾಡಿದ ಹೇಳು. ಐಪ್ಯಾಡ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲ ಇವಾಗ ನಿಂಗೆ ಇದು ಫಿಕ್ಸ್ ಮಾಡೋಕ್ಕಾಗತ್ತಾ ಇದು? ಅಲ್ಲ, ನಾನು ಕೆಲಸ ಮಾಡ್ತೀನಿ, ಅಟ್ಲೀಸ್ಟ್ ಇದೊಂದು ಚಾಪ್ಟರ್ ಮುಗಿಸ್ಬಿಟ್ಟು ನಾನು ಹೇಳ್ತೀನಿ, ಆಮೇಲೆ ಏನು ಮಾಡು. ಓಕೆ, ಅಲ್ಲಿವರೆಗೂ ಯಾರನ್ನೊಬ್ಬ ಇದು ನೋಡ್ತಾನೆ ರೀ. ಇನ್ ಕೇಸ್ ಹೋದ್ರೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಮಾಡಿಸ್ತೀನಿ ಅಷ್ಟೇ. Okay, so always remember a subsidiary of a government company will be a deemed government company, just like a subsidiary of a public company is a deemed public company. Same thing applies in both the cases. Okay, the next definition we can cover in types of companies, and another definition we can see is what is a subsidiary company? What is a subsidiary company? There is one company, Company X. Company X controls in Company Y. They are 5 directors. In that 5 directors, the majority of the directors appointment and removal is under the control of Company X. Then we call Company X is controlling Company Y because the majority decision makers of Company Y is in my control. Now I call Company Y as a subsidiary company of Company X. Now this is section 2, clause 87. Okay, when else a company will become a subsidiary company? There is a Company X, there is Company Y. If Company X is holding in Company Y 51% of shares carrying voting power, so total voting power. If Company X is holding in Company Y, I call this as a subsidiary company, this as a holding company. Scenario 1. Scenario 2, there is a Company X, there is Company Y, there is 51%. There is one more company, Company Z. Company Y holds in Company Z 20%. Company X holds in Company Z 35%. We call Company Z as a subsidiary company, Company X as a holding company. Why? Because the definition says, what is a subsidiary company? A company. What is the definition? Look at the words, whether on its own or through its subsidiary companies. See, singly, that is directly or together with its subsidiaries, controls more than 1/2 of the total voting power. So directly, if I am holding 51%, I am a subsidiary company. If at all I am holding through one of my subsidiary, I am also holding, they are also holding. You have to take it as a cumulative. Add and take it. Hello, Pakana. I hope you guys are able to understand. Okay, third scenario, sir. Company X holds in Company Y 51%. Company Y holds in Company Z 55%. Company Z is called as deemed subsidiary company of Company X. This is clear. So this is called as what people layers. The maximum layers allowed under the law is not more than 2. So this is considered as 1. This is considered as 2. The third layer people cannot be possible in our country. Huh? Okay. Now, is this clear? Hello? Okay. This is subsidiary company. Next one, sir, another connected section that we can do is called associate company. Definitely, what is the associate company definition? Section 2, clause 6. Very good. Section 2, clause 6 speaks about online on associate company. Now, what do I mean by associate company? When one company has significant influence in another company, but not a subsidiary company. Now, what do I mean by significant influence? Significant influence means at least minimum 20 percentage, but not a subsidiary. So I will take it up to 50 percentage. A company holding 20 to 50. I will call Y is the associate of company X. This is clear, all of you. And remember, even a joint venture is also included in this definition. What do I mean that? There is Maruti Suzuki. If it's a joint venture between Maruti and Suzuki, Maruti Suzuki is an associate for Maruti also. It is an associate for Suzuki also. Is this clear, all of you? Okay, done. The next definition we can also see here types of company can be small company. Now, what do I mean by a small company? Yes, sir. Now you guys can have a doubt. There is an amendment not at all applicable for you. So ignore. December 1st, the amendment came for May people. If you're watching in the May, then yes, the amendment is applicable for you. If you are watching it now, the amendment is not applicable for you. Now, what is a small company? Small. If you remember in the class, I would have told you. Today it is this much. In next 2 years, they will increase. They have increased. Pakka it was predictable. Now, people, small company definition. What is small company? First section, 2, clause 85. Now, these are all important. That is why I'm telling you the section numbers. Remember and go. Mark it wherever you're writing. This is important. Clear? Okay. Now, small company definition, sir. What is a small company? A company which is a company. The first thing, a company which is not a public company. So remember, there are 5 companies which cannot be called as a small company. Now see, we see this particular question in only one way and go. What is that? The limit we will remember and go. What is the other important thing? 5 companies can never be considered as a small company. What is that first one? Public company can never be considered a small company. Definition starts with that. Second one, subsidiary company can never be considered a small company. Third one, holding company can never be considered as a small company. Fourth one, a section 8 company can never be a small company. Fifth one, a company which is governed by any act of parliament or state legislature. I will just call it as a statutory company. These 5 companies can never be a small company. Clear? Okay, now come to limits. What do you mean by a small company? A company which is having paid up capital not exceeding 4 crore, turnover not exceeding 40 crore. Now, for people going for Jan 2026 attempt, this is the limits. Don't get confused. Now, for people who are sitting for May attempt, for you, this is not the limits. The limits will be 10 crore and 100 crore. Amendment came on December. The 1st of December is when the amendment has come. So for the people who are preparing for the May attempt, again I'm repeating, the small company definition is this. Is this clear? For Jan, don't worry, the amendment is not applicable for you. This is the limits. Clear all of you? Hello? Okay. And rest of the definition is same. Yes? Any doubts? ಏನಾಯ್ತು? All clear? Yes. Recently, that's what I think. Recently, that I put it on my Insta thing also. I think same thing only. Yes, sir. Okay. Next one, sir. Small company definition is done. What else company we can do? Definition. Section 8 company. What do you mean by Section 8 company? A company which is formed for promoting education, research, development, sports, charity, the list can go. So that is called as what people Section 8 company. Section 8 company, what is the main one essential thing? The company can never issue or declare dividend. That's one of the most questionable point. Now, again, I'm telling you, with the marathon, I'll also be telling you, remember some points are tricky in every section. Remember that and go. Now, what is that part? Revocation of licenses. Can a central government revoke the license given to the Section 8 company? Is it possible? Answer is yes. When will they revoke people? Whenever I have not followed the license, whatever is the section, whatever are the rules of the act, I have not followed it. The license given people will be taken back from me. Correct? Okay. Now, people, if the license is taken back, what will happen to the Section 8 company? This is also important. What is that? The company people, after revoking the license, the government can pass the following orders. What is that? First one, a company, wind up your affairs. So the company will be wound up. After Section 8 license only is revoked, what else will do? Second one, people, I can amalgamate with another company. For example, there is Reliance Foundation. I can tell you, you go and merge with the Infosys Foundation. At least let the cause continue. The third one, I will order for people. What is that? I will first repay whatever are the liabilities that is there in Section 8 company. There will be some payments to be made. I will tell first repay the money. Sir, still money is left. With that, what do? I will transfer that money people to the fund set up under IBC. It is nothing but people insolvency and bankruptcy fund. Hello? Pakka? Okay, sir. And that is the most important part in Section 8 company. This part, remember and go. I will tell you one more part also in Section 8 company. I'm linking it here only. Notice of general meeting. Minimum how many days notice is required? General company 21 days. Remember here 14 days. Clear? Clear days? Yes, Allah. 14 clear days. Remember. One more point again it is required. Tell me, where did you see? Proxy. Who can be a proxy in a Section 8 company? Can an outsider be a proxy? Remember, one more thing. Proxy provision is relevant for Section 8 company. The person who is also a member, only he can be a proxy in a Section 8 company. Whereas, in the other types of companies, you can be an outsider as well. Hello? These are the connected topics for your question. Remember and go. Okay, the next one, any other type of company? Okay, done now. Okay, let us go with again section 3 we saw. Now come to section 3A macha. Important 3A. People, most of the people have doubt here. What is that? Section 3A, 100 people again, even in doubts also you guys will ask me. Sir, 1st January 2026. Let us imagine this is a public company. Public company, minimum number of shareholders, how much? 7. Private company, OPC. Okay, there is a public company, XYZ Limited. This company has 7 shareholders, but on 1st Jan 2026, the number of shareholders have reduced from 7 to 5. Isn't it below the minimum requirement? Agreed. Now, are all the 5 people aware of this fact? Let us imagine. Answer is yes. All 5 people are aware that the number of members has been reduced more than the minimum requirement. The minimum requirement is 7. Now we have reduced to 5. Now people, if these 5 people continue the business for more than 6 months, now people, whatever contracts that are entered during that period, they are telling you, you will be personally liable. See, technically it is limited liability for a company. But they're telling you, if at all a company continues the business for more than 6 months, with number of members being less than the minimum requirement, the people, whoever are continuing the business and cognizance of the fact, look at the word cognizance. I am aware that we are continuing with less than the 7 people. Whoever are aware, let us imagine in 5, if you can prove only 3 were aware, 2 were not aware, the 2 will not be liable. Whoever are aware, 3, they will be liable. Exam question, they can ask you that part. Whoever are aware will be liable. And till today, they have not asked people. So the question is, let us imagine there are two contracts that the company has entered. One people on 1st May 26. Second contract people is on 1st August 2026. Now my question to you, the unlimited liability applies to which contract? What about the first contract? After 6 months, for the first contract also, will it be unlimited liability? No? I hope you guys understood the question. Remember people, until 30th June, still the rules will apply. What is that? The rules are people, it's a separate legal entity. Whatever are the debts or contracts entered by the company, company only is liable. When is that shield broken? Which shield? The shield of separate legal entity. When is it broken? It is broken after 30th June. From that day, you are liable. That's why unlimited liability attracts for the contracts entered after the 6 months period. Is this clear, all of you? If they are testing this in MCQ, remember and go. Now, why they have not asked till now? Because that during that period is a matter of interpretation. How do we read it is a matter of interpretation. Are you getting the point, all of you? Yes, online. I hope it is clear. Yes? Hello? Mitro? Okay, that's your main thing, section 3A. Done. Next one, people, is section 4. Okay. MOA, people. What is MOA? MOA people will have some clauses. What are the clauses in MOA? Tell me. One is called as name clause. Name clause indicates what type of company it is. Private limited, limited, OPC. Name it will be there now. So you will know what type of company it is. Okay, second one will be registered office clause. What will be there in registered office clause? Complete address, no. Only state will be there. Okay, third one. Object clause. It will say what is the objects of the company. People tell me which shifting of registered office. There are 4 types of shifting of registered office. But when will alteration of MOA come into picture? All 4 cases, state to state, ROC to ROC, ROC to ROC, you will alter your MOA. And state to state, you will alter. Agreed? Only one case it will come. That is state to state. Hey, ROC to ROC, same state, no? In MOA, what are you writing? Only the state name you are writing, no? Macha, alala, Coimbatore and Chennai are in which states? In MOA, what will be written? Tamil Nadu. Now, what is being changed? So, remember, Macha, MCQ question now. And whatever you wrote, all of you wrote. Yes, sir. So, remember and go. Important. So, only one state to another will always have a alteration of MOA. When people complain it's a tough paper, the questioning will be like this. Okay. Next one, sir. Object clause will be there. In object clause, the taka will do. What are the doctrines? Okay. What do you mean by there are totally 3 doctrines? There are totally 3 doctrines. Now, what are that? Now, there is something called as object clause of a company. There are 3 doctrines. What are the 3 doctrines? To give an example, ArivuPro is an educational consultancy. Our object clause says we are established to impart education. Now, people, can we do finance business? Now, the building next to us is vacant. Can we start a cafe just like that? Can we do? The answer is people, you can't say no directly. The process is call the shareholders for a meeting, pass a special resolution. Now in object clause, we have education, add a cafe here. Now you do, it will be valid. You can never stop a company forever. They can do whatever they want. Just that there is a procedure to be followed. Sir, what if ArivuPro, without passing special resolution, they start a cafe business? Now, people, we will call such contracts as ultra wires. Why? Because the company has gone beyond its powers. Your powers given by shareholders, meaning the power given by shareholders to directors was you do anything for education business, we will take care of you. If you do any other business, we will not take care of you. So if you go beyond that, we will not be liable. Agreed? Okay. So if at all a company is doing any ultra wires act people, for that the company will not be liable. It will be the liability of the directors. This is clear. But provided, remember, the company should have not made use of that money. That means what? We have borrowed some money for some cafe business. It's an ultra wires transaction. For this, the company will not be liable. Agreed? Now, education, ArivuPro goes and borrows from someone 10 lakh rupees for starting a cafe. We clearly write in the agreement a MOU between ArivuPro and Mr. X to start a cafe. You're giving us a loan of 10 lakh rupees. Now, this is it valid on ArivuPro? Generally, answer is no. But let us imagine ArivuPro took that 10 lakh. Using that money, there were some GST payments that ArivuPro had to do at that point of time. We took that money, we repaid it off. Now, what do I do? Is ArivuPro liable? We took money for cafe business, but we used it for our personal purpose. Is ArivuPro liable? Answer is yes, you are liable. They can ask you this part in the exam, even though it is ultra wires. Is a company liable? Company is liable because you took the benefit of it. Are you getting the point? Hello? Okay. The next type of contractors. What is that? Doctrine of indoor management. Okay. What do you mean by indoor management? Anything that happens within the company, outsiders will not be aware of it. How will outsiders know what happened within these four walls? Now this is only called as doctrine of indoor management. We try to protect the outsiders from the company. Outsiders are protected from the company. We call such thing as people doctrine of indoor management. The last one is called doctrine of constructive notice. Now, what do I mean by constructive notice? Remember, any form that is filed with ROC, we assume that it is sitting in a public domain. Whether you know it or not, people, you are liable. Anyone who enters into a contract with the company, it is assumed that you have read all the documents of the company, let it be MOA, AOA, any other public document. If it is filed with ROC, it is assumed that you have read all those details. Now remember, doctrine of constructive notice always protects the company from the outsiders. Simple. Hello. Okay. Now that is the object clause. Next, the what else clause is there in MOA? Liability clause. What does liability clause indicate? It says whether the company is limited by share, limited by guarantee, unlimited company. What do you mean by company limited by share? The liability of the shareholders will be up to unpaid calls, if any. If at all there is any partly paid share, my liability will be there until I completely pay it. What do you mean by company limited by guarantee? What is there? 1 second done. Okay. Hey, online off. Still nil not wrong. What did we see? Limited by guarantee. What do you mean limited by guarantee? A company is limited by guarantee when the members of the company they agree to be limited by guarantee on the last day of winding up. If company does not have money to pay the outsiders on the last day, if your money is not sufficient, if the company's money is not sufficient, people, then the shareholders will say, that day we will come and pay. Today we will not pay. That day we will come and pay. Such type of company is called as people, company limited by guarantee. And the last one is called as people, unlimited company. Remember, in an unlimited company, the shareholders only are coming and telling, we will agree to be liable, unlimited. But remember, people, outsiders cannot come and directly file a case on the shareholders. Outsiders should first approach the company. The company will recover the money from the members and the members will pay to the company. The company will settle to the outsiders. They can question you even on this process. Can the creditors directly sue the shareholders? Answer is no. They have to sue the company. Company's duty is to recover the money from the shareholders and give it. Directly, they can never file a case. Is this clear? Such type of companies are called as companies limited by unlimited company. Clear, Ram? Hello? Hello? Okay. Now that is done. And next, object clause. After object clause, liability clause, capital clause. What is capital clause done? Authorized capital. What is the maximum capital of company? That is called capital clause. Next one is called as people. Subscription clause. Subscription clause is nothing but people. The number of shares the initial shareholder subscribed. This is going to be the same forever. It will never change with the company's time. This will just tell who are the initial shareholders. The last one people is called nomination clause. Nomination clause will come in the case of OPCs. Clear? Yes, sir. Okay. Next one, sir, articles of association. Articles of association, what is that, sir? Internal rules and regulations of company. What is the important point here, people? Is entrenchment possible? Remember, they can build any case-based scenario on entrenchment. What do you mean by entrenchment? Entrenchment of articles of association means nothing but making the articles more stricter. What do I mean by that? ICAI has clearly said the passing marks for you people is 40 marks. Now, what do I do? For you to pass in ICAI exams, I will say if you score 50 here, people, then there are high chances for you to score there 40. I will put a condition that all our internal tests, the passing marks is 50. Now I'm making the law more stricter so that I will cover this also. And I will also cover your main purpose also. Now, in the same way, people in a company, let us imagine the minimum number of directors in a public company is 3. But my articles of association is telling in my company, the minimum number of directors will not be 3, it will be 7. Then people that will only apply. Now, for example, the quorum. In the case of public company, having say 800 shareholders, what is the quorum? 5 members personally present. My articles of association says for your quorum to be valid, at least 10 members should be present. Remember, whatever is given in the act, whatever is given in the articles, whichever is higher, that will prevail. So my quorum will be 10. Hello, Pakka, understood? Okay, this making the law more stricter to the company is called as what, people? Entrenchment. Now, what is the other important question? How do I entrench the articles? Entrenchment can happen in 2 types. One, before incorporation only. At the time of incorporation only, you will make all the rules stricter. Easiest way. Second one, people, in the case of existing companies, how will you make the entrenchment? Depends upon type of company. If you are a private company or a public company, remember, people, if you are a private company, all the shareholders have to agree for doing this entrenchment. That means what? In my company, if 20 people are there, I'm expecting all 20 to agree for this. Sir, but if at all it's a public company, pass a special resolution, that is sufficient. Remember, important point, they can question you. Write it down somewhere, questionable point. Clear, all of you? Okay, okay. There's articles. Okay, next one, people. Section 6, Act to override MOA, AOA. Now, what do I mean by that? Just a simple draw 3 circles. This is called as what, people? AOA. Always remember, MOA is more superior than AOA. And always remember, Companies Act is more superior than AOA. Of course, in some cases, the Act only would have written follow whatever is written in AOA, not mine. That time, yes, Companies Act is telling AOA is superior than me. When company law only says, example, quorum, I am only telling you that you follow what is prescribed in your articles, not what is prescribed here. Then yes, AOA will override Companies Act. Hello, clear? Okay, these 3 circles only is called as what, people? Section 6. Sir. Is this clear, all of you? Hello. Okay, next one, sir. Section 10, sir. What is Section 10? Nothing but people. Whenever you register your company, there will be two things. First thing, people, the what is that? You will become an artificial person, separate legal entity. All that thing will come. And the next one, people, the companies will be liable to the members. Meaning, after the registration of a company is done, the company will be bound to the members. The members are bound to the company, and the members are bound to one another in some cases, not generally. In some cases, they are bound to one another. Sir, what do I mean by this? Company is liable to members. What do I mean by that? Simple. If at all, I have clearly said in my articles of association that, say, for example, we will conduct, or let us take like this. If at all there is a dividend declared, you have to pay it to the every shareholder. I cannot say I will not pay to you, I will not pay to you. All those things is not possible. Once a company is registered, whoever is your shareholder, it is your duty to pay dividend to everyone. Company is liable to its shareholders for many reasons. What and all you are liable to pay dividend, to give notice of a general meeting, to give you guys the financial statements, to call you for a meeting. You have a right to vote. All of that, the company is liable to the shareholders. Sir, next one. The members are liable to the company. What do I mean by that? If at all there is something in AOA, people, if you guys have all agreed to become a shareholders of the company, whatever are the restrictions there, that will apply to you, provided it does not kill the basic nature of the company. For example, public company, I told you, I cannot restrict the transferability because it is a basic right of a public company shareholders. That I cannot take it away from you. For example, people, there was a case where a company called XYZ Limited, in that they have written, people, in its AOA, it is written that whenever any shareholder becomes insolvent, his shares will be sold by the liquidator or the assignee. At what price it will be sold will be decided by the company and not by the member or the liquidator. This was written in the Articles of Association. Now the question is this clause valid or invalid? In one of the case it was decided it is valid, because whenever a company is registered, if you guys become a shareholder, remember people, whatever are the conditions in that particular articles, you are abiding all of that. You are bound by all of that. It is clearly written in the articles. If at all a shareholder becomes insolvent, then the price will be decided by the company. It is written. You became a shareholder. Now the price will be decided by the company only. Are you getting the point? Yes. Hello. I don't know if you guys remember or not. There's a case law also. There's a case law. Borland's trustee versus Steel Bros and Company Limited. Whatever is the case, I just told you. That's the case law. Remember, of all, this can be a little important. Here, hello. Now, are the members bound to members? Generally, no. Because if I say yes, sir, it will become mutual agency concept. But there are some exceptions. Yes. So whatever one member does, generally other member is not liable. But there are some exceptions. Yes. Hello. Okay, done. Now, sir, that is your section. And the next one, sir, let us see section 7, incorporation. Now, whenever I'm incorporating a company, how do I incorporate a company? Procedure to incorporate a company. Now, in incorporation also, people, remember, there are certain important aspects, sir. Some important points are there. Okay, incorporation of a company. First of all, what are the forms that we use in incorporation of a company? Remember and go. What are the forms used in incorporation of a company? These are the forms incorporated in a company. Now, what is that? The first one, people, we use something called as SPICE Plus. This is nothing but simplified pro forma of incorporating companies electronically. In this, you will give all the details of the company. Along with that, I will file form INC 33. It is nothing but MOA. Along with that, I'll file something called as INC 34, nothing called AOA. There is something called as INC 8. What is that? Macha, this is why we are studying so hard. It is called as people, professional declaration. What do I mean by that people? People, someone has to come and tell, do you guys know what is the meaning of this? This is how all our professions took birth. Why did our professions took birth? Let it be any three sister professions. The government on the top was becoming overburdened. Now I'll tell you in your case, the companies, every company, you will all file financial statements in one time of the month. Now you can imagine central government's duty is to check all those financial statements because they should know whether you're doing fraud or not. Practically impossible, huh? More than there are 50 lakh companies in India. Hey, can central government Nirmala Sitharaman check out everything? Ministry of Finance, MCA will check every letter by letter. Possible? Definitely not possible. There is one institute who came and said, central government, don't worry. I will take your burden away. First, I will check all the documents. If at all I check, then remember, you need not check. We took that responsibility, and that is when our signatures became declarations. That is when our signatures became certifications. And that is why people, your liability became from fine to imprisonment also. Yes, sir. Remember, with responsibility comes power. With power comes greater obligations. Yeah, because people, all these forms, spice form, there will be a declaration. Whatever is the information is given in this form is true. And I have checked it, I have verified it. You are giving a declaration. Our profession was formed for the purpose of reducing the burden of central government. Sir, we will check the financial statements and file. You, sir, kaiku tension. Sir, tension kaiku. Why tension? Correct, huh? Now, people, when we say so much, then of course we should be in tension now. That is what is this. That's why people declaration is coming. INC 8 is declaration. There is an oath, promise, pinky promise you guys do. Sir, मैं जो भी कहूंगा सच के सिवा कुछ भी नहीं कहूंगा. Whatever I'm saying, that is truth. I'm not saying anything apart from truth. I'm making a statement. Remember, if I'm going wrong here, that means I'll be liable. Is this clear, all of you? Pakka, understood? Okay, what is INC 9? INC 9 is nothing but people, a declaration given by the subscribers and directors. What is this declaration? Simple. I am not forbidden or I am not prohibited from forming the company or formation of the company in this country. So there is no rule, there is no order prohibiting me. I have to give a declaration. And one more thing I'm just telling you, I have to give a declaration, sir. I do not come from a country that is sharing land border with India. I have to give a declaration here. Remember that China amendment I would have told you, that will come here. So I have to give a declaration that I am not coming from a country which is sharing land border with India. If you are coming from such country, you have to come and invest in this country only after central government's approval. Directly you cannot come. Hello. Understood? So China, Pakistan prohibited only. We don't have them. It can be Nepal, Bhutan, all these places. If you guys are coming, you have to only come after CG approval. Clear? That's the declaration I'm giving here. Hello. Okay. Now one more important question I'm telling you here will come from this part. What? Very, very important. Remember. Now people, I'll tell you. Now people, MOA, if it is individuals people, that is three individuals are forming a company, then those three people will sign. But there are different types of people who can come and form a company. Agreed? Sir, what do I mean by that? Let us imagine three individuals can come and form a company. Easiest way. He will sign, he will sign, he will sign. Done. MOA in subscription clause. All these three people will sign. The easiest way of incorporation. Now see, the other question was asked was, sir, in this, two people were Indians, but sir, one person was a foreigner. Can happen, na? Yes. Now, sir, who should sign in the case of foreigner? What will be the additional process? Second one, sir. Sir, company A, company B, they together came and formed company C. Who will sign the MOA? Sir, third one, company A and LLP formed a company. Can they form? Possible. Who will sign the MOA? Now, these are the questions. Important exam point of view. Remember and go. Now, what is that? If at all there is a normal person, we don't have a problem. He will only sign. There is no problem. Now, sir, let us imagine in this, one person is a illiterate. He does not know how to sign. Now, what is the condition? He will put a thumb impression and one other person, see, he will put a thumb impression. What is his name? How many shares is he taking? How do we know? There is someone else who should fill that for him and he should sign. What do I mean by that, sir? Let us imagine A is an illiterate. A will put his thumb impression. On behalf of A, other literate, any other literate, he will write the number of shares this person has subscribed, his name, and this person will sign. Understanding? They have asked this question. Very tricky. Once they have asked. Clear? Getting the point? Whenever there is other than individuals who can sign the MOA, there are these permutations. Remember, important from exam point of view. Yes, now what is that telling you here? Where a subscriber is illiterate, he shall affix his thumb impression. Agreed? Okay. Which shall be described as such by the person in writing for him. Someone has to tell he is illiterate and hence he is put his thumb impression. Who shall place the name of the subscriber? He will write. His name is Mr. A. Against or below the mark and authenticate by his own signature. They have asked. Hello. How they have asked? A 5-mark question. MOA. They have given you 4 sub scenarios. Scenario 1. Illiterate, a subscriber. How will he sign a MOA? Company, subscriber. How will they sign a MOA? Very important. Tricky if you ask me from the exam point of view, no and go. Hello? Getting the point? Okay. Next one, sir. Note where the subscriber is a body corporate. Body corporate can I say company? Yes, LLP will again come. LLP partner will sign. In case of a body corporate, my director, officer, or employee of a company, anyone can sign. That means what, sir? Let us imagine company A is a shareholder in company B. Can company A sign? Can company A sign? No. Company A will nominate its director. Even if it is there, you have to nominate. Why? I'll tell you. Because tomorrow, if at all you have to attend the meetings, you remember authorized representative, that person will be this person. Understanding? Because it's a lifeless person. Who will attend the meetings then? So whatever we see later will come here. Hello? What it? Now see, the memorandum and articles shall be signed by director, officer, employee of the body corporate, duly authorized in this behalf by a resolution of the board. Very important. What is a guarantee that this director only can sign? So remember, people, very important, concentrate. There is company A, no? Hello? In company A is a shareholder in company B. Company A will conduct one board meeting. In this board meeting, they will pass one board resolution. In this board resolution, they will nominate Mr. A as their authorized representative. Now, this board resolution should be given in company B's incorporation because power of attorney, randomly a person cannot come and sign on behalf of company A. What is the guarantee he has right? Hello? He will get a right through board resolution. This is important. This word should be there in your answer. Hello? Understanding kada? Okay, next one now. Sir, what if LLP is a part, LLP is a shareholder, then it shall be signed by a partner of the LLP, duly authorized by a resolution approved by all the partners. All. Hello? These will become tricky in exam. Now they will question majority approved. Or what if LLP is a shareholder? That's when it's just paper difficult, sir. We just saw subscriber to MOA and we went. Hello? Okay, next one's here. Macha, this is even more important. Read this note. In either case, C or D. What is C or D? C is body corporate, D is LLP. Stated above, the person so authorized shall not at the same time be a subscriber to MOA and AOA. What do I mean by that? They are telling you company A has sent its director. Let us imagine Mr. Nayan is a director. Yes, sir. Now what they're telling you? Mr. Nayan is the authorized representative in company B. Now Nayan should also not be a shareholder in company B. If I'm already a shareholder, I cannot again be an authorized representative on behalf of the company. My name should not already be there. Such people only you guys can nominate. That's the meaning of it. Are you getting the point? Again, I'm telling you, company A is sending one of its director as authorized representative. Now, who? Mr. Nayan. Now, I'll ask Nayan, Nayan, do you have any shares in company B? Nayan says, sir, yes, sir, I also have 10. Ayyo. Then people, Nayan cannot be authorized representative. You need to send someone else. I will send Vaishak. Now, okay, okay. Hello? Clear? Yes, sir. Possible exam question. Remember and go. Next one, sir. Where subscriber to the MOA is a foreign national. See, foreigner is coming. Hey, macha. Hey, first of all, you tell all of you have Aadhaar card. Are you all staying there only? No, sir. See, we are such a humble and natural and citizens of India. Yes or no? Now, people, now you think. In the case of Indians, it's okay. If it is a foreign national, what will you do? How do you know where this person is from? He's given his ID proof, address proof. Are you sure that he stays there? That's why what do we say? Macha, if you are coming from abroad, then do one thing. If you are residing abroad, then you have to get your documents notarized by a notary public. That means what? He is an officer appointed by their government. You go there, he will say, okay, he has a right to stay. This person is from this place. I am assuring you. So if their country notary public agree, then I will take it as a valid proof here. If not, I will not take it. Hello. Example, let us imagine someone, Thor. Thor wants to come and become a shareholder here. I'll say, Thor Anna will not believe you are from foreign. Prove us, where are you from? He will take his ID proofs to this government. He will go to notary public. He will get it certified. That certified copies he will submit. Now he will say, okay, now I'll make you a shareholder. Getting the point? These words are important. Notary public. And see here, further, if such person is residing in a country outside the Commonwealth or which is not party to a Hague Apostille Convention, the certificate of notary public shall be authenticated by diplomatic or consular office. Now, what do you mean by that, sir? Imagine people, there is something called as a treaty. All our governments have signed. Sir, some governments have not signed, like Pakistan. Now, you are not a person treaty to this Hague Convention. This is called Hague Convention. If you are a person, what they are telling you? Now, see, if such person residing in a country outside the Commonwealth or Hague Apostille Convention, then what are they telling you? Let us imagine you are coming from a country. You're coming from a country which is party to a Hague Convention, not party to a Hague Convention. If you are coming from a country which is entered this treaty, Hague Convention, then people, the rule is simple. What? Just to get the notary public sign, more than sufficient. Sir, no, I come from a country not party to a Hague Convention. Then notary public also required. In addition to that, I need to get it from the consular office. That is what is given here. See, diplomatic or consular office. So notary public also becomes important. Because you are not party to that. I need more authenticity. I don't want to compromise. So I'm saying more stringent provisions for you. Getting the point, huh? Hello? Understood, huh? Yes or no? Okay. Next one, sir. What are they telling you? Where the subscriber to MOA is a foreign national. Again, foreign national. But they're telling you residing outside India, but resident in India. What do you mean by this? Sir, Thor only. But he came to India for incorporation purpose. He's a foreigner only, da. But when all of this happened, he's not from outside. He has come to India. He's following all the process while he's in India. Now you are seeing Thor in front of your eyes. They're telling you then, okay, you need only one document. This Hague Convention are not required. Then you only need his business visa. Do you have power and right to come to our country and do business as per your passport, as per your visa? Are you allowed? If answer is yes, then come and start it. If answer is no, then go back. So I'm again repeating, if at all you're a foreign national, there are two scenarios. One, you are outside only. From there only you are registering. One, you have come to India and you are trying to register. If you are from outside only, then check whether Hague Convention or not Hague Convention. If Hague Convention people, only notary public. No Hague Convention people, notary public and diplomatic or consular officer. And if at all is a foreign national but visited in India, then you will demand for a business visa. All these conditions important, very important from exam point of view. Hello. Okay. INC 8, INC 9, done. INC 9, you'll say I'm not convicted. But subscriber memorandum. Okay. That's all. So if you file all of these people, you will get certificate of incorporation. In that, what all details will be given? Name of the company will be there. What is the date of birth of the company? SIN, corporate identification number, and whatever are the, in addition to that, PAN numbers will come. All of that, address of registration, name of the company, all of that will be present in this certificate of incorporation. Then, okay. Next one, sir. If at all the company has given any fraudulent information and if they have formed a company, then what will happen? If company has been incorporated by giving false or suppressing material fact or fraudulent action, then NCLT may pass an order for regulation of the management. That is, all you shareholders, directors, you come down. I will replace it with my directors. I can even alter MOA and AOA, make these changes in MOA and AOA. Next one, I can even say from today, the shareholders liability is not limited. It is going to be unlimited. I can pass that order whenever I have formed a company by giving fraudulent information. What does that fraudulent means? I've given fake Aadhaar card, fraudulent information. Next one, I can direct the removal of name of the company, that is nothing but strike off, or I can even pass an order for winding up of the company. I will, of course, give an opportunity of being heard for the other party. Only then I will take a call. Agreed? Hello? Okay. And next, effect of registration, I told you, we'll have perpetual succession, common seal and all of that. Is common seal mandatory? Yeah. Okay. What is section 10A? Certificate of commencement of business. Okay. When is it applicable? So what does section 10A say, people? Commencement of business. Declaration is to be filed by the director within 120 days of incorporation. That two conditions are satisfied. What is that? Whoever are our initial shareholders, they have paid the subscription amount. Sir, there were 3 shareholders who have taken 10,000 shares. The face value of the company is 10 rupees. Sir, they have paid 1 lakh. As a director, I'm telling you, no, they have paid 1 lakh. So it's a declaration filed by our directors within 180 days of incorporation. Remember, one is that. Second one, sir, that the company has filed its registered office address with ROC. Sir, we have received money as well as we have filed our registered office with ROC. These people should also be certified by a PCA, PCS or a PCMA saying that we have also verified. So people, if you guys are verified people, then yes, sir, ROC will issue certificate of commencement of business. Now you guys can carry on, start the business. Until you get these people, you cannot start the business. Agreed? Yes, sir. Okay. Sir, what if I do not file this certificate of commencement of business? What will happen? It may lead to strike off. Failure may lead to strike off. Mean penalty or removal of name from ROC. Clear? Hello. Okay. Next one, sir, is section 11 is omitted. Section 12. What is section 12? Shifting of registered office address. Shifting of registered office people can happen in what? Four ways. What are the four ways? One people within the local limits of city, or section 12 is registered office address, which says that at any given point of time, you have to always print the name of the company, the address, all of that in front of the company, that is on the board, on your invoice, on all your billets, invoices, letterheads, seal, in all these places, the name has to be printed. That is section 12. And remember, if at all you are not carrying on your business in that place, if ROC conducts an inspection, now imagine we have said ArivuPro is doing its business in Koramangala. If at all I am coming to Koramangala, and if I am seeing ROC conducts an inspection in a Koramangala, Arivu is not there, it is one of the ground for strike off. So in address you have given, you should be present. And remember, people, it cannot be just a PO address. PO address means what? A post office address. What do you know that postal address means? In this place, I'm not there. I've just told the owner, sir, if at all any letter comes, you give it to me. There has to be one physical person on behalf of you who should be present at that address to take any notices or anything that is sent to you. There should be one person to receive it. Hello, clear? Hello. Okay, next one. Outside the local limits, but within the same ROC. That is, sir, say for example, from Bangalore to Mysore. If at all we are shifting our registered office within same state, within same jurisdiction of ROC, I will just pass Board of Special Law INC 22 is the form we need to file with ROC. Next one, sir, from one ROC to another ROC. This can happen in two scenarios. One in the case of Tamil Nadu, one in the case of Maharashtra. Sir, what is the procedure, sir? Board of Special Law, RD approval, and INC 22. The last one, sir, is from one state to another state. In this case, sir, what is happening? I'm transferring my address from Karnataka to Tamil Nadu. Now, what is happening, sir? I need to take approval of Board of Special Law, CG. Again, the power is delegated to RD only. Remember, one more approval also will come. What is that? I need to take the creditor's approval. That is, people, I should have either repaid their money or they have to give me a no objection. I don't have a problem if you are going from Karnataka to Tamil Nadu. They have to give me a no objection. Hello? Are you getting the point? And one more thing, people, there is one declaration you have to file. Employees are not removed from my company while I'm shifting from Karnataka to Tamil Nadu. You have to give a declaration. Very, very important. You should not remove your employees while you're shifting from one state to another. Is this clear? Hello? Okay. That is your shifting of registered office. Okay. Alteration of MOA. And what else is there in alteration of MOA? Object clause can be altered. Huh? Yes, sir. How do we alter? First, you pass a special resolution. Agreed? Huh? But there is one more section also which you can read here. Let us imagine, people, there is a company, say for example, Zomato Limited. They raised 9,000 crores by issuing prospectus to public. They raised 9,000 crores by issuing prospectus to public. Now, in this prospectus, they have clearly told people this 9,000 crores, we are going to use 4,000 crores for business expansion. That is, we will start more and more hiring people. We'll have to invest on something. They have said we are going to invest this money for expansion. In this, people, another 2,000 crores, we are going to use it for people. Say, for example, marketing expense. Another, so like this, I've given a complete breakup. Now, people, whatever we wanted to achieve, we achieved it, people, in the 7,000 crores only. The rest of the 2,000 crores is pending. The company wants to use this 2,000 crore now. Delivery business is achieved. We achieved everything. We wanted to use this money now to do Blinkit, which is not a, what do you say, food delivery. It's a dark store. It's a shadow store. Now people, Zomato, can they just call the shareholders for a meeting? Can I just pass a special resolution and can I add? We will be starting Blinkit. We will start delivering the groceries also. Just like that, can I add of this? No. One more section will apply. Which section? Section 27 will apply. As per section 27, tell me what all conditions are applicable. Whenever a company has raised money by issuing prospectus, that word is important. So we have raised 9,000 crore and it has some money left. If it wants to use that money for some other purpose, then the company has to issue a notice, call the shareholders for a meeting. I have to pass special resolution. But if the shareholders are not okay, 90% of the people said okay, 10% of the people said no, we are not okay. Then we have to give them exit opportunity. What do I mean by exit opportunity? The promoters or the controlling shareholders, they should be able to buy that 10% and send these people out. That's called exit opportunity. Okay. And second thing, okay, sir, I will take 90% of the people approval. Now, what am I using this money for? I will use this money for buying equity shares of a listed company. Can I use it? Can I use it? This is prohibited. Remember, you cannot use the money for investing, trading, or dealing in equity shares of listed company. Is debentures given? No. So do you want to do? Who cares? Sir, what if it's an unlisted company? Is that covered in 27? No. So who cares? Do it. Only equity of a listed company is covered. Hello? Pakana. So I have to give an exit opportunity and I have to give them, what is that? This prohibition is there. I cannot use for this purpose. And postal ballot. Hello? Pakana, section 27. Done. Remember, important. Clear? Okay. Next one, sir. Alteration of name clause. Can I alter my name? Possible. How do I alter? What is approval? One is voluntary. How do I do voluntary? Pass special resolution and anyone's approval is required. CG approval is required. Remember. Yes, sir. Okay. Next type of alteration. What is the next type of alteration? Mandatory. When will mandatory come into picture? Whenever there is rectification of names, sir, section 16. If the name of the registered company is identical or nearly resembling the name of already existing company, LLP registered trademark, then people, an application shall be made by the trademark holder within 3 years of incorporation. That means what? Say, for example, Zomato. Now they changed their name to Eternal. Their trademark is still Zomato, but they changed their name to Eternal. Now what I will do, sir, I will apply for Zomato name. Can I do it? Their name is not Zomato, no, today, but their trademark is Zomato. They can file an objection within how many days? Within 3 years of this dummy company or duplicate company getting registered. Hello? Sir, now what will central government do? If central government is satisfied people, central government will pass an order. From the day central government passes an order, within 3 months, they will have to change their name. How will they change? They will have to file an application. That application is called as run. They'll have to search for a new name. Run stands for reserve unique name. I will file this form and I will reserve the name for a period of 60 days. Is clear? Now I will pass a special resolution. I will change my name accordingly. Sir, what if I do not change the name within 3 months? Central government only will allot a new name. And that name is something which you will not be proud of. Yes, sir, the name will be weird. It will be clearly written. The central government order not complied. And the series number, whatever is the notification number, that will be there. Limited. Will be the name of your company. So you will not like it. Sir, even after that, can I further change my name? That is possible. Here, hello. And remember, people, central government so moto they do not have this 3 years period. Whenever a registered trademark holder files, you have to file it within 3 years. What if central government on its own wants to tell you to change your name? This 3 year condition will not apply. They can file whenever they want. Whenever central government passes an order, you have to change it within 3 months only. I hope you are understanding this. Important, remember. Here, hello. Okay, next is okay. Object clause, like the name clause, shifting of registration clause, that's the main thing, no? Capital clause, let us see when you're doing section 61 only, correct? Uh, liability clause can be changed, yes, sir. Subscription clause can be changed, you can never change it. Okay. Next one, sir, is can a conversion happen? Answer is yes. Let us do section 18, huh? A company may convert itself into some other class of company by following the law. Can you convert? Yes, possible. How? For example, company limited by share. Can I convert to company limited by guarantee? Possible. Can a private company convert into a public company? Possible. That is what is section 18. You're lucky there are no rules. So don't worry, forget. Yes, sir. But technically, if you see, there are rules. How to convert private company to public, public to private, limited to guarantee, guarantee to unlimited. Everything is rules. That is not there. So nothing to worry for us. Leave. Next one is section 19. What is section 19? Hello. A subsidiary company. Sir, what does section 19 say? They say if there is a holding company, if there is a subsidiary company cannot hold shares in its holding company. But there are three exceptions. That is, even in these cases, a subsidiary company can hold shares in holding company. What are three exceptions? The first one is people, you are holding it as a legal representative. What do I mean by that? Imagine like this. There is a company called as company X. There is a company called as company Y. Now, people in company Y, there was a shareholder people. This person he is holding 50, or say, for example, I'm having 5% of shares of company Y. Now, company X is holding 51%. I've clearly written upon my death, all my shares will get transferred to company X. I've clearly written it in my will. Now, people, this is only called as people acting in the capacity of legal representative. Meaning, I'm clearly telling upon my death, company X will become the shareholder. Sorry, ulta mancha. The 5%, imagine I was holding it here. I'm telling upon my death, the company Y will become the shareholder. Whatever 5% I was holding in company X, that will be transferred to company Y's name. So who will do like that and all, sir? Hundreds of people have done. Tata has died. Ratan Tata ji is no longer alive. Where are his shares? It is the name of so many companies. It's the name of foundations. Some are in the name of charities. So it is possible. It's not always individuals will pass it on to individuals. Bill Gates, he has formed something called as Gates Foundation. Upon his death, 80% of his assets will go to Gates Foundation. 80%. Possible. Not everyone will be like you and me people. At least not like me. Yes, sir. Second one, people, as a trustee. What is this as a trustee? General. So let us imagine there is company X, there is company Y. This is a holding company, this is subsidiary company. Now, company X people, again, people will have doubt here. That's why I'm explaining you. Now, what is this? Because a case-based scenario may come. There's company X, there is company Y. In company X people, there are employees. Correct? Huh? Now, for these employees people, company X wants to give ESOP. Correct? Huh? Now, who will take care of all of this ESOP and all? Company X, what will they do? They will form one trust. Example I give you, Infosys has a trust called as Infosys ESOP Trust. They will do nothing but people. They will monitor ESOP. They have 2% of shares in this trust. What will they do? If at all any worthy employee comes, they will allot that share. Are you getting the point? Now the question is, sir, who is taking care of this trust? What will company X do? They will nominate company Y as its trustee. The administration, the monitoring, everything will be done by company Y. Now, people don't think if I become the owner of this trust, and what you are doing, you are giving me 2% of shares. So your shares I am holding. No, can I hold? They're telling you if you are holding in the capacity of a trustee, it is allowed. Understood? Hello? Okay. Third one, sir. A prior only I'm a shareholder. Company X, company Y. Company X acquired in company Y people 55% on 1st June 2026. But company Y already had shares in company X on 1st Jan 2026. We can continue to hold. We don't have a problem. Another questionable point is that can I vote? In two scenarios, you can vote. In the third scenario, you cannot vote. Can vote, cannot vote. Hello. Simple. Okay, done. Next one, sir. Section 20. What is service of documents done? If at all you want to give any documents to the company, or company wants to give any document to the shareholders, how will you guys exchange these documents? The first one is, if you want to give any document to the company as a shareholder, you want to give some document to the company, how will you give? They're telling you can give it by registered post or speed post. Second one, you can give it through courier. Third one, you can give it in registered, leave it at registered office. That means what? Go and give personally. Fourth one, people, any other electronic means. People remember, people, the mode in which documents may be served on the company or on the members and also on the registrar is as follows. Correct? Have I given here anything as prescribed in articles? So articles cannot restrict my right. Remember, exam point of view, there can be a question. Meaning, if at all the article says you have to give, let us imagine a shareholder wanted to give one some information, some intimation. How should he give? The article is telling you should give it only by email. Can they tell? Answer is no, because the law has not given the right for that section. So the shareholder has a right to give it by registered post or speed post or courier or personally giving it or email. Anything is allowed. You can't stop that right. One MCQ question. 70% of the attendees in this exam wrote wrong. That means something is there. Remember and go. So when we saw section 6 only, we saw if at all the section gives you the right. For example, quorum. Unless otherwise given in the articles, your quorum will be 5, 15, 30. If it is given in your articles, you follow. If not given, you're not supposed to follow. Agreed? So entrenchment is always subject to the section. For example, tell me proxy form has to be given within how many days? I am not coming, I am sending a proxy. 48 hours. Can the company say you have to give your proxy form 72 hours prior? Because the section clearly says whatever is given in the section is final. Entrenchment cannot happen. If the section says that, you cannot entrench. Clear? Okay. Next one, people. Serving of documents to the member or registrar. The company wants to give some intimation to the member. Hey, imagine the notice of a meeting. How do you want me to give? They're telling you can give it by post. That is the only additional thing. Rest of it will be same. Sir, what is the difference between post to registered to speed? Remember, speed means zoom. Registered means post means what is the difference, sir? One class, that is what the example they are giving me. Sir, speed post will go fast. Registered post medium. Post to test match. That's what people remember. People speed post is speed post. That you know, faster. Registered post is that something that comes with an acknowledgement. Imagine, exactly, if at all your bank is sending you a debit card, after you take it, you sign it. The postman will demand you to sign. That's called registered post. Why will we send it by registered post? We need proof of delivery. That's why we say registered post. Post comes with nothing, no obligation. That is the post which will not be there in front of your home. It may be there in front of your neighbor's home also. No, I'm just kidding you. But yes, understood? Huh? Okay. People, but remember, if a member has requested for any particular mode, I'm clearly telling, I want it through speed post. But the company is following a methodology of email. If a particular shareholder is demanding in any particular medium, the company is liable to take up that order. You have to do it. Only condition is that people, they are telling you, you need to bear the cost of the delivery. Now, if it is physical, if it is costing me 50 rupees more, that delivery cost is on you. Printing, physical, it's on you. That cost is on you. And one more thing important, sir, in the case of Nidhi company, imagine people, a company wants to send a notice of a meeting. Very, very important. What is that? In case of a Nidhi company, how will we give a notice? There is another medium that is coming, people. Technically, what and all we saw? We saw only it should be registered post, speed post, courier, personally giving or email, electronic mode. But in Nidhi company, one more thing is coming. What is that one more thing? They're telling you discrimination, no right to equality. What is that? If at all there are two types of shareholders. Sir, this shareholder is holding how many shares? Let us imagine, people, this person is holding 2 shares. Face value is 10 rupees. He's holding, or let us imagine, people, this person is holding 10 shares. Face value 10 rupees. That is, people, he is holding 100 rupees. Correct? Huh? Hello? There is one more shareholder who is holding 100 shares. Or let us imagine 150 shares. Face value is 10 rupees. That means 1500. Yes, sir. Now the question is, when a Nidhi company is coming up with a general meeting, they have to give notice of a general meeting. How will Mr. A get a notice? How will Mr. B get a notice? They're telling you. Now try to see. A Nidhi company, the documents may be served only on the members who hold shares more than 1000 in face value or more than 1% of the total paid up share capital, whichever is less. What do I mean by that? Let us imagine my Nidhi company's paid up capital is 1 lakh or beta. Let us complicate it. Let us imagine our Nidhi company's paid up capital is 5 lakh. How much is 1% of 5 lakh? How much? 10% is 50,000, 1% is 5,000. So, sir, 1% is 5,000 or face value of 1000 rupees, whichever is less. So, which is less? 1000 rupees. Now, in our case, if any person is holding more than 1000, who is holding more than 1000? A will get a personal notice. Sir, what about B? B, no right to equality. What they're telling you, just to give it in 2 places. What is that? One is, people, other shareholders, document is served in public notice in a newspaper. Newspaper. Sir, what if I don't get that paper? That I don't know. I give it that paper only. If you ask me, this is reality. Why? Macha, remember, cost of advertisement in Times of India is different. Cost of advertisement in paper is different. There are hundreds of newspapers in India. We don't even know their names. Agreed? Huh? There is no definition. If you ask me, is it a loophole? 100% loophole. They should have written recognized in India. That is okay. They will definitely give it in a newspaper which is economical. Times of India visiting card size advertisement will cost you more than 1 lakh rupees. So you imagine, how will they give? They will give one whatever newspaper is there. Yes, for other shareholders, yes, and you'll also put it on the notice board of Nidhi company. That is important. Remember and go. Clear? Okay, that's the only thing. And next one, people, section 21, authentication of documents. Nothing but if at all anything has to be agreed on behalf of the company, who will agree it? They're telling you it can be agreed by people, KMP or any other officer or employee of the company authorized by the board. If they are signing, that means company is liable. That's the meaning of authentication. Sir, the KMP definition, who are KMPs? CEO, managing director, manager, or CS, or full-time director, or CFO, or not more than one level below the board, one level, and called as KMP. These will be called as what people? Key managerial person. 2 clause 51. Clear? Okay. Last month, sir, execution of bills of exchange. Who will sign the bill of exchange on behalf of the company? If company is having a common seal, we will authorize any person in writing in respect of any specified matters as attorney. Meaning what? We are telling you on behalf of us, you can enter into these particular bill of exchanges. You can represent us. Now, whether in India or outside India, we can nominate. That is possible. What if a company is not having common seal? How will we appoint any person? That time, people, we will have to make sure that two directors shall sign, or if two directors is not there, then one company secretary. I mean, if company secretary is there, then one company secretary and one director should sign. If CS is there, CS signature is mandatory. Clear? The same provision will apply, cut copy paste for share certificates also. Share certificates, who will sign? Common seal is there, put common seal. Common seal is not there, two directors will sign. CS is there, one director, one CS will sign. Wherever signatures are there, important exam point of view, remember. Hello? Yes, sir. Yes, sir. Okay, that is your first chapter. See, again, what I'm trying to put here, wherever signatures are there, important, remember and go. Here, all of you. Okay. We will go for a break and come on. You want a break? Oh, yes, sir. Yes, sir. You not will die. Breakfast. Breakfast break. Breakfast break and raw. Okay. Back to the view. Yes, people. Let's do next chapter, chapter 3, prospectus and allotment of security. Easy chapter, exam point of view, you can expect question. As I told you, probably tomorrow I'll give you one ABC analysis as well. Which chapter, weightage, how much you can expect. That also I'll try to give you. Probably tomorrow we'll do it. Yeah. That doesn't mean I am telling you to skip some chapter. Simply to plan, I'm giving you an overview. First question, sir, which we can skip? Yeah. See, all this can be okay, I can tell you, but see, institute can never give you a ABC analysis chapter wise. They will give it like a group. 3 chapters put together, they will say weightage can be 15%. In that, what will you do if everything is asked from one chapter? So you can never take risks. See, there is as much as they will try to do their best in terms of asking questions from every particular chapter, but it is your duty to make sure you also are aware of every topic that is there in your book. So never go with that risk. That exam day only the tension will start. Ayyo, I'm 100% sure. See, until day before the exam, you would have taken 100% conscious call. Even if it comes from that, I know it will not come. That's why I left it. On the day of the exam, you'll feel, ayyo, much I know from that only they'll ask. That day you will feel all that. Yeah, okay. Yes, people. Next one, public offer. Okay, let us do the next one, sir. Prospectus and allotment of securities. Section 23 speaks about what are the different ways by which a company can raise capital. If you are a public company, you can do people a public offer. And what you can do? You can do public offer. That public offer, you can do it through IPO, FPO, OFS. Addition to that, you can do private placement, rights issue, bonus issue. If you are a private company, remember IPO, FPO, OFS will not come. Rest and all you can do. Rights, bonus, private placement. And remember, if at all you are doing a public issue, mandatory thing, people, you will have to issue prospectus. Public offer without prospectus cannot exist. Simplest, yes. There has been an amendment which recently added one thing. Earlier, what we used to do, we have seen, I'm now explaining the next section also, that is your section 41 GDR. Now, what does section 41 speak about? In section 41, earlier I'm telling you, imagine if there is a company called Infosys, we want to go and list ourselves abroad. I want to raise money from New York. I want to establish my company there. Now, can I do it? Earlier, what they used to do, a company in India, let us imagine Infosys. They have their equity shares. They take their equity shares, they go to a custodian in India. Generally, imagine these things can be banks. I go and I give all my shares to them. Let us imagine I give them a shares of, say, for example, some 100 crore worth of shares will be given. Now, what will this custodian do? They will take that securities, they will keep it with them like a collateral. And they have contacts in the abroad market. Yeah. Now, who are there abroad? Now, there is a person abroad, people, and that person is called as depository. Now, for example, in India also we have no depositories. CDSL, NSDL, they are depositories. Now, the person in India will call one depository outside India. He will say, bro, one company from my country wants to raise money from your country. Since can you help us? The depository outside with a commission, he would say, yes. Now, what they will do, they will create a new security instrument on behalf of the company abroad. Now, the instrument that is created by the person abroad, you call the instrument as people a depository receipt. Is this clear? He's creating an instrument abroad on behalf of the Indian company. Sir, but on what basis they created this instrument? On the basis of the equity shares here. One fine day, let us imagine after 10 years, whoever are holding these depository receipts, we issue it to the people abroad now. Let us imagine New York or anywhere. Somewhere it is abroad. Now, people, these people, after certain time, say for example, 5 years, 6 years, 8 years, they will have a right. What is that right? You can either convert these depository receipts into these equity shares, or you can redeem it for money. After 8 years, it is your choice. Now, sir, why are these people investing money here? It is for diversification. For example, now if I ask you, which is the topmost company in automobile today? Which is the topmost? Tata's, correct? Now tell me globally, which company you think can become the topmost automobile company? Which one you think has all that? Huh? Tesla. Now I would want to diversify. Why do you want me to restrict to only Tata's? I know the company which is really doing, which is going to grow. I know that. And that company is Tesla. Why is that you're not allowing me to invest? Now, people, through such depository receipts, if that Tesla company can come to India, same way, opposite. Foreign company can also do it in India. We call it as IDR, Indian Depository Receipt. When an Indian company, imagine a company abroad, we have one of the best companies. Now, say for example, a food delivery app for the first time globally was shaped by us. And there is Zomato is there. Now, probably a company outside India, they would want to invest in such companies. Now, Zomato will go and issue a security representing Zomato outside India, and we call such security as people depository receipt. Now, my question is, where is that you're raising this money from? I mean, in which market? If at all you're raising money, people from America, you call it as people ADR. If you're raising money, people from any other place other than America, you call it as GDR. Global Depository Receipts, American Depository Receipts. If a foreign company is raising money from Indian market, we call it as Indian Depository Receipts. You got the difference? All of you. Now, this is the route we used to follow till today. Now go back. Now this part is clear. And one more question you guys may all have. Now, sir, they are having the depository receipts. Who will have the voting rights? Remember, people, until conversion, the depository receipts holder will not have any voting right until conversion. You are not having equity yet. So until conversion, you will not have voting rights. Is this clear? Now go back. In section 23, what did they say? Sir, now this is today. Before, now people, we had something called as section 23, subsection 3. This has been added. Now what is that? Today, people, our Indian government said, why not do so much of, rounded procedure? Directly go and you can issue your equity. I'll tell you which are the jurisdictions. It can be NASDAQ. Go and issue your equity directly. Why does this deposit receipt so much of commissions to be paid in between these intermediaries? Directly go and issue your equity. Till today, we did not have that provision. Today, we have that provision. That is this 23(3). Is this clear? You directly go and invest in New York Stock Exchange. That is okay. You directly go and list yourself in any foreign security, in any foreign jurisdiction. I will tell you which one. Don't go and list in Pakistan. I will tell you where. There you go. We don't have a problem. That is the power of 23(3). Is this clear? All of you? Pakka. Now, people tell me what is the definition of listed company? A company which has listed its equity shares on a recognized stock exchange in India, they can be called as a listed company. What if I have listed a non-convertible debenture issued on a private placement basis? If I've issued this and if I've listed this on a stock exchange, can I consider this as a listed company? No, this is not a listed company. What if a public company which has issued non-convertible preference shares again on a private placement basis and it is listed this securities on a stock exchange? Is it considered as a listed company? Is it a listed company? Non-convertible preference share. I've listed it on stock exchange. Is it a listed company? Remember, no. Sir, what if this is a public company? This is a public company. So next one, what if I'm a private company which has issued its non-convertible debentures on a private placement basis? I've listed on a stock exchange. Is it considered as a listed company? Private company. First of all, can a private company issue debentures? Public stock exchange. Remember, restriction is there only for equity and preference people, not for debentures. So non-convertible debentures can be listed even if it's a private company. It is not considered as a listed company. Third one, sir. This is where the third, again, connected point I'm telling you. If any company has listed its securities as given under section 23, subsection 3, they would have given any company which has listed its equity in the jurisdictions as given in section 23(3). They're telling you that cannot be considered as a listed company. 23(3) is nothing but people. I've listed my equity only, but not in Indian jurisdiction. It is foreign jurisdiction. Of course, it is not a listed company as per India. So my listed company rules will not apply to this particular company if I have listed only my equity in foreign jurisdiction and not in Indian jurisdiction. Understanding? So, for example, let us imagine if there is a company, say Eternal only, Zomato, they have not listed their equity in India, they only listed it in foreign. Then people, according to Companies Act, the listed company does not include this particular Zomato company. Are you getting the point? Remember, exam point of view, important definition. Clear? Hello? Pakka? Yes, sir. Hello? Did someone change camera? Huh? Some changes? Okay. 23 reasons clear? Hello, done. Okay. Next 24 is nothing but people. Who will be the regulator for what? So they're telling you, if you are a listed company, if at all issue of shares, issue of securities, transfer of securities, non-payment of dividend. I repeat, I'm a listed company. I'm issuing shares. I'm issuing securities. I'm transferring securities. Non-payment of dividend. For this people, SEBI can be the regulator. In any other case, the regulator will be ROC, CG, and tribunal, as the case may be. Meaning, sir, am I Infosys? I'm issuing my securities. For this, which law will I follow? I will follow regulator. Everything I will follow SEBI laws. I'll also follow company law. I'm not saying no, but the main biggest regulator will be SEBI. But if it is any other thing, people, then they are telling you, if I'm an unlisted company or if I'm a listed company, any other matter, general meeting, SEBI does not apply. Companies Act will apply. ROC will be the regulator. Sir, change of name, CG, central government, RD, they will only be the regulator. But sir, issue of securities, transfer of securities, non-payment of dividend, for these three matters, SEBI will take a call in the case of listed companies. Any other company, of course, will be taken care by our CG, ROC and RD tribunal as the case may be. Clear? Hello? Done. That is 24. Next one, sir. Types of prospectus, section 2, clause 70. What is that? It says, what is a prospectus? Any document which is prescribed as prospectus is called as a prospectus. First of all, what is a prospectus? Whenever a public company raises money from public, if they want to issue securities, raise money from public, the document given is called as people prospectus, which has all the information about the company. Generally, people, more than 400 pages will be that weightage of that particular document. No, sir, they're telling, what do you mean by prospectus? They're telling you, any document, I will take one kerchief, I'll write here prospectus, it's a prospectus, done. That's the first word. Any document described or issued as a prospectus, on the top of it, if we are calling this as a prospectus, it is a prospectus. What if it is a prospectus? This entire chapter will apply. Okay, next one. Red herring prospectus. Now, what do I mean by red herring prospectus? A prospectus, which section now? Section 32. A prospectus which will have all the information in it. Everything will be there except quantity, that is quantum, or the price of securities. These two information will not be available. Rest and all will be there. Quantity will not be there or price will not be there. Such type of prospectus is called as red herring prospectus. Which companies will generally issue this? All the companies which are not certain about their price. They will come up with a price band. I do not know what exact price I have to issue my securities. I think my price, my securities is worth anywhere between 200 to 220. If I'm giving a range, then I cannot give a prospectus. I need to give something called as red herring prospectus. So a prospectus which has all the information in it except people quantity or price is called as a people red herring prospectus. The next prospectus is called as people shelf prospectus. What do you mean shelf prospectus? A prospectus which is valid today. From the day you make your first offer, a prospectus which is valid for 1 year, just like your products that you have shelf life. No, same way this prospectus also has shelf life, validity period of 1 year. So from the day I make my first offer, I can make any number of offers, second, third, fourth, so on, until the last offer. But people, this will be maximum 1 year. So I can make any number of offers from the date of first offer till the last offer. I can make any number of offers. The prospectus which I have to file only for one time, that is called as people shelf prospectus. And remember, sir, first time I have filed, second, third, fourth. I need not give any other document. You need not give any other document. Just one document you have to give. Full prospectus you don't have to give again. But one document you have to give. That document we call it as what? Information memorandum. What is the format of information memorandum? PAS2. Now, what do I mean by information memorandum? Information memorandum means a document which will have in my first offer when we went, our financial statements was this, our loans was this, charges was this. But when we came to the second offer, our loan, imagine in the first offer, when we made first offer, our loans were 1000 crore. By the time we went to the second offer, our loans has become people 2000 crore. There is an increase of 1000 crore in the loan. Now they're telling you people that part we have to intimate in one document called as information memorandum. When compared to the first offer, in the second offer, we have increased our loan. We have created new charge. We have to intimate this. In which form we will intimate? We will intimate in the form PAS2. Clear? Yes, sir. What and all you will intimate, sir? Information memorandum contains all material facts relating to new charges created, change in financial position between first or the previous offer and the succeeding offer. So if there is any new charges created, there is any new loans taken, that has to be given in this document. So for every issue, you have to keep on filing something called as information memorandum. Is this clear? And remember, sir, in the first offer, if at all there is any shareholder who has paid money in advance, in the third offer, let us imagine the company's loans have increased. He does not want to go ahead with the offer. He should be given a choice to withdraw his advance amount. That option should be given to the shareholder. Clear? So whoever has given the money on advance, they should be given an option to withdraw the money if at all they have paid in advance. Clear? Yes, sir. This is called as what people shelf prospectus. Any doubt here? Hello? No. Now what else is the prospectus, sir? The third one, last one, notice, circular, advertisement, any other document inviting offers from public will be called as what people prospectus. To understand that, let us understand something called as deemed prospectus. What do you mean by deemed prospectus, people? Let us imagine a company, if they directly issue prospectus or if they directly issue shares to public, that means people, they have to issue prospectus. Correct? What if they have to issue prospectus? People, any mistake in a prospectus, you will be liable. There is something called as criminal liability. There is something called civil liability. Any mistake, you are liable. Now, how to escape? What did the company do? Hey, what did the law say? If I give any shares to public, that means I have to issue prospectus. I will do one thing. I will not give it to public. We will create a temporary intermediary to evade the law. So what do? We bypass the law. I will give it to you. You give it to the public. I create a one dummy company. I will go to them. Company B. I will give it to you. You give it to them. Is it okay, na? So I will give it to you. You give it to them. Now, what did the law say? If at all you are giving it to the public, prospectus is mandatory. Where am I giving it to the public? So company A will never come with a prospectus. Now company B is giving the shares to public, but they are not giving their shares. Why will they give prospectus? So people were evading the law. To checkmate this particular move, what did they do? They said, if you are giving directly or even indirectly, it will be considered as prospectus only. So if that is the case, people, there are so many people that they buy shares as an investment. After some days, they will sell. Now what? That will also be considered as prospectus. Huh? So people, they had to define something. So what did they define? Now if imagine, if company A is giving shares to company B is giving it to public. When will we consider this as prospectus? Here people, there are some conditions. What is that? Two conditions are there. Any one condition satisfied, it will be called as prospectus. What are the two conditions? Condition number one. The company, our company, company A, has given shares to company B. And company B is giving shares to public. Now my question is when? Company A gave shares to company B on 1st January 2026. Company B is giving public, they are giving the same shares to public people on 1st May 2026. Oh, that is within 6 months. Then they are telling you people, let us imagine the 6 month people is 30th June 26. Between this period, if at all I give you shares, you further give it to public within 6 months, then whatever we are doing, this thing will be considered as prospectus. It will be considered as public offer. Sir, what if I'm giving, I gave you shares on 1st January 2026. You are further giving it to public on 1st August 26. That is after 6 months. Is this now considered as public offer? So, condition 1 not satisfied. We will see condition number 2. What is the condition number 2? Sir, condition number 2 says, now people, we are giving shares to company A. Meaning what? What we are telling, let us imagine we are giving, company A is giving shares to company B. Company B is giving shares to public. Now let us imagine when company B is issuing shares to public, we have only one question. Hey, you have taken shares from company A, Noda. Yes, yes, sir. Have you paid the money for it? You have taken the shares. No, have you paid money for it? Ayo, no, sir. Remember, people, if you have not paid the whole consideration to company A, without paying, if you are giving shares to public, whenever it is, let it be in 6 months, in 1 year, in 2 years, 3 years, whenever it is, without taking the whole money, I have not paid the whole money to company A. If I'm giving it to public people, then I will call this as a public offer. That means, people, I will have to give a prospectus. Again, I'm telling you, people, companies were trying to do it indirectly. What did they do? They gave shares to an intermediary company. The intermediary company used to give it to public. Now, how do I stop it? They introduce two conditions. If the intermediary company is giving shares to public within 6 months of them getting it, it is called as, people, a public offer. Second one, a intermediary company is giving shares to public within or before making the whole payment to the first company, to the main company. Without making the payment, if I'm giving shares to public people, again they're telling you it is considered as a public offer. If it's a public offer, people, remember, whatever paper company B is using to sell their shares to the public, that paper will be considered as deemed prospectus. That means what? The entire chapter will apply. Is this clear? Sir, now this deemed prospectus, who will sign it? They're telling you, if at all this intermediary company, if it's a company, then people, two directors has to sign that deemed prospectus on behalf of company B. Sir, if this intermediary firm, if it's a firm, not a company, then people, at least half of the partners have to sign. Let us imagine if the company has, say, 4 partners, at least 2 have to sign. Is this clear, all of you? 100%. This is what is called as, people, deemed prospectus, section 25. Any doubt here? Hello. Okay. Next one, sir, there is something called as offer for sale, section 28. What do you mean by offer for sale? Section 28. Sir, always remember, people, there is a one condition. What is the condition, people? Whenever there is a company which goes for listing, they have to mandatorily have, people, 25% of its shares with public. If you say Reliance, Infosys and all, they should have mandatorily 25% of the shares given to the public. Sir, if this number falls down, people, your company can be even delisted, thrown out of stock exchange. So 25% is the constant condition. You have to meet it at every given point of time. Now, what did a company do? A company, example, people, Patanjali, the share, people, in public domain, which should have been 25%, it fell to 19%. There was a notice given by SEBI. They did not increase it. And hence, people, Baba Ramdev's shares were freezed until the number does not go back to 25%. Baba Ramdev did not enjoy any right over those shares. It was freezed. And if you do not act even within time, then people, your company may also end up getting delisted. Now, what did Baba Ramdev do? Baba Ramdev said, hey, in public domain, how many shares are there? 19% of shares of the company is there in public domain. Then Baba Ramdev said, okay, I will do one thing. With me, the rest of the shares are there. I'm just giving an example. So 81% of shares are there with me and my friends. We'll do one thing. We will reduce our shares. Let us increase in public shareholders. So what we will do? We will take some shares from them. That means I will minus 7%. I will add it here. I will do 7%. I will increase it to say 26%. Hello? Now what is the company doing here? I'm taking some shares from my existing promoters, existing shareholders. I'm taking it from them and that I'm giving it to public. This type of share is called as people offer for sale, OFS. When the shares are taken from existing shareholders and given to public. Now, who is doing all of this? The company only will do all of this. Which company? Patanjali only will do. Because that is the company risk, no? The people, the company is issuing shares to public, no, end of the day. Again, they're telling you, you have to give prospectus. Section 28, offer for sale. Any doubt on OFS? Done. Next one, sir. Let us do section 26. What is section 26, sir? Matters to be stated in prospectus. Meaning, whenever a company is going for an IPO, remember people, there are certain essential things that you have to disclose in the prospectus. Now, what is that, sir? The first thing, section 26(1) says the prospectus has to be dated, signed, and it should also state people that as specified by SEBI, what is that? I have to include all those key details. Until SEBI prescribes anything, people, I have to follow the SEBI Act 1992. Whatever SEBI tells me to disclose in prospectus, I will disclose. And not only that, I have to give a declaration. What is that? I have not violated. What will I give a declaration? You'll give a declaration that you have not violated some law. Which law? I will give a declaration that I have not violated SCRA Act and SEBI Act. Sir, I have not what is that? Violated any provision of SCRA Act. I have not violated any provision of SEBI Act. I will give a declaration in the prospectus mandatory. Is this clear? Hello, all of you. Understood? Okay. Next one, sir. 26(2) says what? Section 26(1) shall not apply to. What is 26(1) matters to be stated in prospectus. That will not apply to some cases itself. When you are giving shares, your issue is made to existing members or debenture holders as a rights issue. Meaning what, people? They are already your shareholders. Why will I have to give all the information again? They already know it. Or issue of prospectus relating to shares or debentures is in all aspects uniform with the previous issue. What do I mean by that? Just now I had made one issue. Now say for example 3 months back, again I'm making the issue. Imagine I'm going for a, say for example, FPO. 4 months back only I did a IPO. They are not telling that you are not required to do prospectus. Prospectus is required. Just that, people, I will not give the information given in 26(1). Rest of it is as it is applicable. It will not be in detail. Why? 4 months back only I have filed. All the data is still there in the public domain. Remember, this can be a important point. They can ask you a question here. Exam point of view, important. Clear? Next one, the 26(3), date indicated in the prospectus shall be the date of prospectus. Okay. Next one, sir. Prospectus shall not be issued until it is filed with ROC. Remember, sir, before giving it to before giving it to public, I have to first show the prospectus to one person. Who is that person? ROC. Once I show the prospectus to ROC, within how many days I have to give it to public? 90 days is the validity. So once the ROC approves it, you have to give it off to public. and that validity period is 90 days. If it goes beyond that, people, then again you have to restart the process. People remember, very, very important, in your MCQ, date-based questions, you can at least expect people 2 to 3. What do you mean by date-based questions? For example, what is the last date to make the allotment? Or say, for example, the reservation of name will be for how many days? Depends upon new company. New company, if you're 20 days, old existing company, 60 days. Now, those questions will be asked in MCQ. For example, declaration of dividend within how many days? Have to make the payment within how many days? 30 days. They will give you time. Meaning what? Dates will also be given. 9th of December, 8th of December, 10th of December. They'll give you time. Days-based questions are very important from MCQ point of view. Remember and go. Now only I'm telling you. Hello? Yes. Clear? Okay. The next ones are 26.5. Prospectus shall not have expert statement unless. What do you mean by that, sir? Expert means what? It can be a professional, it can be an architect, it can be a valuer. Hey, end of the day, someone comes and tells you, hey, invest in this IPO. You will invest? No. If someone is coming and telling you, someone is telling in the IPO prospectus, let us imagine, someone is stating, hey, this is a wonderful company. One CA is coming and telling. It becomes an expert statement. People will rely upon it. Then if something happens, remember, tomorrow you are liable. So they're telling you, remember, an expert statement will not be included in the prospectus. No, no, sir, we want to include, sir. Okay, then make sure these things are satisfied. What is that? Whoever's statement is getting included in the prospectus, saying that this is the best company, that person should not already been associated with the company. Sir, when you should not be associated with the company during the formation, promotion, or management of company. Meaning what? Sir, I only signed their INC 8. Incorporation. You cannot be the expert. Understanding? Next one. Sir, remember, if my statement has to be included in the prospectus, I have to give a written consent. And remember that written consent should not be withdrawn. Both conditions have to be satisfied. Or what is the use? If I give it and I withdraw my consent, then what is the use? The last one, sir, a statement to that effect shall include in the prospectus. Meaning, I clearly say I am liable, I understand all of this, and I have agreed. All of that should be going in the prospectus. Clear? Yes, sir. That is your prospectus section 26. Now, next one, sir. Misstatements in a prospectus. There can be two misstatements, people. One type of misstatement is called as people criminal liability. Second one is called as civil liability. Again, for our understanding, I'll be telling it in short, people. What do you mean by criminal liability? Criminal liability means what, people? Sir, will those days be there in the mega compiler? This one. Yes, Sam. Yes, it will be there. If it is days, it will be definitely there. Okay, people. What is that? Hey, there are two types of liability. What are the two types? One is called as criminal liability. What is the second one? What is the difference between criminal liability and civil liability? Criminal liability is, people, punishment. Someone is punishing you so that you will not repeat it. So central government will or may put you in jail. Central government will impose liability on you as penalty. Paid some 5 lakhs, paid some 1 lakh, so that you will not repeat it. Now the second one is, people, the shareholder has suffered some loss because of the misstatement you have made in the prospectus. Why should he suffer a loss? He will file a case on you. Now, people, remember, whatever loss he has suffered, it is your duty to pay for that loss. Because of your misstatement only, that person suffered the loss. And the liability comes as called as, people, civil liability. Remember, criminal liability means, people, it will stop you from doing the mistake again. Government will take the money. You will be put in jail. But the person who has suffered, victim, will not get anything. end of the day, he has suffered. What is the use of government taking money? So his pocket also should be made good. That's why we have civil liability. That's the difference. Now people will have a question also. Sir, is it civil or criminal liability? Yeah? Or both can be imposed on a person? Remember, both can be imposed. You can be put in jail. You can be taken money. You can also be told to pay the money to the person, whoever has suffered the loss. All three can be included. Hello? That is called as criminal liability and that is called as civil liability. I'll just see quickly. Now, sir, if a person has made misstatement, I will be liable people under section 447. Nothing but penalty also can come and jail also can come. However, this rule has two exceptions. What is that? I will not be liable when if the person proves that such statement or omission was immaterial. Sir, misstatement I have done, sir, but it's not so important, sir. You can ignore it. I getting the point. Now, for example, who are the directors of our company? I have clearly written the directors of our company is correct. Spelling wrong. Now, immaterial, no. Based on that, can you suffer any mistake? Is it a misstatement? Technically, misstatement only. But you know, why I have made this. What happened? Your Jatka changed, numerology changed, because of it only you lost 100 crores. That is called as immaterial. If you can prove that whether inclusive or exclusive of this information, if it is not going to make any change in your life, then people it is considered as immaterial. No criminal liability. Second one, he had reasonable grounds to believe up to the time of issue that statement was true. That means what people have not done fraud. I have a reason to say why I have said it so. I have clear backing up with facts. If I can prove that, yes, they're telling you, yes, you will not be liable for criminal liability. Clear? Okay. Next one is people's civil liability. What is that? When a person has subscribed to securities relying on any statement, then people, which is misleading or suffering, then the company and every person shall see personally and unlimitedly liable. If I have suffered any loss, you have to pay me the entire money. Clear? Who and all will be liable, sir? A director of the company. Second one, whoever has authorized himself to become a director, meaning the person in the process of getting appointed. Third one, sir, he is promoter of the company. Fourth one, sir, he has authorized the issue of prospectus. Fifth one, sir, expert. I told you in 26.5, Vendada Mancha. I said, Illa, sir, I want to put my statement. Then put, no, see, anything goes wrong, you will be liable. Agreed? Yes, sir. Sir, but this rule, does it have any exception? Yes. What does the exception say? Sir, I had given my consent, but I withdrawn my consent before the prospectus has been issued. I've given my consent to become a director before the prospectus was issued. I've taken back my consent. You will not be liable. Next one, sir. That prospectus was issued without his knowledge or consent. Sir, I am also a director, but that day's meeting I did not attend at all. I do not know what happened. Upon me getting aware, I immediately issued a public notice that people, the company has issued a prospectus that, but it was without my knowledge. I don't know about it at all. You give a public notice. Third one, sir, the statement made by expert was correct and fair to his knowledge. What do I mean by that? We have said people, the company's valuation, share value can be anywhere between 230 to 250. My question, how did you arrive at it? I arrived at it people based upon discounted cash flow method. I have followed some logical reasoning behind it. Based on that, I arrived at a fact that the share price can be valued between anywhere 230 to 250. I have a reasonable backing for it. Then people, yes, I'll not be liable. Civil liability does not affect me. Clear? Hello? Okay. Next one, sir. Which other liability we have? We have section, a person who is acting as a shareholder. Person for personation for acquisition, meaning what people? Someone who is acting, pretending to be a shareholder. What do I mean by that, sir? I apply shares in a fictitious name. Can I do it? I'll create one Aadhaar card. Can you create it up an Aadhaar card? Ayo, sir, I can, sir. You don't know my hidden talent. No, people, that's how sensitive today it is. You can create one account, right? It's not a big deal. What I can do it or not? I'll do, sir. First, I'll try with ChatGPT. If not Gemini, if not someone, I'll do it for you. Why? No one, Photoshop, I'll do. Yeah, people remember that. If at all, terrorists are having bank account in India, that means people, fake ID cards are existing. Passports, they're able to travel. That means fake cards are existing. Agreed or not? Yes, that is the meaning of a person who is applying for shares in a fictitious name. Fictitious means a person who does not exist. In his name, you are trying to apply. Getting the point? Second one, sir. He makes or appears making multiple different people. Understood? Vaishak, what's your full name? Vaishak K. Okay, Vaishak K is his full name. He will apply one application. V K K V V K. Now everything will apply. Remember, people, in an IPO, you're not supposed to make multiple applications in a different combination. It's a punishable offense. Understood? That's what they're telling you. Multiple applications in different names or understood? Sir, he's like, I do, sir, every time for IPO. Otherwise, induces directly or indirectly any transfer of any securities in a fictitious name. Meaning what? This is applicable in the case of IPO. This is applicable in the case of transfer. Meaning, I had applied, I'm transferring my shares to another person who does not exist. So, they are telling you if any person who makes this people, that person is liable under section 447. Simple, huh? Yes, sir. Okay, done. Section 38. Next one, sir. Section 37. Easiest. What is this? Class action suit. What is class action suit? In the case of Satyamma, when more than one shareholder suffered loss, every person will go and file a case. The court will become Kalyan Manchpada. Judge after everyone, photo everyone will keep going. So we cannot handle the cases, people. In such case, what do? We entertain something called as class action suit. We will combine the entire case into one case, and if at all you win, everyone wins. If you lose, everyone will lose. Amongst so many applicants, they will nominate one person as a lead applicant. That person will take a lead and that person will fight. Now, my question, where do you get money from for fighting this case? See, if it's your case, you will fight. If it's class action suit, who will fight? Where will you get money from? Where? Where? IEPF. Remember, people, IEPF gets credited with certain thing, debited with certain thing. Class action suit is given there. Yes. Hello? Okay. Very nice, that. Full revision, huh? Okay. Punishment for fraudulently inducing person to invest money. Vaishal, invest in Tata. Invest Innu Mado. So, sir, what I'm telling you, if someone comes and tells, will someone tell people, I don't know how many of you get it, but anyone gets investment messages from any broker or from any one point of time you'll get just to visit one or two websites and say accept all cookies. And you just log in. You will get a calls from both. One is from the broker. Sir, it's a wonderful opportunity. Invest. If not today, sir, trust me, you would have become the next Junjunwala. You will pakka regret tomorrow. Huh? Yes, sir. So first they will call. Second, sir, now he orphanage in the phone market. I don't know how they get. They will also get. You will also get what is that? Charity calls. Both you will get. That is how safe our data is. Yes, sir. Now see here. 100%. Hey, I'll tell you one company which paid because of data breach. One company, whole company failed because of data breach. And that company is called as Wazirex. You know Wazirex? Illa. Wazirex, Guttalva. Even I was an investor. I had my account in Wazirex. Wazirex was the only way we could invest in Bitcoins. So even I had invested using that only. I had that whatever you call dog. Ado. I thought Gen Z. Dodge, sure it's called Dodge. Dog. Okay, whatever. That coin and Bitcoin. So when the first time when we invested, Bitcoin was what? Somewhere around 2 lakh or 1 lakh. That was the value to where it is. I have made money there, where even our regulations were not there. Now it is taxable. That is when even I stopped. Regulations are not there introduced. 30%. So I'm very grateful to Thai Nirmala Sitharaman ji. She introduced the tax and I stopped investing. And that is when there was a data breach. You see the news, Wazirex data was breached. What do you mean by data breach? People imagined you guys have invested money or you guys have your savings bank accounts. Someone comes and hacks, say for example, you have your money in one account. Let us imagine which one. Say SBI. Someone comes and breaches account. Every entire money is taken away. What will you do? Same thing happened here. Read. Wazirex has faced significant failures primarily due to massive cyber attack. Look at the value. Yeah, there. Heart will stop. That resulted in the loss of over $230 million in crypto assets. Cyber attack, where company literally rolled, stuttered, with patala. Even I had my account, but I took back entire money. That's why I'm laughing. My neighbor, 35,000 rupees, when disputes are going, when will you recover? Asta, it's a loss. It's a business loss. They did not do fraud. It's a cyber attack. Shareholders are not liable. This is not lifting of corporate wheel and all. Gone. 35,000. Every now and then I'll go and keep reminding him. Yes, no. So that is what they're telling you. What? If someone calls you and tells, sir, invest, sir, they're inducing so that you can invest money. That is the meaning of what? Hello, is it? Punishment for fraudulently inducing, meaning pushing you to invest. If anyone is doing that, see, if you're doing it ethically, that's okay. If you're doing it unethically, that is when this will come. It is the point, So any agreement for, see, acquiring, disposing, subscribing, I'm telling you to, sir, buy, sir, trust me, you will not forget me from tomorrow. That's how I'll do. And you invest your money will go. You will not forget him. Or underwriting of securities. If you are just doing all of that, if you're pushing them fraud, any agreement, the purpose of which is to secure a profit, I'm cheating you to make profit. Again, I'm liable. Last one, sir, any agreement, what is this? Meaning what, people? I'm going to ICICI Bank. I'm going to SBI Bank. One person in 2008 he went and he said, I will be the next kingmaker. Everyone gave him money. One bank to Papa gave him money without collaterals. Suffered until last year. Beka, king of good times. That day was their good time. After that, for the next 15 years was bad time. Correct? No. Now, that is what any agreement with a view to get credit facilities from any bank, a company is going and showing fake financials. Again, you will be punishable for criminal liability. Clear? Meaning you are liable. Understood? Hello. Okay, done. Next one, sir. Which section? Section 40. Okay, securities to be dealt with in stock exchanges. Section 48. What do you mean by that? Whenever a company is going for an IPO, it has to be mandatorily people in a demat form. Agreed? So you have to make an application at least to one stock exchange because you are going for a IPO. And remember, all money, you have to take it in bank account only. No cash. Again, very thankful to one person called us, Arshad Mehta. Yes, Anna Wonder, cash na. However, you can manipulate. Every way is manipulated. They literally removed the word cash only from all the laws. The last one, important, sir. What is that? Rate of commission. Can we give commission? Na? Whom will we give commission to? Underwriters. Will we give commission? Yes. How much can we give? Imagine if you are underwriting equity shares or shares rather. The maximum commission you can pay is 5 or AOA says some other number, whichever is less. There. Visuals can be deceiving. Second one, people, debentures. If at all you're issuing debentures and there is an underwriter, for that underwriter, I'll have to give commission. How much I have to pay? 2.5 percentage or anything given in AOA, whichever is less. Clear? Section 40. Next one, sir, section 39. Allotment of securities. Now, sir, company went for IPO. People, IPO. Yes, sir. When you apply for an IPO, Dave, I'll tell you. One luck point I'll tell you. Recently, one SME IPO came. You guys know, SME means what? Worksmate, this was a company's name. 200 to 204. Yes, sir. This company minimum IPO application. Remember today, if you want to apply for, there are two types of company: normal company, SME company. With SME company people, the minimum investment will be 2 lakh rupees. You have to invest. Yes, sir. So I have been applying for IPOs people. I don't know for the last at least 14 years. I've been applying. So so somewhere in the last, if I say for 11, 12 years, I can say I would have got some 2 IPOs. That's the maximum number. So, Devro, while look at the date. This was around November 27, if I'm accurate. Now only. So, while exactly I was in Sri Lanka, I got this IPO. I'll tell you why is it so important. This was the profit. I'm literally telling in the camera people, my entire Sri Lanka expenses, I got it back. Yes, sir. Listing day, day one, my account, I opened number visible in front of my eyes, 2.25 lakh profit. I said, hey, Mancha, hey, cab, hey, hold up, premium cab. Full. I said, hey, come down. Yeah. And why I'm telling you, I sold, so I got 1,200 shares. What did I do? I always sell off half and I retain half because I was confident about the company. Yeah. Now, what is today's share price? Yes, and that one is down. Probably the closing price, people, you can imagine, you can do 600 into 468 was the high. Yes. So IPOs are so beautiful. Yeah, it can literally, I'm saying you. Now, don't you think I have put one impression in you? You will all will start trying for it. Yes or no? No. No, people, if at all I have done this with the fraudulent intention, I'll be liable. Now I've applied, no, within how many days I should be getting this allotment. For all of that, that is rule, that is section 39 applicable. Allotment of securities. Got a fair idea, na? They're telling you, whenever a company goes for an IPO, I have to allot securities people. First of all, the company has to meet minimum subscription. The minimum subscription is 90% as per SEBI. If minimum subscription is not met, I have to refund the money. See, in total, people, the received amount shall be refunded if not subscribed within 30 days. Meaning it should be subscribed within 30 days. If within 30 days it is not subscribed, within 15 days I have to give back. Within 15 days, if I don't give back, I have to pay an interest at the rate of 15%. Yes. Okay. Minimum application money, you guys would have seen in accounts, application money, allot money, first call, missed call, and condor. Yes, sir. What is the minimum application money as per Companies Act? 5%. Companies Act only says that people, if SEBI says any other percentage, follow that. SEBI says 25%. In reality, we follow this. Next one, sir. Return of allotment. Whenever you are applying and you are allotting securities, you have to intimate ROC Noda. Sir, my revised capital that day was 1 lakh, sir. Today I'm rich. My revised capital is 5 lakh. Company has to intimate, no? Yes or no? The form we use to intimate ROC is called form PAS 3. Return of allotment. The last one, penalty, it's okay, leave it. Clear? Sir, 41 we have done, sir. That is done, sir. GDR, we did not. 42, sir, private placement. People, 42, private placement. Now, what is private placement, sir? If at all we are giving securities to a selected group of defined investors, meaning what? A security, offer letter, macha, given in your name. Dear Vaishak, this offer is only for you and not for your fraudulent friends. I'm only giving it for you. If I'm giving it for you people, then it will be always written in a particular person's name. We call that offer as people private placement. Remember, a private placement cannot be made for more than 200 people in a year. The 200 limit is people per security. Important. Meaning what? Equity 200, preference 200, debentures 200, every security 200 per year. Next year again you give it for 200. Next year again 200. Unlimited. Keep on going. Absolutely fine. Clear? Sir, when I'm counting this 200 people, you're not supposed to add two people in that limit. Who? QIP and ESOP. So any share issued to qualified institutional buyers, don't add them. Any share given to your employees, don't add them. In this limit of 200, a question can come here while calculating the 200 limit. Clear? Next one. If limits exceed, it will be by default considered as public offer. See, it shall be subscribed by Checko. Okay. DD. Okay. Okay. Not okay. Clear? Once they have asked this. Next one, sir, the provision shall not apply to, meaning this 200 or this headache, all of that not applicable to NBFC, HFCs. Non-banking financial companies, housing finance companies, they need not have to follow this law. Special resolution is to be passed. Why? Because I'm raising securities. I'm raising more money. Have to ask my existing shareholders, are you guys okay? Only then I can issue to the new shareholders. Agreed or not? Yes, sir. Now that is what they're telling you people. They can issue securities, but only after passing a special resolution. Before going for every private placement, they have to pass a special resolution. But if you are giving it to QIPs, one special resolution will be valid for the year. You can do any number of private placement for that QIP. What is that, sir? Offer made to QIB, special resolution at any time in the year to be valid for all the allotments to the QIB during the year. It will be valid for that 1 year. One special resolution. For others, sir, every time I make, I have to pass a special resolution. Remember and go. Sir, what are the forms that is there in private placement? There are three main forms. What is that? First one, macha, random person cannot invest in private placement. I should know who the investor is. First, what I will do, I'll take a A4 sheet. I will write down whom should I give the offer to. I'll clearly write A, Mr. B, Mr. C. So first I will have a record of their names. The record the company maintains with them of for whom and all we have given the letter to. We have to maintain that record. No. First form is called PAS 5. Company to maintain the complete record of private placement offer letters. I would have told you the logic also inside the class. Why and all. Now, PS5 is a complete record. Now, sir, I'm giving it to Vaishak. No, dear Vaishak, do you want to invest? Now, what is the format of this letter? It is predefined. You guys need not even bother. The predefined thing is called as people. People. Private placement offer letter. The format is PAS4. You type in Google PAS4, you will get everything. Just to fill in the blanks. That's all. That is what you need to do today. Hello. Now, people, they will apply. Vaishak applied. Within how many days I have to allot shares? He gave me money today. They're telling me I have to, from the date of receipt of money, I have to allot him within 60 days. Do not get confused between this and the previous allotment. There it is 30 days, public, private placement is 60 days. Sir, within 60 days, if I do not allot, within 15 days, I can refund. Sir, if I do not refund, here it is 12 percentage, there 15 percentage. From the 61st day. Clear? Can I run two private placement offer letters simultaneously? Can I run the one private placement offer letter for equity and one private placement offer letter for debentures simultaneously? Sir, exam difficult, sir. Remember, Macha, two private placement offers cannot go hand in hand. First complete one, then start another. Exam question, remember, important. Sir, now all of that is happening between company and Vaishak. Is ROC aware of it? No, no. ROC should be aware of it. No. How much did our Vaishak invest? Money. How much capital we give? All of that ROC should be aware. No. How will we intimate? We'll intimate in a form called as. Correct? Three forms. PS 3, 4, 5. All three important. Remember and go. Hello. Now that is what is important for us. That is what will come here. So remember, maximum identified people 200 ESOP 60 days 15 days 12 percentage PS4 3 5. Now after going home today Sunday, that's when I'll give you. Now people, you should have it. Not everything should come ange. Chitti should become like this. Robo only. Are you getting the point? Hello. Okay. 42. Then, hello. One thing I think I forgot is section 29. What is section 29? A company share should be mandatorily in a demat form. Section 29 first said every public company going for an IPO today, if you are a listed company, your shares should be mandatorily in demat form. They introduced Rule 9A of Prospectus and Allotment of Securities Rule 2014, which said a public company today, even if you are not going for an IPO, if you are a public company, all your securities should be in demat form. 9A amendment. Today 9B amendment. If you are a private company, your securities should be in demat form. Private company. Demat form. Why? Too many frauds are happening. Understood? Only exception, small company. Today, now you see what is my small company. Paid up capital 10 crore, turnover 100 crore. To tell you how big this number is, today Arivu's paid up capital is 7.5 lakh. 10 crore small company. Arivu has 4 branches. By next year, by the next attempt, if you guys are watching, Pakka, there will be at least 6 to 8 branches. Yes, sir. I'm telling the maximum that time also capital will be above by if you take it, it will be around say on 15, 20 lakhs. Turnover, yes, 100 crore it is. Only we should play around. That time again, Nirmala Sitharamanji will be a little more courteous on that. Good, no? Okay. Next one, we'll start off. Next one is called people share capital and debentures. Huh? Yes. Abridged prospectus. Hey, what is abridged prospectus done? Summarized form. Here, that is not the important point. In abridged prospectus, one more is important point. What is that? Allah, abridged prospectus is not required in one case. When two cases. If you're giving to existing shareholders and if at all you're giving issue to the existing shareholders and people, private placement abridged prospectus is not required. But what do you mean by abridged prospectus, sir? Abridged prospectus means nothing but people prospectus in a summary form. 2-1. Your first definition is that. Here, that part is important. Remember and go. Important. Hello. Correct? Okay, fair enough. Okay, people, section 43, types of share capital. Done. Hey, what is types of share capital? Equity and preference. People, tell me, equity can be further classified into two types: with voting rights and without voting allowed. Differential voting rights. For example, Tata Motor DBR share took its final breath in the last year. Yes, sir. They had the DBR shares, people, until December 2024. Even I was one of the investors. I got a settlement of, if people had 10 DVR shares, they got a settlement of 7 ordinary shares. Yes, sir. And they completely wound it up. The reason is multiple shares listed, that fees will be more. You need to pay to the stock exchange. Second thing, do you have a need? Third thing, this was in December 2024. They were planning ahead to have only one category of shareholders. Why? Because in 2025, they had a plan of demerger. I hope you guys know. Now, Tata has two segments, commercial and your passenger vehicles. Today, Tata truck and Tata motor car are different. So, they were playing a game a little ahead for all of this. Understood? So, sir, DVR share means nothing but people, a company which has a differential voting right. What do you mean by differential voting right? Normal share, one normal share gives you one vote. If at all it is a differential voting right, it may be 10 share is equal to 5 votes. Are you happy? Illa. That's why they said here I gave you 1 rupee as dividend. Here for 10 shares, I will give you 15 rupees as dividend. Are you happy now? Now I'm happy, sir. So you and me, or sorry, me, I know I have no voting power. Yeah, what will I go and do? I would have told it so many times in the class also in Reliance. Every time I said no, they will still do what they want. For that yacht build up and all, I am the owner of the company. Equity, nothing. We are fit for nothing only. 100 votes. What will I go and do? What will we do? So I will say instead I will rather trade it with more dividend. Correct? No. So I will, instead of taking normal share, I will take DVR share. I used to take. Now it is no longer there. So we don't have a choice. We take normal share. Few companies did it. One is Tata DVRs, one is Future Groups. They had also done it. Rarely people do because it's a cost on the company. It's very difficult. You have to manage two different category of shareholders. It's difficult. Clear? Yes, okay. Today they're no longer there. Now remember, people, for going for DVR, I have to satisfy with some conditions. What is that? I have to authorize my AOA. Macha, anything they ask you, the first condition you should write this: bonus issue, buyback, preference, DVR, authorized by articles. And one more thing where you guys can go wrong. It is not special resolution. Pass a ordinary resolution sufficient. So company to issue new DBR shares, you have to pass a ordinary resolution. Next one, people, the maximum DBR shares, how much I can issue? It cannot be more than 74% of my total voting power. That means what? If my total voting power is 100%, the DBR cannot be more than 74%. Ordinary should be 26% or more, but not less than 26%. Hello. Okay, you should have not defaulted. In the last 3 years, people, I should have not defaulted in filing my financials annual return. In my last 3 years, I should be clean. Hello. Okay. Next one, people. There should be no subsisting default. But that means what, people? Today, subsisting means when I'm going for a DVR issue, there should not be default in payment of declared dividend, deposits, preference and debentures, and interest and payment of deposits and debentures. Next one, people. You should have not made a default in. Categorize like this only and read. If not, you will get confused. Financial statements, annual returns. Last 3 years, I should be clean. Repayment of debentures, deposits, interest, all that. Today, I should be clean. Last year, something I did not pay. It's okay. Today, you paid. Okay, we don't have a problem. Third category, no default in payment of dividend of preference, request, repayment of loan, interest from PFI, financial institutions, scheduled banks. We have taken loans, we have not repaid, or interest we have not repaid. Statutory payments to employees, provident fund, gratuities, salary. We have not paid that only. And we have not credited money to IPF. Macha, 124 timeline within 7, meaning you're 123 and 124. 124, 7 years done. Unclaimed dividend, what will you do? I have not transferred. Then what are they telling you? Macha, okay, of course, everyone will do mistake. First thing what I'm telling you, let us imagine you have made a default in, say, non-repayment of loan. I've made a default. Okay, sir. Today, in 2022, I have repaid. When? On 1st November 2022, I repaid. Okay, wait for the year to end. When will the year end? Correct? From here, count 5 years. From where? From here, not from here. Again, there will be an exam question, MCQ. They will give you 5 years from this day and this day. You will count 5 years from here. That means what? 23, 24, 24, 25, 25, 26, 26, 27, 27, 28. 1st April 28, I'll be eligible to issue DBR. They can ask you, hello. Next one, I should not be penalized under these 3 acts in the last 3 years. So technically, you guys have seen 4 non-compliances. One is annual financial statements. Next one, deposits. Subsisting it is. Next one, 5 years school offer. Next one is penalized acts. That is 3 years I should not have been penalized under these acts. What is that? RBI, SEBI, SCRA, FEMA. People, conversion. Existing shares should not be converted to DVR. Existing DVR cannot be converted to normal shares. Not like that. This was a scheme of compromise. Section 230, tribunal's approval was taken, and that is how Tata's did it. Yes, sir. If you remember in class, in detail, we opened notice and all, and we saw. But yes. Clear? Okay. What did you do? 43. Okay, preference share, section 55. Tell me, what is the maximum tenure of preference share? 13. 20 years. First, tell the generic condition. 20 years is the generic. If at all your infrastructure company, you can go up to 30 years provided. From the 21st year, a minimum of 10% shall be redeemed at the discretion of the shareholder. Hello. Yes, okay. Next, preference share. Do they have a voting right? They have voting right on 3 matters. One, anything that personally affects them, whichever will make them go to depression. For that, they can vote. Second one, capital reduction. Third one, winding up. On these 3 matters, they have a voting right. Macha, In every place, wherever you guys saw, what? Members personally present, having right to vote. In all those cases, they will have a right to vote. That is, okay, these three. In addition to that, if at all a dividend is not paid for a consecutive period of 2 years, then there is no difference between preference shareholders, equity shareholders, on everything they can vote. Who? Preference shareholders. Correct? Yes, sir. Next one, sir. Preference shareholders can be redeemed out of what? First one is profits and proceeds of fresh issue. Now, people, you tell me, when should I create CRR account, capital redemption reserve account? When I'm redeeming preference share out of proceeds of fresh issue or profits? Whenever I'm redeeming preference shares out of profits of the company, I will have to create CRR, not when proceeds of fresh issue. Remember this. Hello. Again, one more thing we'll do it up here only. What can I use that CRR account for? It can only be issued for one purpose. CRR account, capital redemption reserve account, can be used only and only for one purpose, and that is bonus issue. Remember MCQ question and go. Okay, okay, preference shares done, done. A rollover of preference share done. What is rollover done? If company is not in a position to pay the dividend, what will, sorry, repayment of money, what can a company do? Say, for example, the company has raised debentures, sorry, preference shares. We were not able to repay. Now, what will I do? I will call the preference shareholders for a meeting. Dear shareholders, because of liquidity issues, we don't have money to repay today. But we are having money. But today we don't have. Can we please repay your money after 2 years? If preference shareholders agree, how many of them should agree? 3/4 of them agree, people. Then we can go for a what? Issue of a new preference share. The old one will be redeemed. We will issue in its place a new preference share. Imagine for the 2 years also we did not pay dividend. Do one thing, add that money also to this. If total preference share was 5 lakh, if the preference dividend is 1 lakh, issue new preference shares for a value of 6 lakh. If at all there is tribunal approval is also required. Is clear? And we call this process as rollover. Clear? Okay. And sir, next, what else? Section 50. Allah, what are you doing? 48, 46 we did do, no? Okay, we'll do up that series of 49, 50, 51. What is 49? 49, can I make calls? Can I make first call, second call, third call, missed call and all possible? Company can collect money in calls, no? But remember, can I collect it in different? One shareholder, I tell him to pay 5 rupees. Another shareholder, I tell him to pay 6 rupees. Can I do? Calls has to be uniform. Yes or no? Section 49. What is section 50? Calls in advance. People on advance, people. Imagine one shareholder has paid money in advance, calls in advance. Will he have voting right on that calls in advance? Will he enjoy dividends on that? He can only get interest. Dividend not allowed, voting not allowed. Next one, sir. 51, sir. What is that? What is 51? Sir, whatever is the whatever the dividend, sir, that will be always in proportionate to the paid up share capital, if any. 49, 50, 51. Here, 49 is uniform calls. 50 is people. Advance money can be received, but no voting right, no dividend on it. Interest can be paid. 51 people is nothing but people. Dividend has to be proportionate on the paid up value. This is clear? Hello? Done. Next one, sir. 46 and 47, 48 is done. 48, okay. Certificate of shares done. With this we already saw. Who will sign the certificate of shares? If common seal is there, common seal. If it is not there, 2 directors. If CS is there, 1 CS and 1 director. Can a company issue duplicate shares? Yes. When will they issue? If at all the existing shares are lost, or destroyed or defaced or mutilated or torn. So remember, if it is lost, I cannot surrender. In any other case, I have to surrender. Yes, sir. Now I'll issue duplicate share. Share certificate will be in which form? Form number SH1. If at all a company issues duplicate share, I will maintain duplicate share certificate. Which form? SH1 only. Hey, duplicate share. Imagine that you get a duplicate 100 rupees note. What will be the form of duplicate note? Same only note. Then 100 rupees I'll print it as per US dollar. No, no. Hey, duplicate share certificate will be as per the principal share certificate only. Just that on the top of it, we will write it as duplicate share certificate. Then what is essence do? Is if at all you are issuing duplicate shares, have to maintain one register. In 2023, a person called so and so had come for duplicate share certificate. I will maintain all the details in one register. That is called register of duplicate share certificates. Clear? Huh? Okay. Shares in depository company people done. Next one, people voting rights da. What is one? My God, what is voting rights da? Can we alter voting rights of a shareholder? Sir, preference shares we have issued for 10 years. Now we want to increase it to 15 years. So now we are telling Allah 48 we did it off. Variation of shareholder rights. Now, sir, let us imagine we have issued shares, preference shares for 10 years. We want to increase it to 15 years. Of course, if I call them for a meeting, they will hit me. Sir, I'll give you your money after 5 years. So, sir, how do we deal? I will say, sir, I'll increase your tenure by 5 years, but I will compensate. Now, current interest is 12%. No preference dividend. Now, I'll increase it by 15. I'll give you 15%. Is it okay? Now two scenarios can happen. A certain preference shareholders might be okay. A certain people might not be okay. Agreed? People, if you are able to get, I'm just telling you on the face of it, if you are able to get special resolution, you can go ahead with variation. But remember, people, whoever are not okay with it, if they are at least 10%, they can appeal it with tribunal within how many days? Option 1, 30 days. Option 2, 15 days. Option 3, 21 days. Option D, may attempt. 21 days. Correct? Yes, sir. Yes. Again, the timeline is there in that. 21 days. Clear? I have to go to the tribunal. Tribunal's order is final. Now, people, till today, you are paying 12%. This 12% is increased to 15% now. That means what? Papa, equity shareholder, they will get less dividend. Correct? Papa, his pocket is also getting affected. No. Remember, any variation of one shareholder rights, if it is affecting any other shareholder rights, you have to call them also for a meeting. I will call equity shareholders also. I need to take a special resolution from them as well. But remember, the exact words will be a little different. You will always take it on issued shares. That's the only place where you're seeing issued shares. Generally, you will always be seeing paid up value. What is the word they say? See, variation, you need to take the approval from consent in writing of the holders of not less than 3/4 of issued shares of that class or pass a special resolution. Agreed? Sir, whosoever's value is getting affected, there's a variation of one class affects the rights of equity. The consent of 3/4 of such other class also shall be obtained. So I have to take 3/4 of shareholders approval of equity also. I have to take preference also. 21 days tribunal approval and binding. Clear? Done. Next one. 49, 47. 47, what is 47? Voting rights. What is voting rights? Right to vote. Correct. Voting rights, people, whatever you have seen, generally people, equity share capital will have voting right, preference share capital will also enjoy voting right, if at all. We saw that scenarios and all. The only thing we need to remember here is people, if at all there are both the shares. Imagine people, a company has a capital of 1,200 crore equity shares, 300 crore preference shares. And the company has not paid dividend for the 2 consecutive years. Now, both of them will have right to vote. What will be the voting shares? Proportionate means what? Till today, they have not asked this. How will I take proportionate? Now, people, I will take ratio. Can I say 4:1? So, people, equity shareholder people, if I have one share, I will enjoy one vote. One vote. Preference shareholder people, his one share, I mean, his 4 shares is equal to one vote. So, in reality, let us imagine if there is a person who is holding 50 equity shares. How many votes will he have? 50 votes. Let us imagine if there is a person who is holding 20 preference shares. How many votes will he have? 20 divided by 4. He will have 5 votes. This is what is the meaning of proportionate basis. I've given you an example also here in the exam. I mean, in class, if you remember. Till today, they have not asked this. Remember, and it can be important one. Hello. Dana. What is 52? What is 52? Da? What's a 52? Da? Securities premium account. What is a securities premium account? Issue of shares at a premium price. Now, the premium price, if we raise the money, we can use that money for a certain purpose. What is the purpose? 5 purpose. What is the first one? Bonus share. Second one, another B. What is it? BB. Buyback. Next one, people. Preliminary expenses. Nothing but pre-incorporation expenses. You can use the securities premium account to write off your pre-incorporation expenses. Next one, people. You saw no commission to be paid. Section 40. Underwriting of 5% or 2.5%. Where will you get that money from? They're telling you can use the securities premium account. Hello. Yes, sir. Last one, sir. Premium or issue of redemption of preference shares or debentures. Their face value is 100. We are redeeming it at 120. The 20 rupees can be paid from securities premium account. Clear? Done. Next one, sir. Section 53. What is section 53? Shares cannot be issued at a discounted price. My question to you, can I issue equity shares at discount? Equity can I issue a discount? Generally, no. Preference can I issue a discount? Preference shares can I issue a discount? Preference shares, equity I can't issue. Preference I can issue. Preference. The word says people, shares cannot be issued at a discount. It includes equity as well as preference. Can I issue debentures at a discount? Yes, because they have not used the word securities. Difficult attempt, sir. What I'll tell you in the class, we'll listen, we'll go at home for you. There is no difference between equity share capital, paid up share capital, and securities. For us, everything is same. Sir, hum log buy. Correct. I'll tell you, in your exam, if there is one person called as Katappa, that is always preference share. Pakka. I'll prove you. I'll prove, huh? Tell me, sweat equity, what is the maximum limit on sweat equity? 15% of. Tell me loudly, what is 15% of? Understood, no? I'm telling, what is the maximum sweat equity you can issue in a year? 15% is all answer, all of us know. Tell me, what is the 15% of? Loudly. Paid up share capital, no? Sweat equity. Yes, no? Yes, no? Allah, yes, no? Paid up share capital only, no? Pakka, no? Allah, pakka, no? Macha, ಹೇಳುನಲ್ಲ Kattappa is their biggest preference share. I proved, hence proved. You want me to prove more? I'll tell you one thing. January 7th exam, no? 6th. When is law? 6th, no? 8th, 8th alva. 7th also. Kattappa will be Kattappa on this. Bahubali killed Kattappa. He changed the Bahubali only. Only character that is alive in that movie is Kattappa Papa. So pay attention when you are reading, because again I'm telling you, Companies Act is 13-year-old. They will no longer ask you, keep asking you question on 15% only. Now people will come out of the class and say, sir, out of syllabus questions, we want re-exam. Oh, huh? Ah, yeah, on YouTube channel I was seeing. Nowadays it has become an thing. After exam, they'll come with mic and they'll ask you, how was the exam? On Yana, he was telling, oh, many out of syllabus question. Yeah, the out of syllabus. Everything in syllabus only. Huh? Mahesh, bro, send that video. Oh, you know, Mahesh. Okay. Section 53. So remember, people, can I issue my shares on discount possible? Huh? Generally not possible. There are two exceptions. First exception is sweating video na ESOP. 1 second thought came no. That 1 second thought came no ESOP or sweating video. In exam, remember, you will think both. Yes, sir. Remember, ESOP, we don't have any excuse. Sweating equity, we have an excuse. We can issue at a discounted price. Next one, people. Whenever there is debt restructuring. Debt restructuring means what? We have taken some debt. We are not repaying the money. If I issue the share, so imagine I've taken 500 crore loan. I'm not able to repay. I said, sir, is it okay if I give you equity in return? He said, okay. But if I give it to him at the face value, he will say, hey, then what is I used? Reduce it and give it. First of all, you did not give me the payment. In that, you're giving it at face value. Give some discount. He'll say, okay, sir, I'll give you 8 rupees. Okay, now I'm happy. So I'll get more shares. Understood? Hello. That is your discount. 53. What is 54? Sweating equity, which you guys are accurately right. You are accurate, no, on dot. Tell me what are the values of sweating equity. First of all, tell me which and all shares can we give it under section 54 for an employee? Which all can we give? We can give equity and preference shares and convertible. Convertible preference is possible. Convertible preference shares, see section sweating equity. Take Buddha. Yes, sir. What did Tejas do today? Tejas kept sending material. That's all. What are Tejas, sir? Hey, only equity da machan. Sweating equity is okay. Now listen. What is the maximum I can do in a year? How much I can issue? The maximum is people 15% of the paid up equity share capital or 5 crore rupees, whichever macha, trust me, exam, your mind says macha, act will give higher, it will give lower only. Your brain is your second katappa. Provision will be easy. Your brain will complicate it. It is whichever is higher in a year. If my capital is people, let us imagine if it is 100 crore, if it's my paid up equity capital, the law says 15%. How much? 15 crore or 5 crore, whichever is higher, I can go for 15 crore. Sir, next year, how much I can do? It is every year limit. So again, next year I can do 15% or 5 crore, whichever is higher. So how much I can do next year again? Sir, no, maximum, sir, not exceeding 25% of. Any lip sync tools. Sir, paid share capital. In between, you will hey. Paid up equity share capital. Pagga. Sir, what if I'm a startup? 50% of paid up equity share capital. Yes or no? 50% of paid up equity share capital only, no? Sir, why, sir? KD is, sorry. KB is spelling, sir. They can keep one, no, sir. They can keep one thing, one place. Remember, if you're a registered startup, it is 50% of paid up capital for a period of 10 years. The 10 years is from when? Incorporation. There can be a deceiving there also. It is not from the day you are The startup. It is from the day you are registered, meaning from the day of incorporation. Clear? People, lock-in period of how much? Da? Can a company prescribe higher lock-in period? Think and tell. Can a company prescribe a higher lock-in period? Pakka. No, not possible. Remember, sir, they are telling you. So the maximum allowed is 3 years. You cannot have a higher. Again, exam question. What we read and go is 3. Again, I'm telling you, 3 is no longer the question. Yes, sir. Next one, sir. People, what do you make consideration other than cash? Now, sir, when do we give sweat equity to the shareholder? I mean, to the employee? He should have given us some value. What has he given? He has given us no value addition, IPRs. So in return, for example, he has given us a beautiful patent. In return, we are giving him sweat equity. Now, patent, does it has value? Yes. Is it a tangible or intangible asset? Intangible asset. Then carry it to your balance sheet. Sir, there is an employee who has just worked hard for us. We did not get any value as such, but he has been a really good asset for us. He has given us a value addition or a know-how in a different places, but I cannot quantify it. Now, whatever he has given to us, can I show it in balance sheet? No, he has not given us anything in terms of quantity. He has given us time. Now, what will I treat it as? I will treat it as an expense. So here, our employee is giving us, imagine 3 things he can give us. One, he can give us money. We call as cash consideration. He's not giving us money. We call it as non-cash consideration. Now, what is he giving? It can be asset, which can be tangible or intangible. Next one, he is not giving us an asset, but we have to value him. We treat asset to balance sheet. We treat expense to P&L. Clear on all of you, non-cash consideration forming part of depreciable or amortizable asset carried to balance sheet. If at all it is any other thing other than depreciable or amortizable, then expense it, meaning take it to P&L. Treat it as an employee expense. Important exam point of view. Hello? Okay. What is the meaning of employee? Permanent employee of the company working in India or outside India. Director of the company, whether whole time or not. An employer or subsidiary. Can I give what is that? Okay, that we'll see when we're doing ESOP only. Here, a register of sweat equity. What is the register of sweat equity? SH 3. Very good. Remember. Preference shares done. Section 56. What is section 56 done? Transfer and transmission. Whenever a person has to transfer securities, how does he transfer? They have to file one form, not which form? SH 4. A transferor, if he wants to transfer any shares to transferee, shares or securities, he needs to file one form called as SH4. That's called as what people transfer deed. Now we will file it with the company. Mr. A wants to transfer his shares to B. We enter into an agreement that is only called as transfer deed. And we have to give this deed to the company because company has to make the changes. No. Yes or no? So we have to give it within 60 days of we entering into an agreement. Remember, if it's a partly paid share, the company will cross check saying that, okay, sir. So if it's a partly paid share, company will cross check. Hey, B, are you aware of this share? It is a partly paid share. After 1 month, we will make call. You have to make the payment. Are you aware of it? The company will check. How? By giving him a notice. The notice will be given by the company to B, intimating him. It's a partly paid share. The intimation will be given in the form SH5. Mr. B has to reply to this within 2 weeks. Failure to reply, deemed approval. Hello. Done. And next one, sir. Hey, within how many days we have to issue security? I mean, shares done. Whenever it is subscription, Incorporation of a company. Company is incorporated today. Within how many days should I issue share certificates? Within. Very good people. I love your confidence. 2 months. Whenever a company allots private placement, within how many days they have to issue shares? 60 days. Correct, people. 2 months. If a company is going for transfer transmission, I gave my request. The company has to new shares to be within how many days? If a company is issuing debentures, within how many days they have to issue debentures? Huh? Not bad. Clear? Huh? Hello? Sir, what if we have issued a transfer request? The company rejected it. What should I do? A wanted to transfer his shares to B. We gave a request to the company, please register our transfer. The company rejected it. What is the right he has? He has the right to go to tribunal. Go and cry there. Sir, my request of transfer was rejected, sir. Within how many days I need to go? ಏನು ಇಲ್ಲ. Rock bottom. People, if I am applying to the company has to respond to us within 30 days. Correct, huh? Sir, they responded. We are not going to register your transfer. Do whatever you want. From that day, we will have 30 days to go to tribunal. Sir, what if they never replied to us? Then from the day you filed your SH4 request, from that day, take 60 days. If there is no reply. Hello. This is for a private company. For a public company, this you will treat it as meaning from the day you give a reply, they reply no. You have 60 days time. What if they do not reply at all? It is 90 days from the day you have filed your SH4. Hello, tribunals order each final. Clear? 58. Important. Done. 60. What is 60 Manda? Alteration of capital clause. Capital clause can be altered in how many days? 5. What are the 5 ways? First one is called increase of authorized capital or decrease of authorized capital. Alteration basically. Next term. Share split. Next term. Consolidation, higher denomination. Consolidation, lower denomination. Cancellation of shares. The fifth one is conversion of shares into stock, stock into shares. Whenever you alter capital and whenever you're redeeming your preference share, you have to intimate to ROC. In which form? Very good. SN7 within 30 days of alteration. Remember. Hello. Which section? Alteration is 61. SH7 is given in 64. Remember. Online no? Clear? Hello. Okay. Next one, sir. Let us see section 62. Important. In section 62, there are 4 things for you to concentrate. What are the 4 things? So, in section 62, sir, there is something called as people rights issue, bonus issue, rights issue, ESOP, preferential, and conversion of debt into equity. First, tell me rights issue. What are the timelines? Rights issue. What are the timelines? Minimum 7 days is the offer period. Maximum 30 days. If I give the offer letter today, can I open the offer tomorrow only? There should be minimum 3 days gap between the offer letter given and offer opening. Okay. And can I follow shorter notice? When? 90 percentage of members. Now tell me. 90 percentage of members in number or value? Number or value? Pakkana? 90% in number. They have to agree. Then people I can go for lesser than what is prescribed. Is this clear all of you? Hello. Right to renunciation. What do you mean by renunciation? I give rights issue means what, people? See, whenever a company wants to raise further capital, they will give an opportunity for their existing shareholders, existing equity. No other share enjoys this right. Existing equity shareholders will be given an option. We want more money. Are you guys interested to invest more? If an existing equity shareholder are given an opportunity to invest more people, then such type of issue is called as rights issue. It's only our existing shareholders to whom we are giving an offer, not to an outsider. Hello, clear? Now, the existing shareholder does not want the share. Can I give it to an outsider? I am not buying. You buy it, my friend only know. Remember, whether this buy is an outsider or also an existing shareholder, whoever it is, I can renounce my right to the other person. By default, the company has a right to renounce, but this can be stopped by your articles of association. Hello. Next one is ESOP. Tell me what is ESOP? Shares, an option given to the employees of the company to subscribe to the shares of the company. It's an option given. We give an option today on 1st January 2026. Congratulations, brother. Abba, lottery. Congratulations. We given one thing to our employee. That letter which you are giving congratulations of, that is only called as, people, grant of option. Hello? Now he will have to be with us for a minimum period. Today we are just giving you congratulations. You don't have shares yet. You have to wait with us for some time. What is the time? You have to wait with us for a minimum period of 1 year. Company can increase it because the law says minimum is 1 year. Hello. So after 1 year, he can exercise the option. Today we have given him an option. After 1 year, he can say either an yes or a no. Who? Employee. Yes, sir. If at all it is beneficial for him, he'll say yes. If not beneficial for him, he'll not say yes. He'll say no. So the question they can ask you, in this 1 year, what if company declares dividend? Will he get a right to vote? He will get dividend. Notice of general meeting. He's not a shareholder. He will not get anything. Clear? Hello? Okay. So he does not have right to vote, nothing. But remember, there is an exception. What is that? If at all there is a death, what will happen? Whatever are the shares given to you, it will vest immediately. You need not even wait for 1 year. First exception. Second exception, people. In the case of permanent disablement, whoever is that person, he will get an immediate right to people to say yes. He need not wait for 1 year. The options will immediately vest. Yes, sir. Yes, sir. All of you clear? All of you? Okay. In ESOP, there is one more important question. They will definitely ask, what is that? Who is an employee? Yeah. Employee definition. There is one main point that you guys should not miss at all. Who? Certain people are not included in the employee definition. Employee means a permanent employee who has been working in India or outside India. Okay. A director of the company, whether whole time or not, but excluding an independent director. Sweaty equity was independent director excluded. Sweaty equity shares can be given to independent because it is not excluded. Here it is given. ESOPs cannot be given to independent director. Okay. But can I give it to any other non-executive directors, part-time directors? Yes, possible. That's the meaning of whole-time director or not. Next one, sir. An employee given of a subsidiary company in India or outside India, or of a holding company of the company, or an associate company. Meaning, an employee can be mine, my holding companies, my subsidiary companies, my associate companies. Any employee it can be. We can give our share. But the employee does not include who? An employee who is a promoter. Mukesh Ambani cannot be taken as an employee. Your company, why will you be considered as an employee? Next one. a director who himself or through relatives holds more than exact 10 now, more than 10% is disqualified. Exact 10% is not disqualified. He is eligible. However, sir, if I am a startup, there is a cool off period. These conditions will not apply in the case of a startup for a period of 10 years. You can still give to your director. If he is having 15% of shares of the company also, it's okay. You can still give it to him. Clear? You can give it to your promoter also. Even if he is a promoter who is an employee, you can give it to him. It will not apply up to a period of 10 years. Clear? Hello? Okay, done. Next one, people, is called take of that only. Conversion of debt into equity. Can I convert debt into equity whenever I want? Remember, there is one condition. If a company has issued any, imagine if a company has taken any loan, can they convert that loan into equity? Can they do it? Possible, people. Condition is, people, you should have taken special resolution at the time of taking debt only. That time only, if you have passed special resolution, you can convert the debt into equity. If that is not the case, people, then you cannot convert the debt into equity subsequently. Hello? However, this rule does not apply to one person. Who? If it is a government, meaning what, sir? If government people has given loan to any company, if government thinks in public interest, I will convert this debt into equity. Government can pass an order and say, hey, in your company, I had given debt, no, I want to convert it into equity. I can pass an order. But if the company is not okay with it, they can also go for an appeal within 60 days. Whatever is the order of the tribunal, that will be final. Remember, clear on section 62. Done. Next one will be section 63. Easy. Bonus issue. Only thing I will emphasize here is bonus can be given from what? Sources. Three things. One is free reserves, securities premium, important CRR account. You cannot utilize revaluation reserve and all of that. Agreed? Hello. Done. And it should be authorized by articles. You should have not made any default in payment of your statutory dues, provident dividends, interest to all of that. And remember, you can never issue bonus in the lieu of dividend. For dividend, you cannot give bonus. For bonus, you cannot give dividend. It is irreplaceable. Clear? Done. Next one is people 64. We saw SN7 now. Next one is people reduction of share capital section 66. What is reduction of share capital done? Now, whenever people, let us imagine, people, we have taken, say, we have issued people 1 crore of equity. We have raised money. With that, we started doing business. Company went into losses. We have lost around 40 lakhs. On our asset side, 60 lakhs is there. Our liability side, 1 crore is there. This is the most bad balance sheet you can ever see. So what will the company do? The company has to prosper. They will call the equity shareholder. They will say, Macha, in this 1 crore, we have lost 40 lakh. Can we reduce the capital from 1 crore? Can we please make it to 60 lakh? Remember, people, board approval plus special resolution plus creators approval plus NCLT's approval, all these approvals, if you are able to take, then this people, you can reduce your capital from 1 crore to 60 lakh. I need to take the approval of board, special, creditors, as well as tribunal. If everyone agrees, I can do it. If not, I cannot do it. Clear? Hello? And how and all I can reduce the capital, sir? How and all I can do? Capital reduction, people, can be done in 3 ways. One, people extinguish the share capital not paid up. That means uncalled. That means what? The face value is 10 rupees. 6 rupees is called. 4 rupees is uncalled. You will call them and say, don't pay this. Whatever is uncalled, you will tell, don't pay. Next one, sir. Cancel the paid up capital which is lost or unpresented by available asset. Meaning, I will call and say, people, that 40 lakh, you have to book it as a loss. You don't have a choice. They will also agree and accept. If they accept, people, whatever is the 40 lakh we lost, it's a waiver. Meaning what? We have convinced them, if they are okay, that 40 lakhs goes away from our balance sheet. Going forward, we are not liable for that 40 lakhs. Hello. Next one, sir. Pay of the paid up capital which is in excess. What do I mean by that, sir? 10 rupees face value. We have collected 10 rupees. Entire 10 rupees was paid up. In this 10 rupees, we want 8 rupees. 2 rupees is extra. We will repay 2 rupees extra. We will repay. That is the third method. Sir, what is the difference between first and third method? First method, they have not yet paid. The third method, they have paid. We are repaying back. That's the difference. Hello. So, sir, with this, I can go for a capital reduction. And remember, people, at any given point of time, if we have left out any creditor when we are going for a capital reduction, if he files an application, then people, the tribunal will treat as if our capital was never reduced. We will be liable for the payments that we were liable before the capital reduction. Understood? That means what? After capital reduction, what will happen? The capital of 1 crore will come down to 60 lakh. So the shareholders' liability will now be 60 lakh. But if at all you had left out any creditor's name while arriving at 60 lakh, then they're telling you people, you will be held liable. I getting the point? That means what? Your liability will be treated as if it was 1 crore only and not as 60 lakh. It will be treated as if the capital was never reduced. The shareholders will be liable for their previous, what is that? Outstanding payments only and not the reduced payments. Clear? Yes, sir. That is your capital reduction. Next one, sir. We do of important one. Buyback. What is buyback, sir? Section 68. Now, what is buyback, sir? Whenever a company people proposes to buy back its own securities, it's called as people buyback of securities. Conditions to be satisfied, sources of buyback. Always I tell you, sources and utilizations is the most important questions. Remember and go. Sources of buyback people, it can be made out of free reserves, securities premium, and proceeds of fresh issue. It can be any other kind, not of the same kind. Okay, post debt equity ratio should not be more than 2:1. What do you mean by that? If my equity is 1 lakh, the maximum debt I can have should not be more than 2 lakh. If I have 2.2 lakh worth of debt, it's not a good company, it's a bad company. Any day it can fail. The maximum accepted is whatever is your equity, twice of it can be your debt, not more than that. Okay. Third one, remember before going for a buyback, all the securities has to be fully paid up. Next one, you cannot do a further buyback within the next no further buyback shall be made within 1 year. Cool off is 1 year. 6 months is if I'm buying back equity today, I cannot further issue equity. Today I purchase buyback. Again in the next month I am issuing equity. You cannot issue in the next 6 months. Clear? Okay. Company shall not issue. Same thing 6 months. Provided sweat equity, bonus, conversion, all of that is exception. Register of buyback, SH10. Register of ESOP, very good. SN6. Remember. Sir, extent of buyback. What is the maximum buyback I can do now? If I pass a board resolution, the maximum buyback I can do is people. I'm not questioning you here. 10% of paid up equity share capital plus free reserves. Example, Mancha, remember and go. One place it will be paid up share capital. Remember and go. If I pass a special resolution, people, if I have to derive the value or any security, then the maximum I can buy back people is 25% of paid up share capital plus free reserves. But if I'm buying back equity people, then the reference has to be taken as 25% of paid up equity share capital. Remember, here free reserves is there, here free reserves is there, here free reserves is not there. That's the biggest difference. Hello. And what we get here is number of shares. Correct? Okay, next one. Declaration of solvency. It is a declaration given by the directors saying what in the next 1 year our company will not become insolvent. We give it in the format people SH9. If at all in the next 1 year, if a company goes for insolvency, the directors will be personally liable, unlimitedly liable, because you had money, you're repaying because we have extra money. after repaying if the company becomes insolvent. Correct? Yes or no? Yes. Last one, sir. Return of buyback, meaning after the buyback is made, we have to intimate ROC. If it is listed, we will intimate ROC plus SEBI. That, sir, the total capital we had was 1 crore. In that, we have purchased 20 lakh. Our new capital is 80 lakh. We have to intimate it to ROC. Now, that is only called as people return of buyback. We intimate in form as such level. Clear? So if the question has both preference and equity, and if the question says the shares was bought back, which one to take? They will not give you vague. They will clearly specify which security was bought back. If at all they are giving it like that, then be happy. It would have been a grace marks. Yes, it'll always be crystal clear. It will not be that vague. Clear? Okay. So extinguishment of securities. Once you buy back people, you will take that securities, you will tear. Because remember, buyback is never an investment. Buyback is a strategy of reducing your capital. It is not an investment. So once the buyback is done, you will take the securities, you will tear it. Hello. Done. Next one, sir. Section 67 was important. Let us do section 67. What is section 67? Restriction on purchase by company or giving of loans by it for purchase of its shares. What do I mean by that? In section 67, people, let us imagine what they're telling you is that there is company A. Company A cannot give money to anyone and tell to buy its own share. This type of loan, guarantee, security, any financial assistance should not be given by a company, especially if it's a public company. This is restricted. But this rule has certain exceptions. Now, what is that? That is the important part. Read and go. Now, what is that, sir? No public company shall give loan, guarantee, or security, or otherwise any financial assistance. That's a general rule. But this rule has an exception. What is that? The lending of money by a banking company in the ordinary course of business. Correct? What do you mean by that? Sir, I'm a ICICI Bank. ICICI Bank, I am a person, I have my account with ICICI Bank. I take loan from them, personal loan. How do they know what will I use this personal loan for? I'm taking the loan, I'm using it to buy their own securities. Technically, as per section 67, I cannot give loan to anyone to buy my own shares. He's buying, no. It is not in my control. And this is my ordinary course of business. Giving loan to everyone is my ordinary course. I cannot check why he's taking it for. Sir, exception. Second one, sir. Sir, we are giving our employee ESOP. How many? I gave our employee 1,000 shares. The value of shares, sir, is 100 rupees. That means he has to pay 1 lakh. What is his salary? 30,000 rupees. You tell me, a person earning 30,000, you're asking him to pay 1 lakh. How will he pay? So, you're allowed to give him a salary loan to buy your own shares, which you gave as ESOP. How much we can give? The maximum we can give is people 6 months, provided this employee should not be your director or KMP. You can give it to any other employee, but you cannot give it to your directors or KMP. Remember, important and go. And it should not be more than your 6 months salary. Exam question will come here. Remember and go. Third one, sir, allows the company to fund an employee share scheme like ESOP trust if shareholders approve it by special resolution. What do I mean by that, sir? You remember section 19? There was a holding company, there was a subsidiary company. We created ESOP trust. Correct? No. Now, this ESOP trust, they need shares. What will the holding company do? The holding company will give loan to this ESOP trust. They will open demat account. They will buy shares from the open market. They will buy shares from the open market. Correct? Now, if you look at it, I am only giving loan to buy my shares. No. They're telling you it is exempted. Why? Because this is how ESOP trust works. It's exempted. It is allowed under the law. Then, sir, this restrictions will not apply to a private company if they are satisfying what? Let us imagine XYZ Private Limited. these conditions will not apply to it. If in XYZ Private Limited, there should be no body corporate who is a shareholder, meaning no company should have invested in you, no LLP should have been invested in you. If any of them have invested, then this exemption is not applicable to you. There should be only individuals, no body corporates as shareholder. If that is the case, this private company enjoys the exemption. Clear? Hello. Second one, sir. This private company has loans. How much? Not exceeding twice of its paid up share capital. Their paid up capital is 10 crore. Twice of it is how much? 20 crore or 50 crore rupees. Whichever is less. So you should have loans not more than 20 crore. The private company has loans. Let us imagine it's 11 crore. It's okay. You can go with this particular thing. If your loans is more than 20 crore people, then this exemption is not applicable to you. You will have to come through this section. Section 68 will be applicable to you. 67 will be applicable to you. Next, last one, sir. You should have not made default in repayment of these borrowings. Whatever loans you have taken, you should have not made any default till now. Hello. That is section 68. Then I mean 67. Buyback is done 68. Yes, 69 CRR I told you. 70. Okay. Last one we do it of debentures. Now what is debentures, people? Debentures. What are the conditions of debentures? Tell me everything. What is the maximum tenure of debentures done? The maximum debenture is 10 years. But if you are issuing secured debentures, then you can, if you are issuing secured debentures, the maximum tenure is 10 years. If you are an infrastructure company, people, you can issue up to 30 years. Agreed? Okay. And if the secured debenture, people, I have to mandatorily appoint a debenture trustee. And people have to create a charge on it. CHG1 has to be filed. Correct? Okay. And what is that? I have to create something called as people. What is debenture redemption reserve? What do you mean by that? What is the value of debenture redemption reserve? 10 or 15? 10 or 15? Pakka. So people, remember people, my total outstanding debentures. What is my total outstanding debentures? The total debentures in the company is 100 crore outstanding. Now people, out of this 10%, I have to create something called as DRR, Debenture Redemption Reserve. DRR is always created out of the profits of the company. It cannot be used for any other purpose other than redemption. Hello? Okay. Now next one, sir. What do you mean by DRF? Debenture redemption fund or debenture redemption investment. What do you mean by DRF? Whatever is the debentures that is going to mature during the year. Imagine out of the 100 crores during 25-26, a total of 30 crore debenture is going to mature during the year. On this 30 crore, I am going to make a 15% of investment. Yes, sir. By when should I invest? So how much will that be? 15% is 30 crore. How much? 4.5 crore. I have to invest it in any secured place. What is a secured place? Unencumbered government securities, scheduled banks, unencumbered bonds given in UTI as per Indian Trust. Your Trust Act, whatever the security is given there, I can invest money there. This 4.5 crore. Agreed? And it has to be unencumbered. What do you mean by unencumbered? Which you should have not given as collateral anywhere. Agreed? Hello? So, I can deposit in scheduled bank unencumbered securities. Unencumbered securities given as per Indian Trust Act. Unencumbered bonds given as per Indian Trust Act. What do you mean by unencumbered? Meaning, I'm taking government securities, but I'm taking it to bank. I'm giving it as a collateral and I'm taking loan. What is the use? If you don't repay the loan, they will take away the securities. It should be safe. That's why they have used the word unencumbered. Clear? Hello? And next one, sir. What is that? A certain people cannot become debenture trustees. Who are they? A person who beneficially holds shares. Meaning what? A shareholder can never become a debenture trustee. They can ask you a question here. A promoter, director, or KMP can never become a debenture trustee. A person who is beneficially entitled to money otherwise than as remuneration. What do I mean by that? Imagine people, I'm beneficially entitled to any money other than remuneration. I have given you loan. I have done a FD with you. I earn interest on it. I'm earning money from you. I cannot be a debenture trustee because I'll be biased. Next one, has furnished guarantee, meaning I have not taken loan. Someone else has taken loan from you, but I have given guarantee. If that person does not repay, I will repay. The next one, has any pecuniary relationship, meaning people, monetary, any other relationship of amounting to 2% or more gross turnover or total income or 50 lakh rupees, whichever is lower. You take this amount, whichever is lower. If I am having the transaction with you, I cannot be a debenture trustee. Last one, sir. If I am a relative of your promoter or a director or a KMP, I cannot become a debenture trustee. One more point with regards to debenture trustee. If at all there is any casual vacancy, meaning if at all the debenture trustee leaves and goes, resigns. Now what do? If there is any casual vacancy, then board of directors have to appoint. But remember, sir, if at all it is due to resignation, the majority of debenture holders has to approve that appointment. The next one, sir, can we remove a debenture trustee? They can ask you a question. At least 3/4 in value of the debenture holders has to agree for the removal of debenture trustee. Can a debenture trustee conduct a meeting? Yes, whenever the circumstances provide so. Next one, people, if there is a request made by how many people? 1/10 of the total debenture holders outstanding in value. If they make a request, people, yes, you will conduct a debentures meeting. Is this clear all of you? Hello. This chart, try to remember. In this part, I'm just telling you who should do the debenture DRR, DRF. In the class, we have done the complete explanation for this also. Remember, NBFC HFCs which are listed, they'll have to do DRF. Remaining listed companies who are not covered here will have to do DRF. Remaining unlisted companies who are not covered here, they'll have to do DRR and DRF. DRF is done always by vendor. What is the last day? 31st March. For example, for 25-26, I have to I have to do my DRF by 30th April 2025 of whatever is the debenture maturing during that year. On that, I have to create 15%. Clear? Hello? That is your debentures. Any doubts? No? Okay, done. Should we go for a break and come? Hey, till what time you guys can sit down? Ready? Yes, sir. ಅವನು ಆಲ್ರೆಡಿ ಏನೋ ಮಾಡಿ ಸರ್ ಇದಕ್ಕೆ ರೆಡಿ ಸ್ಟಡಿ ಗೋ ಬೇರೆ ಅಂತ ಲಂಚ್ ಮಾಡಿದ್ವಿ ಯಾಕೋ ಓಕೆ ಚಾಪ್ಟರ್ 5 people acceptance of deposits by companies. Acceptance of deposits by companies. Okay, let us quickly see somewhere my mind says a deposits definition they'll manage. Now I feel anyways we are doing another matter of 10-15 minutes. We'll do that also. It will never end. Okay, now see you. Stay online now. Hi Guru, how are you? Now people. Okay, taka. No advertisement, so only movie. Vega. Now people see what is not a deposit. Let us quickly try to recall whatever we have done. Now people, deposits people. What is deposits? Law tried to say that people, whenever you're taking money, in every place, every transaction is covered, like debentures, preference shares, private placement. For everything, there is a rule. How to do, how not to do. For everything, there was a rule. But people started taking money by using some gray areas. Not every way of receiving money was covered. The best example I can tell you, share application money. The law says you have to refund. If I don't refund, law is telling me to pay interest of 12%. If you use your brain, bank gives you interest at the rate of 15%. Commercial loans to 18%. It is easier for me to take a share application money and keep paying interest to them, which does not have maturity forever. Now, where is all that covered? Where is it all that disclosed? People were taking gray areas. So they said, simple, do one thing, you do it, raise money. I just said, what is considered as deposit? If it is considered as deposit, then you need to do it as per the law. That means what? Disclosures are required. Now, what do I mean by that? You have to, now you would have seen there is something called as DPT3. In that, you will clearly tell, I've taken money from so and so person. Till that day, it was not at all being recorded in any place. No one knew that it happened also. Now, at least it is coming to the light. Okay, something like this is there. That's the whole purpose of doing deposits. Now, deposits, they did not define what is deposit. They defined what is not a deposit. So anything apart from this is a deposit. But it's a vast list. Now, what is it? Taka taka. Any money received from governments. I'm trying to keep it short. Wherever explanation is required, I'll tell you. Any money received from government. It can be state, center, local authority, statutory authorities, and foreign government also will come. Correct? Indian governments, foreign governments. We call this as people subsidy, grant, or whatever name you guys can give. This will not be considered as deposit. Hence, you guys need not have to follow any rules. You take money, you use money, done. There is no reporting required. In the same way, when I talk about foreign, in foreign, what and all came? Foreign governments, foreign international banks, Indian banks are also there. If I take money from Standard Chartered Bank, from foreign country, American Express, or something, if I'm taking from a bank which belongs to abroad, they're telling you that money cannot be considered as deposit. It's a debt. Indian bank debt. Okay. Next one, multilateral financial institutions. Like say Commonwealth, Asian Development Bank. What is Asian Development Bank? Just like World Bank. Asian countries have set up one bank for us. All of us are developing countries. But yes, so we are having one bank for us. Whichever country is going down, now Sri Lanka, now they can go and borrow loan here. They will give. Understood? Okay, next one. Foreign governments and development financial institutions. We just saw. Foreign export credit agencies. What is foreign export credit agencies? They are nothing but people, the financial institutions which will promote exports. They will only give funds towards exports. If at all anyone like that is there from foreign country, we will also go and take. For example, Japan and all, I think I've told you in the class, they give you loans for a very, very reasonable cost. Rate of, it depends, fluctuates. So better to take it there than here. Here the rate of interest are high. So any money taken, not a deposit. Next one, foreign collaborators. What is foreign collaborators? Suzuki. Maruti got money, no? Foreign collaborators. Money received, not a deposit. Foreign body corporates, companies, LLPs, not deposits. Foreign citizens, not deposits. Of course, everything is subject to FEMA laws. I can't take money from Pakistan. Foreign authorities or person resident outside India. Foreign authorities is nothing but people, government representatives. Again, not considered as deposit. Chance of question asking in foreign is little less. So when you feel that no, nothing is going, you can put an end for foreign. Any money received as a loan from bank, SBI, notified banks, corresponding new banks, they are same only people. Any bank which is set up after a particular time, we call them as new banks. Today there is no difference, everything is same. Any cooperative banks, they are considered as, again, not a deposit. Loan or financial assistance from PFI, one definition. What is PFI? Public financial institutions. Who are considered as PFI? Remember these three people. What is that? One is LIC. Next one is IDFC. Next one is any other person CG may add. Next one is any other person CG may add on a recommendation by RBI. Clear? So these people are considered as PFI. So now I have a doubt. For a person to be called as a PFI, public financial institution, what are the criteria I need to satisfy? There are two criteria. Any one you satisfy, you can become a PFI. What is that? The first one, you should be either people, a government company, or people, you should be a statutory company. Meaning you should be set up under any act of the parliament or state legislation, or you should be a government company. Now LIC can be a PFI. Why? Because majority shareholding is with government. That's the fundamental thing that we consider to call someone as a PFI. Clear? Simple? Okay, done. Any regional financial institutions, insurance companies, scheduled banks, Indian banks, I told you. Any money received from them, sir, is not considered as deposit. Amount received using commercial paper. Now, what is that? I issue debentures and raise money. In the same way, I'm issuing preference and raising money. In the same way, I'm issuing commercial paper and raising money. It's an instrument provided I have to do as per RBI guidelines. Any amount received by a company from other company, intercorporate deposits. Now, if you guys have a book, remember that can be a questionable point. Intercorporate deposits. They can ask you like this. Infosys received money from Tata. What is this transaction called? That is important. Remember. Here are intercorporate deposit. One company giving money to another company will not be classified as deposit. It is called as intercorporate deposit or intercorporate loan. It will not be covered in our deposit provision. Clear? Important from exam point of view. Next one, very important. Share application money or securities application money. What is that, sir? In private placement only we saw. If someone is applying for shares today, we have to allot the shares within how many days? How many days? 60 days. If I do not allot within 60 days, what will happen? I need to refund within 15 days. Now the question is, even after 15 days, if I'm not refunding, what will happen? Now they are telling you after that it will be treated as deposit. Understood? Huh? Share application money. Now this is how they'll ask you a question. This is important. Understanding? Directly they'll not, foreign simply they'll not give it. So nothing there to write. Here there is something to write. 60 is there, 15 is there. That is where you can expect the question. Are you getting the point? Hello? Okay. Next one, sir. Any amount received from a director of the company or a relative of a director of the private company. Important. What is it, sir? A director gives money to XYZ Limited. Is it considered as deposit? Declaration is important. What is the declaration? Declaration is that this money is mine. I have not borrowed from anyone. If the declaration is given people, yes, this is not considered as a deposit. Declaration is not there. That means I am taking money from someone and I'm giving it to you. It is a deposit. In case of a private company, director can give or director's relative can also give if it is a private limited. Remember. Hello. Next one, sir. Amount raised by issue of bonds or secured debentures. Important, remember. Remember, if at all I'm issuing secured debentures, is secured debentures considered as deposit? They're telling you it won't be considered provided there are certain conditions that you need to satisfy. If you're not satisfying, then it will be a deposit. If you're satisfying, it is not a deposit. Now, what are those conditions? First one, people, it is secured. That means what? There has to be a charge. That to what type of charge? First money should be given to them, then to anyone else. That's why we call it as first charge. So on the debenture holders, you need to have a first charge created. The second one, sir, such charge should be created only on the assets that is given in Schedule 3. What is that, sir? Nothing but people. You can never create a charge on an asset which is intangible. It should be only tangible. Condition 2. First is first charge. Second one is people. Only tangible, excluding intangible. Third one, people. They should be compulsorily convertible into equity within 10 years. Mandatorily convertible. So remember, if it is secured, it has to be convertible. So the fourth one, sir, the amount of bonds or debentures shall not exceed the market value of the assets. Now, what do I mean by that? It's a secured debenture. That means I've given my land. My land value is 1 lakh. How much is the value of debentures you have raised? How much? It should be 90,000. Okay. Sir, can it be 1.5 lakh? Not okay. Your debt should never be more than the value of the asset. Hello, 4 conditions. First charge, excluding intangible assets, compulsorily convertible value. Remember, important. Next, there will be one number. For example, we generally call it as loan to value percentage. It is generally 85. 75 to 85. Let us imagine if your number is coming to 75 percentage. Clearly a notice will be sent to you. What? Either to repay a certain part of the loan or to add one more amount as collateral or guarantee. Yes, sir. Any amount raised by issue of non-convertible debentures. People come, convertible is coming here. What if it's a non-convertible debenture? Only one condition. What is the condition? If it's a non-convertible, mandatorily listed on a recognized stock exchange. Simple. Hello. Any amount received from an employee, again important. How much are we taking? Not exceeding his annual salary. And remember, can we pay interest on it? It should be non-interest bearing. Agreed? Huh? Yes, Sam. Okay, next one. Any non-interest bearing amount received or held in trust. You can take that ESOP trust only as example. I'm getting it from my holding company. I'm not taking any benefit. I'm just using it for ESOP. Any amount received, ordinary course of business, important. Remember and go. Sir, it's a business. Arivu has taken money from all of you to teach both the groups. Now, one group is going on. The other group is advanced. No, it is not yet taught to you. Within how many days should we teach you? They're telling you the maximum time a company can take something as an advance should not be beyond 365 days. For example, people, I'll give what do you say? For example, I'll give an order for a furniture. He'll say, sir, give me some advance. I'll give it. He'll give me sofa after 2 years. It will be treated as deposit. I've given him advance money. He has to deliver me sofa within 365 days. If it is 366th day, it's a deposit. There's only one exception. What is that? Sir, the delay happened because of a legal fight between us. In the court, the case is going on. That's why it went to 1 year, 2 years. Then this provision will not apply. If not, on a general day, if there is anything where we have to give you money and there is a no court dispute within 365 days, I have to either get the service or the product. If not, it is a deposit. Hello. Yes, next one. As advance received in connection of immovable property. Now, what do you mean by that, sir? Nothing but I've taken a land. Land you guys will give advance, no? Yes, sir. Now, when you are paying the final payment, you will adjust that advance, right? If the money is adjusted, not a deposit. If the money is not adjusted, it is treated as deposit. What do I mean by that, sir? Value of land is 1 crore. Advance given was 2 lakh. While I'm paying the final payment, if 98 lakh was taken from me, this 2 lakh is not a deposit. At the time of final payment, they still took 1 crore from me. This 2 lakh for that person is a deposit. He has to comply with all the rules. Next one, as security deposit for the performance of the contract for supply of goods or services. What is a security deposit? Whenever you guys go and say, for example, in the class we would have seen, you use ULU or bounce, or now whenever you go any outstation. Now, for example, I told you Sri Lanka. I took auto for rent. There we can rent an auto. It's called tuk tuk. Yes, first day, auto ungate went off like this. So because 3 week, it's not like how we thought. ಸ್ವಲ್ಪ difference ಇರುತ್ತೆ. It's not like ನಾನು first ಇಂದನೂ auto ಹಿಂದೆ ಕೂತಿದ್ದೆ. Yes, so what is a simple thing? What they took is passport. ಅದಾದ್ಮೇಲೆ $100. $100 is a security deposit. You have to give. That means what? Our value 8,000 rupees. 8,900 security deposit. Now they'll take passport. Hey, passport. Passport is the main document. Now he took that $100. Why? If tomorrow auto one part doesn't come. So that is what I'm telling you. Any money taken as security deposit as advance received under long-term projects. What is this long-term projects? Infrastructure or any other, say for example, hospitals, medical equipments. When a hospital is starting, building will start today. In full, after every building and all is done, they go and get that X-ray machine. Like X-ray, MRI. The X-ray, MRI, after after this, Xerox and all. MRI. So after that, they will go and know. While the building is under construction, they will always have their vendors. That's called a long-term project. Correct? No? Next one. As an advance for providing future services. What is this? Now, for example, people. Correct. Now, on Urban Company, there is an app. They sell water purifiers. Very good. They come up with, they take 17,500 rupees for water purifiers. Any cost, everything is on them only for 2 years. Now I'll be an idiot if I think this 2 years they're giving the service for free of cost. I'll be an idiot only. They have added the 2 years cost in the price. I think Native, something is the brand. Go Native, yes, so it's a brand. Now 17,500 rupees they will charge. 2 years of free. Anything happens, people, no question asked. Beautiful. If there is any product that I have liked for the last 3-4 years, it is this product. Full fida. It will be beautiful. It will give you a report. How much of water you drank this week. Report it will give you. It will tell that this left side kidney is gone. Not for me, but the purifier. Meaning it has around 10 stage of filters. It will tell which product is it is reaching its life. It will measure in terms of percentage. All of that. The moment I tell you why I said it's good. The moment it hits 0, you need not have to make call. They will automatically come. They will change the filter. They'll go. Nice, no? I'm not promoting them, but they are good. Now, people, now you tell me, in the market, there are other brands also. Now they are telling they have received this warranty, annual maintenance charges upfront from me. Up to what extent they can raise this warranty or annual maintenance charges, they are telling you. Any money received for future services, annual maintenance, warranty, people, the period of service then should not exceed the period prevalent in the business practice. Now you take water purifiers. What is the minimum warranty or annual maintenance they say? Let us imagine everyone is following, say 3 years. Yes, sir. Or 5 years, whichever is less. Now, how much is our fellow giving? 3 or 5, whichever is less 3. How much is our fellow giving? 2. Whatever money has taken is not considered as deposit. Understood? Yes. As an advance received as allowed by any sectoral regulator, TRAI allows the telecom industry to take 1 year, 2 year. Okay. For example, IRDA, they allow 3 years insurance you can pay in prior. Okay. Their regulator is allowing. Then why do I have a problem? Next one, as an advance for subscription towards publication, whether in print or in electronic. For example, magazine, newspapers, all of this. I've given money. They have to either give me the service. If not, they have to at least give me the refund. Agreed? Remember the day it comes to the refund. They have to refund that entire thing to me within 15 days. Whenever the refund triggers, They have to give it to me within 15 days. If not, people, it will be considered as deposit. Hello. Yes. Any amount brought by promoters or by their relatives of the company by way of unsecured loan provided as a stipulation. It's nothing but what people like, nothing but it is called as people down payment. We are starting a project, people. We are asking a bank to fund our project. The bank is saying, I will give you 80% of the loan, 20% you bring. If you are not worth 20, why should I give 80? You take your bike, car, phone, anything, 100% bank only will give. Something you should put, no. The money you are putting in, it is your money you will put in. The company who will put. Promoters is bringing the money because the bank has put a condition. You put 15%, I will put 85%. The money the promoter gave, it cannot be considered as deposit because they gave not by choice, but because of a mandate. They said, if I don't give, they will also not give. That is why I gave. Such money is not considered as a deposit. Clear? Any amount received by a Nidhi company is not considered as deposit because that is their regular business. Sit funds, any amount received by collective investment scheme. What is collective investment schemes? Mutual funds, Allah, like your, what is that? Networking. I will join, another two people you join. All that, such schemes. Or imagine, what is that? Land. Everyone invests 5,000 rupees, one person will get lottery. So all those things come under collective investment schemes. Generally, people in India, there is something called as Ponzi schemes, meaning nowhere it is there. It is not regulated with anyone. They will come with one fancy schemes and they will cheat people. To avoid that, people, the new concept called collective investment schemes were introduced. Yes, sir. For example, a biggest collective investment scam that has happened in our country is called Sharada scam. Yes, sir. Who is Vivekananda's teacher, Guru? Ramakrishna Paramahamsa's mother's name is called Sharada. So in that name, they have floated his company. If I'm not wrong, I might be wrong. If I'm wrong, please excuse me. I think so. In that name, this scam was made. Sharada, see name, why? Trust. Biggest scam. Very crazy money people have lost. Convertible note, very, very important from exam point of view. Convertible note means what, people? Just like convertible debenture, that is, it is getting converted to equity or repaid within a duration of not more than 10 years. Sir, who can issue this instrument? Anyone can issue? No. Only one person can issue. Kaun wo? Startups, sir. It is only the registered startups who can issue this instrument. So convertible note is an instrument which has an option to convert into equity or repay the money within 10 years. Hello? Sir. Now, sir, within this 10 years, okay. What is the minimum amount that startup has to raise? The minimum money you have to raise is, people, 25 lakh rupees. So the 25 lakh I'll give in EMI. Okay, illa, people, you have to give it in single tranche, one transaction. Sir, this 25 lakh, three people together we will give. Okay, no, people, this is one single person giving 25 lakh rupees. If all conditions are satisfied, people, it is not considered as a deposit. Hello. Okay, so any amount received by a company from AIF, venture capitals, infrastructure investment trust, REITs, mutual funds, etc. REIT, I told you, if you remember, real estate, nexus, alternate investment funds, nothing but all your investment funds, venture capital funds, angel investors, infrastructure investment, all your roads, bridges, metro, money raised for these projects, they all come under what? Infrastructure investment trust. Clear? Okay. Taka, 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 taka. Let us directly go off to the procedure. Now, deposits, sir. What is the procedure of deposits? Okay. Acceptance. First thing, people. Section 73, 76. These two sections are important. Remember and go. 73 says that people are prohibited from accepting deposits from public. Then can I accept it from members? Yes, possible. Under 73, it allows me to raise money from members, but not from public. From public, it is prohibited. But this section will not apply to a few people. Who are they? The first one is called as people, banking companies. That's a regular activity. NBFC, HFC, such other companies specified by central government. Remember, in exam, the name if they have given, pay attention and read the question. They would have given you XYZ NBFC Limited. Straight away, deposits chapter itself will not apply to you. Can they raise money? You raise whatever you want. Who will stop you? So names will always indicate something in the questions. Remember and go. Okay, next one. What is the procedure, sir? Sir, we can raise money from members, that we know. How do we raise it? The first one they're telling you people, I have to pass a resolution in the general meeting. Remember, deposit is a debt. Agreed. What is the maximum debt a company can raise? People, there is one section called 181C, which says what is the maximum debt a company can borrow. Paid up share capital plus free reserves plus securities premium. Correct? Huh? Now, whatever is the aggregate, to that extent I can borrow. Imagine this is coming to 2 crore plus 3 crore plus 1 crore. The total I can borrow is 6 crore. Imagine if a company wants to borrow beyond this. Imagine the company wants to borrow 7 crore. To borrow this people, you have to mandatorily pass a special resolution. Sir, if the company is borrowing only 5 crore, that is within this limit, then ordinary resolution is sufficient. Clear? Done. Next one. How do I raise deposits from people, sir? First, I have to come up with something called as a circular. What is circular? Nothing but people like an offer letter, in which I have to give all the details about this deposit and whatever was my previous deposits. If something is still not paid, outstanding, I have to give details about all of that. Along with that, one important thing people is called as credit rating. Remember, if it's a public deposit, credit rating is mandatory. Here, huh? Okay. Next one, sir. Newspaper advertisement, it's optional if it's 73, mandatory if it is 76. If you're raising it from members, newspaper advertisement is absolutely optional. If it is from public, newspaper advertisement is mandatory. Clear? Next one, sir. That is 73 to A. That is nothing but people circular. Now, sir, before I give this circular to the members, I have to first show it to someone, and that person is called ROC. Now, what are they telling you? Before giving it to the members, at least 30 days prior, you should have given it to ROC. If ROC sees, he will tell you what are the comments, modifications, all that you have to implement, and then only you will give it to the members. 73 to B. Next one, people, 73 to C speaks about deposit repayment reserve. Cut, copy, paste whatever we saw in DRF. Whatever are the deposits that is going to mature during the financial year, the 20% on that, you have to create a different reserve. And you have to create it by 30th April of every year. Now, that is only called as what, people? Deposit repayment reserve. Even though I am calling it as DRR, the functionality is as per DRF. Remember and go. Next one, 73 2D is omitted, no longer there. 73 2E, in the past, you should have not made any default. If you have made a default, people, there has to be a certificate that I have made good the default and 5 years have elapsed from the day all of this was made good. Hello? 73A, 73 2A, 2E. What is that? A spoke about circular, credit rating, and statement. 73 2B spoke about filing with ROC 30 days prior. C speaks about DRR 20% 30th April. D, nothing is there. E, no outstanding defaults, subsisting defaults. If at all there is anything, people, I need to get a certificate. All of that I have made good, 5 years have elapsed. Hello? Okay. Now, sir, should every company follow this? They're telling you 73A to E is not applicable for a few company systems. Meaning, I need not have to come with circular. DRR not applicable to me. Nothing is applicable to me. Who are they? They're telling you they are private companies. Which first one? If a private company is raising deposits not more than 100% of its paid up share capital, free reserves, securities premium, meaning ArivuPro. Now we will take our paid up share capital plus free reserves plus securities premium. We will get one number. Let us imagine if we are getting a number of, say, for example, 1 crore. Now, how much we want to raise as deposits? I will say I would want to raise, say, for example, 90 lakhs as deposits or 1 crore only as deposit. That is within the limit. Okay. From whom are you raising? From my members only. Members are shareholders only. Then people, all these provisions will not apply to me. A to E is not applicable. No repayment reserve. Nothing is required. This is clear, huh? Hello. Okay. What are your class? Okay. Or registered startup for 5 years. If you're a registered startup, remember people, this is not a mistake. If you're a startup people, only in this place, it is exempted for a period of 5 years. So once you're called as a startup, up to 5 years, you enjoy this benefit. You need not have to follow A to E. The third one, sir, which fulfills all the conditions. That is nothing but people. You should not be an associate or a subsidiary of another company. This is similar to Section 67 buyback. You're not supposed to give financial assistance and all we saw, no. Not applicable to a private company. Same thing, this particular condition is similar to. Borrowing is less than twice of its paid up share capital or 50 crore, whichever is less, not defaulted in repayment, all to be satisfied. So, private up to 100%, not required. Startup 5 years, how much ever you raise, not required. A private company, which is, imagine after 10 years, they're telling you, if at all you're not an associate or a subsidiary, and if your debt is not more than twice of the paid up capital or 50 crore, whichever is higher, and the next, whichever is less, the third one is people should have not made any default in repayment. If you satisfy all these people, then they're telling you A to E is not applicable to me. Hello. Clear on? Okay. Next one, sir. What is the procedure for accepting deposits from members? Remember, even the public also will be more or less the same. There will be no difference. How does it happen? First, it will be board meeting. Next week, general meeting. Pass the necessary resolution, meaning it can be ordinary or special, depending upon 181C. I will come up with a circular DPT1. I will file it with ROC 30 days prior. And along with that, I will even publish it in newspaper if it is public. Yes, sir. And the DPT1 will be issued to the members along with the application form. They will also apply. Remember, one declaration is mandatory. What is the declaration? That the money is mine. I have not borrowed it from anyone. Whatever the director gave, same thing he is giving here also. Collect the declaration. Deposit receipt should be given within 21 days of receipt of the money. Just like we gave share certificates, they have applied for the deposits. We are giving them depository receipts within 21 days. Next one, sir. Entry to be made in register of deposits within 7 days from the issue of receipt. So I need to register of members, same way. Register of deposits, I have to make an entry. Maintain DRR at 20%. Submit the return of deposits. Now, this is where I'm telling you, you are intimating everything to ROC. You will intimate people by 30th June every year. Sir, this year, this is the outstanding. We have raised so much of deposit, we have repaid so much of every year you will intimate to ROC. Finally, sir, if company fails to repay, the depositor may apply to tribunal. Maximum amount of deposit. We'll see these rules later. Clear, Anna? So, sir, remember the main thing is, try to remember the timeline. Whenever you get the money, within 21 days, the company getting the money, you have to give deposit receipt. Next one is people, within 7 days of receipt, you will make an entry in register of deposits and DPT3 will be filed within 30th June every year. Clear? Yes, okay, done. Next one, sir. Directly go to public. Now, sir, can we raise deposits from public? Is it possible? Yes, possible. By following section 76. Who can raise, sir? You should be eligible company. Now, who is called as an eligible company? Eligible company means it's a public company having net worth of 100 crore or turnover of 500 crore. Yes, sir. And remember, if at all it is within the limit, ordinary is sufficient. Beyond the limit, special is required. Important, remember. Next one, sir. What is the procedure? Same thing. Meeting, appointment of deposit trustee. Because you are raising it from public people, you have to appoint someone called as deposit trustee. In the previous chapter, you would have seen debenture trustee. Here it is deposit trustees. Now, sir, trust deed, we'll have to enter into deposit trust deed in the form DPT2, 7 days before the issuing of circular. We have to appoint one person. Who will this deposit trustees generally be? They are people, banks only, who will oversee the complete process. If something goes wrong, they will always come to protect you. Next one, obtain the credit rating. So I told you, if it is a secure deposit, it's a public deposit, credit rating is mandatory. So which year I have to take credit rating? For the entire tenure, throughout the tenure, credit rating is mandatory. If you have taken deposits for 3 years, first year also you have to take. Second year, if there is revision, that also you have to update. As long as the tenure of deposits are there, remember, there has to be a credit rating renewed every year. And not only that, you have to intimate that credit rating every year with ROC. Hello? And it should not be less than the minimum required rating. Correct? Huh? At least there will be some minimum, right? It should not be below that. It's just like a cutoff. Beyond that, you cannot raise deposit at all. Next one, sir. Charge creation, because it's a secured one. Public, you're taking people. Of course, I have to file CHG1 only on tangible assets. Remember, always the loan has to cover, the charge has to cover principal plus interest. Always. There can be a question here. Here on. Yes, sir. That means what? If the value of the loan is 60 lakh, now interest per year is coming to 10 lakh. Let us imagine if it's 3 years. So it is 30 lakh. Total is 90 lakh. The value of the assets you guys are creating as a charge, that value of the asset should not be people less than 90 lakh. It should be minimum 90 lakh. At any given point of time, your charge has to cover the principal as well as interest. Important exam point of view, they can ask you, remember and go. Issuance of circular, I have to give newspaper advertisement. Sir, if I give a circular, newspaper, how long I can keep raising money? The newspaper circular will be valid up to 6 months from the closure of financial year or due date of AGM, whichever is earlier. 6 months from the closure of financial year. Now, what do I mean by that? Imagine on 1st February 2026, we gave a newspaper circular. Now, using this circular, how long can I raise money? They're telling me from this day, 6 months, that is nothing but 30th September 2026 or whatever is the due date of AGM, whichever is earlier. Remember, you guys should not get confused. Sir, due date means it will be on 30th June only, no, sir. 30th September only, no, sir. Need not be people. The due date of AGM can be even before also. Correct. Top 100 listed companies, they will conduct their AGM within 5 months. Closure of financial year, 15 days, 15 months requirement also have to keep in mind. Correct? Yes. Collect signed application, this are all same. 21 days. Register of deposits, maintain DRR, file DPT 3. Remember, that is same as whatever we have seen. Next one, sir, rules. What is the tenure? Very, very important. Macha. Rules of deposits chapter is like Dilka Dhadkan. Now, people, what is that they're telling you? What is the tenure of deposits I can raise money for? The tenure of deposits, people, they're telling you, you can never take deposits which is repayable on demand, like your savings bank account. You go draw money. Whenever you go draw, you will get your money, right? You cannot do such deposit. You can only do FDs and RDs, not savings bank. So any money repayable on demand can't be received. Okay, what is the minimum tenure? Minimum tenure is 6 months. Maximum, can I raise deposits for less than 36 months? I mean, less than 6 months? Possible. To meet your working capital requirements, you can raise deposits for less than 6 months, but remember, not less than 3 months. So 3 is bare minimum. Sir, for what? This is to meet my working capital requirements. Now remember, sir, what is the maximum money I can receive less than 6 months? They're telling you the maximum I can receive, it shall not exceed 10% of the paid up capital, free reserves, securities, premium account. Clear? Huh? So the maximum, that means what? Let us imagine if the company is raising 35% of deposits. Less than 6 months, the maximum I can raise is 10%. The rest of the 25% should be more than 3 months only. It should be more than 6 months only. It cannot be less than 6 months. Hello? Clear? Okay, next one. Premature repayment of deposits. What is a premature, people? Sir, we have raised the money for 3 years. But someone is coming and asking the deposits in the second year only. Can we give a? Yes. Should we give a? Hello? Should we give a? Yes, sir. Just that one condition is there. Reduce the rate of interest by 1% for whatever is the period the deposit has run. The deposit has run for 2 years. Correct? Huh? So for 1 year, if you are eligible for say 9%, this reduce it by 1%. So what they will that person will get is 8% for both the years. For whatever is the period the deposit has run, for both the years, the rate of deposit, the interest will be reduced by 1%. Hello. Now, sir, while calculating this, sir, if there is any period less than 6 months, you guys have to ignore it. 6 months or more should be treated as 1 year. Now, what do I mean by that, sir? Now, there is, let us imagine 15 months of deposits is completed. A person is coming and asking for premature payment. Now, 15 months, how do I have to treat it? The question is, it is 1 year plus 3 months. Can I take it? Alive. So for 1 year, I've completed 1 year. This 3 months, what do I do? They're telling you, check if it is less than 6 months or 6 months or more. If it is less than 6 months, people, ignore this 3 months. This person will get payment only for 1 year. And that too minus 1%. Let us imagine there is a person who has completed 19 months. Now, how will I write? Can I write it as 12 plus 7? For 12, it is a completed year. We don't have a problem. 7 is 6 months, 6 months or more. This will be treated as second year. So he will be entitled for 2 years rate of interest, provided yes, minus 1%. Hello? Okay. So should we reduce this 1% every time, always? Every time, always correct, but there are exceptions. What are the exceptions? Two exceptions. If at all we are repaying the money to meet our limits. What is the limit? Next condition I'll tell you. Next one, sir, if you are repaying the money for Army, Navy, or Air Force during the emergency, or for their dependents, or for their families, you're repaying the money. You need not have to do 1% reduction and all. You pay the full interest. Next one, sir, higher rate of interest can I give? Answer is yes, provided you need to renew the deposits for a period longer than the unexpired period. What do I mean by that? 3 years is my deposit period. Sir, 2 years is completed. 1 year is pending. Can I say 1 year is the unexpired period? Answer is yes. Now you can go for a renewal. If at all you are going for a renewal, your renewal period should be higher than the unexpired period. So do anything beyond 1 year. Can I take 2 years? Can I do 3 years? Answer is yes. If you go for a renewal, including this 1 year, you will be eligible for a rate of interest at a higher percentage. Hello? Yes. Clear? Okay. It is a higher rate of interest. Quantum of deposits. What's the maximum deposits that I can raise? There are three types of companies it says. What are the three types of company? One is called eligible company. One is called eligible company, non-eligible company, government company. Eligible company can raise money from who? Members also, public also. Eligible company, we saw 100 or 500. They can raise money from members up to 10% of paid up share capital, free reserves, securities premium. Public, sir, maximum 25% of paid up capital, free reserves, securities premium. Every percentage in this chapter is on paid up capital, free reserves, securities premium only. Hello? Now, sir, what do you mean by other than eligible company? Other than eligible company means people, private company or public company which is not satisfying 100 or 500 crore criteria. I will call you as what? Other than eligible company only. If you are other than eligible company, what is the maximum deposit you can raise? It cannot go beyond 35%. Can I raise it from public? No. I can raise only from members. Hello. Next one, sir. Last one, government company. What is the maximum they can raise? 35% from whom? Public. Remember, here they will ask you whatever possible. The person cannot change. Government company cannot raise from members. Or eligible company cannot raise that entire 35% from public. Not possible. The limits are to be taken like that only. You cannot change it. You cannot transfer one limit to another. Not possible. Sir, is this limit same for everyone? Yes, same for everyone except one. Who? Go back. One more exemption. What is that? Private companies. If you are a registered startup up to 10 years, no limit. Raise how much ever you want. Hello? Pakana. Now people will get confused. Sir, there also, at that time only you saw, no, sir, private company exemption. Again, why is it coming? This is for limit. That is for procedure. Now imagine if you are a registered startup. Let us imagine for the first 5 years. As per this, there is no limit for you. You raise how much ever you want. As per the previous exemption, they need not have to follow 73A to E. One is for limit, one is for procedure. Hello. Next one, same thing. A private company which fulfills all the condition. What? There should not be any associate subsidiary. There should not be debt not more than twice the paid up capital or 15 crore rupees, whichever is less, and you should not have made any default. Correct? Huh? If all these conditions are satisfied, such a private company can raise deposits without limits. Hello? Pakana? Sure. Okay. And what else? Deposit trustees there are. Appointment of trustee for depositors. One or more trustee will be appointed. DPT2 we saw. Who can be a deposit trustee? Similar to debenture trustee, is a director, KMP, or any other officer or employee of the company, or if it's holding subsidiary associate or a depositor. Correct? I cannot be a director, KMP, officer of my company, holding subsidiary associate, or I cannot even be a depositor in the company. I cannot do it. Correct? How did we remember this? Company, associate, subsidiary, holding, cash. I cannot be a director in my company. I cannot be a KMP. I cannot be any other officer in cash. Hello? Yes, sir. A person who is indebted to the company, basically cash. If I have taken loan, I cannot be a deposit trustee. I can ask you, remember and go. Just 1 second, people. Hello. Sir, ಅಲ್ಲಿ ಇದ್ದಾರೆ ನೋಡಿ ಸರ್ ಮನೇಲಿ ಕೊಟ್ಬಿಡ್ತೀರಾ ಒಂದೇ ನಿಮಿಷ ಸರ್ ಒಂದೇ ಒಂದು ಸೆಕೆಂಡ್ ಸರ್, ಎಲ್ಲಿ ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಬಂದಿದ್ಯಾ? ಒಂದೇ ನಿಮಿಷ. ಸರ್ 2349. 8 times he has called. So, okay. ಕೊಯ್ಯರ್ ಪಾಪ ಹಂಗೇನು ಹೇಳಕ್ಕಾಗಲ್ಲ. Has any material pecuniary relationship with the company? Material pecuniary means what? Money related. Has entered into any guarantee? Someone has taken loan. I said if he doesn't pay, I will pay. Is related to any person specified here above. What do you mean by that? So I cannot be director, employee, or any other officer. Neither can I be any relative of a director, relative of a KMP, relative of any other officer. Hello? Yes, sir. Okay. Can a trustee be removed? Huh? Can a trustee be removed? Can a debenture hold trustee be removed? Can a debenture, what is the procedure? 3/4 of debenture holders in value or in number? In value. What if there is a casual vacancy? Board of director will appoint. If there is a resignation, who? Debenture trustee is removed and shareholders will come and approve. What will debenture holders do? Play goal here. Debenture, hey, macha, remember na? If it is casual vacancy, board of directors, okay. It is one is number, one is value. Here also what they are trying to tell, see here, this is not the same. There the directors have removed, but they took the prior approval of debenture holders. Now see here what they are trying to tell you. The trustees shall not be removed after the issue of circular, except with the consent of all the directors present at a meeting. In case the company is required to have independent directors, at least one independent director shall be present in such meeting of the board. Macha, if you ask me important level, I will say in the scale of 10, 15. Very important. Pakka they will ask you. Because for debentures, it's a different provision. For deposit, it's a different provision. Remember. So can I remove? Yes. How? They're telling you. Take board approval. Everyone have to agree. All. And people, at least one independent director should be there in that particular meeting. Possible question. Remember and go. Hello. What is the maximum rate of interest and brokerage that we can pay? Whatever RBI has fixed for NBFCs. RBI said, Muthoot, you cannot pay beyond 12%. Same percentage applies to the companies accepting deposits also. Read. But it shall not exceed the maximum rate of interest or brokerage prescribed by RBI in case of NBFCs. Clear? Okay. Can we make deposits in joint name? Possible, not exceeding 3. Document filing, we saw 21 days. Deposit receipt, 7 days. Register of deposits, we saw 7 days. You have to make an entry. People, the register should be maintained for how long? 8 years from the date of latest entry made. Whichever is the last entry you make, from that date is 8 years. Prepayment of repayment, we saw. $74, absolutely leave and go, not at all required, because $74 applies to the deposits which you have accepted before Companies Act 2013 have started. We have come across 13 years. It's a 13-year-old provision. It is absolutely not applicable now. So even the institute also will not ask. It's an outdated provision. Why? This is a transitional provision. When Companies Act 1956 to 2013 came, what about the deposits which was already accepted? For that, they gave a 3-year breather space. So for 2017, this provision only came to an end. So if section is there, but absolutely not required. Don't waste your energy to remember it. Sir, punishments, section 76A. Try to go through the punishment penalties. Done now. Done. Okay. Taka concentrate being finished off charge chapter at least. Huh? Because management administration, I don't think we can touch. I'll give you half an hour, 45 minutes break. I'll give you count up. Right? 4:15 now is your class. Now what time? 2:57. 3:30 will finish. Then we'll go for a tea. Okay, now. KV is like, yeah, sir. So I leave charge and go. You leave this chapter. What a KV? What is it? Lunch break. ಎರಡು ಕ್ಲಾಸ್ ಬ್ರೇಕ್ ಕೊಟ್ಟಂಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಷ್ಟು ಬೇಡ registration of a charge, people. Now what do you mean by a charge? Charge is nothing but it's a lien, it's an interest which is created in the favor of a lender. Failure to repay the loans, the lender will always have a right to recover the property against the loan given. Agreed? Remember, important points can be charge can be created on immovable property, movable property, tangible, intangible, in India, outside India. All three important. Anyway, they can ask you a question. Clear? Okay. Now, sir, whose duty is it to register a charge? For that, they have said, now in this thing, left side literally ignore. Why? In 2018, that is nothing but 2nd November 2018, the rules got transitioned. So this rule itself is 7 years old. So what we will focus is on charge created on or after 2nd November 2018. Now what do I mean by that? Let us imagine, sir, there is Kingfisher who enters into a loan agreement with ICICI Bank. They enter into a loan agreement. Now, whenever they are entering into a loan agreement, this is called as what, people? Creation of a charge. They have made a loan agreement. On that, Kingfisher has said, sir, if I don't repay, you can take away the big building. On that, I have good mansion also. Yes, sir. UB City is there, sir. You take that. If I don't repay, sir, you take this building. Now, people, we have created a loan agreement. Now, this is only called as what, people? Creation of a charge. Once the charge is created, people, I need to intimate this to ROC. We have just created between parties. The government is not aware of it yet. It is my duty to intimate them. Now, what is the timeline that the government has given to me? From the day you create the charge, the law gives me 30 days time. So within 30 days, I have to register the charge. Look at the words I'm using. One is called creation. This is creation. Registration is you filing it with ROC. I need to file it within 30 days. Sir, what if I don't file it within 30 days? The law gives you an additional time of another 30 days. Or while you're writing, you have to write 60 days from the date of creation of a charge. So it is 30 or 30 or 60. Within 30 days, if I do not do, then 30 plus 30. So technically 60. Within 60 days, I have to go and register a charge. If I'm going in the 30 days, I just have to pay normal fees. If I'm going after that period, I need to give an additional fees. That means it's a little higher fees. Now your doubt, sir, is it normal fees plus additional fees? Of course. I'll have to pay both. That's why it's a fine. Now, sir, if at all I'm going additional, I remember. Now, sir, if at all you imagine, if I'm not going even this time also, the law is giving me, people, another 60 days time. So technically, how should I look at here? Imagine this is the day I register the charge. The first timeline is 30. Second timeline from here, it is 60. Or 30 plus 30. Everything is same. Sir, even now, if I'm not registering, from here it is 60. So technically 120 days. Remember, sir, this comes with the additional cost. and we call it as a penalty ad valorem fees. Yes, sir. It's like we call it as a punitive. That is nothing but people penalty. It's a fine that we have collected from you. So this is the timeline for us to register a charge. Tell me which form we used to file or register a charge. CHG1. Now, whenever we are filing CHG1, ROC will reply to us in which form? CHG? Sakana? Huh? CHG2. Modification. 4 is for Yen bro. CHG4 is for satisfaction. CHG5 Memorandum of Satisfaction. Registrar's reply. CHG6 appointment of receiver or a manager. CHG7 register of charge. CHG8 rectification of any errors or satisfaction of charge not done within 300 days. CHG8 condonation of delay with central government. CHG9 creation of charge for debenture holders. So what is CHG2? Certificate of registration of a charge. Now, sir, we file CHG1. Now, they will reply CHG2. Is this clear? Yes, sir. Okay. Now, sir, what is the consequence of non-registration of a charge done? What happens if I do not register a charge? Then people, I will come across two scenarios. One is called void against liquidator. One is called void against creditor. Void against liquidator means people. Let us imagine Kingfisher went into insolvency. Now the liquidator has to repay all the creditors using the Kingfisher assets. I will tell all the creditors to come in line. Of course, the VIPs will be the secured creditors. Whoever is not secured, I will pay them last, unsecured. Now, people imagine you have created a charge, but you have not registered. The liquidator, when you're asking for repayment, you're coming in the queue. You thought you're a VIP. You came and stood in the front. But people, the liquidator said, sir, is your charge registered? He said, no. Then please go and stand in the back. So I'm not saying I will not repay your loan. I will repay, but you will not get priority. That is the meaning of void against liquidator. After paying secured, I will pay you. Next one, void against creditor. What do I mean by that? Imagine people on the same building. If Kingfisher again takes loan from Axis Bank, if Axis Bank goes and registers first, and then I will register, the priority will be always given to the creditor, whoever has registered first. So that is the meaning of void against creditor. This is clear? Sir, charges are of two types. One is called as fixed charge, one is called as floating charge. Fixed is nothing but something which remains same with time. The property cannot be sold but can be used by the borrower. For example, I take a charge on this building. I can use it, but I cannot sell it. Now, such type of charge is called as fixed charge. Example, plant and machinery. Example, land and building, as the case may be. Next one is called as floating charge. What do you mean by floating charge? An asset which can be sold without the lender's approval. It is like my regular business. Example, people stock in trade. For example, I have stock. Imagine we have textbooks. We can pledge it. We can take loan. Now, when I get an order, I will sell it, but we'll again reprint it. This process will keep on repeating. I will not check with the bank every time can I sell it. Fixed charge you have to, but floating charge you will not. Until when, sir? Remember, people, the agreement will be written like this. If at all I fail to repay any interest, the floating charge gets fixed. That means what? Now, correct. That's called crystallization of charge. Now, whatever books are there in the probably the godown, the entire books gets seized. Now, no longer I'll be able to sell it. When from the day the floating charge gets crystallized. When does the floating charge gets crystallized? The floating charge gets crystallized when the company goes into liquidation. Next one, company ceases to carry on business. We are stopping our operations. The third one, people, creditors or debenture holders take steps to enforce security. What is this? You appoint a receiver, you appoint a manager to go and take the possession of the property. From that day, the fixed charge gets floating charge gets crystallized. Next one, happening of any event specified in the charge deed, your charge agreement. Example, what can that be? Failure to repay interest 2 times consecutively. That is what is written. Then if that happens, that's all people from that day, they're going to tell that the floating charge gets crystallized. One more important point. Who can sign, authenticate the charge? If the I have not added in this, here. Duty to register charge. Now, sir, where a company, important people, where a company creates charge on any property, whether movable, immovable, tangible, intangible, in or outside India. Now, who should verify it? Who should sign it? They're telling you, if property is situated outside India, that documents, who will sign? They're telling you, common seal or director or CS or authorized officer of charge holder. Who is the charge holder? Basically, bank or I'm speaking about lender. That's a charge holder. Correct? Creator of a charge is a borrower. Charge holder is always a lender. So they can come and sign it. Okay. Or some other person, some person other than the company who is interested in the mortgage. What do I mean by that? Let us take, for example, company has issued secured debentures. From whom will they raise money? Debenture holders. Now they are the people who is interested in the mortgage. Who are the people other than interested in the mortgage? The people representing him, who? Debenture trustee. He will come and sign. Or let us imagine company has given security. We have raised loan, but one person has given a surety. Our regular person, Vijay Malia. If no one else pays, I will come and repay. I don't have any interest in this property, but I am interested or I am related to this transaction. I can come and sign. That is this person. Clear? Yes, sir. Okay. What if the asset is in India, people? It's only one or two. The third condition will not come into picture. Hello. That is important. Remember and go. Next one, sir. Application for registration of charge by a charge holder. Now, what is this? Sir, the time limit was given to me 30 plus 30 or 60. I did not do it, sir. Then they're telling you, why do you want to wait for 120 days? Who? Bank. The borrower has not registered the charge. No, you do one thing. You wait for maximum 30 days. If within 30 days, if he is not registering, you go and register a charge. Now, we gave 30 days time to Kingfisher to go and register the charge. He did not register. Now, people, after 30 days time is done, we will tell ICICI Bank, now it is your time to register the charge because you have to be secured. It is your interest now. Now, what will the ICICI Bank do? ICICI Bank, of course, they have exceeded the 30 days time period. You have to pay fees plus additional fees. And I will recover all that money from the borrower. That is, Kingfisher will have to pay all of that money to ICICI Bank. Hello? Is this clear? Okay. Now, randomly, what if some bank tells that, hey, I gave loan for that person, that property is mine. What if randomly people start filing? That's why remember, if ICICI Bank files an application with the registrar saying that this property is subjected to charge, the registrar will issue a circular or checking with the company, Kingfisher. ICICI Bank is telling that they have given loan to you and this property is subjected to charge. Isn't true? Can you confirm? We will wait for ICICI to confirm. Within how many days? 14 days time will be given to you. If ICICI does not respond, it is considered as deemed approval. We will issue a certificate of registration of a charge in CHG2. Hello. Done. Okay. Section 80. What is section 80? Section 80 is nothing but people constructive notice. What do I mean by that? Let us imagine people, if someone, there is a, for example, take this only, Kingfisher has registered the charge with ROC for the loan taken from ICICI Bank. Now, people, someone else wants to buy this property from Kingfisher, which one? That mansion. Now, Kingfisher did not tell anything that we have taken loan on this property. Nothing was disclosed. On the date of registration, Mr. A got to know that Kingfisher has loan on that property. Mr. A is telling what Kingfisher did is fraud. You cheated me because you never intimated me that on this property there is a charge. The question is what Mr. A is telling. Is this valid? What Kingfisher did, is it fraud? Why? Section 80 done. What does it say? The moment people, a charge is registered, it is a public document. You cannot say you did not know. If a person is entering into a contract with the company, you are expected to read all the public documents. And first of all, this whole concept was conceived for the people like you only. And if you only don't read, then what is the use? Said law. Clear? Huh? Yes, Sam. Hello? That is section 80. Next one, sir. Sir, now one thing, people, let us imagine. Okay, Kingfisher had the property. Charge was registered. Now this person is buying it. Let us imagine there is a company B which wants to buy that property from Kingfisher. The loan is still not completely repaid. Now, company B is of an opinion. Anyways, the charge is already registered. Now, I am buying that property. I need not again register the charge. Company B is of that opinion. My question to you, should company B, if it acquires a property which is subjected to charge, should it again register? Is it required? Remember, people, whenever a person who acquires the property on which there is already a charge created, it is the duty of the acquirer to register the charge. Mandatory. Which form? Again, you will follow the same condition. CHG1 only. Hello? Pakka? So, sir, that is the section, people. CHG1 now, whenever there is a person who acquires the property and modification, both has to be intimated to the registrar, both in the form CHG1 only. Registration of charge also CHG1, modification of charge also CHG1. Any doubts? Hello? Hello? Okay. Company to report satisfaction of charge. When registered charge is repaid or satisfied, company shall give. Again, same thing, people. Now, Kingfisher has repaid to ICICI Bank. Now, Kingfisher will have to go and intimate ICICI, ROC within 30 days. Sir, we have taken loan. No, we have repaid. Sir, what if within 30 days, if I do not go, you will have one-time delay, people. They'll give you maximum time of 300 days. If you miss 30 days, you will get time of 300 days. Sir, what if in that 300 days also I did not go? So you can go to the next section called section 87. Go and apologize central government. Sir, please excuse me. Because of some genuine reason, I was not able to come and register the satisfaction of a charge. If central government is satisfied, they can give you any additional time period. There is no restriction. Yes, sir. Oh. Yes, sir. So there is no additional restriction. So if there is anything, people, beyond 300 days, there is no timeline. Meaning, again, I'll not say 30 days, 60 days, nothing like that. Beyond 300 days, absolute discretion of ROC. I can give you literally any timeline. Are you getting the point? Yes, sir. Again, this is called as what people? Condonation of delay. And this we can get it done by going to central government. I have to apply for it. In which form I will apply? I'll apply in the form CHG8. Sir, and what else reason we will go to central government? Imagine we have filed some charge documents in CHG1. There are some mistakes in that. I need to rectify them. To rectify the mistakes also, again you will file CHG8 only. Hello, is this clear? Pakka CHG8. One is omission in giving intimation to ROC with respect to payment or satisfaction. Macha, remember, CHG8 is not applicable for registration. It is applicable only for satisfaction. Today's date, registration is impossible beyond 120. You did not register within 120, you will die. That's all. No other shortcut. No option also. Satisfaction, no one is at trouble. That's why they are giving you time. Purpose only is done. Agreed? Now, same procedure will repeat in satisfaction also. What happened? Kingfisher is telling I've repaid to ROC. What will ROC tell? ROC will cross check with ICICI Bank. Hey, ICICI Bank, Kingfisher is telling that he has repaid your loan. Is it true? 14 days time will be given. If you do not respond within 14 days, deemed approval. Hello. Okay, that okay. Last two parts. Acquisition of property subject to charge and modification. We did a person who buys and whenever there is modification. Form is same, CHG1. People will have doubt. Then what do you mean by modification and condonation of delay? Where we are filing that, sir, there is a mistake. The modification is different, mistake is different. Modification is when you guys agreed the tenure of your loan was 3 years. Now you want to increase it to 5 years. This is modification. Mistake is you have not given the details accurately. Documents are mistake. Your ID proofs are mistake. So that is a mistake. This is modification. Rate of interest is being increased. That's a modification. Hello. For all of this, I will file from CHG 1 only. Modification is CHG 1 only. ROC will reply to me in which form? CHG 3. Very good. Next one, section 80. Constructive notice, I told you. Section 81. What is that? In class, we would have seen. Can we check all these things are public documents? All the details filed by the company, the ROC will maintain it as a register of charges. By paying such fees, anyone can come and inspect it. Allowed. Done. Hello? Section 81. Next one, section 82. Company to report satisfaction, we just saw. Section 83. Power of registrar to make entries of satisfaction and release in absence of intimation from the company. Now, what do I mean by this, sir? Imagine people, say for example, there is Kingfisher, there is ICICI Bank, and there was a loan taken. Now this person acquired this property, and this person repaid the entire loan. Neither did Kingfisher intimate ROC, neither did ICICI intimate ROC. Now today it is this person's property. He will be under a headache. Now what will he do? He will file satisfaction or an intimation to the ROC. Sir, you remember that charge that is there in your register? I have purchased that property. I've completely repaid the loan. I will completely give all the evidences. If registrar is satisfied, registrar can automatically issue memorandum of satisfaction of charge. Even if the parties did not intimate, if the registrar gets to know, registrar can issue memorandum of satisfaction of a charge. That is section 83. Hello. CHG 4 is satisfaction of charge. CHG 5 is the reply given by the registrar. Hello? Sir, intimation of appointment of receiver or manager. Now, what do I mean by that, sir? Sir, Kingfisher has given loan to ICICI. ICICI did not. Kingfisher has taken loan from ICICI. ICICI did not get the loan back. Now what will they do? First thing, now Vijay Mallya ran away. First thing the Kingfisher will do, I will check in my charge, whatever we have created. Do I have a right to appoint a manager? If I have it, what will I do? I will appoint a person. I will tell, go and take the possession of the property. Going forward, that is ours. There are stock, take it. If there are books, take it. Anything that is there, go take the custody. First appoint a manager. Sir, what if right to appoint a manager is not there in the charge you have created? Then people apply to the tribunal. Sir, can I please appoint a receiver? Because the person has not repaid the loan. Can I please appoint a receiver? So that a person can be appointed by the court and please help me recover that property. So two things can happen. One, a power to appoint a person is reserved in the charge. You appoint a manager. Power to appoint is not reserved in a charge. You seek the court's help. The court will appoint you a receiver. Whether manager is appointed or receiver is appointed, you need to intimate it to ROC and the other party as well. I will intimate it in the form CHG6. A Kingfisher, I'm sending a manager to you. A ROC, I've appointed a manager. I will intimate in the form CHG6. Mr. So and so has been appointed as a receiver or a manager. Clear? No, sir, he was appointed. He did whatever the job required. His appointment came to an end. Whenever his appointment comes to an end, within 30 days, again you need to intimate. So you will intimate people, appointment also, cessation also. In the form CHG6. Hello? Company has to maintain all these registers. Section 85. Remember, sir, an instrument creating charge shall be preserved for how many years? For a period of 8 years. From when? From the date of satisfaction. Whenever you repay the loan, have to maintain the loan documents 8 years. Register of charge will be maintained permanently. Again, I repeat, instrument creating charge 8 years from the date of satisfaction. Register of a charge permanently. Clear? Hello? Punishment for contravention? Done. On punishment letter, it will be punishment for you. Okay, once quickly, taka see of CAG1, no. A charge, I mean, a form for creating or modifying the charge. Reply by ROC, certificate of registration of charge. CHG3, if I am filing modification, he will reply in CHG3. CHG4, I am repaying the money, satisfaction of charge. CHG5, reply given by ROC, memorandum of satisfaction of charge. CHG6, receiver. CHG7, register of charge, format. CHG8, central government, condonation of delay or rectification of errors, mistakes. CHG9, creation or modification of charges in the case of debentures. Done now? Okay, let's catch up tomorrow. Agenda for tomorrow, we'll have to finish the rest of the corporate laws. Last day, we'll be doing other laws. Hopefully.
Yes, people, good morning. Good morning. Online able to see it? Audible? Online? Are we audible online? Yes. Okay, done. I hope you guys have revised what we have done yesterday. Yes. Okay. Let's quickly start your chapter 7, management and administration. Okay. Chapter 7, management and administration. So we start with section 88. We had stopped at 87. Now, section 88 speaks about register of members. Now, register of members, people, first of all, who and all have to maintain register of members? It is mandatory for all the companies. Now, what is the format of register of members? The format of register of members is MGT1. Remember, the format is same for equity as well as preference. What if you are a debenture holder? Then it will be MGT2. Not only debenture holder, even if you are any other security holder, it will be MGT2 itself. Now, how long will I maintain these registers for? Most of the cases, remember people, of course, there are a few exceptions. If not, most of the cases, the registers will be permanently, most of the cases. But yes, there are differences. But if not, in general, most of the registers will be permanently. Now, what is that they're telling you? In the case of MGT1, you will preserve these books permanently. What if it is any other security holders? You will maintain it for a period of 8 years from the date of redemption. That is, if at all, if I have to give an example of debentures, whenever you repay, from that day, you will be maintaining it for a period of 8 years. Okay. Next one, the place, where do we keep these registers at? By default, any registers, we will keep at the registered office address itself. However, we have a right to keep it outside the registered office also. Now, if Infosys has its registered office at, say, for example, Bangalore, in one of the places in Bangalore, they can keep it outside the Bangalore also, allowed. But for that, what is the condition? They are telling you, you can keep it anywhere, just that you have to pass a special resolution. If you pass it, a special resolution, you can keep anywhere within Bangalore. Their registered office is an electronic city. That's the area. I mean, that's the place. Technically, you are supposed to keep it at the registered office itself. But if you are passing special resolution, you can keep it anywhere in the Bangalore. Sir, I don't want to keep it in Bangalore. I want to go beyond Bangalore. Can I go beyond Bangalore? For that, they are telling you more than 1/10 of your total number of members, wherever they reside, yes, people, there you can keep. Now, what do I mean by that? Let us imagine if my company has around, say, for example, 2,000 shareholders, and in that 250 shareholders are from, say, for example, West Bengal. That means I can keep my registers at West Bengal. That's what they're telling you. More than 1/10 of the people have to reside. Simple. Next one, sir, index of registers. What do I mean by index? Just like your page numbers, index. You need to know in which chapter, which page, which chapter is. Same way, imagine if a company has 200 shareholders, 300 shareholders. Now I need to know in which page, which shareholders details are mentioned. So that is only called as what people index of the registers. Remember, index is not required. When exactly 50 required, exact 50. Less than 50 not required people. That means what? 49 registers are not required. Exact 50 registers ka index is required. Next one, sir. Foreign registers. Is it mandatory to open a foreign registers? No. Can the shareholders demand for a foreign register? They want their demand, but the company is not under an obligation to open a foreign register. In foreign register, what we will maintain? In foreign registers, we'll maintain the details of the foreign shareholders. Now remember people, even if you maintain the details of the foreign shareholders, all those details has to also be transferred to even your principal registers maintained in India. If, just because you are maintaining your details in foreign register, that doesn't mean that you need not have to maintain those details in principal register. Now, what is the detail? What is the what is that? Within how many days you will transfer the details, people? You will generally transfer the details within 15 days. What is the format of foreign register? MGT? What is the format of foreign register? MGT1 only. Remember, people, whatever, yesterday, remember, your fake note will be like fake note only. It will not become dollar. So, any foreign register also, the register, the format will be same. If I'm maintaining it for equity, it will be MGT1, other security, MGT2. Sir, but whenever I'm maintaining a foreign register, if I'm opening or closing, I have to intimate someone. Who is that? I have to intimate ROC. In which form I'll intimate? I'll intimate in the form MGT3. When will I intimate? Within 30 days of opening the register or closing the register. Now remember, a company at its discretion, they can close the foreign registers whenever they want. They can ask you then questions in any possible way here. Remember it. Here. Okay, sir. Next one, sir. Closure of registers. Can a company close its registers? Is it possible? Yes, sir. What is the maximum time it can close? The maximum time it can close, first thing is at once, in one stretch. Cannot close beyond 30 days in a series, aggregate, meaning in the complete year. If I add everything, I cannot close beyond 45 days. Now remember, all the registers will be open for inspection. People will be coming and checking. Now, whenever you have closed your registers, people, the inspection will not be available. That's why it is your duty to intimate the shareholders. Sir, today the registers will be closed. And not only that, why else we will close the registers? What is the reason we close the registers for? We close the registers for identifying the corporate actions. That is, if at all the company has declared any dividends, bonus, rights issue, I need to know who exactly is the shareholder who is eligible for these rights. That's why what do? We close the registers as on that day. Whosoever name is reflecting in the registers, that person will get all the rights. Agreed? Okay. And whenever you are closing your register, it is your duty to intimate the shareholders that the registers will be closed. You will intimate 7 days prior. How do I intimate, sir? Depend upon what type of company you are. If you're a listed company, people, you will put it in the newspaper and website of your company. If at all you're a private company, people, newspaper advertisement is not required. A private communication is sufficient. That is, just send an email. That is sufficient. Here, this whole provision is section 91. Okay, and next one, let us do of, we are doing anyways registers. Let us do of, what is section 94? Section 94. There are two aspects in section 94. What is that? One is, where do I keep my registers? And inspection. Agreed? Okay. Place of keeping, we have already seen. Inspection of registers. Who and all can come under inspector that will give you the registers, index returns shall be open for inspection and service. Who can? Any member, any debenture holder, any other security holder or beneficial owner during the business hours without payment of any fees. So for all these people, it is free and by any other person. People tell me in interpretation of statutes, what do I mean by any other person here? Belpuri person is not. Huh? First of all, tell me which rule you will apply. Interpretation of statutes. Which rule will apply? Existing generous or nocider or sources? Which interpretation? First of all, I hope this question is clear. Because it's a generic word, iOS. Interpretation of statutes. Nocider or sources? Not existing generous? I think existing generous. He's like the first I only thought. You simply disturbed my thought. Nocider or sources, not existing generous. Pakka. 100%. 90%. What is nocider or sources? What is the example we saw for nocider or sources? Where did I write the word orange? In existing generous or nocider or sources? So remember, nocider or sources, the word will have its own meaning. If it's not having the meaning, if it's a generic word, any other person, does it have any meaning? But if I ask security holder, is there a meaning? So security holder, if there is a meaning, then nocider or sources will come. If it is any other person, it's bland. That word has no meaning. Then existing generous will come. I think I showed you one case also that Anil Kumar Podi versus ROC. I mean, sorry, some company. So what had happened? For example, what is the words they have written? Members, comma, debenture holders, comma, other security holders, comma, beneficial owner. One random person who is nowhere related to the company. He wanted to come and inspect the registers. He said, whatever is the fees, I will pay. 50 rupees no take. I want to inspect. Question is, let us imagine some companies there. Let us imagine some competitor company XYZ. I want to go and inspect the registers. I'll take all the data. Can I go and do it? Why I'll pay 50 rupees? 50 rupees, no take. I'll come to your storeroom, wherever the registers are. I'll access every data. So people in this case, they applied the rule of one person actually asked for the registers. The company denied the access. In this case, they have actually implemented the rule called as people edges dim generous. In this case, they said it is not possible. You need to read you need to read the rule. What is read the rule? The read the rules, people, you need to see the series of words. See, it is following one category. What is the category? Hey, edges dim generous, nah. What is edges dim generous? Same species. It is basically there should be the words are simple. They example you should not give. You should give me the provision. Enumeration of series of words, and then a generic word follows. So series of words, I can make some interpretation here. Member connected with the company, debenture holder connected with the company, security holder, beneficial owner, all the people are connected with the company. Any other person also should be connected with the company. Why did we say that? That means I could not interpret, I could not add everyone to this list. So any other person can be here. What? Creditors. The word is written creditors. No. Creditors can come and check. Banks can come if at all they have given loans. They can come and check because they are connected now. Understood? That's how we need to interpret it. This is the rule of edges dim generous. Remember, on payment of such fees not exceeding 50 rupees. For outsiders, that means if you are not covered here, then for others people, you can charge 50 rupees. Time period of inspection shall not be less than 2 hours on every working day. The books has to be open for you to go and check. And sir, can any person come and take any extract? Extract means what? Sir, I'll get my own paper. I'll write down whatever details I want. Yes, you are free to do. Sir, can I ask for a Xerox copy? Yes, you can do. Provided people, they can collect a fees not more than 10 rupees. That is for members as well as for others as well. Okay, remember next one, sir. Whenever I'm going for an inspection, a certain details of a person will not be available for inspection. What are those details? The details are address and registered. I mean, basically, if it's a body corporate, registered address of that company, email ID, unique ID number, that is nothing but like an Aadhaar or any other number, and PAN number. These details will not be available for a person in inspection. So, register of members are available for inspection. When I go and check, these details can be masked. It will not be given to any random person to come and check. That's the meaning of it. Clear? Hello. Okay. The next one, sir, we will see section number 89. What is section number 89, sir? Register of nothing but people, declaration in respect of beneficial interest. In short, try to understand the concept of 89 and 90. What does 89 equal? Whenever, say for example, money is mine, but I will not invest my money in my name. I will invest that money in someone else's name. Why? It can be any reason. But if I'm not investing in my name and if I'm investing in someone else's name, now this person will be called as what people are benefit registered owner. The entire benefits will come to me. I will be called as beneficial owner. So the person whose name is reflecting, like for example, this is nothing but people, all our daddy, our home fathers or grandfathers, as the case may be, they never did the transactions in their names. Now, what do? They will give, let us imagine, let it be by buying property, or it can be buying gold, it can be anything. They will go and do it in the mother's name. Why? Because of any laws. Probably they want to hide from IT laws, or they want to hide, or any reason. Now, people technically, mother is not taking the decisions, but her name. Now, for example, this person has invested in a company called XYZ. In her name, he has opened in a bank account in the name of wife. Now, in every place, her name is there. But who is taking the decisions of those shares? The decision is taken by the father. So this person will be called as what? Registered owner. This person will be called as beneficial owner. Allah. This person will be called as registered owner. This person will be called as beneficial owner. Whosoever name is reflected in the books. So mother's name is reflected in the books, her name. Now that's why we call her as a registered owner. Entire benefits is taken by daddy, father. Drawing or ATM card or selling the shares, so enjoying the money, dividends, everything is father only. So father will become what people? Beneficial owner. Now what is that the law is expecting us to tell? Is this fair? Is this fair? No, sir, but ನಮ್ಮ ಮನೆಯಲ್ಲೆಲ್ಲ this only, sir. Yes, sir, our entire home is this transactions only, no? Yes. Now, people, that's what they're expecting you to do. The registered owner, that means mother, please come and tell that you are the registered owner and you are not getting the benefits. Please come and tell to ROC. We are expecting the mother to come and tell. Next month, we are also expecting the daddy, beneficial owner. Please come and tell you're only the person who is eligible for the benefits, but you are not the registered owner. Both of them have to come and disclose the details. Where should we come and disclose, sir? Both of them will disclose people to the company. What will the company do? Company based upon, of course, I'll wait for both. But if both are not filing, even if one person is filed, after that 30 days, people, I will further forward it to ROC. Is this clear? All of you? No, this is only called as what people, section 89. A registered holder but not a beneficial owner. This is nothing but people, the registered holder of shares and not beneficial owner. I'm speaking about mother. Now she will disclose the details in MGT4 within 30 days of entering the name. File declaration. Now what will I have to tell? Mother has to disclose the details of the father. Father has to disclose the details of the mother. Same thing here. A person holding beneficial interest. That means father. Within 30 days of getting beneficial interest, I have to disclose. Now I'll disclose everything. This is in the form MGT file. The company will take all the details. We are disclosing everything to the company. Company will forward it to ROC in MGT6. Hello. Penalty. Okay. Long time for penalties. Next one, people. Section 90. 90. Anna. 90. ಇಲ್ಲ ಸರ್ ಇವತ್ತಿಲ್ಲ ಸರ್ ಶನಿವಾರ So people, section 90 people, what is section 90? That is significant beneficial owner. Now try to understand what is a significant beneficial owner. There is a company, there is another company. This company is holding at least 10% of what? Shares, voting rights, total distributable dividends. For example, I'm telling you, let us imagine if this company A, if at all they are having, say for example, 100, say 1 crore shares. Now this company B should have at least in that 1 crore shares, they should hold at least 10 lakh shares, or they should at least hold 10% of the voting power. Or imagine company A, the total dividends they have declared during the year is 10 crore. This company received 1 crore. So out of the total distributable dividend, if one company is getting 10%, then people, SBO provisions gets triggered. Now, what do I have to find? Now, I will again go. Hey, in my company, who is a shareholder? Company B. Hey, you are also a lifeless person. I do not want people to take advantage of artificial person. You invest them, you invest them, you invest in them. Ultimately, who is that individual? Who is this person? This person is who? Al Qaeda, Dawood, Ibrahim. Who is this person? It can be any person, no? Actually, if you want to know, Vijay Mallya, is he allowed to come and register a company now in India? No, it will take ages. So many bans are there. What are the tags? Economic, fugitive, offender, willful defaulter, insolvent. How many tags can he come and register a company in India? No. What will he do? He will open one company in UK. Who? Vijay Mallya. He'll open one company in UK. 100% control is with him only. Now, what will this company in UK do? This will open one company in Switzerland. Now, this company will go open one company in Mauritius. Now, they will come and form a company in Dubai, and that company will come and form a company in India. Now this company's details is what? XYZ Private Limited. Now tell me, who was banned in India? Vijay Mallya was banned, but not company D, no? Hello? Sir, you can say, sir, what is the lifting of corporate veil and all? Hey, okay, I will lift. It is company D. Okay, I will lift company M. Okay, Venta, for lifting at least you should know no, who is hiding. If you know, you will lift, but if not, if you do not know, only how will you lift the corporate veil? So for that only people they introduced one provision. Ultimately, it is a company, it is the duty of the company in India to ask company D, hey, you are a company who is holding 10% interest in my company. Then you tell me who is the individual who is controlling you. I will keep going until I find our main person, that is Vijay Mallya, that is individual. Hello. Remember, SBO provisions will not apply if a person is directly holding a share in company. This person is holding 80% of shares in the company. SBO will not apply. Why? We already know who he is. What are you trying to find? Are you getting the point? We will only, section 90 will apply only when we do not know who the individual is. When we already know, what are you trying to find then? Are you getting the point? Sir, what if, let us imagine, there is a company which is holding 8% of shares in another company, then section 90 will not apply. 10 is a minimum criteria, that's the landmine. 9.99, it will not apply. 10 apply. Sir, okay, this company, let us imagine, is holding 18%. Sir, in this company, there are, say, for example, I would say 20 shareholders holding 5% each in this company. There are 20 people holding 5% of shares in this company, company B. Now tell me, SBO is applicable? Huh? Yes or no? Whose details you will disclose? Whoever, sir. Disclose everyone. That's all, no? No, where did I say together? There are 20 shareholders. So remember, if they are relatives, if they all belong to one company's board of directors, or imagine if they are all group companies, like company, subsidiary company, associate company, holding company, they are all together holding shares. Then you will add together. Randomly, some 20 people are holding, you are not supposed to add it. But relatives, if I had said, yes, your interpretation is right. Now here, every person is holding only 5%. No one is controlling anything here. SBO provisions does not apply. Because no one is controlling. Hello? Yes. So for example, as I told you, let us imagine these 20 people are the directors of company C. There are high chances they are all acting together. Yes. Now you need to take it as a pack. You're acting together. Now, yes, you need to disclose all their details.
So in A company, it has 5%, but he is controlling them also.
A company,
In A company, he is holding 5%.
he. Okay, he or she. Aha. Gender equality. Okay, he or she. You only done applicable SBO.
And he is controlling. Like,
Okay, sir, I have only 5%, but this company is in under my control. Now tell me, SBO is applicable, huh? Applicable or not? Remember, people, why, huh? What SBO you will apply? You already know who is. What are you trying to find? You already know who is.
maybe like not an
I'll explain you. Say, for example, there is company,
like hiding.
there is a company called company B. Company B is, say, for example, holding 1% of shares. But company B is having control over company A. Possible? 100% possible. You want example? One company came and controlled one company. Today, this company does not even exist today. Which company? This company is called as Reliance. This company is called as Dunzo. Dunzo was the first of its kind in this country, and the person who initiated the idea does not exist anymore. Whatever your Rapido service and all you're booking, no, sending parcel. Who started it? Dunzo started it. Where is he today? Then why? There's a mammoth investor who invested. Reliance. Some conditions were there. That conditions did not go through. That's all. Dunzo's end. That's how Dunzo's story coming to a decline. Yes, sir. I'm not saying what Reliance did is bad. They expected something. There was agreements. Whatever company Dunzo has to do, we have clearly said you cannot do certain things. Complete control was with us. No, I'm not saying shareholding. We do not have a majority. I'm not saying that. But control of this company was with us. Why? Based on agreements. One more company, similar. They had zero. They had not even given 1 rupee. But the company only came to an end. Which company? Again, Reliance. Future Group. Where is Big Bazaar? Where is Brand Factory? ಎಲ್ಲ ಏನು ಇಲ್ವಾ ಸೆಂಟ್ರಲ್ it is a Reliance Central now. It has become Centro, not Central. Yes, Reliance Brand Factory also is there. Different name. Why? Debt was given by Reliance. Debt was not repaid. That's all. Reliance just said from tomorrow, rebranding. Overnight, all the Future Group stores were changed to Reliance. See, that's the difference between government and private. One day, everything went away. Nice, no? Control. Where is shareholding? Nothing was there. Clear, no? Yes, now I have to disclose in Future Group who is having the control. I need to disclose if at all I have that control. Now let us imagine who is having control in Future Group. Reliance. Reliance is a lifeless person or lifeful person? Okay, tell me. In Reliance, I don't think so anyone has a control over it. It has, they have, anyone has control, Kaun? Kaun? Ambani ji. 40%, should I disclose, Now take it, Ambani ji, Anant Ambani ji, Anita Ambani ji, Nita Ambani ji. Inyar Guru? Isha Ambani, Ambani, Ambani. Correct, full family. Now, should I add it? Yes. Now, this is what is collected. Got it? I have to disclose. Together, they are having the control over it. So, the person who is having the control, their details, we will have to disclose. Clear? Now, sir, what should they disclose? People in Ben 1, you need to disclose that I am the SBO. You have to clearly disclose that I am the person. Say Vijay Mallya or Ambani, as the case may be. Now, people, they will further take that people and the company will have to further forward this information to ROC. And all this, they will also maintain it because they do not know. No, they will maintain one register of SBO for all the details of such individuals. Agreed? That is what I've been given here. So, what do you mean by an SBO? In relation to a reporting company means an individual who possesses one or more of the following rights. Which one? First one, people. A person who holds indirectly or together with any direct holding a minimum of 10% of shares. Next one, not less than 10% of voting rights. Next one, 10% of distributable dividend. Next one, a person who is having control. In these cases, SBO provisions will trigger. And I have to disclose of that individual who is controlling, not a regular person. I will only disclose a person who is controlling. Agreed on? Hello? So they'll have to disclose. Every SBO shall make a declaration in Ben 1 within this part ignore 30 days of becoming SBO, or you change to be an SBO. Within 30 days of change, you need to disclose it to the company. The company shall maintain the company shall receive the information. They will forward it to ROC within 30 days in the form Ben 2. Now, sir, the company shall maintain the register of all the details in the form Ben 3, like register. Now, sir, this is clear, sir, only when the person only is coming and disclosing. But of course, our India, they will disclose, illa. Now, people, what are they telling you? You future group, it is your duty. You know, no, Reliance is having 15% of shares in your company. You know, no. You know, SBO will be applicable, no. Now, what is the duty of this future group? The future group has to write a letter to Reliance. Dear Reliance, as per 90 provision, you are holding 15% in my company, hence SBO provisions triggered. Can you please tell me who is the individual or who is the majority shareholder in your company? Now they will say, Reliance will reply to future group, sir, in our company, the maximum shares are held by one individual acting collectively or together with their family. So now this person has the control of over our company and his details is Mukesh Ambani. Now we are disclosing them. Now the letter we wrote to Reliance asking to disclose. This letter is called as people Ben 4. Notice seeking significant beneficial ownership. We write a letter asking you to disclose. Hello. Now, once it is given, information shall be given within 30 days. So we write a letter, Reliance has to reply within 30 days. What if they don't reply? Future group will apply to the tribunal. Sir, Reliance did not disclose, sir. I gave them 30 days time to reply. 30 days is done. Within 15 days, after the 30 days, I will have to go and apply to the tribunal saying that, sir, the person did not respond or they did not respond properly, sir. What will tribunal do? The tribunal people shall seek shares in question be restricted with respect to the transfer and such other rights. Why are we going to the tribunal? They are telling that, sir, until they disclose, can you please seize these shares? Meaning the person should not be able to transfer these shares until he discloses. Now, Mukesh Ambani people cannot transfer even 1% of shares in Reliance until he discloses it. Clear? I mean, your what is that? Reliance Allah. Future group, the entire 15% will come to an halt. It cannot be sold, it cannot be purchased, you cannot enjoy any right over it. Okay, now what will happen, sir? Within 60 days of application, of course, an opportunity of being heard will be given. And if the person does not disclose people, then what we will do? Within 1 year from the order, the company or person may make an application to the tribunal. Now, what has happened? Currently, we have just seized. Now, Mukesh Ambani, we will still give you 1 year. Even in this 1 year, if you are not disclosing the details, people, then they are telling you, we will file one more application to the tribunal saying that, sir, this person has not given the details even in the next 1 year. Do one thing, take those shares away from him. The shares will be taken away from him, people. It will be transferred to IEPF account. It is clear, all of you? Yes. That is section 90. In section section 89, there is one more point I wanted to tell you is that now for doing all these, what do you say, coordination, someone has to take it from beneficial owner, someone has to take it from registered owner, section 89. Someone has to file it with ROC. Who will do all of that? There is an amendment. This was in 2023-24. So what did they say? There has to be certain people designated to do this job in the company. If they do not do it, it will be their responsibility. Now, who can that be? They're telling you the company may designate the following people. Who will that be? They're telling you if a company is appointed as company secretary, then the CS will be the first designated person to take the details from father, mother, file it with ROC. Sir, what if the company has no CS? Then it can be any KMP. Who is KMP? Full-time director, managing director, manager, CEO, CFO, CS, any other person, one level below the board and designated as KMP. Now take CS from there. The other people, anyone can be designated for the purpose of coordination. Sir, okay. What if there is no CS or there is no KMP also in the company? In such case, they are telling you every director will be responsible as a designated person. This is they are telling you any these people can a company can appoint. What if company never appoints anyone? First we give a hint. See, you can appoint him, you can appoint anyone. What if company does not appoint anyone? If company does not appoint anyone people, then they're telling you until a person is designated, the following person shall be deemed to be the designated person. Assumed. Who will that be? First one. CS is there. CS will by default be the designated person if company does not appoint. Hello?
Yes, sir.
Next one. Every managing that if CS is not there, every managing director or manager, CS is not there, MD or manager will become the by default next designated person. Third one, every director. What if there is no CS, no managing director, no manager? Then they're telling you every director shall be the designated person. So the company's duty is to file who the designated person is in the annual returns that the company files every year. Which form? Annual return now. MGT 7. For OPC and small company 78. Very good. If the company changes the designated person, can we change the person at any given point of time? Answer is yes. We just have to file a form called GNL2. Remember and go. That is one thing. That is section 89, 90, 91, 94, 95. What is 95? Simple. Prima facie evidence. What do you mean by that, sir? Sir, whosoever details are written in the registers, by default, they are considered as the owners of the company. Who has the right? They has the right. But that is prima facie evidence. What do I mean by that? If I can prove, sir, my name was written in the register, not properly, it was by fraud. I did a fraud. If I can prove, then people, just because someone's name is written in the registers, he cannot be considered as a owner as a conclusive evidence. If someone can prove he is not a owner, someone can prove with evidences. Remember, section 95 that time will not apply because section 95 just says on the face of it you are the owner. So on the face of it, primarily you are the owner. But the actual owner is different. The actual owner will be people, a person who can prove. That is called as what people conclusive evidence. Yes, sir. For example, whatever I see, based on that, I'll have a judgment. But I'll come and talk to you. Then I will understand it in a different way. Yes. For example, in general, I'll be telling. Imagine one person is holding one cigarette. Now, a teacher, a parent, anyone who passes, I see a cigarette. That's all done. It is you only. But technically, what happened? His friend was tying lace. He gave macha on inside call. He was keeping it. That is what is called conclusive evidence. If you can prove, sir, that what you see is not truth. Primarily, it is true. Yes. Correct. Yes, sir. Hello. Okay. Okay. Next one, people, is 90. We'll do of annual return. Okay. Now, what do you mean by annual return, people? Annual return is nothing but people. It's a non-financial information which the company files every year with the ROC. Sir, is it mandatory? Yes. Every company by default has to file something called as people annual return every year. There is no exception. If you're a normal company, people, you will file it in the MGT 7. But if at all you are a small company or if you're a OPC, you will file it in MGT 7A. Correct? Okay. 7 point. And so what will be the details that will be there in annual return, people? Annual return is basically filed for a non-financial aspects, sir. All financial information will go in AOC 4. What about the other things? What are your other things, sir? Imagine during the year, someone has filed a case on us. There is a litigation going. There is a change in shareholders. Promoters have changed. New directors have come. Company has conducted 8 meetings. All those details. We saw turnover, the list of subsidiary companies. So there are so many things. All these details. This simple example, the details of your director's salary, remuneration, their ESOP, if they are holding shares, everything will be disclosed in where? That will be disclosed in annual returns. Now the format is MGT 7, MGT 7A. The annual return should be signed by whom? If the company has one director and one CS, will have to mandatorily sign. What if a company does not have a CS? There will be one director and one practicing company secretary. But in the case of OPC, small company and all, one CS. If CS is not there, one director is sufficient. Correct? Form MGT 7, MGT 7A, abridged form. Additional compliances, sir. What is that? Sir, if at all a company is big, just the normal sign is not sufficient. Someone has to check that every information filed in this form is accurate. That time, people, in addition to whatever is the signature of the form, we have to give something called as certification. Meaning someone has filed, but I am again coming and checking. For example, in big companies, the company's financial statements, their accounts, journals, everything is again in big companies. It is again maintained by CAs, ACCAs. It is already reliable. Then why do you want another external chartered accountant to come and audit it? Already it is prepared by CA only, no? Yes or no? Exactly. He wouldn't make mistakes, He wouldn't make fraud, That's the difference. A person signing has prepared the form. He might have made fraud. He might have missed information. Now, an external person like an auditor is coming and checking whether this form is right. Cut, copy, paste concept is AOC4. A chartered accountant, why is he signing? Audit report, why? Because he is again certifying, yes, everything is correct. Why? Already a CA only has prepared, no? It is correct, no? Hello? Understood, That is what is called additional compliance. An annual return filed by, if it's a listed company, or a company having paid up capital 10 crore or more, or turnover of 50 crore or more, they need to get an additional certification, like a certificate. All the details given in the annual return is true. So for that, there is a format prescribed. That format is called as MGT8. Clear? When will we file annual returns? We will file it within 60 days of 60 days of closure of financial year AGM. From the 60 days of completion of AGM. AOC4, when will you file? Within 30 days of financial year end. Alva. Within 30 days of conclusion of AGM. Accounts only is adopted in AGM. Without adoption, how will you file? Yes, sir. That is section 92. Okay. Next one, people. Section 96. AGM. AGM, every company should conduct. Mandatory. No exception. OPC is an exception. Okay. At least every company should conduct a one general meeting in a year. And that is called as people AGM. When do we conduct this AGM? If it's your first AGM, people, you need to conduct it within 9 months of closure of financial year, first AGM. Subsequent AGMs will be conducted within 6 months of closure of financial year. Sir, and remember always the gap between two AGMs should not exceed 15 months. Sir, extension at any given point of time, if I'm not able to conduct an AGM within 6 months, I can always apply for one-time extension with the approval of ROC. But remember, people, for the first AGM, this extension will not be applicable. Sir, please, where do I have to keep the, where do I have to conduct the AGM? By default, registered office. If not, you can conduct it in the same city, town, or village. I told you example also, the Christ College, all the AGMs of Infosys was always conducted in Christ College. It's the same city. Should I take any approvals for that? No approvals required. You by default have a choice to conduct anywhere in the same city. If possible, conduct it at registered office. If not, there is no problem. Hello, sir. If you are an unlisted company, they can do anywhere in India with the consent of all the members. Remember and go. Hello. Okay. Next one, the date. I can conduct it on any day, people, except a national holiday. What is national holiday? Christmas is coming. National holiday or not? Christmas. New Year. Republic Day. Here Jayanti, Gandhi Jayanti, and Republic Day, Independence Day, and Gandhi Jayanti. These 3 days are considered as what people national holidays. Rest of it all is not a national holiday. Public holiday you can conduct a AGM. Public holiday is nothing but people. You take your Christmas or Eid or Diwali, whatever it is. Sunday, Saturday, every day you can conduct. Okay. A report of AGM to be filed with the ROC within 30 days of completion of AGM. In this, I will clearly disclose all the details, people, that the company has filed, have conducted the AGM, have discussed the following things. The following things have been approved with a majority of 88%. The following things were rejected. The number of people who voted against was 12%. I will give complete report, but this applies only in the case of listed company, which is a form MGT 15. Report on AGM, that is section 121. Remember, sir, AGM provisions, section 96. First AGM to be conducted within 9 months. Second AGM, subsequent AGM should be conducted within 6 months. Sir, if at all there is any time, if we were not able to conduct a AGM, everything is between 9 and 6 only. So 9 minus 6, I will get one time of extension of 3 months. And a gap between two AGMs should not be more than 15 months. AGM should be conducted between 9 to 6. Remember and go. Yes, sir. This one also. Report on AGM. MGT 15. Correct? So remember, very, very important from your exam point of view. The next provision is, sir, section 100. Section 100 speaks about people, EGM. Now, what is EGM? Whenever a company, they cannot wait only for one meeting happening in a year. That will happen only in the month of September. What if we have some other matters to discuss? That time we can call any number of meetings, people. That is only called as EGM. EGM will happen in 4 ways. One, the directors only. They will call whenever they think they have to discuss something. For example, alteration of name clause, or addition of, or imagine, object clause. I will have to pass a special resolution. I will call you for a meeting. So that is the thing. That is so motto. Whenever the company wants, they will call you for a meeting. By default, the easiest. Always remember, it can be held any place in India if it's an EGM. But if it's a wholly owned subsidiary of a foreign company, it can even be held outside India. What if it's an AGM of a wholly owned subsidiary of a foreign company? It has to be in India only. Remember, AGM, there is no exception. Next one, sir, by board on requisition by members. What is that? Now, the company is only conducting a AGM, but not because we want, it is because you want. The shareholders have made a request to conduct a EGM. How many people have to make a request, people? It depends upon whether a company is having share capital, not having share capital. If company is having a share capital, people holding 1/10 of the total paid up share capital, the company not having share capital, 1/10 of total voting power, they make a request, then the company has to conduct a EGM. So what should they do? Within 21 days of the request, they have to make arrangements to conduct a EGM. Arrangements means, people, like sending notice. So they will make arrangements within 21 days. And remember, people, within 45 days, they have to actually conduct a meeting from the date of request. Sir, what if within 45 days they did not conduct a meeting, sir? Then, people, within 3 months from the date of request, you only conduct it off. That is, shareholders themselves will conduct a meeting, but they should know, no, sir. The support will be given by the company. How? They will give the register of members to the shareholders. Now they will send the notice of the meeting. Are you getting the point? Huh? So remember, people, what if we miss sending the notice of a meeting to anyone? Accidental omission will not invalidate the meeting. But if at all it is wantedly done, incidentally done, and it was not accidental, then, people, whatever was discussed in the meeting will be invalidated, meaning it will be void. Sir, and the expense of the meeting, who will bear the expense of the meeting? It was a duty of the directors to conduct the meeting. That's why, people, the company will reimburse the expenses of the meeting to the shareholders. It will be deducted from the director's salary. And remember, people, if at all in a requisition requisition EGM, if at all the people who requested, they have requested it, but the quorum was not present in the requisition EGM, what will happen? The meeting stands adjourned. Illa. In the requisition EGM, people, there is no adjournment. By default, it's a cancellation. Hey, you guys requested for that. If you only don't come, why again adjournment? The meeting will come to an end. Hello. Okay. It should be okay. That is section 100. Last one is people, section by tribunal. What is tribunal, people? By tribunal, there are two sections, 97, 98. What is 97? On an application made, the tribunal may tell you to conduct a AGM. Next one, on an application made, the tribunal may tell you to conduct a EGM. Hello, what is 99? Penalty. If at all you guys have not complied with all of this, there is always a punishment. So remember 97, 98, 99 and go. Okay, next we'll do notice of a meeting. Section 101. People tell me, notice of a general meeting. How many days notice should I give? So people, a company is required to give 21 clear days notice. Agreed? What if what do you mean by the word cleared? You should not count the date of the meeting and date of giving notice. Apart from both of that, people, there should be a clear gap of people 21 days. So, for example, if I'm giving my notice, people, on 1st of Jan, don't count 1st of Jan. If my meeting is actually on 23rd of Jan, don't count 23rd of Jan. So, between 1st and 23rd, there should be a gap of 21 days. And do not exclude holidays and all. It is a continuous, that's all. Hello. Okay. An expenser. If at all I'm sending it by post, what if I'm sending it by email? What if I'm sending by post? If at all it is by post, add another 48 hours to it. That means what? Now, in our case, we generally give 21 days. No, add another 2 days. So you have to give a 23 days clear notice. Okay, sir. Can I conduct the meeting with a shorter notice or I have to always give 21 days? Shorter notice is possible. What are the conditions for shorter notice? Then it has to be agreed by. If the consent in writing, this is important. Shorter notice is important. Remember and go. If at all a company wants to conduct a AGM, then people, the members entitled to vote, 95% of the members entitled to vote should give their consent. People, 95% of the members entitled to vote. I'm speaking about value now. I'm speaking about number of members now. Voting rights or number of members are. I'm speaking about the number of members. But which member, not preference. A person entitled to vote. I'm speaking about equity shareholder. This is the question. They will ask you, they will confuse you with the voting rights and number of people. Clear? Okay, next one. What if it is any other general meeting? Then they are telling you a person holding. If company is having share capital, this is very important. Majority in number representing 95% in value. What do I mean by that, sir? AGM people. Out of, imagine we have 10 people. 95% of the people have to agree. That means all 10 have to agree. I don't have a choice. If I have 100 people, 95 people have to agree for AGM. Now, for any other general meeting, let us imagine EGM, there are 10 people. What does majority number means? How many? 6 people. That is more than 5. Now, the 6 people should have 95 percentage. That means you have to satisfy the number also, majority number also. You have to satisfy the 95% in value also. Sir, look at the other way around. How can they give you? A company wants to conduct a AGM at a shorter notice. There are 10 people. There are 3 people holding. There are 3 people holding 98% of the shares. Now, what do I have to do? Can I conduct a shorter notice? Not possible. I have to get majority number. This has to be 6. If not, I cannot conduct a possible question. Remember and go. Hello. Okay. And what else? In the case of Section 8 company, 14 days. Who are the members entitled to receive the notice? Who and all will get? All the members. Preference?
Yes, sir.
Preference shareholder will get. Preference shareholder. Yes, sir. They will get every member legal representative of any deceased member. What do you mean by that? Transmission. The assignee of an insolvent. Remember, in the case of assignee, they may ask you a question here. Who will have the voting right? Assignee here means people. Nothing but if a person has declared as an insolvent, he does not have money. Court has appointed a Macha Goda, take all his assets, sell it off, repay the liabilities, and be done with it. Now a person is still appointed. The shares of say Vijay Mallya is not yet sold. They're telling you the voting right will still be with the insolvent. But the right to receive dividend, right to sell the share, all of that will be with the receiver or the assignee. Clear? Next one, the auditor or auditors of the company. Hey, auditors also have to call it down. What if they are not able to come?
They can send their someone.
They can send online.
CA already see
Other equally qualified person. Which section?
148 and what.
ನಾನು 14 ಬರ್ದೆ ಅಂತ 140 146. What is this? Auditors, if he is not able to attend the meeting, macha, you can send someone else. Provided they should also be qualified to be the rightful auditors. They should understand. Should not send someone. Hello. Every director of the company should be invited. Okay, done. See, we have clearly written accidental preference shareholders. Nodalla book. Book ತೆಗೆದ್ರೆ ಅಲ್ವಾ? Okay, next one, explanatory statement 102. What is explanatory statement of? The company explaining people, one, whatever transaction, let us imagine company A wants to do a transaction with company B. We want to take shareholders approval. We have called our shareholders. We have to clearly say, sir, whatever transaction we are going to do with company B, there is no hidden agenda. None of our directors are doing this for money. They are doing it for the purpose of the company's own good. How will we declare? How will we say this? We will disclose this people by clearly telling. We have to disclaim. I mean, we have to first give a disclaimer. If first of all, explanatory statement is applicable for what? When and all I have to give. There are 2 types of business. One is called as ordinary. One is called as special. What do you mean by ordinary business? Adda. One is appointment of auditor, appointment of auditors, and fixing of the remuneration of auditor. Next one, appointment of directors. In the place of retiring director, casual appointment will not come here. Next one is declaration of dividend, adoption of financial statements, boards reports, as the case may be. Now, sir, this is only called as adda. For this people, this is a regular business itself. Every year it keeps on happening. For this, I need not have to give any explanatory statement. And remember, ADDA should always be conducted in AGM only. So if there is any other matter apart from this, for example, altering object clause, shifting registered office clause, probably issuing DVR or issuing rights issue, whatever it is, all this will come under special business. It is the duty of the company to disclose why you are calling this meeting. Now, what and all I have to disclose? I have to disclose people the nature of concern or interest in this matter in respect of every item for every director and the manager. Now we are entering into a contract. No, A is entering into a contract with B. We have to clearly disclose. Is my directors having any interest in this? Are they doing it for commission? Are they getting anything in return? You have to disclose. Next one, I have to disclose any KMP, CSO, CFO. Are you guys getting any money for this contract? I have to disclose. The third one, relatives of the people, that is relatives of the directors, relatives of the managers, relatives of the KMP. Are you getting any benefit? What do I mean by that? Let us imagine people, company A wants to appoint, say for example, one company as their internal auditors. Internal auditors are better. Let us imagine people, we want to appoint or we want to reappoint people an independent director. Independent director. This is not your regular ADDA provision. Now we need to take shareholders approval. Special resolution is required. Technically, I'm telling you. Now, who is this independent director? If this independent director is relative, somewhere related, I have to disclose that. Because if it is relative, that means this person becomes disqualified. I cannot appoint this person at all. So these facts cannot be hidden. Or let us imagine we are entering into a contract with company B. Company A is entering into a contract with company B. Which is this company B? Company B is technically A as a director. A has wife. It is wife's company. We are entering into a contract with our wife's company. There will be a benefit. Of course, I have to disclose this. Are you getting this point? Sir, let us imagine. Forget about wife. This person only has some shares in company B. Our director only has some shares. Ayo, pakka you have to disclose. That is what they're telling you. If special business to be transacted at a meeting of the company relates to any other company in which extent of shareholding of every promoter, director, manager, KMP shall be disclosed. If shareholding is 2% or more of that other company, company A, company B, company A ka director is having 3% shares in company B, I have to disclose. Hello. Yes, sir. Okay. Sir, and any other matter on which the shareholders can take an informed decision, I have to disclose. Meaning nothing but I have to explain the facts. Example, section 61, alteration of capital. Company decides to do share split. It's a special business. Explain why. What is the purpose? Simply you're saying we are doing a share split. What is the purpose? Disclose. Okay, that is your explanatory statement. And what if a person does not disclose all of this, sir? Remember, whatever benefit you make, you have to transfer it back to the company. You cannot keep it. No secret profits. Hello. 102 done. What is 103, sir? Quorum. For example, in the case of public company, what is a quorum? Depends upon the number of members you have. If it's a public company, people, 5 members has to be present. If it's provided, if your total number of shareholders in a company is not more than 1,000, so 1,000 comes here. What if the number of shareholders in my company is more than 1,000? So 1,001 comes here. Up to 5,000. My quorum will be people 15. What if my number of shareholders is more than 5,000? 5,001 I mean. So 30 members should be present. This is a minimum attendance required for a meeting to be valid. If this number is not there, then the meeting is invalid. It gets adjourned. If there is no quorum, the meeting gets adjourned. Hello. Pakana. Yes, sir. But remember, sir, if a company prescribes anything else in its articles of association, it's AOA or this, whichever is higher. If it's a private company, sir, at least 2 people should be present. Hello. Okay. And remember, quorum has to be present throughout the meeting. But sir, there are a few VIPs in our company, sir. That VIPs are called as people, President of India or Governor of a state. Now, only for these 2 people, you cannot expect them to come and attend the meeting. What will they do? They can send someone else as their representative, authorized representative. That person will have all the right, just like a member. Now that person will be counted for the purpose of quorum. Section 112. Next one, sir. Sir, company A is a shareholder in company B. Of course, company A cannot go. What will company A do? Company A will appoint authorized representative. Where do you see who that person will be? Director or
Employee
KMP or officer of the company. Where did we see?
Incorporation.
Correct. Very good. Subscription clause, I told you. Understood? Now that person will come and attend the meeting. Sir, what if that person is not available? You will pass a board resolution. You will say, I'm authorizing this person to take a decision. So we will send a person. Now this person will be counted for the purpose of quorum. Section 113. Hello? So remember always, there can be group companies. Now what do you mean by that? Imagine there is Reliance, let us imagine there is company A. company B, company C, company D, company E. All these companies are shareholders in company A. Yes, sir. Now, what are these companies? They all belong to a common group. Let us imagine Tata. Hello. Now, why to send different people for every company? End of the day, they will all listen to me only, no? Tata will send one person as authorized representative to, what do you say, represent all these people. Now, this person, for the purpose of quorum, this person will be counted as 4 people. 1, 2, 3, 4. How many ever companies you are representing, you will be treated as that many for the purpose of quorum. Clear? Hello? Pakka? Done. 112, 113. Consequence of no quorum. What will happen if quorum is not there? By default, the meeting gets adjourned to the next week, same time, same place, or such other day as decided by the board. If it is next week, same time, same place, should I give again a notice? Yes, very good. 3 days. 3 days notice is required. What if I'm adjourning a meeting for any other time? Say, for example, beyond 30 days. If you're going beyond 30 days, you have to again redo everything. Give a fresh notice. Everything has to be redone. Now, people, even in the adjourned meeting, if quorum does not come, what will happen? How much time you will wait for the quorum to come? 30 minutes will be, you will be waiting for 30 minutes for the quorum to come. Even in the adjourned meeting, if at all the quorum is not present, then the people present will be quorum. But remember, in secretarial standards, it is written, the people present cannot be one. At least 2 people should be present for the purpose of quorum. So number of people present being not less than 2 should be quorum. Clear? Hello. And people, let us imagine if a decision is taken in an adjourned meeting, what will be considered as the date of resolution? Is it the date of original meeting or the date of adjourned meeting? The date of adjourned meeting. Section 116. Adjourned meeting. Yes, sir. Okay. That is your quorum. Next one, people. Section 104. What is section 104? Chairman of a meeting. Chairman of a meeting, people, a person who presides the company's meeting. He can be appointed either as a person like AOA or in every meeting. The people present there, members present there, they will elect one amongst themselves as the chairman on show of hands. But what if someone demands for a poll for appointment of a chairman? Can they demand a poll for appointment of chairman? When should they conduct the poll? Within how many? Within 48 hours or immediately? Poll, if at all you are demanding for poll, for 2 things, you have to conduct the poll forthwith. What are the 2 things? To appoint a chairman, the poll has to be taken forthwith. Second one. Poll. Second one. Very good. Impressed. Adjournment of a meeting. Whenever you guys are adjourning the meeting, if you want to adjourn a meeting, to decide that if you want a poll, then people, it will be taken forthwith. Any other matter, people, should be taken within 48 hours. Hello. Sir, what if in the case there is an equality of votes? There are 2:2. The chairman will be given the third vote. That only is called as casting vote. Second vote or casting vote. Yes, sir. Next one, sir. Section 105, proxy. What is proxy? A person representing someone else in the meeting can, by default, a preference shareholder has the right to proxy. Illa. A person entitled to attend the meeting and vote. So by default, preference does not have. So we generally say equity has the right to appoint proxy. Should a proxy be a shareholder? No. Proxy can be a random person. Yes, in the case of Section 8 company. And next one, proxy can represent how many people? One person can represent how many people? 50. One person can represent how much of voting rights? So if this 50 people maximum, okay. What if there are 50 people, all their shares put together, I'm getting 15%. Can I represent? No. Remember, Up to 50, it will be valid. Anything beyond that, it will be invalid. Now, I can represent 50 people, but the voting rights cannot be more than 10 percentage. Sir, what if one person is only holding more than 10 percentage? Then you can only appoint one person as a proxy. He cannot represent anyone else. Sir, if at all I'm appointing a proxy, within how many days I have to intimate to the company, I have to intimate about these people, not basically earlier than 48 hours. I have to intimate at least 48 hours prior to the date of the meeting. Does a proxy has a right to speak? No. Is a proxy counted for the purpose of quorum? No. But remember, section 97, 98, tribunal conducted AGM, EGM. Tribunal can, in its order, say one person present can also be considered as a valid quorum, and that one person can be a shareholder or even a proxy. Hello? Okay. Proxy form in the form MGT 11 and proxy inspection is there, no? Can anyone go and inspect the proxy forms? Huh? When will it be open and when can I inspect? How? What is the procedure? 24 hours prior to the date of the meeting, it will be available for inspection now. Proxy form, the when will it be available for inspection? Every member entitled to vote on any resolution shall be entitled to period beginning 24 hours before the commencement of the meeting. On, let us imagine, 15th of Jan, 5 p.m. is our time of meeting. Then people, inspection starts on 14th of Jan, 5 p.m. Hello? And remember, but if I have to come and inspect, I have to first only intimate at least 3 days prior. A proxy cannot be counted in the quorum, cannot speak, cannot vote on show of hands. But a proxy can be demand poll and proxy can vote in poll. Yes, sir. Okay. Next one, people, is okay. Voting section 106. Restriction on voting rights, people. Can a company restrict a voting rights because a person has not paid call money, but its articles is silent? Can I still restrict? A person has not paid call money. The company's articles is silent about this fact. Nothing is written. Can a company restrict the voting rights? Articles of the company may provide that mandatory. If AOA is silent, I cannot restrict. That's how they question. Yavagro realize ಆಗ್ತೀರಾ? We go thinking, sir, call money not paid. Okay, restriction of voting rights. Okay, no member shall exercise any voting right in respect of any share in his name on which any amount is due from him. Sir, what if I did not pay calls? Okay, I can restrict. What if I did not pay loan? I can restrict any other sums payable. Sir, can I restrict it in any other scenario? Any other reason can I restrict a voting right? A company shall not prohibit any member from exercising voting rights on any other ground. Hello. By default, every matter will be conducted by show of hands. On a poll taken at a meeting, a member entitled to more than one vote need not use all his votes. What do I mean by that? We have seen this practically in the class also. If I'm having 100 votes, I can only vote 40. I need not use the entire 100. It is my discretion. Also, such member cannot sign a requisition for an EGM. That a person who has not paid call money and all of that. In case joint shareholders, they might concur in voting unless the articles provide to the contrary. That means what, people? In the case of joint shareholders, who will have a voting right? A person who is a senior in them will be having the voting right. What do you mean by senior? Nothing but, people, it will be decided on the basis of the order. A person whose name is written first will enjoy the voting right. Hello? Clear? Insolvent. Can he vote? Can insolvent member vote? ಅವಾಗೇ ಹೇಳಿದೆ ಮತ್ತೆ ಹೇಳಿದೆ ಇನ್ನೂ 5 times I tell you. He can vote until the shares are liquidated. You can vote. Can directors also vote? If they have shares, they can vote, sir. Okay. Next one, sir. Okay. The next one, people voting. Generally, people, there are 4 types of votes. One is voting by show of hands, e-voting, poll, postal ballot. By show of hands, people, by default, every meeting will be voted by show of hands, unless a poll is demanded or the chairman feels that we have to take a poll. Rest of the matters, people, you will be deciding by show of hands only. Now, what do you mean by the word poll? Poll means, people, generally one share is equal to one vote, but when it is a poll, I mean, generally people in a show of hands, one person is equal to one vote. In a poll, one share is equal to one vote. So here, me and Ambani are not same. But in the section 107, me and Ambani are same. So Ambani gets, his ego gets a little triggered. He said, how can me and him be same? I want the meeting to be conducted by a poll. So who can demand a poll? Chairman on his own, or a request is made by company having a share capital, a member or proxy holding 1/10 of the total voting power, or 5 lakh or more of the paid up capital, either this or that. You satisfy, you can demand a poll. They can ask you a question here. Any other company, then 1/10 of the total voting power, they can demand a poll. When can the poll be demanded? Remember, you can demand it whenever you want. It can be even before the results are declared, even after the results are declared. You can demand a poll. Can a poll be withdrawn? Answer is yes. Who can withdraw? Whoever requested it only should withdraw it. Next one, poll shall be taken forthwith. I told you, adjournment or chairman. Any other case, 48 hours. The polling paper format, MGT 12, nothing but the format used. The scrutinizer shall count and report on the result. The report to be scrutinized in form MGT 13. It shall be submitted to the chairman within 7 days of taking the poll. That is called as poll. Is this clear? Okay. Next one is, people, electronic e-voting. Voting through electronic means. Now, what is that, sir? There are these companies, listed companies. Now, we will be shareholders of 5, 6, 10 listed companies. I cannot go to every place to vote. So, what did they do? They gave us an option to vote remotely. That option given is called as, people, e-voting. Okay. Yes, people, e-voting. For whom and all it is mandatory, applicability. Every listed company. Next one, companies having 1,000 or more members. So 999 not required, 1,000 required. Non-applicability, sir. It is not applicable to Nidhi company or any institutional investors. Notice of the meeting can be sent by directly website or newspaper advertisement. Contents the notice, meaning you will clearly have to say you have an option to attend through e-voting, ID, password, all of it is correct. E-voting, people, what will be the time period of e-voting? This is important. It shall be open up for a minimum period of 3 days and it shall close at 5 p.m. on the day preceding the meeting. What do I mean by that? Let us take, for example, if the date of the meeting is 15th Jan. The e-voting, people, that will give, it shall close on the day preceding the date of the meeting, that is 14th at 5 p.m. and it shall be open at least for 3 days, 14th, 13th, 12th. So from 12th to 14th can be your e-voting. Okay, next one. Who can be? Now you have to appoint a scrutinizer as well. Who is a scrutinizer? The person who will come, who will check the votes. He will say whether the what is that? That particular agenda item is passed or not. So he will check everything, and based on that, people he will say whether this particular item is passed or not. The resolution is passed or not. Along with the votes also, he will clearly tell the number of votes cast in favor, against, everything in detail. One report will be given. Who can be appointed as a scrutinizer generally? It can be people, a person who is a CA, CS, CMA, or an advocate in practice. But remember, it can be any person, just that that person should not be in the employment of the company. Yes, sir. The scrutinizer shall prepare not, he has to prepare a report with the time not later than 3 days from the date of the meeting. The results has to be disclosed on the website of the company, stock exchange, as the case may be. Okay, the next one is called as postal ballot. Postal ballot is nothing but people. Why does a company go for a postal ballot? The reason is people for a wider participation of shareholders. Second one, people, if at all you conduct anything by postal ballot, you need not again have to conduct a meeting. Meeting becomes optional. So physical meeting will not be required. Only voting will be there. Such type of a thing is called as what people? Postal ballot. Postal ballot is nothing but an option given to the shareholder. There will be no meeting, but only a voting will take place. I will give you the resolution. It can be by an email, it can be by a software, it can be even by a post. You will reply to that saying yes or a no. That is only called as what people? A postal ballot. Postal ballot, people, you cannot use it in two scenarios. When is that? One, for ordinary business. That means what? AGM becomes mandatory. Next one, people, any business where the directors or auditors have a right to be heard. For example, removal of directors or auditors. Correct? Okay, next one. Exemption of postal ballot. OPC and any company having 200 members. Which company? Allah, it can be any company. 100 same also you'll say private company only. Next one, sir. Following items shall be discussed only in a postal ballot. We have seen so many cases also, but remember easy ones. Buyback, DVR, alteration of the object clause, variation of prospectus, all those things. Correct? Next one, scrutinizer's report. He shall submit the report not later than 7 days. Results to be declared on website along with the scrutinizer's report. Postal ballot, how many days you will have to reply? 30 days. Very good. Yes, sir. 30 days. That will be the time period for postal ballot. Hello. Okay, next one, people. Circulation of members resolution, section 111. What do you mean circulation of members resolution? People, as a shareholder, you have a right to, you also discuss something. I also want some resolution to be passed. I want it to be passed. I can propose. Now, for example, we saw now, can the shareholders demand dividend? I will make a request. I'm asking. Company is not liable to take it up, but it's my demand. I'm asking. Now that is only called a people. Circulation of members resolution. Now, sir, how many people can request? Members can propose a resolution. Who can propose? If a company is having a share capital, the members holding people, 1/10 of the total voting power, carrying rights. Next one, people, if the company is not having share capital, then 1/10 of the total voting power. Correct? Their paid up share capital here, voting power. Hello. Sir, special condition. Remember, it should be signed by all the requisionists. Next one, sufficient money should be deposited for meeting the circulation expenses because you are giving the, so the cost of circulation, that notice, imagine if I have to give it in a newspaper, that cost, why will I have to pay? You give, it is your request I'm transferring. Hello? Sir, time limit, when should I submit it? They're telling you a requisition requiring a notice of resolution. If I want to pass any resolution, then they're telling you people, it should be given people within 6 weeks before the date of the meeting. For example, declaration of a dividend, it requires a resolution. Then such request have to give people 6 weeks before the meeting. What is the meeting, people? Let us imagine 30th September 2026 is the date of the meeting. Give 6 weeks prior. I'm just assuming 4 weeks in the September, 2 weeks in the August. Leave it. Just somewhere filling August 13th. I will give it by August 13th. Huh? Any resolution. It can be ordinary or special, because if at all, whatever is the request you have, if that request can be passed only by passing a resolution, it can be ordinary or special. In such case, what I'm telling you, I have to give you a notice within 6 weeks before the meeting. Let us imagine if the shareholder wants to give something, but in the law, they have not said ordinary, special, nothing is given. For example, I want to give you a comparison of data, how our company is performing, how our competitor is performing. I want to disclose this. So as a shareholder, I've asked, can you please circulate this information also? That information the company will give 2 weeks prior to the date of the meeting. September 30th is the date of the meeting. It should be at least given 2 weeks prior. Let us imagine 14 days. September 15th, you have to give the notice. If it does not have to be passed as a resolution, or as per the law, for this, they have not written anything. Ordinary, special, nothing is required. In such case, just to give 2 weeks before the date of the meeting. Sir, you told me if at all I have to pass a resolution, I have to give it at least 6 weeks to the prior to the date of the meeting. What if I gave it on August 14th, but they conducted a meeting on September 20th? That I'm not satisfying 6 weeks condition? No, they're telling you it's okay. When you gave your notice, if the AGM is not yet called, how can you predict it? You thought 30th September, but they called prior. It is still okay. It will be assumed that the meeting notice is given valid. Here on, okay, 112 we have seen on authorized representative, that is President of India and Governor of a state. Next one is people, 113 body corporate being a shareholder. 114 people, ordinary resolution and special resolution. Ordinary people, majority of the people have to approve. Special resolution people, the people who voted for the resolution should be at least 3 times of the votes against the resolution. The number of people who voted no is 5. For me to pass it as a special, I need to at least get 3 times of the votes. So the 15 people have to say yes. Remember, the number of shareholders in the company, the number of people attended the meeting, all of this information is irrelevant. Clear? Okay, next one, section 115. What is 115 now? Special resolution requiring special notice. When will we require a special notice? Simple, sir. To appoint an auditor other than retiring auditor. Sir, this person is there now. We don't want him. Or the retiring auditor not to be reappointed. Sir, you appoint anyone, but don't appoint him. Or to remove a director before the expiry of tenure. Appoint another director in his place. We make a request. Who? The shareholders. You make a request. That request only we are calling it as a special notice. How many people have to make? They're telling you members holding individually or collectively 1% of the total voting power, or shares on which minimum 5 lakh is paid up. So many people have to come and make a request. Sir, we don't want this director. Then what will the company do? The company people will take your request. They will send it to the company. They will send this notice to the company. They are telling you, when should I give this notice? To be sent not earlier than 3 months, but it has to be sent at least 14 days before the date of the meeting. What do I mean by that? If the meeting is on 30th September 2026, it should be sent not earlier than 3 months. Take 3 months prior. September, August, July. Correct? Huh? I cannot send it before 1st July 2026. I cannot send it before. Correct? Huh? But I should send it at least 14 days before the meeting. 14 days. Can I take 30th September, leave it and take 14 days? What will it be? 13th September. Okay, clear days it is. 13th September 26. So I have to give the notice anytime during this period. Remember, they can ask you a question. Next one, sir. Company to give notice to other members individually if possible. I try to give 7 days before the meeting. If 7 days not possible, individually if it's not possible, I'll give it off in the newspaper. All the days here are clear days. Section 115. Here are 116. Adjourned meeting. 117. Resolutions. Certain resolutions that are required to be filed with ROC. In which form you will file it with ROC? In FGD 14. Which and all you will file? All the resolutions which you want to pass it as a special resolution, you will have to file with ROC, no? Which form? MGT 14. Then how many days? 30 days of that particular resolution. Sir, what if we said to pass as a special resolution, but you guys agreed unanimously? That should also be filed with ROC. Law says special, but 100% you guys got an approval. Still, that should also be intimated to ROC. MGT 14. Next one, people, appointment or variation or any change in terms of managing director. If you are doing it, you guys have to appoint MD people. If I have to tell you, the most powerful person of the company is always an MD. Example, people, Reliance Industries ka MD is Mukesh Ambani. Chairman and MD. So MD is the most powerful position in a company. So if you are appointing anyone as an MD, that's the most important person. It's an important decision. Intimate ROC. That's what they're telling you. Hello. Next one. Resolution agreed by any class of members, which, if not so agreed, would not have been effective for their purpose unless they had been passed by a specified majority. What do I mean by that, sir? You guys have already seen also, no? Section 48, variation of shareholder rights. So if any specific category of shareholders decisions you guys are saying, take that, intimate to ROC, inform MTD 14. Next one, people, if at all you have passed a request for voluntary winding up, intimate ROC. Next one, any other case as per section 179, nothing but power of board. Yes, sir. Hello. All this you will intimate to ROC, MGD 14. That is 117. 118 people, what is 118? Minutes of the meeting. In this important, for every meeting, people, you have to maintain a different minutes of the meeting. Next one is, people, minutes of the meeting. How many days should you maintain it? It shall be preserved for permanently 8 years. Permanently. Now, sir, minutes shall be signed by whom? Minutes shall be prepared within how many days? It shall be prepared and signed within 30 days. It shall be signed by whom? It shall be signed by the chairman of the meeting. In the case of board meeting, in the case of general meeting, what if the chairman of that meeting is not available to sign? He has gone for a trip. He has some personal emergency. Who will sign? Board meeting, remember, again it will happen next meeting. It will be predictable. Next quarter it will again happen. So what they're telling me, then they're telling you the chairman of the subsequent meeting will come and sign this particular minutes. Sir, what if it's a general meeting? If the chairman of the current meeting is unavailable, the board of directors will authorize one amongst them to sign this particular meeting. Remember, they can ask you a question here. Important. Now, my question, people, from the minutes of the meeting, can a chairman exclude any matter? What are those things? Defamatory, immaterial, detrimental to the interest of the company. Those three matters can be eliminated. Defamatory, irrelevant, and detrimental. They can ask you a question. Remember it, go. Hello? Chairman or signer that and every page has to be initialed, last page has to be signed. It should be done within 30 days. For every meeting, you have to maintain a different register. Correct? Inspection of minutes, it can be done section 119. It can be done in electronic form. The minutes of the proceeding of any general meeting or a resolution passed by postal ballot shall be kept at the register office. It shall be open for inspection. We saw also for how many days? Every business day, it shall be open for inspection at least 2 hours. A member shall be entitled, if he is asking for any copy, I have to give it within 7 days. You can charge for it as well. That is section 119, 120, sir. I can maintain all these things in electronic form also. Every listed company, but the word is may. They can maintain all these registers, minutes, all of this in electronic form. A company having not less than 100 shareholders and a listed company may maintain their minutes, registers, all of this in electronic form. Reporting of AGM 121 we have done. What is 122? Will all these provisions apply to OPC? Will it apply? OPC. OPC will apply. Can OPC conduct a meeting? He'll conduct meeting with whom? So people remember, in the case of OPC, the conducting of a meeting, notice, all this cannot apply. So how will he pass a resolution? He will intimate his intention to the company. The company will directly write it down in the minutes. That's all. That is considered as a resolution. And remember, section 101, 107, and 109 shall apply to the private company at its discretion. If it's by its articles, it says this will not apply to me, it will not apply to them. Exemption. By its articles, it can decide the applicability of 101 to 107 and 109. In its articles, it says these sections is not applicable to me, not applicable to me. Hello. Done. Done 122. That is your management and administration. You go for a break and come on. Okay, go for a break and come. Shall we catch up again by 9:15? Sorry, no, 10:15. Okay. Next chapter, we will chapter 8, declaration and payment of dividends. Okay. Easy chapter. Okay. Now, what is the declaration payment of dividends? Sir, dividend is nothing but a return on investment. A company is not under an obligation to pay the dividend. It is absolutely a discretion of the management. The directors decides that the company is having a good cash flow this year. The directors can always recommend the paying of dividend. Always remember, there are two types of dividend. One is called as final, one is called as interim. If it's a final dividend, it is always recommended by the board, approved by the shareholders. Whereas if it is an interim dividend, it is always recommended as well as approved also by the board of directors only. The shareholders' approval is not involved here. However, remember, a final dividend, once you declare it, becomes a debt on the company. You cannot revoke it. Whereas an interim dividend, with the consent of all the shareholders, you can still revoke the interim dividend. Clear? Yes, sir. Okay. Final dividend, sir. Remember, whatever is recommended by the board has recommended 9%. If at all the shareholders wants, they can ask for a lesser percentage, but they cannot demand a higher percentage. This is your dividends. Okay. Now, declaration of dividends, sir. Section 123. Sources of dividends. How do I make the payment, sir? From where will I get money? That will you out of the profits of the company, that is current year profits or previous financial year free reserves. I can make the payment, or it can be both. But remember, if there is any depreciation, I have to first deduct the depreciation. Remember, while taking free reserves, you're not supposed to take revaluation reserve or any statutory reserves for that matter. Next one, like for example, DRR, CRR, as the case may be. Next one, sir, from money provided by central or state government. Yes, that is also one of the source to declare a dividend. Next one, before declaration of any dividend, the following should be deducted or set off. What is that? Previous year losses and depreciation of the previous year, including the current year. We have to first deduct that. Only then, whatever is the profit remaining, that can be used to make the payment of dividend. Next one, sir, the transfer of money to reserves is not mandatory and it's completely the company's discretion. What do I mean by that? Every year, now, for example, the net profit available to shareholders, let us imagine is coming to 1 crore. How do you use this 1 crore is your discretion. Meaning you want to transfer any amount to free reserves, you are free to do. I do not want to transfer even 1%. It's absolutely fine. There is no obligation that every year you have to transfer some percentage to be reserves. There is no obligation. Clear? Yes, sir. Okay. Next one, sir. Rule 3, declaration of dividend out of the profits of the previous year when there is inadequacy or absence of profits. Now, what do I mean by that, sir? In the current year, I want to declare a dividend. Now, I want to declare a dividend, but in the current year, I do not have sufficient profits or there are losses. Now, in this case, if I still want to declare a dividend, then people, I'll have to satisfy in rule 3. Imagine people, if you already have sufficient profits, then we don't have a problem at all. You declare how much ever you want. But if at all there is inadequacy or losses, that is when rule 3 will apply. For example, if a company is earning 1 crore, after making all its statutory payments, DRRs, all that, it can use the entire 1 crore as dividend. There is no way written that this is a maximum dividend you can pay. You can pay entire 1 crore as dividend. But if at all it is a time of losses or if it is inadequacy of profits, in that case, people, you cannot use the entire money. On that time, there will be certain called as restrictions. Now, what is that? There are 3. Now, what are 3 restrictions? The first one, what is the maximum rate of dividend that you can pay? What is the maximum rate of? It cannot exceed average of 3 preceding years. Now, for example, you tell me, year 1, they have given 10. Year 2, they have given 6. Year 3, they have given 5. Now, in my current year, there are losses. I still want to declare dividend. What is the maximum rate I can give? 7%. Let us imagine year 1, 10%. Year 2, people, 4%. Year 3, people, 0%. What is the maximum rate I can give? What is the maximum rate? 6%. How should I do the average? Total divided by what? 3 or 2? 3 sure, 100%. So remember, we do divided by 3 only. So I will have to take 10 plus 4 divided by 3. Whatever is the number. Now that number, I cannot go beyond that. Clear? In exam, you might get confused to take whether 3 or 2. It is 3 only. But remember, sir, then can I declare dividend? In the past, we have not declared at all. Now what to do? Any percentage or I cannot declare dividend at all. I can't declare. The first condition will not apply to you. Then you will have to satisfy only second condition and third condition. It shall not exceed average of dividend declared in the 3 preceding year. This condition shall not apply if company has not declared dividend in the past 3 financial years. Next one, maximum amount that can be drawn. So I am paying dividends now. For that, I'm taking money from where? I'm taking from where? Free reserves, correct? What is the maximum money I can withdraw? They are telling you the maximum you can withdraw is 10% of paid up share capital plus free reserves. That's the maximum money I can take. My free reserves can have 100 crore. I cannot use the entire thing. Free reserves are also for futures. It's not only for your dividends. So what is the maximum I can take? Take how much ever your paid up capital plus free reserves, add it. Whatever is the number coming to, the 10%. The 10% is the maximum you can withdraw. Clear? Sir, okay, I've taken 10%. Imagine my paid up share capital of the company is, say, for example, 500 crore. Now, my free reserve is 100 crore. 500 plus 100, 600 crore. 10% is how much? 60 crore. Now, I will take 60 crore. Yes, sir. Now, my paid up capital is 1000 crore. Now, 100 crores I can withdraw now. Then next, on face value. Let us imagine it's face value. So the third condition will come into picture. Understood? Now people will ask why third condition also. Both are similar now. Why third condition is there is because of this. If 10% is covering the whole of the free reserves, then where will you go for future? To protect your future is why the third condition is there. What is the third condition? Balance in reserve. After you take money, the balance in reserve should not fall below 15% of paid up capital. Now you take first scenario only. Okay, you take this only 1000 plus 100 crore. What is paid up capital? 1000 crore. 15% is how much? 150 crore. Now, how much is my free reserves? 100 crore. That means I can't even withdraw 1 rupee as a dividend. Not even 1 rupee. Take the previous scenario. Imagine it was 500 crore. What is 15 percentage of 500 crore? 10 is 50, 25, 75. 75 crore should be still left behind. 10 percentage, I mean, 75 crore should be left behind. Now, if I take 10 percentage condition, I got 60 crore. So if I do 40 crore is what I'm getting, oh, then I cannot withdraw 10 percentage. The maximum I can withdraw is 25 crore. Now you tell me, I didn't know. You tell me what is the rate coming to? What is the rate? What is the rate, da? On what? Everything is there only. Rate of dividend, how will you calculate?
5%.
5 percentage. How did you guys calculate? 25 we have always divided by your paid up capital into percentage. That's why it's 100. Correct? So in exam clearly see, are they asking you number, percentage? If you write in percentage, if they have asked value, then answer is not correct. Please pay attention when you guys are seeing that question. Clear? And remember, sir, whatever is the amount drawn here, we have drawn now 10 percentage. If at all there are any losses, first the losses has to be set off. What do I mean by that? 10 percentage, we got 60 crore. Imagine in the year, the company also had losses of 20 crore. I cannot use the entire 60 crore. Then the maximum amount I can use is 40 crore. Hello? Understood all of you? Three main conditions. Now the question is, sir, if a company is paying interim dividend also, the same conditions are applicable? Rule 3 only? Yes or no? Remember, Rule 3 does not apply for interim dividend. Only average rate will be applicable, not everything else. Hello?
Yes, sir.
No. Loss part you will not take. Now, for example, here 60 minus 20 you did. What you got was 40, no? What you take here is 40. The loss part you will not add it. Clear? Hello?
Yes, sir. So if AO specified listing in AO,
AOA,
then they can,
I didn't get you.
in AOA, they are saying like 5% dividend they have to do.
No. Yes, that AOA will be applicable to you. Yes. Okay, because dividend is not an obligation on the company, no? Payment of dividend, people. Dividend should be paid only to the registered holder, to his order, to his banker. What do you mean to his order? I will tell, don't pay to me, pay to him. When will that happen? A has transferred his shares to B. They have filed form SH4. Now, for the transfer, what is the time that the company will take? How many days? 30 hours, 60 hours, 45 hours, 7 days. Next attempt, what is the answer? Within 30 days. You remember, we saw no, if at all the company does not transfer within 30 days, you have to reply. Then 30 days they have to transfer. Yes or no? So in SH4, I'm clearly telling, sir, within the time if you transfer, by the time you guys register, let us imagine if you guys are declaring any dividend, Papa, don't give it to me, sir. Give it to him. Because amongst us, I have sold him the shares. You may take time to update your register of members, but it's okay, pay it to him. Because we have settled the matter. That time only it becomes his order. I'm telling, don't pay to me, pay to him. Clear? Next one, my bank. Bank today's date, everything will come under bank only. Next one, sir. Dividend can be paid only in cash, not in kind. Cash here is bank only. You can pay it in dividend by check, dividend warrants, by electronic mode, NEFT, RTGS, that is allowed, but it cannot be paid in kind. And remember, bonus cannot be issued in the lieu of dividend. Dividend shall not be paid if company has not complied with the deposits and Section 8 companies prohibited completely. Interim dividend people. What are the sources to pay interim dividend? The first one is people. Surplus and P&L account. Surplus and P&L account. What do you mean by surplus and P&L account? In my previous year, I have some carry forward of P&L. I have not transferred it to reserve. I have the credit balance. Remember, if it's there in P&L account, I will not even consult the shareholders. This comes under the rights of directors only. Again, I repeat, what is the difference between free reserves and credit balance of P&L? Free reserves is in my previous year, whatever I get net profits available to shareholders, from that, a money will be appropriated, transferred to free reserves. So, if the money is transferred to free reserves, then we will use it for any of our futuristic purpose. If money is not transferred, it is still lying in my P&L account. That means what? I have not tagged any expense with this profit. It is just lying there in P&L. If we call that thing as people surplus in P&L or credit balance of P&L, that money is discretion of the directors. That's what they're telling you. The directors can use that money to declare interim dividend. Hello. Next one, profits of the current financial year. Can I use that? Imagine in the quarter 3, we declare dividend. In quarter 1, quarter 2, we made good profits. Declare out of that. Next one, profits generated in financial year till the quarter preceding the date of declaration. That's what I was telling you. You can take this as quarter 3, quarter 4, any reason, any time period. Until the quarter you are paying, previous quarter, if there were profits, using that you can pay. This one, profits of current financial year, when will this come? What is the difference between these two? Here, year is not yet completed. Here, year is completed. But you're not waiting until the AGM is done. What do I mean, sir? April to March. This year is done. AGM, when will it happen? We will declare dividend on probably say 1st of May. I can declare interim dividend. Hello. That is what they are telling you. Next one, restriction during losses of current financial year up to the end of immediate preceding quarter. What do I mean by that? Q1, there is a loss. Q2, there is a loss. Q3, we want to declare dividend. Can we declare?
No, but
Can we declare? Q1 loss, Q2 loss, Q3 can we declare? Yes or no?
yes, sir.
Where will we get money from? Free reserves only, no? Free reserves?
No,
Free reserves. Hey, macha, interim dividend, you cannot touch free reserves. Then, people, what are the sources of paying interim dividend? 1, no, 2, no, 3. 3, we know it's not there. 2, we know it's not there because you're saying it's losses current year. Then what is the only source left? Surplus in P&L account. You cannot touch free reserves. Hello? Remember, that's why I told you rule 3 will not apply to interim dividend. But sir, if at all I'm paying using my surplus, then I have to make sure the rate of interim dividend shall not be more than the last average 3 years. Only this one condition will apply, no other condition. Hello? Dividend declared has to be deposited in a separate scheduled bank account. Which bank account? Section 124. That is only unpaid dividend account, or you can also call as timeline. Now, what is this, sir? Imagine whenever a company declares dividend, the company people within 5 days from the date of declaration, they have to deposit the entire money into a separate bank account. Why? So that you will not end up using it. Once declared, it's a debt. So separate it from your regular bank accounts. Okay. Within 30 days from the date of declaration, that is from here only, I have to make the payment to the shareholders. Sir, what if I have issued it like a dividend warrant, meaning like a check? Then people within 30 days, you need not have to pay. Within 30 days, you post. That is sufficient. But within 30 days, you should have posted it. They have received it or not also is okay. But within 30 days you post. That is considered as a valid compliance. So within 5 days people, I will separate it. Within 30 days people, I will pay it. Hello. Now within 30 days, sir, no one came to collect it. Now what to do? We will wait for 7 days. After 7 days, we'll open one more account. We'll call this account as UDA, Unpaid Dividend Account. Now, in this unpaid dividend account, we will transfer all the money within 7 days. And people remember, in this account, the money will sit for a period of 7 years. Even in the 7 years, if no one comes, people, then I will transfer all this money to IEPF. What and all I will transfer? I will transfer the money also. I will transfer any interest on it. Also, I will transfer the shares. Hello, Makana. They can combine General Clauses Act and General Clauses Act and the Dividends chapter. Why? In General Clauses Act, they would have told you how to count time. Whenever they have asked you 30 days, how to count 30 days, there is a rule there. First day is excluded, last day is included. That means what? If a company has declared a dividend on 1st Jan 2026, do not count first day. Your first day will start from second. So count like that. Second, third, fourth. Like that, it will be 30 days. Whenever you're getting the 30th day, that is the last day. Hello, Pakana. Yes. Uh, that is one thing that they will ask. Next one, sir. IEPF, section 125. What is IEPF, sir? It is a fund established by central government. What do they generally do? They take care of investor protection. That's why we call this as people Investor Education Protection Fund, IEPF. Here, yes, sir. Now, sir, you are saying it is a fund. From where and all this fund will get money? This fund people will get money from all these scenarios. What is that? One is grants from central government or donations, or imagine under Companies Act 1956, if there was any IEPF, all that money gets credited to IEPF under 2013 Act. And what else? Till now, whatever you have seen done, where from here, dividends are UDA, till what is this? For example, deposits. You saw 3 years. You have to come and collect. The person did not come and collect. What will I do? Transfer to IEPF 7 years. Share application money. 60 days I have. If not, 15 days I have to refund. No one came. What do I do? 7 years. You'll have it with you. After 7 years, transfer it to IEPF. Everything same scenario. Preference shares, debentures, interest on it, dividend on it. Every scenario will follow the same thing. You will have it for 7 years. If they do not come to collect, you will transfer it to IEPF. Hello. What is this? Correct? Hello. Done. Sir, next one. Fund is debited with. One fund is getting money. How will fund debit money? Whoever you have taken money from here, 7 to 11, for all these people, they came and asked back the money. You will have to give back the money. Correct? For example, share application money, they came back. Dividends people, they came back. How do I get back the money? Write an application directly to IEPF. There is some procedural requirements. Once you follow the procedure, people, you will get back your money. Clear? All of you? Okay, that is what is given here. Next one, promotion of awareness, investor awareness. We would have seen in class also. They gave investor awareness in villages and all, if you remember. They taught them share market. Wait, huh? You judgmental people. Protection of interest of investors. Distribution, especially protection of investors. Lot of ways they try to protect their interest of investors. For example, there is one segment called as commodities. If you want to trade in commodities and all, SEBI, with every trade, once in a month you will have a call also. Are you really aware of the transactions, how to do? Do you have complete knowledge to trade in commodities? They will keep asking you. Once in a while, you have to press that IVR message. Sir, 1 or 2. I have to keep pressing it. Yeah, because very risky market. Commodities are called as futures. I think you guys would have heard of futures contracts. You have seen or no, na? I don't know. Correct? No. Oh, is it? So future contracts, always remember, if one person has to gain, one person has to lose. There is no win-win situation in commodities. That means futures. That's how the contract is. If one person has to get money, someone has to lose money. That's mandatory. Two people cannot win. Yes, sir. So investor awareness. They'll keep sending messages. Don't give OTPs to anyone. All that they will say. Now there is one more requirement also. What is that? Your trade wherever you have your demat account. Let us imagine in your demat account you have some fund, some say 30,000 rupees. You have not utilized it. They have to refund this money to you at the month end. Why? Wazirex. I showed you. What will you do if such things happen? Investor education, protection. Clear? Huh? Okay. Next one, the distribution of disgorgement amount to person who suffered loss. What is this done? Imagine Arshad Mehta did all money. He will take away all of that. But someone has suffered loss, no, because of him. We will repay him with whatever is the losses we have recovered. He did all illegal profits. We recover that money from him. We will give it to the person who has suffered it. The order passed by the court for taking away that illegally made profits. That is only called as people disgorgement. Yes, sir. Last one, sir, we already saw class action suit. Authority to administer the fund. EPF. This is okay only. Don't bother. Go to the next one. Section 126. Dividend to be held in abeyance. What if abeyance means people? It will be on hold, set aside. Why? There is a conflict. Or there is, say for example, A has transferred his shares to B. We have given SH4 to the company to register, but the company has not yet registered because they have 30 days time. Within 30 days, company declared dividend. A did not tell it to pay to B. Now, whom do we pay? Right in front of my eyes, they have given. We did not register, but neither did we do any non-compliance. In such case, they're telling you, do one thing. It's a dispute. Until you guys are able to figure out, keep that dividend aside. That's only is called as people abeyance. Transfer deed is delivered to the company, but the transfer is not yet registered. So in such case, what will happen? The dividend of such shares shall be transferred to UDA, unpaid dividend account, if the shareholder has not authorized the transferee. Order. Hello. Keep in abeyance in relation to such share all the rights or bonus if issued. Understood? So until it is decided, I'll keep it in the UDA account. Punishment for failure to distribute dividend within 30 days. If I do not distribute dividends within 30 days, what is going to happen? I'm liable for punishment. Penalty, people. What is the penalty? Company will be liable to pay 18% per annum as penalty. Interest. Director, put him in jail 2 years. Fine and 1,000 rupees per day of default. Next one, sir. Exemption. Important. Whenever some cases you were not able to pay dividend. Why? What is the reason? The reason is due to operation of law. Your shareholder all of a sudden became an alien enemy. Pakistan, I cannot pay. China, you change the rules. That's why we are not able to pay. Then that is one of the reasons we will excuse you. Even if you do not pay the dividend within 30 days, we are going to excuse you. Next one, shareholders' direction of payment could not be complied and same has been communicated. Now, for example, one shareholder told me to pay his dividend to a particular bank account, but people, the account number is mentioned wrong. We tried to process, we could not pay. The company has to intimate the shareholder, sir, whatever your request was, we were not able to fulfill. If it is not communicated, it is a non-compliance. Third one, adjusted against some due from shareholder. Imagine I had to pay call money. I adjusted, valid. Dispute in right to receive dividend, abeyance. Non-payment is not due to default of company, any other reason, but we should have not done the fault. In such case, people, yes, the shareholders, I mean, the directors will not be held liable. Clear? Yes, sir. This is your section 127. Any doubts? Cold. Turn off.
They just turn off the safety right that behind sir, if you turn on the AC, it's not here.
ಏನ್ ಮಾಡಿ ಹೇಳಿ ನೀವ್ ಹೇಳಿ. Okay, Tejas. At least increase if you want. Someone can do it. Huh? 23. I think this will be lesser than that. Then increase that. That's all. Like, even out. Can anyone increase that? You guys know? Immortally, Arnavotli. Pakka. I told you, as soon as we entered, it was Kashmir. It changed, huh? Then turn off for some time. Or put it on fan mode. Waterfall started, huh? There it goes proper, huh? Where does it fall? It falls in. Okay, then okay. Chapter 9. Taka. Accounts of companies. I'm not sure how much I can do today. Throat is gone. Accounts of companies. Let us at least try to do till at least foreign company. We'll see. Foreign company. I think my throat gone. You think it? Huh? Okay. Teacher's best friends are two things, sir. One is gargling, one is step-still, sir. You, at least in my cupboard, no, I'll have exactly. I'm not even ignoring the fact. I think I'll easily have what cough cells, coughlets, step stills, everything easily 150, 60 easily. Yeah. ಅಲ್ಲ ಇದು ಶೀಟ್ಸ್ ಏನ್ ನಾನು ಮೆಡಿಕಲ್ ಶಾಪ್ ಶೀಟ್ಸ್ ಇಟ್ಟಿದೆ ಮಾಡ್ಬಿಡ್ಲು ಮೆಡಿಕಲ್ ಫಾರ್ಮ್ ಮೆಡಿಕಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ನಾನು and hot water gargle. Books of accounts are to be kept by company, section 128, and in that you guys ಹೇಳ್ರು ಅಂದ್ರೆ ಎಲ್ಲ ರಾಂಗ್ ಹೇಳ್ತೀನ. Okay. Every company shall maintain for every financial year what are books of accounts of books or papers, books and papers, financial statements. This is important. We'll see this. Financial statements, it shall include balance sheet, P&L account or income and expenditure, cash flow statement, statement of changes in equity, explanatory note. Certain companies are exempted from CFS. Can you tell me who are they? OPC, small company, dormant company, a registered private company, which is a startup. Correct? Huh? So these companies are exempted from being called as a, they need not have to maintain cash flow statement. Here, remember, they can club subsidiary company definition and small company definition and the cash flow statement cut definition. They can club these three provisions. That is, now say for example, small company need not have to maintain a cash flow statement. Yes. So what they will give you? They will give X limited, Y limited. Y limited is a registered startup. X limited is a holding company. Y limited is a subsidiary company. Now they'll ask you, is Y limited exempted from uh, filing cash flow statement? Is it exempted? Yes or no? You will have to first write the definition of subsidiary company. It's a subsidiary company. Now in cash, what is it? In a small company, who and all is not considered as a small company holding subsidiary. Subsidiary cannot be considered as small company. Now I will write, because of that, this company is not exempted from CFS. They will have to maintain CFS. Hello? Why I'm saying you have to write subsidiaries, they will not give a direct relationship. Oh, so X Limited holds 51% all, they'll not give. They'll say X Limited is controlling the composition of board or things like that they will give you. So you will have to write, all three provisions. Remember, they make combine it tricky, important. General requirements and preparation of books of accounts, true and fair view. Of course, no one will tell you to do fraud. You have to prepare it every financial year. Explain the transactions of registered office and branch office. Where will you maintain the branch office books of accounts? You can maintain it in branch office only. Just that. A summarized return. Once in how many days? Quarterly once. You will send summarized return to the registered office. Accounts must be kept on approval, double entry system. Place of maintenance of books of account. Where will you maintain? Registered office of the company. Can I maintain anywhere else? Yes, provided at least more than 1/10 the people should decide. Yes or no? No, nothing like that is there. Should I pass special resolution or not? Special resolution, da? Any other place in India after passing board resolution, remember, plus intimate ROC, AOC file in 7 days. That's a new address is this. This is where you can find my books of accounts. Next one, sir. Notes, branch of office people, whether in or outside India, it will be maintained there only. Quarterly intervals, it will be sent to the registered office. Inspection by directors. Any director can inspect the books during the business hours. He can inspect the books of subsidiary company also. Just that the board of directors should authorize you to go and check it. The financial information maintained outside India, you need not go there. You can just ask them only to send the books of accounts. They will send it to you within 15 days. Remember, you have to ask this request directly, not through any agent or attorney. Long back, probably some 6 attempts prior, they had asked that question. This agent. Here, next one, period of preservation, sir. The books of accounts will be preserved for 8 years. Till excluding the current financial year. Don't take this current financial year. So take it from the previous year. You have to maintain it for 8 years. Minimum 8 years preceding financial years. If company incorporated newly, then such period of existence. Meaning if I'm in presence only for 4 years, then where will I maintain for 8? I'll maintain for 4 only. Yes, sir. I hope you understood that 8 years logic. Imagine if you are in 25, 26. Don't count this. If current year is 25, 26, don't count that. Take 24, 25, year 1. 23, 24, year 2. 22, 23. 22, 23. 22, 21, 20, 19. 1, 2, 3, 4, 5, 6, 7, 18. So it will be 17, 18. 17, 18, I have to maintain as on 25, 26. What if I go to 26, 27? You can you can discard these statements. Hello? But remember, if central government has passed an order, no. I doubt your company. You have to maintain all your records for 15 years. Then you have to maintain it for 15 years. Next one, sir. Person responsible to maintain books of accounts. Very, very important. Who shall be responsible for maintaining books of accounts? Managing director, whole-time director in charge of finance, CFO, any other person authorized by the board. Very, very important. They can ask you. Remember and go. Next one, sir. The financial statements. How to maintain the financial statements, sir? True and fair. You comply with accounting standards and you have to maintain it as per the format schedule. As per schedule 3, if not complied people, accounting standards is applicable to me. What if I don't comply? You have to give a reason for such deviation. First one, you have to say we have deviated. Next one, reason for deviation. Third one, what is the financial benefit that you guys derived because of the deviation? For example, you had to do, I tell you right now, for example, you have to take WDV method of depreciation. You did SLM. Now, what is the difference? If you had done that, what would have happened? If you have done this, what has happened? You have to disclose. Hello. Okay. Next one. Non-applicability. These rules will not apply to insurance company, banking company, electricity, any other company specified by CG. Board shall lay full documents in AGM. What and all? I will lay down financial statements as well as consolidated financial statements of all my subsidiary company and associate company. But remember, consolidated financial statements will not be required when there is an exemption. When it is a unlisted company or it should not be in the process of listing in or outside India. Next one, its ultimate or intermediary holding company files CFS with the ROC. What do I mean by that? There is company X, company Y, company Z. Company X has already filed it for everyone. Now again, company Y need not have to file. Logically, no. Next one, sir. It is a wholly or partly owned subsidiary of another company and all its members have given no objection on non-presentment. What do you mean by that, sir? There is company X, there is company Y. Company X holds, say for example, 75% in company Y. The 25% is held by others. They're telling you the others have to give you a no objection. Even if you do not present it as a CFS, we don't mind. They have to give you a no objection. That's the meaning of it. So one company X. Next one is the other shareholders also. Apart from your holding company, they have to give their approval. Even if you do not present it, we are okay. We will not demand CFS. If they give you a no objection, people, then yes, CFS is not required. Kira, hello. Next one, exemption by central government from section 129. Upon a request made, go and request, sir, please, because of this reason, do not make me follow all these sections. If CG is satisfied, they may exempt you in the public interest. Next one, reopening of accounts, section 130. What do you mean by reopening of accounts? Reopening of accounts can happen, people, whenever any authorities feel there is a mismanagement in your company, your accounts has been fraudulently prepared. Now I will write an application to the tribunal and ask, sir, can I go and reopen their books of accounts? For example, we are in the year 24-25. Sorry, 25-26. We have a problem in the financials that they have prepared in 1920. Can we go back and reopen that? Is it allowed? Answer is yes. Can I go and reopen 14-15? Remember, they will club this provision and reopening of accounts provision. The maximum you can reopen is for a period of 8 years. 8 preceding financial year, anytime preceding the current financial year. Don't take the current year. The last 8 years is the maximum you can take. Before that, people, you cannot open because they would have destroyed it legally. Hello? How to reopen, sir? To reopen and recast its financial statement, application is to be made by central government, SEBI, IT authorities, IRDA, TRAI, any other person concerned, they will have to write an application to the tribunal. Sir, in our company, I think there is some mismanagement. Satyam case, there is a mismanagement. For example, SEBI says there is a mismanagement in Satyam. Now, what will tribunal do? Tribunal will take your application. They will again forward that application you have filed. SEBI has filed to tribunal. Tribunal will again give it to all of them. Hey, SEBI is telling like this. Does any of you have any problem? IT authority will say, yeah, I have a problem. I've taken tax on that amount. So I feel whatever the financials prepared, it is proper only. Now, people, there will be a hearing. And according to whatever the tribunal order, that will be final. Hello, Pakana. The reasons for reopening of accounts, people, accounts were prepared in fraudulent manner or the affairs of the accounts were mismanaged. The board cannot reopen for more than 8 years. It can be reopened if there is a direction issued by central government that you have to maintain books of accounts for more than 8 years. The accounts, once revised, shall be final. Here, yes, sir. Okay. Section 131, voluntary revision of financial statements. What is the difference between 130 and 131? In 130, authorities are initiating a procedure against you. 131, you only realize that something is wrong. You only will go and file an application to the tribunal. Sir, in that year's records, we have made some mistake. Can we rectify it? If tribunal is satisfied, again he will file an application to others. We will wait for them to reply. If no one replies, tribunal will allow you to change whatever you guys have made an error. You can change. Clear? The rule will apply both to financial statements as well as board's report. Any mistake can be rectified. And remember, the maximum time the books can be reopened for. How many years can I reopen? If you are doing it voluntarily, people, 3 years. Clear? That is what is given. When to do if the board thinks financial statements and board's report is not properly prepared as per the section, they will file an application to the tribunal. Tribunal will again forward to government IT authorities as the case may be. The tribunal's order will be final and we'll have to forward it to ROC. The maximum duration we can open it is people for 3 preceding financial years. It can be reopened only once a year. Once revised, it is going to be final. And next one, remember people, whatever is the reason for the revision, you will have to write it down in your board's report. During the year, we had revised the financials of this particular year, and the reasons for that was this. You have to give it in your director's report. Next one, sir, limitation of revision. That is, how much can I change? Can I change the entire financial statements? Can I change the entire board's report? They're telling you whatever is the error. Now you are supposed to prepare financials and director's report as per 129 and 134. To comply with this, whatever changes you need to make, you make it. Not beyond that. You cannot replace full format only. That all is not possible. Getting the point? Yes, sir. Why? Because the financials are already adopted in the general meeting. They already have seen the previous one. And it is also filed with the registrar. So it's now a public document. Everyone have relied upon it. I cannot allow you to change how much ever you want. That is what is given in 131. Clear? Hello? Okay. Next one, sir. Section 132. 132, what is 132? NFRA. Exam point of view, okay. Functions, there was, see, you remember I told you in your class also, there was Dilka Dadkanda, they removed it. This was the main provision of NAFRA. This part only they have made it as an extra need. Meaning they have said if required, then study. Anyways, it is not,
mandate this rule. But NAFRA, what is NAFRA? Here and there they will put a bomb. Yes, sir. What is NAFRA? Composition, chairperson. What is NAFRA? It's again a body created by central government on 2018. Before NAFRA, who was there? Nakas. Yes, sir. Who is eminent person having experience in accounts, audit, finance, and law? Will make that person as a chairperson. The chairperson members shall declare to CG regarding no lack of independence or conflict of interest. Sir, you can make us chairperson or member. We don't have any lack of interest. We don't have any lack of independence. We will take proper decisions. You have to tell to CG. Chairperson and members in full time shall not be associated with any audit firm during this tenure. When you are on NAFRA, you cannot be associated with any other audit firm. And 2 years after such ceasing to be a member and chairperson also, you cannot be associated with any audit firm for a period of 2 years after you leave NAFRA. Next one, such part-time, for part-time people, there is no limit, meaning this one, this will not apply. That is, even after leaving, you can still continue in any firm. Next one, sir, the members not exceeding 15 can be part-time members. Functions of NEFRA: make recommendation to central government on formulation of accounting and auditing policies and standards, monitor enforce accounting auditing standards, oversee the quality of professionals. You only know if you guys are not doing anything properly, then there is the penalty, all of that. Perform such other functions as may be prescribed. Leave this part. And remember, whenever what is that? Every such body corporate, if at all you are covered under NAFRA, whenever you appoint an auditor, you need to intimate NAFRA people in form NFRA 1 within 30 days of these rules. Yes, sir. So basically, if you are covered under NAFRA, who is covered under NAFRA? The ones given above. Correct? Huh? Now, these people, whenever they are appointing an auditor, they have to intimate NAFRA. Sir, we have intimated, we have appointed an auditor, sir. We are going to intimate NAFRA. Inform NFRA 1. Clear? Huh? Sir, penalty, if at all you are caught on such investigation, if a professional misconduct is proved, then penalty, if you are an individual, minimum 1 lakh, maximum can go to 5 times of the fees received. Next one, if at all you are a firm, minimum is 5 lakh, it can go up to 10 times of the fees received. Whoever is aggrieved by the order, I can always go for an appeal. Debarring the member, I can also debar a member from being an auditor, internal auditor, or taking up any audit. Performing any evaluation for a minimum of 6 months, I can debar you for a period of 10 years. Nice, no? Yes or no? Next one, sir. Audit and annual report. Because it's a government body, people, annual accounts have to be prepared. Who will audit it? CAG, person appointed by CAG will audit. That person will submit his report to CAG. CAG will prepare something called annual report. That annual report, people, will be forwarded to central government. Central government will lay it down in both the houses of parliament. Yes, sir. Next one, financial statements board's report, section 134. Authentication of financial statements. Who will sign the financial statements? Very, very, very important. Who will sign? They're telling you, chairperson if authorized by the board. What if chairperson is not authorized? 2 directors. If at all an MD is there, one should be an MD. Second one, sir, if at all your company has CEO, CFO, CS, if all 3 are there, all 3 should sign. The last one, sir, in case of OPC, 1 director is sufficient. Very, very important from exam point of view. Clear? Okay, next one. Contents of the board's report. All people, whatever we have seen, DVR, sweat equity, ESOP, now only we saw revision of financial statements and reporting of fraud, anything, people, in general, POSH policies, CSR committees, related party transactions, declaration given under deposits chapter, everything will come under board's report. But one thing in board's report is important. What is that, sir? That is only called as
director's responsibility statement. Now, what do you mean by director's responsibility statement, sir? We have to make sure we write these 6 things. What is that? First one, the company has prepared its accounts following the accounting standards. Next one, sir, the directors have selected the best accounting policies for the company, whichever helps them to give true and fair view. The third one, sir, the company has maintained sufficient accounting records. Whatever is required to be maintained under the law, we have maintained it. Next one, the company is preparing its accounts on a going concern basis. The company has sufficient internal financial controls to avoid fraud. The last one, we have proper system in place to make sure we comply with all the applicable laws. What do I mean by that? In a company, close to 40-50 laws will be applicable. Humanly impossible if you try to remember everything. Have systems to make sure it reminds you. Today is the last day for AGM. Today is the last day for filing AOC4. Have systems. If not, it's going to be a big problem. That's what is the director responsibility statement telling us. It is a point, 6 points. Remember and go. Important. Hello. Correct is yes. Next one, CSR. Hello. CSR. 135 134 135 పక్కానా ఫుల్ రివిజన్ 135 ಅಪ್ಪ ಸಾಮಾನ್ಯನಾ ಹಿಂಗೆ ಹೇಳಿದ್ರು ಓಕೆ 135 ಡಾ CSR ಡಾ ಮಚ್ಚ ಮಚ್ಚ here MCQ chances of CSR one question maximum is there. Remember in MCQs, people, 3 chapters where you can definitely guess the question from. CSR, chances are there. LLP, put 100 stars. Pakka will be there. LLP. FEMA, Pakka will be there. MCQ, Pakka. Guaranteed. Promise on you. You tell me who is your most favorite person in the class on him. Pakka they will ask. Yes, sir. So remember and go. These things. I said I'll give you the ABC analysis. I'll try to give it to you. Yes, sir. Last time nightmare MCQs. Yeah. There is not nightmare or not, but we should have. We'll take up. We'll see the paper. We'll do. Tomorrow morning class? Oh, morning you have class, huh? He said you'll have. Have it. Maja pannam. Yes, sir. Applicability, of course, give importance for that only. Applicability, people, every company having net worth of 500 crore or more, turnover of 1000 crore or more, net profit of 5 crore or more. During the immediate preceding financial year, they shall constitute CSR committee. That means CSR will be applicable to me. Hello. Now, sir, I need to check this condition every year. Correct? See, if a company ceases to meet the requirement for 3 consecutive financial years, they shall not be required to constitute CSR committee. This was a rule. And this rule was an amendment, was taken off. Now I just made one statement. No, what is the statement? Every year you need to check this condition. Correct? Why did I say I have to check every year? Because this rule was there. This rule has been removed. That is once applicable, 3 years applicable. It was there. That rule has been now removed. So indirectly, it gives me an interpretation that what? Every year I need to check CSR applicability. Clear? Huh? Sir, tell me, should a foreign company do CSR? Huh? Foreign company. Foreign company. Da. Yes, they have to do for Indian operations. Sir. Should a private company do CSR? Huh? Private company. Private company. Remember, every place you would have seen public company having a. In this place, it will be written every company having. Should a Section 8 company do CSR? Huh? Section 8 company. Think an answer. Section 8 company also should do CSR. There is no exception. No, anyone you are. You have to do CSR. No one is exempted. Holding company, subsidiary company. Holding alag, subsidiary alag. Hello. Okay. Next one, sir. What is CSR committee? Composition. How many people? Da? Minimum is? Minimum is how much? Da? 3 directors. In that one shall be independent director. In case of private company, 2 directors. Correct? No? In case of private company, 2 only is sufficient. We do not need a 3. In case of foreign company, 2 directors or 3? 2 members people, directors Allah. Because members are only there in India. And in that one person shall be a Indian resident. The board's report shall disclose CSR committee. Role and responsibility. They shall formulate CSR policy. They shall recommend how much is CSR expenditure and monitor the CSR policy. Sir, now CSR committee, everyone should form. Yes, everyone should form. Allah, everyone. Yes, sir. Sir, everyone. Okay, wait. One exemption irko. Kya hai? Amount to be spent does not exceed 50 lakh. The CSR committee shall not be applicable. What do I mean by that? My CSR expenditure, I have calculated 2%. No, that 2% they're telling you is coming to 50 lakh. Up to 50 lakh. Why does CSR committee build up and all? That and all is not required. You just directly spend. Any director will take care of the job. You need not have to form CSR committee. Here are okay. CSR expenditure. How much? Company shall spend 2% of average profits of company during the 3 immediate preceding financial year. And remember, there is something called as administrative overheads. It shall not exceed 5% of total CSR expenditure of financial year. What is administrative overhead? Expenses to maintain CSR. For example, what is that? You take an office space to run a old age home. Your employees will sit in one place to run a old age home. Old age home is a CSR. What is this office space? That comes under administrative cost. For example, you are having a running cost, operating cost, cleaning, maintenance, security for old age home justified. Why for you? Administrative costs. So the cost to maintain the CSR. Then where will you spend on CSR? I tell you, all this was not there till 22. That means what? People have exploited CSR. Full left and right. 1 rupee bittilla. In 2017-18 and all people, you'll not believe, we used to get calls from trusts, foundations and all. Sir, let us enter into a tie-up. Please, CSR applicable to you. Hey, yours is the first ID they will get it. Don't get surprised if you get a call. You will get. Why? Public domain. You'll be appointed as a CS or CFO now. They know you will only take the decisions. It will come to you. So in the initial years, they used to call, sir, can we enter into a tie-up for CSR expenditure? How much you want, you can let us know. Direct percentage. Now imagine, Reliance ka CSR expenditure, how much? 1,300 crore. We'll take 1%. Jasti beda. You should not be too greedy. Arnav is like, sir, give me 0.01, I'm happy. Yes or no? So it used to happen. That's why they brought in CSR registration. Today, random trust cannot run CSR. That's the reason. That's I'm telling you, no, full provision, exploitation. Okay, surplus arising out of CSR should again be put back into CSR only. What if I have spent any extra CSR? You can carry forward it people up to 3 years. So in this year, if I have spent 50 crores more, set it off against next 3 years. Allowed. Next one, people, activity is not considered CSR. What and all? Life boy, buy one get one. CSR, huh? Activities done in the ordinary course of business cannot be considered as CSR. Exception was research and development, COVID. But this ended with the 2022. 3 years there was a relaxation. Activity outside India, except Indian training sports. Imagine some Olympics. We do not have training facilities here. You send money to our people, get them trained outside, allowed. That alone is considered as a valid CSR, spending outside. Political contribution, not a CSR. Activities benefiting only employees. In exam, we have seen COVID, your vaccine to only employees or even their dependents, families cannot be considered CSR. Sponsorship, not CSR because it is marketing. Fulfillment of any statutory obligation. What is statutory obligation? For example, this pollution industries, they set up the pollution treatment plants. It's your cost. You cannot claim it as CSR. Charitable contributions, TV shows, advertisements, see marathon. That marathon, okay. Unspent CSR. What is unspent CSR? Now, a CSR can be of two types people. One, no, small project. One, no, big project. Now, for example, people will come up with projects like, what is it? Vantara. Yes, Vantara and all. Now, Vantara can be built in one day, one night, 1 month, 6 months. They have built one swimming pool for elephants. Jacuzzi is there. I don't even know, I swear, whether that elephant will feel the jacuzzi or not. Because my experience with jacuzzi, I will never feel that there is jacuzzi at all. One of the worst. Jacuzzi, they do know. Nothing. Even I got excited only first time when I went to. One bath shower, Allah. One bathtub will be there. In bathtub, inside there will be pipes. Inside. There will be pipes. Where that pipe will hit you? The water will not be any. See, the logic is it should be like a massage. Here, nothing will be there. I will not even know. Hey, yellow anirodha. You will be searching. You should be searching it. I only am not feeling the elephant. You should see it's a jacuzzi pool, and they have heater, heated pool. Yes, sir. So see, now to build all that heater, jacuzzi, whatever motor, now people will all that happen in one day. Now what I will say, sir, I will call this as an ongoing project. What do you mean by ongoing project? A project from the day you started, exclude that year. Apart from that, 3 years time will be given. For example, for 24-25, CSR became applicable for us. I have to spend the money in 25-26. We started Vantara here. Don't count 25-26. Apart from 25-26, 3 years will be given to you. 26, 27, 28, 29. So people, you'll have to complete this money or construction or whatever. Maximum time given to you is 3 years. Here are such type of projects is called as what people? Ongoing projects. Now, what is the guarantee you will use money for that only? So what they're telling you is people, as soon as you treat any project as an ongoing project, remember, even a project which you initially thought a single year, later can be converted to multi-year project. It is allowed. What you need to do, such amount shall be transferred to a separate account within 30 days from the end of the financial year. What do I mean by that, sir? 25, 26, we started, no? By 26, I got to know it's an ongoing project. Take 30 days. 30th April 26, transfer that money to a different account. And you have to spend that within 3 years. Sir, now I have to spend it by 29. Correct? Huh? Sir, by 29, if I'm not able to spend, what will happen? Within 30 days of closure of the financial year, that is 30th April 26, 27, 27, 28, 28, 29. So 30th April 29, I have to transfer this entire money to any of the funds which is given in Schedule 7. It can be PM Cares, Clean Ganga Fund, or any other fund which is given under Schedule 7. You have to maintain, you have to transfer all that money, whatever you have not spent, to the Schedule 7 accounts. Clear? Hello? What do you mean not ongoing project? Not basically single year project. So 24, 25 CSR applicable to me. In 25, 26, I have to spend the money. Sir, what if in 25, 26, I was not able to spend the money within 6 months of the closure of financial year, I have to transfer it to the fund which is given in Schedule 7. Now, what is Schedule 7, sir? Schedule 7 is nothing but people which speaks about what are the activities that is considered as CSR. Can you give me some 5 to 8 examples? Eradication of hunger, gender equality, slum development, plantation, flora, fauna, women empowerment, old age homes, children education, malnutrition, all this, rural sports, slum development, what is that? Rural development, historical places, adoption of that, all of this can be considered as what people Schedule 7. In the Schedule 7, during COVID, they have added recent things. What is that? One, research and development, I told you. 3 years was considered as a valid CSR expenditure. What else was added? Any makeshift hospitals was considered as valid CSR. And Har Ghar Tiranga, Azadi Ka Amrit Mahotsav, 75th year of independence. Anyone who helps in the production of national flags can be considered as valid CSR. Here, okay, next one, sir. Non-compliance. A company will be liable for a penalty 2 times of the amounts required to be transferred to the fund, or unspent CSR, or 1 crore, whichever is less. In the case of officer, 1/10 of the amount required to be transferred to the fund. What do I mean by that? Imagine the total money we had to spend was 1 crore. Yes, sir. So if I have not spent 1 crore, 1/10 of that amount, 10 lakh. Imagine in 1 crore, I spent 20 lakh, 80 lakh I did not spend. So in 80 lakh, 1/10. Whatever I have not spent on that people, 1/10 I will have to transfer. I mean, I have to pay as a penalty. Or 1/10 of the unspent CSR, or 2 lakh rupees, whichever is less. CSR reporting, sir. Board's report, it is mandatory to include annual report on CSR containing activities, website disclosure. I have to disclose on my CSR policy, which is a committee and all of that. Impact assessment report, important. What is impact assessment report? Now, sir, you guys are doing slum development, or you guys are doing hospitals, education, schools. You guys have done the school. How is that school being utilized? Are people coming to it? Have you done some difference? See how, what do you say? How our irony of our system. We have government schools. For that, there is no impact assessment. Not our money, no. Private, their money, no. Easy to come with rules. Don't you think so?
Yes, sir.
Reality of life. And who imposes this? Government only. Impact assessment. Why? As a corporate citizen, you have to make different systems. Huh? And you guys end up eating our tax money, sir. Correct, no? Ayyo, what? Zero development. There will be no difference only. Sorry. I mean, they said, not me, da. You need it though. Honestly, no. ಹೇಳ ಯಾಕ ನೀನು ಹೂ ಅಂದ್ಯನೋ ಬಟ್ ಐ ಮೀನ್ ಇಂಡಿಯಾ ಇಸ್ ಡೆವಲಪಿಂಗ್ ದಟ್ಸ್ ನೋ ಡೌಟ್ ರೈಟ್ ಡೆವಲಪ್ ಆಗಿದೆಯಲ್ಲೋ ಇಟ್ಸ್ ನೈಸ್ ನಾರ್ಸ್
Nice.
see da in our country we test your car tires, we test the private sector. What if you're not given good tires? That's why we don't have roads. Drive it and see. See, I mean, I thought I feel everything is perfect. What do you think? Huh? ಇಲ್ಲ? Then it's perfect, right? Huh? Companies with average CSR obligation. Sir, when will you go for politics? We will vote for you. Venkatesh, I'll tell you one thing. You will only not vote for me. Yeah. Ingande Papa, all our heroes, they are cheated by us only. We will say everything. Papa, when the voting comes, we will not vote. Everything we will say. It's first time. Papa, they get best example. I'll give you in every industry. Papa, in the industry of Andhra Pradesh, Chiranjeevi. Here, Chiranjeevi Papa, he was in his prime. Kamal Haasan, sorry. Kamal Haasan, Papa, how much he has learned, he went and advised Rajnikant, brother Venda. Yeah, and Pawan Kalyan, first time. Then 5 years, he did not even get his own vote. I mean, his constituency also he did not win. And then Upendra here. ಎಲ್ಲಿ ನಾವೇ ಹೇಳೋದು ಅಣ್ಣ ಬನ್ನಿ ಅಣ್ಣ ನೀವು ವಿ ವಿಲ್ ವೋಟ್ ಫಾರ್ ಯು ಪಾಪ ಎಷ್ಟು ಚೀಟಿಂಗ್ ಯು ಗೈಸ್ ಬಿಲ್ಡ್ ರಿಮೆಂಬರ್ಡ್ ಯು ಗೈಸ್ ಹ್ಯಾವ್ ಸೀನ್ ದಿಸ್ ಮೂವಿ ನೋ ಸೊರಾರೆ ಪಟ್ರು correct now you have seen no that movie is made on whose life you know Surya is there you know huh? Vijay Malyana ಒಂದು ಕ್ಯಾರೆಕ್ಟರ್ ಅಣ್ಣ ಅದು who is that person Captain Gopinath. Captain Gopinath stood for politics in Bangalore. Utterly lost. Yes, you know one of the co-founder of Infosys, Nandan Nilekani, stood for politics in Bangalore. Lost. This is how it will be. Then Nandan Nilekani is a person who worked behind your UPI project. With him only you got all your Google Pay, Phone Pay and all. Aadhaar project, Nandan Nilekani. They co-founded with Narayan Murthy, the person who was there on the day one of Infosys was Nandan Nilekani. We did not vote. We said, sir, you will not understand politics. And you will say, sir, you leave teaching and go. You leave us. Irodu hogi. Companies with average CSR obligation. Okay, remember, impact assessment. When is it required? Yes, whenever companies with average CSR obligation of 10 crore or more in the 3 immediate preceding financial year. So in the last 3 years, I should have keep on spending 10 or more. Then CSR impact assessment is applicable to me. Okay, next one. It shall undertake an impact assessment through an independent agency of their CSR project having outlay of 1 crore or more. What do I mean by that? Let us imagine my CSR expenditure is 10 crore. I spent it on 2 activities. One activity, 9.5 crore, I spent on education. 0.5 crore, I spent on women empowerment. I spent on women empowerment. So, sir, they're telling you any project now out of 10 crore, I'm spending 9.5 crore on one project, 0.5 crore on one project. Remember, people, Any project having 1 crore is when people you need to come up with impact assessment. 50 lakhs people for this project, impact assessment is not required. That's the meaning of this. Any project outlay having 1 crore or more, for them impact assessment is required. Now what will I do? I will send an independent agency. When will I send? Let us imagine we started this project in the year 25-26. You do not have to do the impact assessment in the first year. What will be there? Buildings will be there and rocks will be there, stones will be there. What will I write in the first year? So second year only it will come. No, the reason is that only 25-26. Imagine we are building hospital. In first year, what will be there? In the corner, gutka will be there. What else will be there? That's all. No. I don't know that also. Da. Why on wall only? They can. Adu no, attitude. No. 9.5 crore. So I have to get it done now for education now. What will I get it done? You need to go to an independent agencies. You need to get your impact assessment. Meaning what? Now you have set up a school. How many students are coming? Has it increased over a period of time? How many teachers are there? What is the change you have brought in for this particular area? All that will be given by an independent agency. Will they do it for free of cost? Illa. Can I have to pay them also some money? No. Can I treat that as CSR expenditure? Money paid for them to do CSR inspection and impact assessment. Can I treat that as CSR? Yes, provided the impact expenditure cannot be more than 2% of CSR expenditure or 15 lakh. So up to 2% I'll allow, or maximum limit of 50 lakh rupees, whichever is higher. Earlier it was lower, again amendment, it is now higher. Clear? Hello, this is your CSR. Yes, sir. One thing, audit trail, can a company use accounting softwares to maintain the records, books of accounts, all of that, or it should be in physical copy? Possible, but provided people, you need to use such softwares which has edit log facility, audit trail. So you cannot turn it off. It cannot be disabled. Only then you can use the software. If not, not possible. Audit trail facility, remember. Okay. And have I covered almost? Anything left? My God, internal audit we did not do. Hey, financial statements we did. Hey, 137 this financial statement. So this is very important. One question you can expect. People, when do I file my financial statements now? Which format? AOC 4. If it is CFS, if it is XBRL, okay, every company should maintain financial statements. They'll have to file with ROC within how many days? Very good. 30 days of conclusion of AGM. Now, what if in my company we conducted a AGM, we did not conduct an AGM? Let us see a scenario where we conducted a AGM. Now, when you conduct an AGM, two scenarios can happen. One, all your shareholders were okay with your financials. They were not okay with your financials. This is the most easiest way. Your accounts were approved. Then people, you will file it with the registrar within 30 days. What if your financials are not approved in the AGM? Then you are going to adjourn the AGM. But remember, people, whatever is that unadopted, you guys will file that only with ROC as a provisional financial statements. It will be filed as a provisional financial statements. Now, registrar will take it, people, as provisional on their records until you file the final one. Once you file the final one, people, it gets replaced by this provisional financial statements. Clear? Yes, sir. Now, what if company never conducted the AGM at all? So the law is telling you whatever is the due date from that day within 30 days, you have to do two things. One, file the AOC form along with the reasons why AGM was not conducted. Cut copy paste applicable to MGT 7 as well. Hello. Okay. XBRL is applicable to whom now? A company listed in India and all its Indian subsidiary companies. They have to follow XBRL. Next one, company is having paid up capital of 5 crore or above. Next one, company is having turnover of 100 crore or above. All companies which are required to prepare their accounts as per Ind AS. Remember, once XBRL, always XBRL. Few companies are exempted, NBFCs, HFCs, and banking companies and insurance companies are exempted from filing XBRL format. Hello. Macha, internal auditor, important. We can expect a question. I'll tell you the places where they'll ask you question. That is where they will ask. Promise on you. Now, people, criteria people, for whom and all internal audit is applicable. First, what is our acronym? Deepika Padukone works only in L&T. Correct? Huh? Because Deepika Padukone works in L&T. Why? Because L&T is a public company. Deepika Padukone does not work in a private company. What do you mean by that? Limits people. For whom is it applicable people? First of all, listed company applicable. Huh? Applicable. For a public company having deposits. Deepika Padukone, L&T. Deposits people. How much down? 25 crore multiplied by 2, 50 crore multiplied by 2, 100 crore multiplied by 2, 200 crore. Yes, sir. This is for a public company. For a private company, Deepika Padukone won't go only, no. So remember, only L&T condition will be there for a private company. Hello, Pakana. Okay, in that one will be a landmine. What is that? Everything is 25 crore or more, 50 crore or more. But L people, low no, remember that people, that is exceeding 100 crore. Hello, Pakana. Yes, sir. Okay. So, sir, next one, sir. Now, when should I see whether this condition is satisfied as per the preceding financial year? Now, people, we need to focus on the star marks. What is that? They are telling you wherever there are two stars, one, two, three, one, two, three. What is this? In case of deposits and in case of loans, in case of deposits, in case of loans, if at all in the previous year, even for one single day, if you guys have touched the limits, meaning in the previous year, in the month of April, you touched the loan of 101 crore. By the end of the year, it became 90 crore, but still internal audit is applicable to you. Wherever the two stars are there. Rest of it, you need to check as on the last day of the previous financial year. But only these three conditions, you have to check even one single day in the preceding financial year. Clear on? Who can be an internal auditor? Chartered accountant, cost accountant. You excluded me? CS can be a. Can he be a? Remember, people. Yes, possible. Or directly you can't write any other professional. Okay. Remember, that is one other question. Another question I'm telling you. An internal auditor, should he be a consultant or should he be an employee? Employee for sure, no. Remember, internal auditor can be a consultant as well. Clear? You need not be a full-time employee of the company. Hello. Clear? Manisil, are you? Okay. Now, people, who can be a internal auditor? Da? Should it be an individual or a company? LLP. Firm, partnership firm. Can I appoint partnership firm as a partnership firm? Which may be individual. Clear? These are the maximum things that they can question you. Clear? Hello. Okay. Done. Yes, sir. Hello. They asked this in September. Yeah, I tell you, Noda. September ade, January no ade, May no ade. Every attempt I tell this only. This is where they will ask. That day, that student would have said, "Okay, sir keeps telling." Huh? You ignore, and they ignore you, and you will feel bad for that. Yes or no? Okay. If you don't mind, we'll take one coffee break. Huh? You all can become teachers now. Who said no? But don't become law teachers. That's all. Why? Where should I go? ಮತ್ತೆ ಆಗೋಣ ಆಮೇಲೆ. Huh? I don't take only. Huh? You never know. Life is a miracle. FEMA. FMC. ಮಾಡಕ್ಕೇನಿಲ್ಲ. I can say I'll try. That I can definitely say. If you ask me, probably sometime down the line, I definitely would want to try. But today, again, I have to reinvent myself. I have to deliver the way that subject is required to deliver. I might have not been used to deliver a practical subject now. I'm confident with the way the subject will be delivered, but it is all about reinventing myself. That is a pain. That is not worth at this point of time. Again, I'll have to sit, notes, charts, yak ಬೇಕು. Audit and auditors, money. Okay, people, chapter 10, audit and auditors. Your chapter. Section 139. How to appoint an auditor. There are two types of auditors. First auditor hai, first auditors. First auditors who will appoint depend upon the type of company. If you are a government company, then people after incorporation within 60 days, Comptroller and Auditor General of India will appoint the first auditors. What if they fail? Then within next 30 days, the board will appoint. What if even they fail? Within next 60 days, the shareholders should appoint. If they fail, die. Yes, sir. Even 3 people will fail, Ada. So people, they're telling you, first is CAG. CAG shall appoint within 60 days. Next is 30 days. Next is another 60 days. CAG, directors, shareholders. So any other company people within 30 days of incorporation, the directors will appoint the first auditors. If they do not appoint people, then the members will appoint within the next 90 days. At the first annual general meeting, now I'm speaking about the subsequent auditors. The first appointed auditors will always hold the position up to the first AGM. In the first AGM, they will retire. What about the subsequent auditors? The subsequent auditors will be appointed for a period of 5 years. Now, sir, they will be appointed by, if you guys have an audit committee, they will refer you the name. If you do not have an audit committee, the directors only will refer the name, but the appointment will happen by the shareholders. So remember, shareholders will appoint the subsequent auditors. The tenure of these auditors will be from 1st AGM to 6th AGM. And remember, you have to give your consent and you have to give your declaration that the audits are within the limit and I'm not disqualified, debarred, and all of that. You have to give a declaration. Here are, whenever an auditor is appointed, it has to be communicated to ROC in the form ADT1 within 15 days of appointment. If you are a NAFRA covered company, then people NAFRA 1 in 15 days to NAFRA we will file. Clear? Okay. Next one, sir. Tenure or rotation of auditors. Applicability. Rotation of auditors is applicable to whom? First, it is applicable to a listed company. Next one, unlisted public company having a paid up share capital of 10 crore or more. Private company having a paid up share capital of rupees 50 crore or more. And people, what is that? All companies having public borrowing from financial institutions, banks, public deposits of rupees 50 crore or more. So, sir, for these people, rotation of auditors will apply. Now, what do I mean by rotation of auditors? That means, sir, whenever I appoint an auditor, the same person cannot continue forever inside the company because he becomes financially dependent. He will not be able to be unbiased anymore. He will be biased, of course. So what do we expect? We expect you cannot be there forever. If you are an individual, you can be on the firm. That is, you can be as an auditor for a period of 5 years, one term of 5 consecutive years. If at all you are a firm, we can appoint you for a 2 terms of 5 consecutive years each. Sir, whether you are an individual or you are a firm, if you want to be again reappointed, there is a cool off period of 5 years. For individual, after 5, cool off of 5. For firm, after 10, cool off of 5. Sir, next one, sir. A firm with common partners cannot be appointed, that we know. But the common partners at the time of, from the date of appointment, that time if it is not there, that's a loophole. The existing company shall comply with these provisions within 3 years of commencement. That is 1670, not important. Casual vacancy of auditor in case company whose audit a subsequent auditors. In the case of government company, who will appoint? CAG will appoint within 180 days of commencement of the financial year. CAG will appoint every year who the auditor on the government company. In case of company whose audit is done by CAG, if there is any casual vacancy, imagine there can be a death or it can be any other scenario. Within 30 days of casual vacancy, the CAG shall appoint the next auditor. What if CAG fails? Board will appoint. So, in the case of other companies, within 30 days of casual vacancy, the board will appoint. Imagine if it was a death. But, sir, if at all it was due to resignation, auditor left. Now, what they're telling you, board only will appoint, but resignation people, something should be problematic. Now, what they're telling you, if it is due to resignation, if the board appoints within the next 3 months, people, it should be further approved by the shareholders. And such person, whoever is approved, his appointment will be up to the next AGM. Clear? Hello? Okay. Reappointment of retiring auditor. What do you mean by this, sir? A retiring auditor may be reappointed at an AGM. Remember, people, rotation provision is not applicable to everyone. If at all I'm a private company, if I'm having my paid up capital of 30 crore, for example, I told you also the auditor of ArivuPro, it's the same for the last 10 years. Individual only. For the next 20 years, also same only. Now, where did this provision go? Can we reappoint him? Yes, we can reappoint him. Why? We are not coming under the rotation provisions. Hello? Agreed, huh? No, sir, that is what they're telling you. Can the person who is retiring, can he only be reappointed? Yes, provided he is not disqualified. Provided he is not giving his unwillingness, meaning he said, hey, beda pasako. I don't want you guys. If he said, I don't want you anymore, then I cannot reappoint him. Third one, imagine his reappointment is such that we will have to pass a special resolution, or a special resolution is passed that we do not want this auditor. Special notice. Then people, I cannot go ahead with the same person, I cannot reappoint him. The last one, no auditor is appointed or reappointed. Then people, let us imagine all this did not happen. Then whoever is the retiring auditor, the same person will stand to be reappointed. Agreed on? Okay. Next one, sir. Removal or resignation of an auditor by giving a special notice, which we already seen. 115. Shareholders are given a special notice. Now the request has come. The company will intimate it to the auditor as well. hey auditor, we got a request that they want to remove you itself. First people, we will pass a board resolution. Okay, let us remove the auditor. After the board resolution, people, I need to apply to the central government. Dear central government, we have decided to remove our auditor. How will we apply? We will apply in a form ADT2. Within 30 days of board's approval, we need to apply to the CG. Once CG approves people, within next 60 days, we need to pass a special resolution. This has to be the process. First to board, next to CG, next to SR. Is this clear? Hello, Pakana. Sir, resignation. If an auditor wants to resign, you are free to resign, people. The auditor will file a statement in form ADT3. If you are a government company, you will also intimate CAG, company, as well as people, ROC. If you are not, I will just intimate ROC and the company that, sir, I want to resign from your company as an auditor. Clear? Remember, in reality, I'm telling you, if there are conflicts between auditor and the company, will it happen? Ayyo, pakka it will happen. Lot of times it will happen. Now, in this case, which method it will come under? Let us imagine if a company is not happy with the auditor, or if the auditor is not happy. Auditor is not happy, he will resign. The company is not happy, what will they do? They'll remove, they'll not remove people. They will intimate the ROC, they will intimate the auditor, sir, let us discontinue, we are not happy with it. Then what will the auditor do? If everything is okay, auditor only will resign. Removal people, here it is clear, simply given in what is that? Some three process. They CG approval, that means something will be there. They will involve you both. Both of you will have to take some time. Neither you want it, neither the company wants it. So both of you will go with an easy method only. That is resignation. Unless what you are fighting for is not something serious. If it's serious, then yes, you will make it an issue. If it's difference of opinion, that is, you are expecting something to be filed by a particular day. They are not doing it by that time. I'm a company. I'm expecting you to reply to me, respond to me. You are not responding. There's differences of opinion. I'm not saying there is fraud. Now, in this case, they are telling you, they will intimate you. You will only resign. Removal and all, very rare.
But resigning is not.
So now the thing is, that's what.
Like it is defaming kind of opinion.
Ah,
It's like defaming kind of auditor is resigning. Something bad to the company.
resigning the, I'll tell you the predefined letter also. Due to my personal commitments. That's a resignation reason. Of course, people, if at all the auditor feels, no, I should not leave, he will not leave. But I'm telling you, imagine there are differences of opinion. Yes, sir. Okay. Next one, sir. Section 141, eligibility, qualification, disqualification of auditors. Okay, important. Let us go to eligibility, disqualification. This one now 140. Auditor acts in a fraudulent manner. What will happen? CG applies to the tribunal. Sir, this auditor is there now. Ekdam fraud. Now what will CG do? Central government will file the tribunal. Tribunal people, after giving an opportunity of giving order, the tribunal will pass an order to remove that auditor of that company. Whoever is removed on the grounds of fraud, that person will not be reappointed in any company for a period of 5 years. Now CG only will appoint someone else in that particular auditor's place. That is a fraud. Clear? Eligibility qualification of an auditor. Who can be? He should be a accountant and a chartered accountant. A firm where majority of partners practicing in India are qualified as CA may be appointed by its firm name to be the auditor of a company. So partnership possible. LLP possible. Company not possible. So disqualification, a body corporate other than LLP is disqualified. Second one, an officer or employee of the company cannot be appointed as a statutory auditor, not allowed. Next one, a person who is a partner or who is in employment of an officer or employee of a company. What do I mean by that? I am being proposed to be appointed as an auditor of Reliance. Let us imagine, sir, in this Reliance, there is an officer, or in this Reliance, there is an employee of Reliance or officer of Reliance. Now, these people, they may have two things. What? They may have one company, or they may have some partnership. In this partnership firm, if I am a partner, or in this company, if I am in the employment, then this employee, this partner cannot be an auditor in Reliance. Clear? Huh? Hello? A person who is or his relative or partner, me, my relative, my partner, that means what? In a partnership firm, if this person is being appointed as an auditor, these two people also should not have any interest. Imagine if this person's relative is, holding more shares than allowed. Even the partners also cannot be appointed as an auditors. Remember that. In a partnership firm, let us imagine if our partner's wife is holding 1,50,000 shares face value. The person, husband is disqualified. What about husband's partners? What about them? They are also disqualified. Remember, clear? Okay. A person who or his relative or a partner is holding any security of interest in the company or its subsidiary or its holding associate or subsidiary of such holding company. What and all they're telling you? You cannot hold securities in company, in company's associate company, in company's subsidiary company, in company's holding company, and company's subsidiary company in which it is also a subsidiary. Meaning, there is a holding company. To this company, I am a subsidiary company. There is one more subsidiary company for this holding company. My person should not be a shareholder in this company also. Fellow subsidiary or the sister concerns, you call it as, or group companies. So remember, I generally call this as cash. My company, you cannot be a shareholder. Associate company, you cannot be a shareholder. Subsidiary, holding, subsidiary of the holding, where this company is also a subsidiary. Again, I'm repeating, we are subsidiary company. We have a holding company. That holding company has one more subsidiary company. My person, whoever is being appointed or proposed to be appointed as a director, you cannot be a shareholder here, nor here. Clear? Hello? But sir, there is one exception in SIMS. What is that? Provided that the relative may hold security or interest in the company of face value not exceeding 1 lakh rupees. Interpretation of statutes, this 1 lakh here, you have to take it as not per relative, it is all the relatives put together. Here, hello. Next one. A person who is indebted to the company, subsidiary, holding, associate, or subsidiary, so cashes of holding company in excess of rupees 5 lakh, up to 5 lakh, okay, beyond 5 lakh, not possible. Has given any guarantee, provided security in correction with indebtedness of any third person. I have not taken loan, someone else has taken, but the proposed auditor has given guarantee to that loan. Now we are planning to appoint one person as an auditor. He has given a guarantee that that person, if he does not pay money, I will pay the money. So, sir, in whichever company I've given a guarantee, of course, you cannot be an auditor of that company only because you will be favorable, biased. That's what they're telling you. Has given a guarantee of providing any security connection with indebtedness or some other party or it's something in excess of rupees 1 lakh. Remember, people, securities up to 1 lakh, okay. Debtor beyond 5 lakh, not okay. So up to 5 lakh, okay. Guarantee up to 1 lakh. Okay. Remember, people, limits are very important. Exam, you can expect a question in disqualification. Important. Next one. A person or a firm which has business relationship, but certain things are exempted. What in a business relationship? If I'm getting some money from them, I'll definitely be biased to know. But they're telling you this business relationship does not include two things. The first one, people, whatever is entered in the ordinary course of business, that means what? I am a auditor of Geo. My SIM card is Geo. Business relationship only, no. They're telling you it's ordinary course of business. Whatever is the plan charged for outsiders should be the same for me also. Then allowed. Arm's length price. Whatever you charge an outsider, charge the same thing for the auditor also. No special treatment. Then yes, exempted. Second one, sir. Whatever I'm appointed for, why did you hire me? For the professional services, no. Then that I have to give, no. That is exempted. So, excluding these two, any other way, if I'm related to you, then I have disqualified. I cannot be appointed as an auditor. Hello?
Yes, sir.
Next one. A person whose relative is a director or is in the employment of a company or as a director or KMP. What is it, sir? A person whose relative is a director. What do I mean by that? Let us imagine, sir, there is Mukesh Ambani. Mukesh Ambani is a director of Reliance Industries. A person whose relative is a director, say for example, Mukesh Ambani's son wants to become the auditor of Reliance Industries. They're telling you not possible. Why? Your relative is a director of Reliance. So next up, or is in the employment of the company as a director or KMP. The same thing, no. A person whose relative is a director or is in the employment of the company as a director or KMP. Even KMP also, sir, I cannot be
Auditor.
auditor. Correct? Huh?
Yes, sir.
That is correct. Next one, sir. If such person or partner is at the date of such appointment, what is the maximum number of audit assignments one person can take? 20. In the 20, certain companies are not included. Which are there? Dormento, OPCA, smaller private company having a paid up share capital of 100 crore, less than 100 crore. People, one thing remember, you guys may get confused between this and CFS. Here it's not a startup. 99% of the people will remember the private company here as startup. High chances of you going wrong here. Remember. Hello? Okay. Now, as per 140, there is a limit of 20. A person who has been convicted by a court of an offence involving fraud and a period of 10 years has not yet elapsed from the date of such conviction. So, if you are arrested, people, 10 years cool off period, people, you cannot be considered as an auditor. Next one, a person who directly or indirectly renders any services given under section 144. What is given in 144? 144 says, I cannot give certain services to the company. Example, investment banking services, investment advisory services, management information system, internal, what is the internal auditor? Okay, accounting and bookkeeping services, internal audit. So all these services an auditor cannot give. Internal audit, implementation of financial information system, actuarial services. Actuarial is nothing but risk assessments, all of that. Investment advisory services. What is investment advisory? I'll help you manage your cash flow. Sir, you have this much, no, invest this much in gold, invest this much in silver, invest this much in, say, shares. Investment banking services. What is investment banking? IPO, FPO, merger amalgamations. You want them. They will act as agents. Merchant bankers, you call them. Your JP Morgan, your Goldman Sachs, Northern Trust, rendering of outsourced financial services, payment of your payroll, GSTs. I cannot manage any of it. Management services, report giving, consulting, not possible. Any other kind of services as may be prescribed. As of now, nothing. So remember, I'm not telling you people, I'm not saying CA cannot give these services. I'm telling people that a auditor appointed to the company, that person only cannot give these services. It is like you writing your exam and you only correcting it. In practical life, they only prepare balance sheet. Says who? Tell me your name. Tell me. Shall tell na? Illa sir. No sir. Correct no. In reality, maybe I don't know. You guys are telling. Yes. Yes, Sam. Yes. That's how it is. Yes, sir. But technically, how it should happen? The company should have prepared the accounts. The auditor should have to come and give his opinion. Reality of that's how it happens. No, 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 no. Yeah. Okay. Vaisak is like name yak sir. No, correct ಮಾಡ್ತೀವಿ. We manage. Remuneration of auditors is always fixed in the general meeting. In case of first auditor, remuneration will be fixed by the board. They can ask you this question. Remember, correct? The remuneration mentioned aforesaid shall include the expenses, if, in addition, include the expenses, if any, incurred by the auditor in connection with the audit of the company and any facility extended to him. But the remuneration does not include any remuneration paid to him for any other services rendered by him at the request of the company. If at all we are taking any other services from him that does not included in this, he can get paid more. Clear? Okay, powers and duties of auditors. What are the powers and duties? Done. What is the powers and duties? It is your duty to go and audit everything, check everything, true and fair view. Duty, ask for every proper record, get the sufficient information. Without getting that, don't sign. Make sure the personal expenses are not added for the business expenses. Deposits are categorized properly. Directors are not disqualified. Sufficient books of accounts are maintained. Internal financial controls are present. And from here, write your BCom answer, something. Yes, sir. But what is the important point here? Audit of a government company. In case of government company, what will happen, people? A person would have audited. The auditor will give his report to CAG. The CAG can do three things here. First one, he can conduct something called as supplementary audit. He can also conduct something called as test audit. What do you mean by that? Test audit means, people, whatever you have audited, from that only I will also cross check. If at all it is going good, good. If it is not going good, now CAG thinks, Macha, you guys have screwed up this company. Now what will CAG do? CAG may conduct one more round of audit that is only called as supplementary audit. So on all of these reports, CAG will pass his comments, which will also be circulated to the shareholders of the company. So in the case of government company, three things can happen. What is that? What is called? Supplement audit, test audit, comment on the reports, which will be circulated to the members. Remember that and go. Next one, reporting of fraud. How will you report? As soon as possible, within 2 days of the auditor getting to know that there has been a fraud. What will you do? You need to first check what is the amount of fraud. Is it less than 1 crore or is it 1 crore or more? If it is 1 crore or more, then what will you do? You will, within 2 days of the knowledge of fraud, you will clearly write a letter to the audit committee, or to the board of directors. You will say, sir, this is what I have come across. What? You will write, sir, your company has done this fraud. You guys have to please give me an opinion within 45 days. Now I'll wait for 45 days. If they give me a reply, people, within 15 days of the reply, my report plus their reply, we will club it and we will send it to someone called as central government. That is nothing but, people, secretary of MCA. We will send it in an email and a sealed envelope in the format ADT4. Yes, sir, if this is 1 crore or more, both less than 1 crore, so 99.99. What I will do, within 2 days of knowledge of the fraud, I will intimate to the company. The company, in my report, I will give three details. What are the three details? Parties involved in the fraud, nature of the fraud, amount of the fraud. I'll give three details: nature, amount, parties. For this, the directors will give reply. Now go back and say directors report 143 subsection 12. In the directors report, directors have to give a reply to this. So in the current year's audit, the auditor has pointed out that this is the parties involved in fraud, amount, nature, and what is the corrective action you guys have taken. You have to give it as a fourth reply. Hello, here are this process is same for cost and secretarial audit as well. Auditors to sign audit report 145. The person appointed as an auditor shall sign the auditor's report. In case of a person who is a CA will sign. The qualification, observation, comments, if any, shall be read in the meeting. Remember, 145, 146, which we already seen. Punishment for contravention, punishment of. Okay, 148, sir. Central government to specify audit of items of cost in respect of certain companies. Now, what is this, sir? It's nothing but people, your cost audit. Now, sir, cost audit. Okay, you see this overview. This is good. Okay, cost record, sir. Cost record people. It is mandatory for the companies engaged in production or supply of goods and services as prescribed. Example, telecom, electricity, your steel, pharmaceutical, drugs, medicine, arms and ammunition, all of them will come under the cost records. Fertilizers, all these companies will come under cost records. Provided, what is the criteria to be satisfied? Turnover of 35 crores. They will, or more. Now, sir, for them people, cost records will be applicable. Now, go back and check your books of accounts definition. If you are covered here, then people, I'll have to maintain books of accounts in which cost records also becomes mandatory. If I'm not covered here in books of accounts, the items of cost will not come. Okay, sir. Now, books of accounts, I have to maintain cost records. Should it also be audited? Answer is yes. Now, who will audit it? Allah, 1 second. A qualified cost auditor will be appointed as a cost auditor. Now, the question is two things. Who will appoint the cost auditor? Appointment will be done by board of directors. Remuneration will be ratified by the shareholders. Remember, appointment will be done by board of directors. Do not get confused. Internal auditor appointment will be done by board only. Shareholders not required. Same thing. Cost auditor appointment is done by board of directors only. Shareholders not required. Remuneration also will be fixed by them only. It will be ratified, approved by the shareholders. Cost auditor. If they're asking you, remember this question. Hello. If company has audit committee, then they will recommend to the board and remuneration shall be up. See the word. Approve. That means who fixed it? Directors will first fix it. It will be approved later by the members. If company does not have committee, board shall appoint and remuneration shall be fixed by board and approved by members. According to me, important. Remember. Next one, sir. Now we saw who is the cost auditor. Now who shall be the cost auditor? We saw, sir. Now cost audit reporter. The cost auditor shall submit his report people to the board of directors within 30 days of receipt. A copy of CAR, that is in the XBRL form, will be forwarded to the ROC applicable to company for financial year commencing from 2014. By default for them, the format is CR84 XBRL format only. And we would have written one more thing also. What is that? In the case of certain companies, this particular thing is not applicable. SME, MSME. Within how many days will I have to submit the cost auditor, the cost audit report? Within 180 days of closure of financial year. Every cost auditor appointed as such shall continue in such capacity till the expiry of 180 days from the closure of financial year. That is his tenure, or till he submits the cost audit report for the financial year for which he has been appointed. Can a cost auditor be removed? Yes, sir. Which approval? Shareholders, government, and board approval also required. Board approval. Huh? They whoever appointed, they only can remove. No one approval required. Board approval more than sufficient. Not even central government's approval. Remember. Hello. CRA 2 to be filed with central government for intimating appointment of another cost auditor and shall enclose the relevant board resolution of appointment. Okay. And okay, more or less the same thing. So that's this auditor's part. Uh, what is that? Have you left anything else, Ada? Huh? Have you left anything else? Fair enough. Or did we discuss? I mean, did anything you guys want me to discuss? I feel we have covered most of it. Anything we have left? A1, huh? Forms of cost auditor, CRA 1 to 4. Hey, one more thing, that the financial year definition now. Can companies have different financial years done? Remember, we just have to file. If I want to follow a different financial year, to make sure I follow my consolidated financial statements because of a holding company abroad, subsidiary company abroad, to meet with it, I can follow a different financial year. I just have to file an approval with the central government. If they approve people, yes, I can follow a different financial year. That is one thing, remember, important. CRA 1, the manner in which cost records is to be maintained, nothing but like books of accounts of format is CRA 1. CRA 2 for intimation of appointment, or even if there is a new auditor appointed in the place of a removed auditor, CRA 2. CRA 3 is the format of cost audit report. CRA 4, filing of cost audit report with central government. Yes, sir. Okay. Audit of accounts of branch office. Okay, who will take up the audit of branch office of company? If it is in India, same auditor can do it, or you appoint a different auditor. Example, if there is now Bangalore office, there is Koramangala head office. There is a branch office in Chennai. auditor of Koramangala office can only go and do the audit of Chennai office also. Or appoint one more auditor here. Send him to, ask him to send summarized return. And this auditor will add it in his records. The first one. Imagine if your branch is outside India. Now, who will audit the branch of its outside India? First one, it will be an accountant there, or our auditor, or the third person, any other professionally qualified person as per your jurisdiction. They will audit our records. Example, CPA, US, ACCA, they will audit, send it back. If it is allowed as per your jurisdiction. Clear? And remember, if I'm a listed company, on my company's website, I will have to post my company's financial statements, CFS, also my subsidiary company's audited financial statements. What if, according to the country, my subsidiary company is in, say, Mauritius? In that country, audit is not required. Then I can take a declaration. This company is set up in a country where audit is not required. I can upload unaudited financial statements itself. Clear? In the languages, in any other language, I have to file a certified translated copy in English. Clear? That is what. Knowing what is too much with regards to materials is also clarity in life. No, I'll only give one more chart. So, put it, sir. Yellow money, it will be there. You give. Tomorrow if I want, I'll use it. So at times information also will become more. That also you guys should know. Yes. Full year I'll read in one book. Now because my friend is reading in that, I'll also read that book on this. I'll come. Again I'll come. Companies incorporated outside India. Now we'll do. Yes. That's one. Idu, yenadu. Ambition. Foreign company. I want to go and teach in Dubai. We have students, but that doesn't mean I'm seeing Dubai, no. We can, because same syllabus we can go and teach. Lot of CA students are there. There are CA academies and all. I don't know if you guys know it. Go and open in Dubai. No. The students who are Indians, they do CA there and they take up the exams here. And it's correct. Yes. And that, yes. One attempt, go and write there. You never know. Look at him. Sir, first I should fail here. No? There are all these places that teach ACCA. Machan, trust me. If you guys want to teach, don't teach Indian courses. Teach international courses. Illada, you teach, it's okay. Am I a CA? Then I'm not bye. You have to manage and teach. If it's your subject matter expert, see, I'll tell you, how does the world work? Entry point is you should be a professional and you manage whatever you want. As long as you are able to make sense, yes. Sandesh sir taught ACCA. Yes. So that is nothing like that because the subject is same, no? So teach ACCA. Why I tell you? Macha, one subject, one course, accepted in 180 countries. I'll tell you, Maldives, huge demand for ACCA teaching. She's like, I'll go to Maldives, you go to Dubai. He'll CA, who will write CA? So do that. See, moving on to do. Yes, you should. Once you clear CA, you have so many paper exemptions. Then write. If I were you, I will write. Vaishak is like, sir, first tax class in the evening. We'll attend that. Amel high ambitions. You know, Vaishak? Vaishak is like, that's the only mistake I did in my life. What? Telling him. Beka ಕೇಳಿದ್ರು ಅವರು ಅದೇನಾ? Now you are not doing it, huh? He did it because of Shia. Complicated people. But Vaishak is dedicated. No, I find him serious, dedicated. You know? Oh, then, no, sir. For myself, you're dedicated. Hey, count रहे हो? टीचर बोल रहा है तू गुड, वो बोल रहा है मैं बैड. क्या रे तो? देवरू नीनु. It means any company. What are you doing? Oh, sorry. Foreign company. Sorry. Companies incorporated outside India. So, what is a company incorporated outside India, people? A company which is incorporated outside India. First one has a place of business in India. Second one, third one conducts the business activity in India. All three there. Any Allah, all three there. Then you are considered as a foreign company. If not, we call you as company incorporated outside India. If you are foreign company, rules applicable. If not foreign company, rules is not applicable. So a company which is incorporated outside India, you have a place of business in India. That is, it can be directly physical form or through an agent. That is, for example, now whenever you guys want to travel, Emirates, now you guys will book tickets through Go IB Make My Trip. Now they are agents. Or, sir, Emirates website is directly operational in India. Okay, electronic mode. If you are present through an agent or through physical or through electronic mode, then I am telling you, you are qualified as a foreign company. Yes, remember, conduct place of business in India. Two offices specifically. There is a what do you say? A section which says if you have a share registration office, share registration and transfer office, this company, I mean, this office is considered as what people, a company is having place of business in India. Meaning a company is incorporated outside India. Their share transfer request is taken care in India because probably the labor works out good here, economical. Now, in that case, what will happen? They're telling you people, it will be considered as if you have a place of presence in India. Clear? They will ask you question on that point only. Remember and go. Okay. Now, sir, I got to know. Now I'm a foreign company. Now, section 379, foreign company as per 242. What does it say? If 50% or more of paid up share capital, whether it can be equity, preference, partly preference, is held by one or more Indian citizens or body corporates or citizens and body corporates, such a foreign company shall be treated as if it's like an Indian company. What do I mean by that? Not only this chapter, many more provisions will apply to them. What am I trying to tell? Let us imagine there is Amazon outside India. Now, Amazon has a place of business in India. It's called as a foreign company. Now, if in Amazon, 50% of capital is held by Indians, they're telling you for Amazon, not only this chapter, not only this, more chapters can also be applied on this foreign company. Understood? Okay. Next one. What if it is less than, sir? Then people, this particular chapter alone will apply. Of course, when I say this particular chapter, in this chapter only there is one section which says more sections are applicable. Which one all is applicable? By default, you only know of few. Which one? Dividend. ಒಂದು ಇಲ್ಲ. Charges. Just now we saw one section CSR and annual return is applicable. Annual return, all of this is applicable. CSR also we saw noda. Annual return, CSR, charges, inspection, inquiry, investigation done by ROC. All these provisions are applicable to this company. Hello. Okay, next one. Section 388. Documents to be delivered to ROC by a foreign company. Important. I'll tell you where they'll ask. You have to first to file charter documents. If it is not in English, then translate. Now, what is this, people? Whenever a foreign company comes and sets up in India, imagine a branch office. A XYZ company is from foreign. XYZ INC. China. Aitu guru. Now, somehow it will not feel like foreign. Foreign means yes, sir. Okay. So XYZ company is registered in America. Now, people, they set up one subsidiary company in India. Now, tell me, is this considered as foreign company or not? XYZ is incorporated outside India. They set up an Indian subsidiary in India. Is it a foreign company or not? Arnav, the entire class had answered wrong. Da. You helped them. Okay. Now, people, correct. Da. First, you say Indian subsidiary means. Remember, people, if it's a subsidiary company, that means you're setting up an office, a company in India. That means it is a registered company as per Indian Act. It is not a foreign company. It is an Indian company. Sir, what type of company? In EGM provision, you saw company outside, wholly owned subsidiary in India. Google India, Adobe India, Accenture India, Microsoft India, everything is this only. Do not write them as foreign companies, I lit you. They are Indian companies owned by foreign. That's all. Now, once they come and set up a branch office, branch. Now, people, they are telling you any example. I think I've given you know Citibank. It's a foreign company. Wells Fargo is a foreign company. What is Wells Fargo? It's a bank. Go and open account. We'll see. Why open? Oh, go da. Then it's a bank, no. Limited. Only for that area they will give. Now, people. Yes, what you said is right. Limited, they will be doing only limited actions. Not everything they can do. They are getting their work done here. In Trump and sneezes, 100 people are losing the job. Why? Because of that only dependency. Yes, sir. Hey, I just got to know Trump age. Do you guys know what is Trump's age? Trump's age. 87. 87. In that age, Anna is shaking the world every day. I don't know whether he's shaking the world or not. My portfolio is shaking. Anna, Yeradina, Supirana, I exiting profits. Simply, you know, they pay Katia lots of I always think he is not related to me, but my finances are getting hit by him. Such unfortunate world. Yes, I should see his wife. My wife will hit me if I see his wife. Yen and all you guys will give. Okay, charter documents. I need to give the charter documents of my principal company, foreign company. Address of my principal office, foreign office. List of directors and secretary and their details. The foreign companies. Name and address of authorized person in India. Acha CSR committee. Resident in India. Remember, if you give notice to him, it is like giving it to the foreign company only. One section covered. If you want to give us court summon, some notice, something, if you give it to him, it is like giving it to the foreign company only. Address of office of company in India. Where are you establishing here? Particulars of previous opening and closing, if any, if you have come and gone in the past. Declaration that the director or authorized representative are not debarred from formation of company or management of company. MCQ. They have asked the following people if they are debarred. The company cannot start a foreign company in India. In MCQ options they have given. Director, authorized representative, secretary. Secretary, director. So they have given you permutations. Remember, because secretary is here, in exam, you will not know where exactly the debar thing will come. So even if secretary is debarred, it will not affect anything. You can still form a foreign company's branch office in India. It will not affect you. Just that director should not be disqualified. Authorized representative in India should not be disqualified. Possible exam question, remember. Approval from RBI and FEMA guidelines. FEMA Noda, of course, it is coming from outside. I need to get RBI approval. When and what to file. All this information will be filed in form FC1 within 30 days of establishing a place of business in India. Any changes in the information filed, you have filed now. Any changes, people, I need to again file it within 30 days in form FC2 from the date of alteration. Where will we file all of this? To ROC. Which area? New Delhi. Wherever you are setting up, the jurisdiction will be New Delhi only. Clear? Okay, next one. Accounts of foreign companies. Every foreign company within 6 months of closure of financial year of foreign company, if at all there is need, ROC may extend by 3 months. I need to file with the registrar what and all. Balance sheet, P&L account of its Indian operation in accordance with Schedule 3. And I'll have to, of course, follow Chapter 9. Consolidated financial statements of parent company also have to file. A list of all places of business established by some foreign company in India. I'm there in Chennai, I'm there in Pune, I'm there in Delhi, I'm there in Tamil Nadu somewhere. I'm telling I'm present in all these places. Statement of related party transactions. Have you done, if any? Repatriation of profits. Repatriation. We have earned. Have you taken back any money this year? Next one, transfer of funds. Capital. Have you taken back any money? Plus accounts of such foreign companies shall be audited by a Indian CA. Ababa, lottery. Okay. Sections or provisions applicable to a foreign company in addition to this chapter. What and all applies? As per section 384, debentures applies, annual returns apply, FC4 to be filed within 60 days from the end of the financial year. Section 135 CSR, books of accounts, registration of charges, inspection, inquiry, and investigation. ROC. In general, matters to be stated in prospectus. We saw no, sorry, we will see. There will be foreign companies can raise money from Indian market. They can issue prospectus. Now there, whatever we have seen with regards to the prospectus, those provisions will apply. Which one? Criminal liability, civil liability, class action suits will apply. Hello, sir, and winding up. However, we wind up, they will also wind up in the same way. Hello. Display of name of foreign company 382. Three things, remember, people. Section 382. What does it say? There are three details, people. One is called name. Next one is called as people from which country you are from. Third one, people, what is the liability of your shareholders? Again, I repeat, what is the name of your foreign company? From which company you are from, basically registration. Third one is, people, what is your liability, unlimited or limited arm? These three details should be given in three places. Where? So, foreign company has come to India, Citibank. These three details has to be given by Citibank, where and all. First one, outside every office, displayed in the board. Second place, people, wherever your letterheads, invoices, bill heads, official documents, in all the places put it. Third one, if you are going for an IPO, prospectus, put it. Hello? Yes, sir? Okay, done. Service on foreign company. I told you, if at all you want to give any notice to foreign company, give it to the person, whoever you have given in that section 380, authorized representative. Give it to him. It is like giving it to the foreign company only. Sir, what if I did not give? I came and established my business, but I did not intimate ROC. What is the effects of that? I the meditation, huh? Now tell. Hey, if at all I set up my business in India, I have not intimated ROC. What will happen? What is the consequence? Correct. Similar to partnership, you can't sue, no claim, no counter claim, no set off. They can file a case on you. You can't file a case on them. What do I mean by that? Imagine the foreign company in India. They have not registered. They have not intimated ROC. That means if you have entered into any contract with an Indian company, let us imagine, if they have not made the payment, we will not take up your cases. But can they file a case on you? Answer is yes. But sir, this continues till when? Until you get registered. So subsequently you can get registered and then file a case. Allowed. Huh.
Just employment in India. They are just taking work in India. They're just,
Wells Fargo. Place of business only, no. Place of business only.
even if they're just giving jobs here, it will be considered.
Yes, yes. Uh, Company's failure to comply with the provisions. Any failure by a company to comply with provisions shall not affect the validity of any contract, dealing, transaction entered into by the company or its liabilities. See, just because you are not registered, that contracts will not come to an end. It will continue to be, but or its liability to be sued in respect thereof. Someone can file a case on you. However, the company shall not be entitled to bring any suit, claim any set off, make any counterclaim, or any legal proceedings in respect of such contract. Until when? Until the company complies with the provision. Important exam point of view, remember, they can ask you. Clear? Hello? We had seen. Idea, we have seen the, while I'm doing section 41 only, I told you. Ulta is idea. Foreign company wants to raise money from Indian market. The first company that did it also is called Standard Chartered Banker. Standard Chartered PLC. So they raised money from Indian market around 2000 odd crores, 2000 or 3000 crores. Now it is no longer effective. That ideas are suspended. Clear? Hello? Okay. In the prospectus, I think this is the last one now. Interpretation, I told you, place of business includes the share transfer or registration office. Remember this. They can ask you that part. Okay. Dating of prospectus and particulars to be contained therein. Prospectus has to be dated, that we know. No person shall issue, circulate, distribute in India any prospectus of a company incorporated or to be incorporated outside India, whether company has or has not established the place of India, unless the prospectus is dated and signed. So if you want to issue prospectus in India, it should be dated and signed, and it has to contain the particulars, what and all, the instrument defining the constitution of the company, chat with this one, certificate of incorporation, MOA, AOA, The enactments under which the company is incorporated. For us, companies Act 2013. Like that, where are you registered under? Which act? Address in India, where the said instruments can be inspected. If anyone wants to inspect all those, let them come and inspect. Give the address where we can find it. The date on which the company, the country in which the company would be or was incorporated, where were you incorporated, whether the company has established a place of business in India. Have you established? State the matters specified under section 26. What is section 26? SCRA, SEBI, anana. Provided that 1, 2, and 3. What is 1, 2, and 3? My constitutional act in which and address in India. This will not apply if at all the foreign company is in existence for more than 3 years. Sorry, for more than 2 years. That is, if a foreign company is not a newly formed, then this basic details and all is not applicable, not required. But if you are a newly formed company, you will have to give all of this. Clear? Sir, no waiver of compliance, meaning what, people? You cannot exempt yourself from any provisions of prospectus. Everything will be applicable to you. No provision is exempted. Form of application for securities to be issued along with prospectus, meaning no person shall issue to any person in India a form of application for securities of company unless the form is issued with a prospectus. Meaning what? Application form is for you to apply. They are saying you cannot just give an application form without giving a prospectus. Both has to be pin and then give. Only application form cannot be given. It has to be given with information. That is prospectus. Exception, if it is shown that the form of application was issued in connection to enter into an underwriting agreement. For underwriters, that is not required. 387 further provides that the provision of section 387 shall not apply to the issue of existing members or debenture holders which are in what is this section 26 also you will see, and even in abridged prospectus also same thing you will see. If at all the you're giving your offer to the existing members, or if it was uniform with the previous one, but more accurate and thing will be 26. So if it is same way, then we saw there 26 one, whatever details we need not have to give. Same thing we are seeing here. Provision as to expert consent and allotment. Expert consent can be given. They are telling where the prospectus includes a statement made by an expert, you can give, provided he has not given. That means what? Generally I can give, but if he has not given his consent, then I cannot give an expert statement. Or he has given his consent, but before the delivery he has withdrawn his consent, then I cannot include an expert statement. Remember all the prospectus related provisions. If the prospectus does not have the effect where an application is made pursuant thereof of rendering all person connected bound by all the provision of section 33 and section 40. What do you mean by that? You have to make an application to stock exchange. Section 33 is what? Abridged prospectus. So you have to also have an abridged prospectus as well. You have to make an application to one of the stock exchange as well. Why? Because your company should get listed. No. Hello. Registration of prospectus. No person shall issue, circulate, distribute any prospectus in India unless before the issue a copy thereof certified by chairperson of the company and two directors of the company as having been approved by resolution of the managing body has been delivered for registration to registrar. Remember, first I have to give my prospectus to the ROC. Same like 26, no? 90 days validity, same thing they are telling you here. Before you issuing prospectus, first get the prospectus signed by your chairperson and two other directors, and first you have to deliver that to the registrar. Before that you cannot issue it. Here to the prospectus we have to give all these things. What is that? Consent to the issue of prospectus, expert statement if it is there, along with the prospectus you have to give his consent form. Copy of contracts of appointment of MD manager, management, managing directors, appointment letter you have to give. Such other material contracts, copy of underwriter agreement, copy of power of attorney, who is eligible to sign. All these details you have to give. IDR is what we saw in 41. Directly go to exemption under this chapter, okay, right? See this, sir. Exemption under this chapter is this chapter. Remember, people, we had a section that the central government has a power to exempt any company from any of these provisions. They had power. So central government used that power. They introduced a new section called 393A. And according to 393A, CG has exempted from the provision of 387 to 392 the following companies, who the foreign companies and the companies, whether incorporated or to be incorporated, that is, they're in the process of incorporation, and whether they have a business place of business in India or not. So whether you're a foreign company or a company which is in the process of getting registered, you both are exempted from 387 to 392 as far as they relate to what? Offering of securities, requirements of prospectus, and all the related matters. So nothing but people, if you are issuing securities and if you are issuing prospectus, who a foreign company or any company which is in the process of registering or registered, whether you have a place of business in India or not, if you guys are going and getting listed in IFSC, that is where I'm giving you a reference of gift cities. So people, we are promoting people. If I say all these are exempted, I want you guys to come and set up your business here so that my country will also prosper. So for any foreign company, if you want to come and issue securities in Gift City, IFSC, for you, these provisions 387 to 392 not applicable. Even for the registration of prospectus also, all these provisions are not applicable, whatever we just saw. Clear? Only with regards to the IFSC, not in any other jurisdiction. Hello? Done? No. Look at this. All matters incidental thereto in the International Financial Services Center set up under the section of SCZ. So it has to be IFSC. Exemption is only for them. Remember and go, they may ask. Clear? Yes, sir. Okay, chalo, let's end up here for today. Tomorrow we'll do the rest of it. Let us try to do as much as possible tomorrow. Clear? Hello. Tomorrow we'll do iOS. Right? iOS is easy, no? You ask me, easiest is iOS. Nothing is there. That's realization. Yes, people. Let's start. Chapter 12, sir. LLP. So the basic things. What is that, sir? What do you mean by an LLP? LLP is nothing but people. It's a type of body corporate which is a hybrid instrument of the company form of business as well as a partnership form of business. There are some advantages that is taken from the partnership. There are some advantages that is taken from the company point of view. So LLP is nothing but an entity which has a certain features of partnership also, a certain features of company also. That's why we call this as always a hybrid instrument. So it's always having both the features. What do I mean by both the features? See, from the partnership, we have taken the advantage of flexibility. Why? Even partnership is governed by partnership deed. This is also governed by LLP deed. However, you guys want to function, you function. Law says nothing about it. Your duties, everything is your wish. Responsibility is your wish. Profit sharing, your wish. Everything is at your discretion. That's why we say you have maximum flexibility. Governed by LLP deed, managed by the partners. Remember here, we will write LLP is always managed by designated partners is what is our assumption. LLP is always managed by all the partners. Designated partners will not manage LLP. Designated partners will just take care of the legal compliances. That is GST filings, IT returns, or your Companies Act filings, financial statements, signing, all of that will be taken care by designated partner. See, each of the partner handles one or the other job. the job handled by the designated partner is legal compliances in addition to running the business. So never think that like a company, in a company who runs the management, we will say directors. Like that, here it is designated partners. It's not like that. All the partners will run the LLP. It's not one designated partner. Is that clear? Yes, sir. And do we have mutual agency, the concept of LLP? Is it there, mutual agency? Yes or no? Remember, one partner can bind the LLP, meaning you go and sign a contract. For that people, the LLP will be liable. But people, one partner cannot make the other partner personally liable. Mutual agency concept means what? One of them acting for all or any of them acting for all. I mean, all of them acting for all. Now, in this case, one partner can bind the entire LLP. That means what? We have three partners. We have brought 1 lakh each. So the total capital of the LLP is 3 lakh. One partner can go and sign on behalf of LLP. That means what? I'm telling you, I'm going and signing on behalf of the LLP. I can maximum bind the LLP up to 3 lakh rupees, not beyond that. Not even 1 rupee beyond that. Is this clear? Sir, what if that contract gets into loss? Will the partners be personally liable? The answer is no. That's the meaning of mutual agency is partially there. One partner can bind the LLP, but one partner cannot bind all the other partners, unlike partnership. I hope that is clear. Yes. Okay. So disadvantages. See, mutual agency. It's deleted in LLP. Partially there. Next one, sir. Unlimited liability. Deleted. It's limited liability. Maximum number of partners in the partnership firm is how much? 50. In LLP, how much? Unlimited. There is no limit at all. Correct, sir. What are the features that we have taken from company perspective, company's characteristics? We have taken the feature of perpetual succession, meaning same like company. If a person dies, the next shareholder will take it over, right? In the same way here also. But remember, this is one of the most important and tricky part. Just like partnership, here also, if a partner dies, their legal representatives will take over the share. But remember, people, they will not be treated at par with the other partners. You will not have a right to involve in the management of the LLP. You cannot take decisions. Very tricky part. 2 times they have asked you. What do I mean by that? Remember, people, whenever there is a partner, if the partner dies, the next legal representative will get his share. That means if we were giving him 20% of profits, we will give him also 20% of profits. That you straight away get. But this person was getting involved in the management, decision taking. That right you will not get. You will just get the right to share the profits. But the right to take part in the decision making, that you will not have. Yes, sir. Same thing. You will not have access for the data, all of that information, all that you will not have. The right same cut copy paste applies to. Imagine there is a partner. The partner transfers his rights to another person, outsider. So there were A, B, C. C transferred his share to an outsider, D. Same thing, cut copy paste. D will not enjoy the same right as C. D cannot take part in the decision making of LLP. Yes, sir. But he will be entitled for all the profits that is there. But he cannot take part in the decision making of LLP. Day-to-day operations you cannot involve. Why? Because people, all of this runs on a mutual trust. Second thing, whether it's there or not, at least to an extent, mutual agency concept is there only, no? One partner can bind the whole of the LLP. That means I should know who is signing on behalf of LLP. That trust I should have on you. Yes, sir. See, I'm not saying you will never enjoy this right. If you guys want, by your LLP deed, you give that right. But by default, you will not enjoy this right. Are you getting this point? Yes. Okay.
Two partners is there in LLP and in some accident they both died. is there any compulsory that legal acts cannot continue the LLP and they should dissolve it?
No, nothing like that. Again, same thing only, perpetual succession. The next legal heirs will have to continue. They will continue.
You can get all the rights.
Yes, no, because there is no one else. So they will get the right. Now, if at all there is only one outsider, imagine everyone else are the partners. You will not be treated at par with them. You will not have that, the same right as other partners. But when everyone dies, I don't have a choice.
One of the legal acts is a partner.
That is possible. Yes, sir. Now, company advantage, limited liability we have taken, no limit on maximum numbers. Same thing here, no limit. You can have any number of partners. You will be also treated as body corporate. Can you tell me what and all is coming under the definition of we have seen also? Body corporate, I think somewhere we saw. What and all is considered as body corporate? Company, foreign company, LLP, foreign LLP. It does not include a sole proprietor, that is sole corporation, cooperative society. Apart from these two, these four are considered as body corporate. Remember and go, important. Now, all these advantages are retained in LLP. Disadvantages, people, there is no flexibility. Companies doesn't have flexibility. That part is from some part has been retained. Like, for example, why do I say the companies do not have flexibility? Every information of yours is sitting in public domain. Now, LLPs also will sit in public domain. Why? Change in partner. You have to intimate to ROC. Change in designated partner, change in address, change in name, financial statements, annual returns. Everything should be filed with ROC. Then where is secrecy? That disadvantage, if you call it a disadvantage, it was there in company, it is there in LLP also. Yes, sir. Sir, why would someone choose LLP over company? Why not? They have their own advantages. As I said, it's more flexible. For example, the easiest thing I'll tell you, let us forget the book. In a company, whether you have profit or losses, you have to mandatorily appoint an auditor. You only, ADT1, mandatory. Your yearly fees can be anywhere between 20,000 to 50,000. It's a cost on the company. Even if it's in a loss-making company, it's a cost. Yes or no? Like that, how many are there? Oh my God, lot of forms are there. Annual return should be signed by who? One director, one CS. If no CS, then PCS. At least it is after turnover. This this one no turnover, no limit. If you're a company, you have to get it certified. Now you tell me whether a CS will simply certify. No, he will also demand. Unnecessary expenses. All these are. Now, how many documents are mandatory? Register of members. Yeah, you take the list. Nothing applicable here. First, simple thing, minutes of the meeting. There is no provision which speaks about that here. AGM, there is nothing here. Then Ian, what is there? Nothing is there. Yes, sir. Who will do exactly? I have only done. I only have an LLP. Yes, then why can't I choose company when I am only using LLP? That means there should be some advantage, no? Then there is advantage. But yes, I mean, there is an LLP. I mean, what I meant to say is that, see, in initial 3 to 4 years, that will make a huge difference. You will be able to save around 50,000-60,000 rupees easily. So, why that additional cost? Agree? No. Next one, investigation by registrar. People, there also, if you remember, inspection, inquiry, investigation. Same provisions will apply here also. Anything happens here also, it is applicable. Apart from this, what and all is there? Common seal. For company also, you may have a common seal. LLP also may have a common seal. And you have a concept called as foreign company. You have a concept called as foreign LLP. Can a foreign person, foreign citizen, can he be a shareholder in can he be a partner in LLP? Is it possible? Foreigner. Foreigner. Possible a foreigner. Possible. Foreigner can be a shareholder. Foreigner can be a partner. Yes, sir. Of course. Subject to the FEMA provisions. You have to look into from where that person is coming from and all. But yes, possible. Foreigner can come and invest. Yes, sir. Apart from that, what else there? It's considered as body corporate. Yes, sir. So these are the advantages.
Small LLP concept is there. What do you mean by small LLP? Adbhutilla, sir. Capital of 25 lakh or more and contribution of 25 lakh or more and turnover of 5 crore. 40 lakh. Yeah, bro. Turnover of 40 lakh. Children provisions only, you guys will mess it up. Yes, sir. So remember, at any given point of time, an investigation can be carried by ROC. Okay. Next one, sir. Partners. Types of partners. Minimum 2 partners. If the number goes below 2, then you are given 6 months time to increase the limit to 2. What if I do not do it? One of the reason for dissolution. Remember, and of course, same thing as section 3A. If possible, try to remember this section, section 6. Yes, sir. Sir, when audit is mandatory for LLP, for now it is not there. For us, it is not there. Don't worry. But turnover and all should exceed turnover, or your contribution should exceed a particular limits, which keeps again changing. 20 lakh, 40 lakh, it keeps changing. Failure to increase number of members. So one is it may lead to dissolution. Next one, people, the continuing partner shall be liable for contracts personally unlimited post that 6 months. 2 partners only can become 2 designated partners. That is also possible. Why, sir? In a company, I mean LLP, there should always be minimum 2 designated partners. Minimum shall be 2. They are authorized to take care of legal compliances. So any liability will be on them. One designated partner should be a resident in India. So that is nothing but people 120 days. When? In the previous year, in the current year. During the financial year or the preceding financial year? During the 120 days during the previous answer no confidence. That I striked off. I shouldn't have striked off. How you guys would have answered? Asli answers would have come then. Sir, what if there are 2 body corporates who are partners in LLP? Imagine one company and one LLP. Together they start one LLP. In that case, who will be a designated partner? Correct. You guys have to nominate. Now you have to nominate one person. It can be a director. You will have to nominate one person. It can be your partner. Now they will be the nominees or authorized representatives who will act as designated partners on your behalf. Yes, sir. Okay. And this is important. Who can become a partner in LLP? Individuals can become. An individual can be an NRI or overseas citizen of India, as well as foreign nationals. 3 people are there here. What do you mean by NRI? A person who is a citizen of India but staying abroad. Overseas citizen of India. Meaning what? A person of Indian origin. Your roots are here. Sundar Pichai. But he has got the citizenship outside India. Now you call such people as overseas citizen of India. As well as foreign nationals. Meaning people belonging to the other countries. Anyone can come and invest. Possible. LLPs possible. Company including foreign company possible. Foreign LLP possible. LLP is incorporated outside India. What is the difference in foreign LLP and LLP incorporated outside India? Both are same, no? Foreign LLP is nothing but company incorporated outside India but has a place of business. This is just having incorporated outside. They don't have a place of business in India. We call them as incorporated outside India. Next one is foreign companies. Cooperative society and corporation show cannot become a partner in a LLP subject to FEMA. Minimum partners, remember it goes small LLP 25 lakh and 40 lakh. Financial year concept important. What is a financial year? Financial year means people in a LLP any day starting from 1st April of any year to the 31st March of subsequent year. The only difference why I said it's important is in its first year of incorporation, if an LLP is incorporated on or before 30th September of any year, then your financial year ends as it is. But if at all your LLP is incorporated after 30th September of any year, then your financial year will end in the subsequent year. What do I mean by that? If an LLP is incorporated on 1st September 26, then my financial year will end as it is. But if a company has incorporated on 1st October 26, my financial year will be 31st March 2028. That is subsequent year. This applies only in the case of first year. Remember and go. Hello. Okay. Designated partner, we saw. Who shall be a designated partner, people? Your incorporation document will be there, no? Which is the incorporation document in the case of LLP? Very good. Proud of all your revisions. Philip, people. There is one thing called as Philip. You have to file a form called as Philip. It specifies who are the designated partners. So such person shall become the designated partner after incorporation. So what if the Philip form states that each of the partner from time to time of LLP is to be designated partner. In that case, every partner shall be a designated partner. Now, what do I mean? Now, imagine there are three partners. The partners, see how many minimum designated partners are required? Two. Now, one partner is saying, or these two partners are saying, hey, why should always we be liable? Because if anything happens, there's liability. Penalty not is on them. They too are telling, hey, why only we too should become. You also become a designated partner. So we can agree that let us all rotate every year. This year we too. Next year me and you. Next year again him and you. So let us rotate it, sir. In that case, people, every person will be considered as a designated partner. Hello. Okay, you have to take prior consent. 30 days you have to appoint. Okay, every designated partner should have a DPIN. DPIN means what, people? Designated partner identification number. See, any liability, people, will be on the designated partner. I am responsible for, I mean, yeah, that only. Any responsible for doing all acts, matters, and things as are required to be done by the LLP in respect of compliance of provisions of this act, including filing of any documents, returns, statements like reports pursuant to the provision of this act, and as may be specified in LLP agreement, and liable to all penalties imposed on LLP for any contravention of those provisions. Everything is not designated partner. Yes, sir. God chosen child. Next one, sir. Important. They may ask you a question. Remember and go. Somehow they have not asked till now. A LLP may appoint a designated partner within 30 days of vacancy arising for any reason. What if one person dies? What if one person leaves? They're telling you, you have to replace it by another person within 30 days. At any given point of time, there should always be two designated partners. Okay. Sir, shall apply in respect of such manner, provided that what if no designated partner is appointed? Sir, we ignored. There is only one person. We have not appointed the next person. Now, in this case, what to do? They're telling you. There is, if at all there is only one designated partner, then people imagine if in your LLP there were four partners, but only one designated partner. You have not appointed the second person. They're telling you in such case, every partner shall be deemed to be a designated partner. Very, very important from my perspective. You guys can pakka expect a question here. Hello. Yes, sir. Punishment for done. Salient features, sir, done. Next, incorporation of LLP. How do we incorporate that? We have to file one form. That form is called as Philip. First, we'll reserve name. We'll look at from that only. Yeah. Okay. First, we reserve something called as name people by filing a form called Run LLP. And once the name is reserved people, what do? We file a form called as Philip. In that, we will give all the details of the LLP, name, designated partner, so capital, office, object,
profit sharing, everything I will try to give in this Philip form. And the major thing there, if they are asking you a question, it will be this. Along with the Philip form, there has to be a statement. What is the statement? Macha, whatever you are telling is correct, fair, accurate. You have not hidden any information. Who has to give these people? Remember, it is us plus any one partner. That means what, sir? There shall be filed along with incorporation states document a statement itself made by advocate of CS, CA, CMA who is engaged in the formation of LLP. We have to give a statement and people it is. Us and anyone who subscribed his name to the incorporation document. That means who has subscribed? Partners. So one partner and one us. That what? All the rules has been complied. We have not done any non-compliance. Any certificate of incorporation will be given within 14 days. Okay, done. Incorporation by register, insert a retainment document and he'll give you certificate of incorporation. Okay, effect of registration, you'll become an artificial person. You can sue, be sued, you can have properties in your name, common seal and all of that. Registered office of LLP, remember, whenever a LLP is registered, same like company. At every given point of time, you should always have a registered office. If at all you are shifting it, that also should be intimated to the ROC. That's all. Name people, cut, copy, paste, whatever you saw in section 13 and section 16. What do I mean by that? If at all at any given point of time, if you want to change your name of the LLP, you're free to do so. Sir, if at all at any given point of time, if my name is identical with any existing trademark or LLP or a company, then people, they will file an application to the central government. Central government people, if they are convinced, then they will pass an order to change my name. If they pass an order, I need to change my name within 3 months. Failure to do it, central government only will allot a new name. Hello, same thing. Yes, same thing. Cut, copy, paste. Yes, sir. But remember, easy one to remember. Wherever possible, remember. What is the section there? 16. What is the section here? Next number only. 17. Yes, sir. Remember and go. Wherever possible, remember. High chances of asking no. If you ask me in this chapter, what and all you are remembering, remember section 6. Chances are there. And section 17. Remember and clear. And designated partner. Partner and their relations. Okay, relation of partners. Same thing, whatever we saw. What? It is all governed by LLP deed. Whatever you write, that will be the relation. Whatever you write as duties, that is the duty. Liability, liability. Cessation of partnership interest. When will a partner cease to be a partner, people? A partner will cease to be a partner when? Whenever he becomes a insolvent, whenever he becomes a unsound mind, whenever he becomes a death. Correct? Okay, see, I've combined this. Now, sir, remember people, whenever there are changes in anything, like imagine there is a partner who changes his name or address. In incorporation document, we have given different name and different address. Now, what if there is a change in that name and address? That telling you, it is the duty of the partner or the designated partner. Whenever there is change in address or a name, I need to inform to the LLP within 15 days. What will the LLP do? LLP will further intimate that to the registrar within 30 days. Sir, in my partners, there are some details. I'm just filing this form for you for your information. I have to intimate. Now, remember, people, not only that, whenever a partner, there is a change in the partner, like, sir, what if I am leaving? I mean, if I'm coming in or if I'm going out, that is also a change. Now, sir, that is also the liability of the LLP. It is your duty. You have to intimate the registrar even about such changes, change in partners, addition or deletion. Deletion can happen how and all. It can happen by insolvency, death, by notice. Sir, there is nothing but transfer or something like that. Now, in this case, what they're expecting me to do, they're telling me wherever a partner ceases to be a partner, he shall receive capital contribution and accumulated profits, whatever he needs to get, we will get, and we need to intimate all of this to the registrar within 30 days. Is this clear, all of you? And remember, sir, if partner believes that LLP shall not forward the details to ROC, he can also directly forward to ROC. Now, ROC shall confirm with LLP and give 15 days to respond. Failure to reply will be deemed as approved. What is that, sir? Let us imagine, people. If a partner has resigned from LLP, but LLP has not communicated to the registrar. Now, the LLP people still carried on the business. They went and they entered into a contract with a third party. Now, this particular transaction, people ended up in a loss. Now, my question is, let us imagine this person resigned on 1st Jan 2026. This contract with the third party was entered on 1st February 2026. So, when his share was being settled, what did the LLP do? They deducted this contract, whatever the losses they incurred. They deducted that loss and they tried to settle his amount. Imagining the total amount he needs to get is 10 lakh, they deducted 5 lakh, whatever is the loss that occurred in this contract. Now, the question is, people, is the LLP right in what they did? Is this partner liable for the third party even after filing his resignation? Because the contract was entered after that. Is the partner liable? Yes or no? Here another meditation. Hey, liable or not, Ada? Why yes? Why no? Why?
So after the resignation, only the
Correct.
contract after resignation.
Correct. So is he liable or not? You guys have to answer it. Hey, nah. So the only question you have to answer with this is he liable or not? My only question is a third party aware that he is not the partner in the LLP? Is he aware? My question to you, is he aware? If the answer is no, sir, I am not aware, then even Brahma, any God also cannot come and save you from liability. You are liable in his eyes. If he thinks you are a partner, you are a partner, done. No, she feels unfair, sir. Correct? No. Yes or no? You feel it is unfair? No. No, people, then that's why they're telling you, you intimate to ROC that you are no longer a partner. Who should intimate, sir? See, technically the LLP should have intimated. They did not intimate. Law has given you also an opportunity, no? If you think the LLP is not going to intimate to ROC, then you intimate.
There is no time limit for the partner to give it to us within 30 days.
Now, see, I have intimated 15 days. They have not taken any steps. See, within 30 days, they have to further intimate. In this 30 days also, they have not intimated. Why take risk? In reality, people, it is a matter of 300 rupees form. Who is losing it? You or LLP? You only, it's a loss. Agreed, no? So, if you think LLP is not further going to intimate to ROC, you intimate. So any of these two things are to be done. What? You directly intimate to third party. I'm not a partner. Or if you cannot, of course, I cannot go and intimate to every person in the world. I'm not a partner. So intimate one person. Who is that? Intimate to ROC. ROC will put it in public domain. Public domain is called as constructive notice. That's all. No. Whoever enters into a contract with LLP, you are assumed to have knowledge about it. Remember and go exam, they can ask you this question. Hello, sir, can any other type of business convert into LLP? Yes, people. Anything can be converted except a listed company. Listed company cannot get converted to LLP. Rest of everyone can get converted. Partnership or private or unlisted public company can do it. How? There are procedures prescribed. In our scenario, we don't have procedures. So just file the prescribed form, you can convert into a LLP possible. Hello. People, a former partner, meaning I was a partner, I transferred my right to someone. Now I am called as a former partner, like a retired partner, or a person entitled to his share in consequence of death or insolvency. Death has happened, so a new person has come in. Of the former partner shall not have any right to interfere in the management of LLP. This is where they'll ask the question. Remember and go. Yes, sir. Registration of changes in partner, whatever we saw, 15 or 30, 30. Extent and limitation, I told you, partner as an agent. People, first of all, tell me that there is a partner. Let us imagine one LLP entered into a contract on 1st August 2025. Subsequently, people, this partner filed his resignation on 1st January 2026. He directly filed with ROC only. Now, people, the contract which he entered on 1st August 25, it ended up in a loss. But on 1st January 26, he has already been out. He's liable now. Sir, we don't want your question also. Answer is this. Who cares what the question is? He's liable now. Remember, people, whatever are the contracts that are entered when you were a partner, for that you continue to be liable even after you leave the LLP and go. What do I mean by that? Imagine people, they have missed writing one creditor's name. After 2 years, that fellow will come and file a case. Now, this fellow has taken all the money, has left. Is he liable? Answer is yes, he is liable. Hello. That is what is given here. Okay, next one, extent of liability. LLP is bound by anything. A partner, in fact, has no authority to act for LLP doing a particular act, and the person knows that he has no authority or does not know or believe him to be a partner. What is this, people? Extent of liability of LLP. What do I mean by that? A LLP is not bound by anything done by a partner in dealing with a person. What is this, people? Let us imagine a LLP is there. The LLP has one partner. This partner has gone and entered into a contract with a third party. He has entered into one contract. Now they are telling you what? The LLP will not be liable for the contract entered by the partner with a third party, it seems. When they're telling you if the LLP is not bound by anything done by a partner in dealing with a person, if a partner in fact has no authority to act. What do I mean by that? We have clearly told no partner can enter into a contract beyond 1 lakh rupees. One person cannot enter into a contract. You have to consult everyone and then only you can take a decision. But this fellow entered into a contract for 3 lakhs. Beyond his power, okay. So they're telling you, if at all the partner is acting beyond his power and the person knows that he has no authority or does not know or believe him to be a partner of the LLP. Meaning what, people? The third party also knew, oh, the partners of this LLP cannot enter into a contract beyond 1 lakh. This third party knew and still he entered into a contract. If both the conditions are satisfied, the LLP will not be liable for this 3 lakh contract. Even if any one condition is not satisfied, LLP will be liable for the 3 lakh contract. What is the question they can ask you in exam? Remember, the third party was not aware of the restriction. The LLP will be liable. Indemnity will come into picture. LLP will have to pay the money to the outsider. The LLP can recover the money from the partner. Right to indemnity. Capital only. LLP also is liable only up to the capital contribution only. Unlimited liability come only in the case of fraud. No other scenario. Which one? A ratification is possible. Yes, that is possible.
Doctrine of consulting notice cannot be.
No.
Deed is a public document. They should be aware.
No. It is not a public document. Because Wherever personal details and all of that will go, no, they'll not make it public. The LLP is liable if a partner of an LLP is liable to any person as a result of wrongful act or omission on his part in the course of business. In class we would have seen an example. What is that? If any partner negligently acts, meaning it is his scope only, but he did a wrongful act. For that, people LLP will be liable. What do I mean by wrongful act? We had seen the example of, I think, strawberry juice. One hand goes off. So it was a duty of one of the partner. Say, for example, wrongful act means what? Let us imagine it is my duty to take care of all the operations of this particular class. Let us imagine. Now, what I will do, there is so much of setup involved, money is involved. So it is my duty to take insurance. I did not take. It's my wrongful act. If any loss is suffered by the company, they are telling you in that case, is the company liable? Yes, I have not done fraud, but it was a duty of your partner. If your partner is liable, your LLP is liable. But later, it is his duty to do it. You can recover it from him. Indemnity is possible. Clear? Shall be method or order? See, a partner is not personally liable, but this section shall not affect the personal liability of a partner for his wrongful act or omission, but a person shall not be personally liable for wrongful action of any other partner or there will be no personal liability. Correct? Okay, next one, people. Partner by holding out. What is my partner by holding out? Estoppel. So let us imagine there are three partners. In front of these three partners, there is one manager of the partner who is telling to the whole world that I'm a partner, I'm a partner. These three partners are not stopping him at all. So to whomsoever this person said I'm a partner in front of them, in all their eyes, people, this person will be considered as a partner. And hence, he is eligible for all the profits of that contract as well as liable for all the losses of that contract. Simple. Next one, unlimited liability in the case of fraud. As I told you, any fraud. That case, people, unlimited liability will pakka be there. What is whistleblowing? There are three partners. All three partners did fraud. One partner went and accepted everything in front of tribunal. So technically they are liable people. Each of the partner is liable for 10 lakh penalty. But one partner went and accepted everything. No. So people, first of all, both will say whistleblowing means what? A person who is going and accepting all the mistakes or who is going and reporting the fraud he knows. So anything, when a person goes and reports a fraud, he knows, sir, in our NLP, full fraud is happening. Even if you're a party to it or if you're not a party to it. Imagine if you are also a party to it. Here, even I was a party to it. Now they are telling you people, we have to give him some advantage. Or Papa, he gave so much of information. So what I will do, people, we will reduce his penalty or even we can waive away his penalty. What do I mean by that? If at all I have to lawfully charge 1 crore rupees from you, I will say, why da 1 crore? You do one thing, you pay some 10 lakhs. You pay 5 lakhs or you do one thing, don't pay at all. Remember that word is important. See here, reduce or waive. Here they can ask a question. Why? Compounding. What is compounding? The LLP going and compromising their mistake. Sir, what is the difference? People, whistleblowing comes out only in the case of fraud. For example, people, when should a LLP file annual return? Beautiful. This is, I appreciate for the depreciation. Meditation. Yeah, you'll go for meditation. 60 days of closure of financial year. Good. People, you have to file annual return within 60 days of closure of financial year. Now we did not file. Now people, we missed it. What we will do? We will only go and say, Sir, registrar, before you getting to know, we are only coming and accepting. We did not file. Please excuse us. Here, did I do fraud? It's a non-compliance.
I getting the difference. So, sir, there I will go and accept my mistake. Sir, I did this. That's called as what? Compounding of offense. Hello? I getting the point, huh? Now remember, in compounding of offense, you did a mistake. As per that section, minimum penalty is 10,000. Maximum penalty is 1 lakh. The authorities cannot reduce the penalty less than 10,000. Not possible. They have to collect 10,000 from you. See, maximum is 1 lakh. They can say, hey, okay, pay 10,000 and leave. But they cannot tell pay 5,000 in compounding. Remember that. Compounding can never be less than the minimum fees that is prescribed in the Act. Fraud, a person who is coming and supporting it with proper evidence, whether it can be a partner, employee, you have cooperated, you have given all the information. Based on the information, if that person even gets convicted, meaning so much of evidence you have given, then people, we can either reduce or waive your penalty. Understood? Huh? I hope you guys are not confused between these two. Confused? Huh? Clear? No? Okay. Now, sir, not only that, what is the whole scope of whistleblower? What is the whole scope? The whole scope of whistleblower people is nothing but whoever is the person who reported, people should not start ill-treating him, removing from his job or harassing him. All that we have to support him. That's why we call it as we have to support him from victimization. No one should harass, demote, suspend, remove the job. That is what is given here. Correct? Huh? Remember and go. Section 31. Hello. Contribution can be monetary, non-monetary. Remember and go. They can ask you this also. In MCQ, here and there they'll drop off a bomb. When we are reading it, we will not understand that. Yes, that's all. Now it will come. Why? I'll tell you. A contribution of a partner may consist of tangible, movable, immovable, intangible, or other benefit to the LLP, including money, promissory note. This is very, very peculiar. You know, because Companies Act does not allow you to take promissory note. As per Companies Act, you have to take cash only. Promissory note is not allowed. Commencement of business, I have to get money, not promissory note. Promissory note is not a money to pay. It's a promise to give money in the future. Yes. Other agreements to contribute cash or property and contracts for services performed. The monetary value of contribution. Okay, done. Remember this and go. This is important. Hello. Financial disclosures, sir. There are two disclosures the LLP should do. Mandatory every year. What is that? What is called? Financial. What is called? Annual return. When do you prepare financial disclosures? When should you file? Should be filed within 6 months, huh? Okay. So tell me, by when should you file financial disclosures? Within 6 months from closure of financial year, no? Remember, people, you prepare the financial statements within 6 months. It's not filing. 30 days will be given. That is not there in our book. Read. What does is there? In the class only, I'm clearly told that also. You would have written extra information now. LLP shall maintain proper books of accounts, correct? Statements of accounts and solvency, nothing but financial statements. Every LLP shall, within a period of 6 months from the end of financial year. See here, what are they telling you? What is this? Is there a difference between preparing and filing? Here you're preparing. I'm not yet filing with registrar. When should I file with registrar? After 6 months, so you will be given 30 days. That is when you will find that 30 days is not there in our syllabus. Hello. Prepare a statement and solvency for the said financial year on the last day in such form as may be prescribed. And here, such a statement shall be signed by the designated partners of the LLP. Every LLP shall file within the prescribed time the statements of accounts and solvency with the registrar every year. See, by such fees as may be prescribed within the prescribed time they have given. That prescribed time is 30 days. That is not there in our syllabus. Clear? Huh? Hello. Okay, next accounting and auditing standards, same NAFRA will apply, nothing will change. Annual return, important go. Every LLP shall file an annual return duly authenticated with the registrar within 60 days of closure of financial year. Inspection of documents kept by the registrar, any person can go and inspect by paying such fees. Penalty for false statements, okay, power of registrar to obtain information. Compounding of offenses done, section 39. As I told you, what is compounding of offenses? You filing an application to a person not below the rank of regional director. They will take up the matter. What do you mean by compounding? Compounding means people nothing but compromising. Sir, I did a mistake. I am only accepting. We should have filed within 6 months. We did not file. We should have maintained these registers. We did not mind. We did not file. We are only coming and accepting the mistake. Please excuse us, sir. Okay, if at all the LLP is satisfied, if the regional director is satisfied, people, he may reduce your penalty from maximum to minimum. Instead of levying 1 lakh, he may say, okay, pay 10,000 and leave, but it can never go less than the minimum penalty. Possible question 39, very, very important. Yes, sir. That is correct. Yes, sir. The people, one more thing. What is that? Uh, uh, what is the maximum times you can go for compounding? Every year I can keep going. In a year I go 5 times. Huh? Can I go or not? Yeah, then it's your class. Every day to go. Hey, what is compounding? Remember, whatever is the offense you guys have compounded today, for the same offense, you cannot again go for the next 3 years. For a different offense, you can go, but for the same offense, you cannot go for the next 3 years. That 3 years is from when? From the day I did the offense, or from the day I did the compounding. From the day of compounding, 3 years will start. Yes, sir. Hello. Remember and go. The section is important. Section 39. Yes, sir. So remember something like this. 3 3s are 9. Correct? 3 can be minimum penalty, 9 can be maximum penalty. This 3 is the years compounding. So it will be minimum or maximum. It can be any amount between that. Yes. Okay. Assignment and transfer of partnership. Macha, very important. This one. The transfer of right pursuant to this section does not by itself entitle the transferee or assignee to participate in the management or conduct of the activities of the LLP or access any information concerning the transaction of LLP. Section 42. Dilka Dadkan. Remember and go. Hello. Conversion to LLP possible. We saw firm can convert, private can convert, public company can convert. Uh, Next to foreign LLP, same as company. Compromise arrangements and amalgamation. Section 60, 61, and 62. What is given in section 60, 61, 62? Section 60 speaks about what? Compromise. What do you mean by compromise? Now let us imagine there is one LLP. The LLP has some creditors. We were not able to repay. LLP says, Macha, we don't have money. What do we do? Creditors say, no, no, we want. We say we don't have money. Then we have to enter into a compromise. What will we do? The LLP will file an application to the tribunal. Sir, we don't have money, sir. Please excuse us from this liability. The tribunal will tell, how can I decide that? You do one thing. You conduct a meeting. So upon the LLP filing for compromise, sir, we want to compromise. We are not able to repay the liability. Can you please reduce our liability? Tribunal say, I can't decide all of that. You conduct a meeting. You guys decide and you let me know.
So we will conduct a meeting of the creditors. If people, now we will conduct the meeting of the creditors. Now in the meeting people, what I need to do? I have to pass a decision. What? People, I need to give you 10 lakh. No, I'll be able to give you only 5 lakh rupees. I'll have to give them a resolution. Now this decision has to be agreed by majority of the people representing 3/4 in value. What do I mean by that? The total credit we need to give is 10 lakh rupees. Now people, in this 10 lakh, how many people should we give this to? We have to give this 10 lakh to 5 people. Then people, for your decision to go through, it has to be agreed by majority number. 3 guys have to agree. And these 3 guys have to hold 3/4 in value of the total outstanding debt. What's the total outstanding debt? 10 lakh. In that, these people should be holding 7.5 lakh worth debt. If they are holding if they pass a decision, then people, your decision is final. Now, whatever is the approved decision by this meeting, we will forward that to the tribunal. The tribunal will pass an order accordingly. Hello, this is what is given in section 61. Any doubt? No, sir. 60, sorry. In section 60, this is what is given. Now, in section 60, sir, we entered into a compromise. We said we will repay this loan of 5 lakh rupees in the next 3 months. But in the next 3 months, we did not repay that at all. We did not repay. Now, people remember, the tribunal has a right to supervise this entire scheme. I have passed, but I'll not wash off my hands. I will clearly monitor what are you guys doing. Now, people, that is what I'm telling you. I will monitor the scheme, people. I have a right to supervise. At any given point of time, I feel I have to do some modification to the scheme. I have a right to modify. But people, if the tribunal is convinced, hey, this LLP cannot repay this, they cannot even follow the scheme, they are fit for nothing. If tribunal thinks, the tribunal will pass an order for dissolution. It has a right. If you can't repay 5 lakh also, then die. Says who? Tribunal. Here, hello, section 61. Power of tribunal to enforce compromise or arrangements. Then people, I can, if the scheme cannot be worked, what I will do, I can pass an order for binding. Last one, sir, section 62. What is section 62, sir? Nothing but, now whatever is the scheme that we have filed under section 60, if that scheme involves merger or amalgamation of any 2 or more LLPs, meaning LLP1 and LLP2 are planning to merge. Now, sir, which section they have to follow? They have to follow section 60 and section 62. Both have to be read together. Agreed, huh? Hello? No, same rule applies for company also. Yes, sir. So you have to go there, they have to get an order. Now see, amalgamation of any 2 or more LLPs. Now, sir, tribunal, if at all, same thing again. Majority number, 3/4 in value. If you get that approval, the tribunal will pass an order for the amalgamation. In that order, what and all details will be there? In that order, the tribunal says, hey, going forward, LLP1's properties will become LLP3's property. LLP2's property will become LLP3's property. All the assets, all the liabilities, all the cases that is going against the company, all the employees, everything gets transferred in the LLP3's name. After everything, if LLP3 is now continuing, what will happen to LLP1 and LLP2? They will end up dissolution without winding up. What do you mean by dissolution without winding up? There is no need for liquidation. No assets, no liabilities. Then why winding up? Liquidation process se la. Correct? Hello? Yes, sir. See, transfer of properties and liabilities, continuation of legal proceedings. This can be important. Read and go. The dissolution without winding up. The provision is to be made for any person who dissents. Important. What is this?
dissenting shareholders, exit opportunity. If at all any partner is not okay with this, give him an exit opportunity. Buy his share, send him out. Or such other incidental matters that can be done. Correct? Hello? Liability. Winding up and dissolution, people. What is that? In this is deleted. LLP may be wound up by the tribunal if LLP decides voluntary. If for a period of more than 6 months, the number of partners are reduced to below the less than minimum requirement. If the LLP has acted against the integrity and sovereignty of India, GR. If the LLP has made a default in filing, registrar the statement of accounts and solvency or annual return for 5 consecutive financial years. If the tribunal is of an opinion, just an equitable loans. Just an equitable is nothing but people, etc. It can be management, not in talkative terms, or dispute. People are fighting. Yeah, all those reasons can be just an equitable loans. No, I didn't go. Yes. So whatever your earlier entity, that will come to an end. Payment of additional fees, enhanced punishment in case of LLP or break. Speak. What time will take a break? 11? Yes. Or after this chapter?
Okay, I'll sit here then.
Yes, sir. Enhanced punishment is what people, whenever a person is doing, LLP is doing the same offense, second, third, fourth time, whatever are the penalties given in the section, we can even levy them twice of the maximum amount prescribed. For the first time, we will levy whatever is there in the section. Again, you are doing, again, then we have to punish you more. Simple, huh? Then, that is your LLP. I believe we covered good enough of LLP. I am happy. Okay. Next, let's start with what? Other laws. Shama will do. Okay, let us start with FEMA. Okay, Foreign Exchange Management Act, sir, 1999. Now, sir, in this, yes, let us start with our important definition of the people. That is nothing but residential status. When will a person be considered as a PRI? It depends upon whether you are an individual or you are other than individual. If you are an individual, the condition is simple. What is that? The first simple condition is the status of residency. You will be treated as a person resident in India if at all you are staying in India for more than 182 days in the preceding financial year. Again, I repeat, for the current year, your residential status is derived based upon your stay in the previous year. So in the previous year, if you have stayed for more than 182 days, in the current year, you will be treated as a PRI. That's the most simplest way. In the previous year, if I'm not staying for more than 182 days, then I'm not a PRI. As simple as that. Remember, citizenship has nothing to do with residential status. Second one, this 182 days condition remember and go as 183 days because it is always more than 182. So exactly if you are in India for 182 days, do not, it is not considered as PRI. You should stay in India for 183 days. Yes, sir. Third one, the day of leaving India, the day of coming to India, you take it if they're asking you, if the day comes for you to count, the day the person is leaving India, the day he is coming into India, take these 2 days as a person is present in India only. Take it for your counting. Sir, the next fourth confusion you guys will have, the 182 days condition is not consecutive. It can be in bits and pieces also possible. Is this clear, all of you? So this is the most simplest definition that we can have. More than 182 days, you are a PRI. However, from this definition, certain people are excluded. Who are they? They are telling excluded categories in the current year. Who? A person who has gone out of India for employment, to do any business or vocation or any other purpose, and intention of the stay outside India is unknown or uncertain. Now, if you have gone outside India for these three purposes, you are excluded from the definition of PRI. That means, let us imagine in the year 24-25, I have stayed in India for 200 days. But in the year 25-26, I just went to Sri Lanka and came. Now, will I be treated? You tell me. I went from November 14th till 24th of November. I was there. What is my residential status for that time? You tell me. For this year, tell me, 25-26 only it is. Is it PRI, PROI? The question I will ask myself, why did I go there? To do some part-time business? Belpuri? No. Then why did I go there? I went for a trip. Now, people, the trip is included, is not excluded. Agreed, huh? Yes, sir. Now, let us imagine we have some connects in Sri Lanka also. I can go and teach if needed. Yes. Yes, sir. Now, our ACCA and all is handled by Sri Lankan faculties. Yes. So, I can go and teach there. I can go and record. We have same setup. Now, why did I go? I went there to do a particular class. Can I go for a month? 100% possible. Now, if I go to Sri Lanka for that 1 month and I come back, what will be my residential status? I'm going for employment. Remember, in FEMA, you can have dual citizenship in the same year. Again, don't get confused. So if I'm going, let us imagine I went to Sri Lanka on 14th of November for employment. For employment. Until 14th November, I was in India only. I am a PRI. I mean, just not to complicate, I'm just telling you. It will come under profession only. Is that because we do not have employment card? I mean, yes. So, sir, 14th November, you take it as PRI. From the next day, today I left it, 14th only I left it. But today I'm in India only. I can't tell residential status even for time. So, for the whole day, take it as PRI. From 15th people, I will be treated as PROI. Hello? Done? Pakka? Now, sir, my job is done there. I finish my job. I come back. I again take up employment in India. I have to come back and teach here. No. What is my residential status, sir? I become PRI. Why? Now, see. Okay, when that comes, I'll tell you. For now, this part is clear now. So, a person who is going out for trip people will not come under a PROI status. He is a PRI only. Is this clear out of you? Okay. So, next one, sir. A person, now I'm speaking about a person going out of India. Now, you take our Sri Lankan faculties. Now, there are people from Sri Lanka, there are people from Maldives who come and teach for us. Now, if they are coming and teaching for us, they are coming into India. Why? Vacation, na? Profession, no. Business. A person is coming and teaching in Arivu. You're coming and doing employment in India. Now, people, a person who has come to stay in India, not for taking employment, business, or any other purpose, again, certain, uncertain, we don't know. Then we are telling you people, such people are considered as PRI. So that's what we said in short also. For the above purpose, if you are coming to India, our Sri Lankan faculty coming and teaching for these three purposes, they are PRI. If you are coming to India for any purpose other than these three, you are considered as PRI. Example, sir, if a person from Sri Lanka comes to India for a trip, he finishes trip, he goes back, he will come under the definition PROI. Hello. But if at all he is coming for India for the purpose of employment, then PRI. Hello. One more confusion you guys can have. Let us imagine, sir, our Sri Lankan faculties in the year 24-25, they have not stayed in India even for one day. Not even one day. They came to India first time in 25-26 only for employment. What will be their status? PRI or PROI? PRI, or they will not come at all. Remember, people, when a person is coming to India for these three purposes, don't look at the 182 days condition at all. Even in the previous year, if the 182 days condition is not satisfied, in the current year, if they are directly coming in for employment, from that day, they are treated as PRI. Clear? Hello. So again, I'm repeating, when a person is coming to India for that three purpose, it is irrelevant what he has done in the past year. Even if he has not stayed in India even for one day, but coming in India this year for those three purpose, he is a PRI. Any other purpose, PROI. What do I mean by that, sir? Now, if you get this right, you are right. Yes, sir. If not, we will do special class on FEMA. Okay, we'll see. A person who came to India from Sri Lanka for a trip in 24-25 stayed in India for 190 days and went back. Trip. He liked India so much. Again came to India in 25-26. Again for trip. They're asking you what is his residential status for 25-26. PROI or PRI? PRI or PROI? PROI ಅಲ್ಲ. Hey. PROI ಅಂತ. PRI or PROI? Mami PRI da? PRI. That's all. PRI or PROI? People, why PRI? Yes, stayed in 182 days. Okay. Now come and see what are they telling you. If he has stayed in India for more than 182 days in the previous year, he is a PRI. Correct? Okay. If this word was not there, your answer is correct. What it is say, even in the previous year, if you have stayed in India for more than 182 days, the following categories are excluded. Who are excluded? They're telling you, person who has come to stay in India not for these three purposes is excluded. Now, why did you come to stay in India? Employment? Business? Occasion? Any uncertain? No. You came for trip. So, you have not come for these three. That means, according to my definition, you are excluded. Yes. So, remember, what do I mean by this? If a person keeps coming for his entire life, every year, 190 days, 190 days, 190 days, if he keeps on coming, we will treat that person as a PROI only, not PRI. Why? He is covered under excluded category. Understood? All of you? Pakka, I know it's a tricky part. That's why I said it here. You thought it that. I thought it what? Clear? Okay. Now, people, online, yes, done. You are all, Einstein and you are same, da. I know. Okay, next people. What if, I hope this residential status is clear, na? Simple children, I know. Sorry. Residential status other than individuals. Meaning, in the case of officers, body corporates, branches, LLPs, company, etc. When will you be treated as PRI? They're telling you any person or body corporate incorporated in India. That's all directly. Infosys, so everything. You're directly incorporated. You're a PRI only. Second one, any office, branch, or agency in India owned or controlled by PROI. This is a perfect example of foreign company. You have a company outside India. You don't have a wholly owned subsidiary. You have a branch in India, or you have an agency in India, or you have an office space in India. It's not a registered entity. You're just having an office branch. I hope you guys know the difference between branch and subsidiary. ArivuPro in Chennai is not another company. Ours only one sister, the extended branch, that's all. In the same way, if a foreign company has one branch in India, they will not register it as another company. Agreed, huh? So that's a perfect example for foreign company. Next one, office branch agency outside India, owned or controlled by PRI. What do I mean by that? A branch or office which is outside India, but control is with us. That is also considered as what people? PRI. Here they will put something in order. Achi masala, kitchen masala, simple da, these three things and go da. Huh? But yes, masala will pakka be there. Yes, huh? Sir, resident but not permanently resident. What is this? The third category, resident but permanently not resident. People, I think, very potential once they have asked a question on this. What do you mean by a person resident but not permanently resident? A person who has come into India for employment, job, or any assignment, but the duration of stay in India should not exceed 3 years. What do I mean by that? Imagine a foreigner. There is their branch office in India. He has come to set up the process. He'll be there for 2 years. After this 2 years, the branch is set up. He will go back to his country. Agreed? Huh? Now that person will come under people resident but not permanent resident. Can anyone tell me what is the significance of this person? Why should we add this person as a different category? Why? What is the need? LRS limit. What is it? He can even utilize the 2.5 lakh as you are saying. So people, the purpose of introducing this is people to say that 2.5 lakh dollar is not applicable for you. Meaning what? That limit is not applicable for you. Imagine the 2 years I came here, I worked here. My salary, let us imagine, is 10 lakh dollar. I don't have any purpose to spend that in India. For my living, I will spend. But my expenses are outside. My rents are outside. My fees to be paid are outside. My dependents are outside. What do I do keeping this money here? And if you tell me maximum I can take outside is 2.5 lakh in a year, but that's not how it works, right? My dependency is outside. That's why we give you a special status that is only called as resident but not permanent resident. What is the benefit this fellow enjoys? Net of taxes. Pay whatever taxes you need to pay. You take everything outside India. We don't mind. Just that you should not be from Pakistan. Rest of the countries we don't mind. Here, hello. Okay. Next one, sir. Transactions people can be considered as current account transactions, capital account transactions. What do you mean by current account transactions? Current account transactions can be further classified into rules and schedules. Schedule 3, Schedule 1, Schedule 2, Schedule 3. Now, Schedule 1, Rule 3 is important. That's where the question comes. Whatever you guys said, so very difficult question. It came from this only. Why difficult? I'll tell you. If you guys remember that Rocky by example, same thing they are given. No question. Prohibited current account transaction, Rule 3 and Schedule 1. I actually pity, the last paper was so easy. You guys went through the paper? Anyone? Did you guys find, no, you guys have done with the classes. You guys found it difficult? Lengthy, good, difficult, good, there is. And see, I tell you where I feel, I'm not against anyone. I feel there is a too much of spread of news in social media. People started coming and claiming the most difficult paper, and that's how the tag came. See, even if I'll do a video tomorrow, most difficult paper, that's all. Whoever views it, oh, difficult paper it was. You will not even use your brain. It was not difficult paper. It was very much approachable. If you ask me, that was not at all difficult. Probably little of application, and it was lengthy. I keep my first class, I'll tell you, the paper will be lengthy. You cannot write 100 marks. You go prepared for that. That should not be a surprise. Agreed, huh? Okay, prohibited current account transactions. Now, what are the current account transactions that is prohibited? It is given in Rule 3 and Schedule 1. In Rule 3, what is given, people? There are two things that is specifically given in Rule 3. What is that? If you want money to go to Nepal or Bhutan, there is no need for taking foreign currency. Our foreign currency reserve is very precious for us. You're not supposed to exploit it. Why? In Nepal and Bhutan, people, remember, your own currencies are accepted. Your Indian currency is only accepted. Why do you want to reduce our foreign currency reserve? So we will not give you money, people, if you're going to Nepal or Bhutan. For travel purpose. Second one, okay, sir, travel you don't give. Can I go and book my accommodation there in foreign currency? Why? Even that fellow there, shopkeepers, hotels, they will accept your Indian rupees. Then why do you want foreign currency? That's the second thing. Any transaction with a person in Nepal or Bhutan also, you cannot do it in foreign currency. You have to do it in Indian currency only. Clear? Hello? Okay, done. Next one, sir, is Schedule 1 transactions. What do you mean by Schedule 1 transactions? Schedule 1 transactions are the transactions which are prohibited. You cannot do it if at all you are in India. What is that? First one, remittance of lottery winnings. If you play lottery, spend the money here, you're not supposed to take it outside India. Example, I win a lottery ticket. I win a gamble. I have to spend it here. I cannot take it abroad because the money will be huge. First one. Second one, there is no effort involved. Why will a country give away its reserves just like that? No one will give. You did not earn it. See, resident but not permanent resident, I'm telling you, you take away all your salary. I'm saying even beyond 2.5 lakh dollars. I did not even put one limit, no. Because you earned it. That's the difference. Clear? Next one, remittance of income from racing or riding. Similar to gambling? Not allowed. Third one, remittance for purchase of lottery tickets, banned magazines, football pools. This football pools and all is nothing but your IPL sort of things in footballs. Manchester, Chelsea. Correct, Noda? Football ನಮ್ಗೆ ಅರ್ಥ ಆಗಲ್ಲ. Sorry to football fans. I mean, I don't know. This generation is football generation, no? Noda, Arnav, I expected you to be a pro footballer. Huh? Outside India, na? Once go to Kerala. Noda, sir, Kerala is outside India only. Huh? I feel today's your generation is complete into football only. Huh? You're not into anything. We took me also into it. Huh? Okay. I tried, people. People say, no, hey, football is cool. One day I tried to watch. Nanga arthane agilla. One, they're running from here. I mean, with all due respect, I'm not saying it is a bad sport. I didn't enjoy. Same way people can feel for cricket also. What is there? So I totally respect that also. But they were coming from here to there. They are going again back. So, I mean, it's a good sport for the people playing. But I don't know. But yes, people enjoy it crazily. I understand. But someday, yes, even I should play. Play ಅಂತ ಗುರು 2 ರೌಂಡ್ಗೆ ಸಿಟ್ಟು in sports day of Arivu, there was basketball now. I got to know basketball is not just throwing. It took me only 3 minutes to go and say, hey referee, you play, I'll become referee. Yen Guru also. How much fitness you need? Huh? From where to where it is going? Sir, what about chess, sir? No controversies. I like every sport, including everything. Okay. Remittance for purchase of lottery tickets. What is this remittance for purchase of lottery tickets? Sir, in Swiss, Mauritius, Los Angeles, sir, in all these places, sir, there are lotteries, there are casinos, Las Vegas. Sir, give me one thing, give me one crore. I'll double it and I'll bring it. I'll give you 1 crore, Anna. You will make more debt and come back. So they're telling precious reserves. Don't go and spend on something which is uncertain. So I'm not giving you money to go abroad and participate in gambling, which is not sure that you're going to win. Agreed? Next one, remittance of interest income on funds held in non-resident special rupee scheme account. This is nothing but people, whenever an Indian goes abroad, whatever their savings bank accounts or whatever their accounts, their earnings in India, it has to be deposited to an account which you have to specifically call it as people non-resident special rupee scheme account. Now you have to deposit your money into this. Okay, now I've deposited. Imagine I'm getting some rent in India. I'm depositing there. On that rent, on that money that I've put in this account, I will earn some interest. They're telling you free money. See, whatever you earned, that time not telling anything. Interest on. See what I'm telling you. Free money. That you spend in India. Law is simple. Free money. I'll not give you any benefits. Arul, you do whatever you want. Clear? Okay. Next one. Payment of commission on. This is where the question had come from. Payment of commission on exports made towards equity investment in joint ventures, wholly owned subsidiaries abroad of Indian company. What do I mean by that? Let us imagine, sir, I export something. Imagine, what did we export? Something. Oil. We exported oil. Now, people, how much worth? We exported oil worth people $10 lakh. No, they did not pay the $10 lakh. Then we are telling you, sir, instead of the $10 lakh, do one thing. Give me some equity in your company. I'll make your company my subsidiary. Why money, sir? Give me that. So we did not take money. We got equity in return. Hey, money was coming in. You're saying no, and you took shares. And for this transaction, there was one intermediary, one agent, and for him, you want to pay commission now. That you want to pay in dollars. When you had an opportunity to earn money, you took shares. And for the agent, you want to pay in dollars, which you never earned. That means what? You're taking from RBI's reserves. RBI will hit you. Why will RBI give you? RBI will not give you because you did not earn in spite of having an opportunity to earn. They are telling you, we will not give you even 1 rupee towards what? Towards a commission that you need to pay for exports made towards equity investment because you did not earn. And what I'm telling you, I'm not telling you should not take equity. You take and die. I'm not telling you should not do that. I'm telling you, you're not supposed to pay commission on exports. Hello. Payment of commission under exports under rupee state credit route. What is rupee state credit route? Is nothing but I told you we have certain agreements between the countries that let us not settle it in foreign currencies. Let us settle it in our local currencies. When our country and Russia, we have an agreement. Why involve dollars? So we are clearly telling you no foreign currency, only Indian currencies or their local currencies. So when the exchange is not happening in foreign currency, remember commission also cannot be paid in foreign currency. Commission also should be paid in local currency only. Example, if we export anything to Russia or today's date, any Asian countries, we are reducing the dependency on dollars. We do not exchange dollars at all. We exchange our own currencies. Now imagine there was one mediator who helped me deliver some goods to Russia or any country in Asia. I am not getting dollar, but the agent is from some country. Imagine Dubai. He is from Dubai. He is asking me for a commission in dollar. They're telling you, did you earn a dollar? Ah? No, no. Then don't expect dollar as commission also. We will not allow. But sir, we felt it is unfair. No, sir. There has to be some excuse. We said, okay, India has a abundance exports of two things. One, pufu and one combination. So tea and tobacco people, you are allowed to give commission up to 10% of invoice value. Meaning, if my export is worth 10 lakh, you can give up to 1 lakh. We don't have a problem. I'm giving you $dollars only. I'm giving you people all of this logical. In tea, first we thought Assam is famous. Now I can tell you another 10 places for famous. Kerala, she said. Chikmagalur, see. Assam, Darjeeling, Ooty, name alike put tea. That means more famous. Yes or no? Then, eh? Howda? That is famous. Rameshwaram is famous. Hey, Rameshwaram cafe na. Hotel. I don't know. Rameshwaram. I don't know. I'll not. So I'm so sorry. You might be more. I don't know. There it is famous. No, no. Okay. Darjeeling, correct. Yes. Darjeeling is famous. Payment related to callback services. What is callback services? In simple, I tell you, foreigner is calling you. They're saying, why, sir? We will only call you. See, he is spending his money and calling us. You're telling, no, 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 no. We will call you. Call, okay. So imagine Amazon is telling, you don't call, we will call. Amazon says that only, no? You can request for a call. Hello? Now, if you call from India, banned Baja Bharat, it's expensive, tariff. So, now what did Amazon do? Amazon will go to a little less developed country. That's why, macha, foreign companies ka BPO will be in India. Foreign companies ka BPO will be in India. Why? Less developed countries, their customer care, we will be the customer care. Because in front of the tariffs, our employee cost will be less. And our tariffs, Jio na, hey, you recharge for 3,000 unlimited life, sorry, life Allah. 1 year. Then outside, no. In one of the Jio meetings, you see, he will say, what is the average cost of 1 GB ka internet in different countries? He'll give you a comparison. See that. Where India is, you will know. We are in paise. In the US also, it is still in dollars. Correct? No. Now, what if some country wants to utilize it? They can utilize. In the same way, what if we want to utilize someone else? Because people, FEMA, it's not today's drafted. When FEMA was drafted, Geo was not there. Our tariffs were more when compared to others. So what will Amazon do? Amazon will go to a country, imagine Mauritius, where call rates are less. We will outsource our calling department to Mauritius. If from India, if I call, one call might cost me 20 rupees. But if I'm calling from Mauritius, one call, it is coming to say, for example, 10 rupees. Half cost we have reduced, no? Yes or no? But people for Mauritius, you have to pay dollars, no? In India, it was rupees only. Macha, this is I will not agree. It was your business expense. You're converting it into a country's expense. This I will not approve. Understood? That is what is callback service. Eighth one is people dividend balancing method. What is dividend balancing method, people? If at all there is a foreign shareholder in my company, can I pay dividends to him? Yes, allowed. But remember that has to be as per dividend balancing method. Dividend balancing method is nothing but, people, you can declare so much of dividend, that much you need to earn. Do exports, earn money. That much you pay in dividends. I don't mind. So earn your dollar. That's the dividend balancing method. Next one, people, is current account transactions which are allowed. We saw a list for not allowed. We are seeing it for allowed. Schedule 3. Now, who's Schedule 3, sir? One is for individuals. Next one is other than individuals. For individuals, people, this is called as people LRS limit. Nothing but liberalized remittance scheme. This is nothing but whenever you are a person resident in India, you will enjoy a right of using certain dollars in a year. Now, whenever I'm going outside, imagine even if it can be for a trip, I have a right to go and exchange 2.5 lakh worth dollar from my country. I can take dollars and I can go. Agreed, huh? Yes, sir. Now, people, this is only called as what people? LRS. Now, sir, I've gone so many trips, sir. I have exhausted all my limit. Then, people, if you want to even go beyond this, you need to take RBI approval. Clear? Yes, sir. But trust me, people, 2.5 lakh dollars is way more sufficient for us. At least for me. For you guys, I don't know. I know. But yes, more than sufficient. 2.5 lakh dollars comes to easily around more than 2 crores or more than 1 crore. Yes, sir. So, 90 rupees. So you can take it. So it covers literally more than sufficient. But yes, all our VIPs and all, for them it is not sufficient. 2.25 crore rupees. Good enough? Yeah. And remember, people, you alone will not go. I mean, I believe you have not become that sage yet. Yeah. Yes or not? Huh? Now, if two of you are going, your limit will become 5 lakh dollar. So your limits are always sufficient enough. Clear? Huh? Okay. So, sir, excess people RBI approval. Travel to any country. Day FEMA in our time, I left this chapter and went. For each of the transaction, there was a limit. For education, limit was different. For during our time, ಏನ್ ಮಾಡಿದ್ವಿ ಗೊತ್ತಲ್ಲ? We tried. One day I tried. It didn't work. I left. Yes, FEMA I never touched. FEMA I left and went. See, karma. Boomerang comes back. Travel to any country. So if I'm going for a trip, people, private trips, I can take money, exchange, possible. Gift or donation, people are staying abroad. You want to give money as a gift abroad, allowed. Going abroad for a SIDA gift, bank transfer, physical note. Okay, we'll see. Going abroad for employment, you need some cost note initially. Yet day one, get land, get your salary. Some minimum amount you need to take and go, no? Immigration, no? What is immigration, no? Shifting, go there only. Maintenance of close rent. Hey, remember, education went off. Oh, it is down, okay. Maintenance, sorry, immigration, important. Maintenance of close relatives abroad. Our probably parents might be there, children might be there, spouse might be there. You can send money to their maintenance allowed. Business travel, attending conferences, special trainings, or any medical expenses, checkups abroad, accompanying as an attendant to someone, all of this will come under 2.5 lakh only. Remember, people, for medical, or I'll put it as medical treatment. Again, there is one special note. And next one, people studies. Now, what is a special note? Generally, if you are taking money beyond 2.5 lakh dollar, you need to take RBI approval. But if you are shifting your residence permanently, that is immigration, you think that the cost of living there is so high, this 2.5 lakh dollar is not at all sufficient, then you get an estimate from their embassy saying that 2.5 lakh is not sufficient for the inflation of this country. You can take beyond 2.5 lakh dollar without RBI approval. Second one, I want to go and study in, say, for example, Harvard University, where per year fees is around 80 lakh. If it comes to around, say, 5 year, 8 5s of 44 crore, and if this money is not sufficient, I have to deposit on day one.
So they're telling you, then it's okay, people. You can go beyond this limit. Again, no specific RBI approval is required for the purpose of education, provided you need to get a what estimate from the university that the fees here is expensive. 2.5 lakh dollars is not sufficient. Then no RBI approval required. You can go beyond 2.5 lakh dollars. Next one, sir, medical treatment people. I told you there is a complicated surgery that is to be done, which requires welding. Kidney aren't open, we have to weld and all. Then people, this is an underwater surgery we have to do. So in such complications and all, what to do, people? They're telling you, you can go for beyond 2.5 lakh dollar, get an estimate from your hospital. No RBI approval required. Those three, remember. Hello. Next one, sir. Other than individuals. What is the limit, sir? Up to the limit, no approval needed. Beyond needs RBI approval. Again, they'll ask a question here. No and no. What is that? If at all a company wants to do some donation, how much they can do? Free, machan, free money. That's why they're thinking whichever is lesser. So if a company wants to do a donation, how much they can do? They can do up to 1% of 3 previous years forex earnings or rupees 50 lakh, whichever is less. How much ever I have earned, or 50 lakh dollar, whichever is less. That much I can donate free. That's why whichever is less. Rest of it will be higher because you are earning. Okay. No, sir. What can I donate for? You can donate it to create chair. What is chair?
Education.
It is nothing but people. You can sponsor a particular department or a teacher or a professor. That professor will be called as people. Say, for example, say Tata. Uh, say, for example, it's the subject. Science, I don't know, biotechnology professor in science chairs Tata. That's how it will be written. That means what? That professor or that designation in that college will be called out in your name. It's like a lot, it's a prestige. It's a matter of status to you. Second thing is that if at all that person is contributing in that field, it is also beneficial to you. We will not just like contribute to some chairs. We will contribute to those chairs which will add some educational value to us also. Research and development happens to us also. Only to that we will, donate. In IIM and all, it is there, very popular. In economics, in commerce, there are so many chairs. Tata only holds 2 of it. They donate. What do you mean by that? The entire salary will be taken care by Tata. Next one, funds promoted by educational institutes like scholarships to technical institutes in the field of donor company. Imagine Tata Steel is there. There is something called as Association of Steel Industries Global. Now, together, if at all you are making an R&D, it will benefit my company also. You can donate because it will benefit you also. Clear up? So you can donate up to 1% of your 3 previous years forex earnings or 50 lakh dollar, whichever is less. Remember, you guys asked a question also. Sir, what if in the last 3 years I don't have forex at all? Then it will be 0 or 50 lakh, whichever is less. Which is less? Then you cannot donate. That means what? You have to earn first. Next one, commission per transaction to agents for sale of residential or commercial plot in India up to $25,000 or 5% of inward remittance, whichever is higher you're earning. What do I mean by that? Sir, Prestige is coming up with a new project in Bangalore. Now, these plots are sold in Dubai. People are there. Are people there in Dubai? Indians are there, huh? Half of it is Indians only. No. Now imagine an agent wants to take a benefit of it. Sir, invest today while you are here. You are earning good money. Now a person is getting that money back to India. Now that is what they are telling you. Any agent who is facilitating this, pay him commission. How much? $25,000 or whatever is the value of the property, 5% of it, you pay it as commission, whichever is higher. Hello. Okay, next one. ಆಯ್ತು ವಯಸ್ಸಾಯ್ತು. Okay, remittance for consultancy services per project. Now, what is consultancy services, sir? Sir, we want some help to set up something in India which we think we don't have. Example, infrastructure, metro, sir. We have only a metro which can go on the bridge. We want something that can go in India, world. It want to go underground. It should go on my top of my balcony, one stop and all. Where do we have that? Japan, it's there, on top of my building will go, sir. Yes, sir. So if you think you need that technology, get it from some other country. That's why you have infrastructure project. So if it's infrastructure project people, they're telling you you can pay up to $10 million. 1 million is 10 lakh. 10 million, 1 crore. 1 crore dollar, 89 crore. They're telling you close to 90 crore pay. It's okay. Other consultants, is it sufficient or nowhere sufficient? One metro last bogie will cost you 100 crore. It is very expensive. Other consultancy, education, science, research. You want some, consultancy, IT, finance. Now you are such a good chartered accountant. You are so good. Imagine you start doing blogs and all. Someone from Japan calls you. Wait, believe in yourself. Illa. Mr. Tejas, we want your consultancies. How much will you charge? Everything you have. That's what I now. So, in the same way, imagine, sir, if I want some services from abroad, then I should be also able to pay. That is only called as up to $1 million. I can pay them. If at all any other services, it can be finance, it can be science or anything. Next one, remittance by entity for pre-incorporation expenses, preliminary expenses, whatever you got before this company was set up. You can take back how much? Up to 5% of whatever is the investment you brought, or $1 lakh, whichever is higher. Clear?
This remittance of your repatriation of whatever.
Repatriation is again different. That's a capital. You call, there are two things. Profits you can take back. If you are taking back your capital, again there are limits. There are procedures and all for that. It was there in your CA final. They have removed it. Okay. Next one, people, let us do. We did schedule 3, we did schedule 1. Schedule 2 is feeling bad now. Let us do schedule 2. Transactions which require prior approval of the government of India. Macha, directly government of India. That means what? We are taking the approval of central government. Of course, central government is busy. For everything, I cannot call Mr. Modi ji. Correct? So Modi ji's, what has he done? He has tried to diversify the risk. So there are multiple ministries. If you need an approval, you have to call that ministry for the approval. Correct? So people remember, even 1 rupee here, you have to take the approval. Now what is that? The first one, people, Anirudh wants to go and conduct one concert outside India. Who go? Cultural tour. They're telling you first to come and take a Department of Education and Culture's approval. If not, you cannot do it. Hello. Next one, advertisement in foreign print media for the purpose other than promotion of tourism, foreign investments, and international bidding. 3 things. One is tourism. Next one is foreign investments. Third one is international bidding. Exceeding USD $10,000 by a state government and its public sector undertaking. Here I have given you one chart, if you remember inside the class. That's why I have given you. There are so many details. Yes, sir. Now what do you mean by that? Sir, who is spending money? State government to public sector undertakings. They are spending money. Why are they spending money? They might be spending money for these 3 purposes other than those 3 purposes. If at all they are spending money for those 3 purposes, what are the 3 purposes? tourism, foreign investments, and bidding. If at all they are investing money for people, these three purpose. Which one? Bid. For bidding, investment, and tourism. Machan, no limit. Spend how much ever you want. Who? Public sector undertakings and state governments. Why? You're going abroad, you're running an ad, you're promoting the tourism of Karnataka. You're going and probably running an ad of promoting tourism of Gujarat, which Amitabh Bachchan does. It gets played. Of course, we want people will come into India. Now, without going promoting, how will they know? So go, it's okay. The entire country is getting benefited. How, sir? Taj Mahal, entry ticket for you and me, 200 rupees. For them, $20. Exploitation, no? They took no from us. So we are taking back. Everywhere it is the same people. Foreigners, we will charge more. Yes, sir. Now, people, for those three purposes, no limit. You spend whatever you want. Any other purpose than tourism. What is investment? Foreign investments. I'm going and promoting there. People, we have SCZ. Please come and invest. Who did? Andhra Pradesh. Telangana and Andhra Pradesh, they got split. Now, in Andhra Pradesh, they wanted to bring in what do you say, economy. There are no companies. They went and they did it. Kia came in. Now I heard something. Lulu Mall is coming in along with Andhra Pradesh. Who else went for bidding? Kia. 3 states participated for Kia setup. Which 3? Karnataka, Tamil Nadu, Andhra Pradesh. But Andhra Pradesh's what do you say, bid, no one could meet. They said literally 5 years, don't pay anything. You enjoy everything free of cost. Because they wanted that. They know that the entire thing around them will get develop. It will happen. I getting the point. I have to go and promote no outside. Allowed. State government. Because why lost? For example, now I'll tell you the number of cars that gets manufactured in that one place, rural place, gets completely shipped to the entire country. There is not even a second factory of Kia. Forget about that, it gets exported. Whatever the cars that are manufactured in India, I'll not even tell anything. It's around, I think, what, 400, 500 acres. You think the number of people that will work there? How many we will think? You give me an estimate. 2 lakh plus. Let us be very minimal. 50,000 people are earning. We'll give them an average salary of how much? Some 30, 40,000 will give. 40,000 into 50,000 people. They'll pay IT, income tax. It goes to central, it goes to state. GST, CGST, SGST, both are there. Then why loss? Third one, people bidding. Bidding again, for example, tenders. Now, for example, Karnataka Metro. I want you to, macha, because in our state, metros are falling. Yes or no? Then that's what I'm telling you. For these people, these three purposes, no limit. Other than those 3 people, the limit is $10,000. Beyond that, we will not allow you. Beyond that, people, you have to take CGM. Sir, what if I'm not a state government? I'm not a public sector undertaking. This thing will not apply to you at all. Sir, in CG, whose approval should I take? Ministry of Finance, Department of Economic Affairs. Remittance of freight of vessel chartered by a PSU. What do you mean by vessel chartered by a PSU? I told you people, for example, a public sector undertaking is importing something. And they're telling you people, they could have given this import order to an Indian shipping company. What did they do? They did not give it to an Indian shipping company. They give it to a foreigner. That means what? I have to pay the freight charges, the shipping cost, not in rupees. I have to pay in dollars because you did not give it to an Indian shipping company. That's what they're telling you. Remittance of freight of vessel means ship, chartered by a public sector undertaking. If at all that is the case, being a government entity, a public sector undertaking, if you are not giving to an Indian shipping company, you are unnecessarily taking dollars, then people are telling you, you have to take approval of Ministry of Surface Transport. That is the CG that is required. Clear? Next one, people. Payment of import through ocean transport by a government department or a PSU on a CIF basis other than FOB basis. I told you clearly, FOB basis means what, people? I will tell you, Macha, you manufacture. I'm importing something. Imagine I'm a public sector undertaking. I'm importing something from you. Who? Imagine you're from Dubai. You manufacture it and you keep it in front of your factory. From there to my godown is my responsibility. We have so many Indian companies who can take care of that. But what did you do? You public sector undertaking, what did you do? You said, no, 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 no. You manufacture, you load it to a truck, you load it to a lorry, you bring it to the port, you ship it to our port, and you come and you put it in my factory. Until that, it is your responsibility. But for everything, I will pay you. Unnecessary cost, insurance, freight, ship, transport, everything you could have avoided. They're telling you, people, that means you need to take the approval of Ministry of Surface Transport. Clear? Multimodal transport is nothing but whenever there are multi operators. For imagine, people, if I'm sending some goods which goes through a road route, ship route, air route, train route, we call this as multimodal transport. Chances of money laundering happening here is more. That's why they're telling you the registration certificate is required, not approval. Not everyone can run it. You need to have a registration certificate which is given by Director General of Shipping. Next one, remittance of hiring charges of transponders. Nothing but imagine we giving telecasting rights or we entering into a collaboration with the foreign channels. For that, whatever is the money we are paying, for that, I need to pay. I need to take the approval. If it is a TV channel, I need to take the approval of Ministry of Information Broadcasting. If it is internet, Netflix, things, Ministry of Communication and Information Technology. Next one, remittance of container detention charges. Container detention charges is nothing but the container that you take, you put it in the ship, the big containers. That you cannot keep it beyond a certain period. The law allows you, you can keep it, you can take it to your factory, you need to unload it and bring it back. If you're taking 15 days, 20 days, 30 days, people, it's an unnecessary rent you need to pay for the container. Beyond a point, they're telling you, you have to take the approval of Ministry of Surface Transport. Next one, remittance of prize money or sponsorship of sports activity abroad by a person other than international, national, state level sports body if the amount involved exceed 1 lakh. What do you mean by that? Let us imagine two people are giving prize money. We are conducting a cricket tournament outside India. Who is conducting? Let us imagine two people are conducting. One is BCCI, second one is people, some company, Paytm. If you are a international, national or a state level sports body, then people, you go and do it, we don't mind. Sir, if you are a person other than international, national or state level bodies, then for you the limit is, people, $1 lakh. For them, no limit. For you, the limit is $1 lakh. So Paytm, if at all they are sponsoring, they're giving a prize money or you do anything for sports outside India beyond $1 lakh, you guys have to take prior approval. From whom will I take? I'll take approval from people, Ministry of Human Resource Development. Sir, now the question is, should I remember these ministries? Pakka, you have to remember. Pakka. Don't write of CG and come in the exam. Yes, sir. Remittance for membership of P&I club, protection and indemnity club, nothing but it's like an insurance. So if you have taken any money towards this insurance, which is a little informal sector of insurance, that is what I can say for now, P&I club, you need to take the approval of Ministry of Finance. Clear? Hello. Okay, sir. This is your current account transactions. The next one is called as people capital account transactions. A transactions, macha. Is a simple definition. A transaction which alters assets or liabilities, including contingent. Very good. A transaction which alters assets or liabilities of PRI outside India or PROI in India. We call it as people capital account transaction. What do I mean by that? If a PRI is buying a big plant and machinery outside India, he is importing it to India. What type of transaction is this called as? A person buying plant and machinery outside India, I'm importing it to India. What type of transaction is this called? Current capital. Current capital. Plant and machinery. Current capital.
It depends on paid or
Okay. So it depends upon whether you paid or it's on credit. Remember, people, if it's money paid, I will bring back that asset to my country. So I am a PRI. An asset is getting created. That plant and machinery, you will keep it there only, bring it back to India. Now. You're bringing it back to India. There is nothing that is belonging me that is getting created outside India. So this I will call it as current account transaction. Now, when will it become capital account transaction? You are a PRI. You buy a plant and machinery, but this time you are buying it for credit. How long? Imagine I'm taking a loan for 2 years. From that, I'm giving you this money. I mean, I'm getting this plant and machinery. People remember, a liability is getting created for a PRI outside India. A liability is created. You'll bring back the plant, but that is a liability, no, for you. So, and liability is getting created, it is getting increased. Now, this transaction will now be called as capital account transaction. Sir, what if I'm getting a plant and machinery, but the credit period is 5 months? What type of transaction? Current capital. Na? Current account, the reason being people, the short-term credit facilities will be treated as current account. Who said that? Current account transactions only have defined it that way. Then why should I take tension? They're telling you it is considered as current account transaction. Clear? Huh? Cut copy paste applies to PROI also. If at all there is a PROI, if any asset gets created in India, it will be called as what people? A capital account transaction for the PROI. Sir, I'm not telling whether you can do, you cannot do. I'm not, telling anything like that. I'm just telling you these are called as capital account transactions. Now the question is, can I do it or not? Capital account transactions. They're telling you can do. There are certain rules. Up to what extent you can do people capital account transactions? What is the limit? Any limit is there or no limit? No limit? Of course, no. Huh? Any limit is there? No. Of course, people. Yes, I mean, I'm very proud of you all. There is limit, people. That limit is people $2.5 lakh. Current to capital, both will be covered under people. LRS da. Hey, why you will do like this to me? Huh? ಸ್ವಲ್ಪನೂ ದೇರ್ ಇಸ್ ನೋ ಏನಂತಾರೆ ಪಾಪ ಪುಣ್ಯ ಅಯ್ಯಬ್ಬಾ FEMA permissible capital account transaction regulation 2000. People, for a PRI, what he can do is given in schedule 1. For a PROI, what he can do is given in schedule 2. Here, what is all come down? I can take up investments, I can take up liabilities, guarantee, loan, what else? Immovable properties, transfer of immovable properties, foreign currencies, cash, notes, all these are allowed for PRI. Same thing for PROI also, no? Yes or no? I can take up liabilities, assets, immovable properties, investments, contingent liabilities, guarantees. All these are allowed for PROI in India. Okay. But remember, people, these rules are exempted. 3 times they've asked you. Some 8 times they've asked in RTPs and MTPs. Now, what is that? Let us imagine, sir, there is a PROI. But, sir, this person had come to India. We saw no resident but not permanent resident. That time, while he was working in India, probably he has started or he has made some investment in some shares while he was working here. He has made some investment in some, say for example, he has opened some FD. Now 2 years is done. He went back to his country. All these shares are still in his name. This FD is still in his name. Now my question is, sir, after going back, now, technically, don't you think it's a capital account transaction? I'm a person now resident outside India. I went back to imagine I came from US, I went back to US. But I have assets in my name in India. So if at all I'm selling these shares, will it be considered as capital account transaction? Should I follow all these rules? Not required.
He bought that when he was a PRA.
So they're telling you people, these rules will not apply when a PROI had come to India. He has stayed in India. He has done employment. That means he has become PRI. No. When you were a PRI, if you did any asset here, for those assets, these rules will not apply. Why? Indian rupees you have done it with. Then why dollars are coming into picture? Hello. Cut copy paste ulta. Even person resident in India, all our people are going and earning money abroad. No. From that money, they purchased land there, buildings there. Now they came back. Now they became PRIs. But the properties are still there outside India. Should that property, will it come under FEMA? Answer is no. We did not take $1 from India. It was earned there. We invested there. Hello? Now imagine a person went abroad, earned nicely, made some properties. He came back. While he was in India, he passed away. His daughter got all the assets. Now tell me, is capital account transaction applicable to her? She's acquiring, no. Remember, inheritance. If you get any property, these rules will not apply. Understood? That is his exemption. See, a PRI may hold, own, transfer, invest in foreign currency, foreign security, immovable property if it was acquired or owned by such person when he was a PROI. So how did I get a property outside India? When I was a PROI, I earned it. Or there was someone who was belonging to me abroad. They earned it. They passed away and hence I got it. FEMA rules will not apply. Hello? Same thing only. Will also that only, no? When he was a PRI or inherited from PRI, same, opposite. Yes, sir. You can continue to hold. That will be, it will not come under Indian regulations because you are earning money using the foreign sources. It's nothing to do with India. You can take back. That is allowed. You can take back any income that you are getting it. Allowed. Net of taxes. Next one, people, prohibited transactions are the last thing under capital account transaction. There are some sectors, people, you are not allowed to invest in any way. What is that, sir? One is chit funds. Exception, NRI can, with the prior approval of the registrar of chits, you can invest, allowed. Nidhi company, not allowed. Agricultural or plantation activities, you are not supposed to invest. Real estate business or construction of farmhouses, you are not supposed to do. Exception, the real estate will not include these things. That means what? You can do this. Brigade, they come and develop a township. It's okay. They are not owning it. They will sell it to you and go. Construction of residential or commercial premises, they are constructing it. They are not owning it. They will do, they will go. It's for our development. Third one, roads or bridges. If we say no, our karma. Read real estate investment trust. I've told you in the example. Trading in TDR, transferable development right. What do you mean by that?
If they are not paying dividend, they pay right, you can build more loan.
Perfect. So whenever a government acquires some property from you, they give you something called as TDR in return. Meaning you have acquired from you this property, no compulsory acquisition. You go and build something else somewhere. That if you want, you only use. If not, sell it to someone and you can use it. Allowed. Yes, sir. Just like people in your rights issue, you would have seen right to renunciation, no? Same way, I can sell it. Yeah. Next one, other prohibited transaction. Simple people, it should not be a person from North Korea. You cannot be associated with any person in North Korea or a body corporate in North Korea. If at all you have done, then you have to withdraw it. You cannot continue. There was a notification in 2017. Kimmanna, nuclear person. Yes, sir. Good enough? Okay. Chalo, go for a break and come. He came only for that. Okay. Let us do even next one, interpretation of statutes. I'll try to take it as slow as possible. Important. Remember. Okay. Interpretation of statutes, definition. First definition that is important here is people, a document. Now, what do I mean by document? Document means people, something which has these four elements in it. What are the four elements? One is called matter. Next one is called substance. Third one is means. Fourth one is record. Matter means people. It defines what is the purpose of the document. For example, heading, sale deed. Whatever we are using that particular document for, that's the purpose. That's the matter. Second thing is people, substance. Substance is nothing but on what this particular matter has been recorded. It can be people, a paper, a card, it can be a pen drive. We have seen in the class. Evidence also can be considered as document, or it can be stone, rock, substance, element on which the mental or intellectual element finds permanent form. So it can be etching, carving. So anything can be considered as substance. Third one, means. Means is nothing but how have we expressed letters, figures, marks, symbols, etc. Third one is record. Record is nothing but people. How did we express it? Is it by writing? Is it by printing? Is it by carving? Is it by etching? That is only called as what? Record. So these four things, if at all it is there in anything, it is called as document. Remember, if at all there is any evidence, it can be a videotape, it can be considered as a document. Clear? Huh? Yes, sir. Okay, done. Next one, sir. Classification of interpretation. Interpretation can be classified into two things. One is called as legal, one is called as doctrinal. Now, what do you mean by legal form of interpretation? Legal form of interpretation, people, can be further classified into two. One is authentic, one is usual. Authentic means what, people? This is binding on the judge. Authentic, what do you call the authentic Andhra cuisine? Authentic continental. Meaning what authentic means what?
Pure.
So there is a difference between Chinese and Indo-Chinese, no? Chinese means people. Simply some three flavors. Indo-Chinese, one black sauce, one red sauce, one brown sauce, one white sauce, one light green sauce. Everything should go and touch the roof. And you should toss for the rest of the meal, drip up. That is called as what? Indo-Chinese. Yes or no? Authentic you call her. No, no. Authentic is people always reliable. Meaning your gobi manchuri prepared by the Chinese fellow only is called authentic. Meaning that's the usual, that's the actual way. Indo-Chinese people, it is not something that is actually true. So authentic is nothing but people. The lawmaker himself has told you how to interpret the law. Best example, definition can be authentic, explanation can be authentic. Associate company, significant influence. He only has told you what significant influence means. Why should you break your head? A recipe is made. He is telling you it is 20 to 50. Authentic. Understood? When rule of interpretation is derived from the lawmaker, legislator himself, we call it as authentic. Usual means what? Usual. Usual. What do you mean by usual? Customs. It's been the same. Tie not. Sir, tie. Example, so people, usual is nothing but people, it can be customs. As I clearly tell, all our religious laws will come under usual. Which law? In parliament they have passed. They passed a parliament. Sir, marriage means there should be 3 times only, not why? Because the threat will be strong. Is it written? Have they passed it? Official Gazette of India, President has signed it? No, nothing. Then that is what they're telling you. Usual is nothing but people. When the law has come by customs or case laws, depending upon some case laws, the new rule will come into picture and you will have to follow that. Now that is only called as what people usual. So usual can be all your religious laws. For example, it can be Hindu law, it can be Mohammedan law, Christian law, Parsi law. We have everything. And you will follow according to that. If you guys are part of LLB, you will have to read everything. So we have everything in LLB, every religious law. It's actually a beautiful law. Actually, if you read it, so we have had a a conviction, and of course a part of syllabus also to read every religious law. Mohammedan law will come in second year. Hindu law will come in the first year. You have to read everything. You'll get a different perspective on everything, which everything is good. Beautiful. The next one is called as people doctrinal. What do you mean by doctrinal people? First one, doctrinal can be considered as grammatical, logical. Grammatical is nothing but macha, follow English. This means this only. Orange. Yes, sir. Grammatical is nothing but people. For example, comma. How to read comma should be read as comma only. Don't use your brain and all there. But sir, what if this comma, if I put it here, I'm not able to make sense. For example, and or and. Which rule? And can be read as or can be read as and. Which rule? Which rule? Huh? Exceptional construction. Or it can also be considered as. What can it also be considered as? Why are we calling it as exceptional? No side or association. Day. I am asking one question. He is answering what he knows. What? They and can be considered as or can be considered as and. See, that is only called. If I consider and as and, grammatical will come into picture. If I consider and as or, exceptional rule of construction, logical will come into picture. For people who are still wondering, PMLA had given you an example. Beneficial. Common sense rule. ಅದೇ ಇಲ್ಲ ಇನ್ ತೋರಿಸ್ತಾ ಇನ್ ಕಾಮನ್ ಸೆನ್ಸ್ ಸರ್ ಎಲ್ಲಿ ಸರ್ ಹೆಡ್ಡೇಕಾ ಸರ್ ಅವೇ ಇಲ್ಲ ನಮ್ಗೆ PMLA section 3 I told you when it comes I'll tell you. Okay, grammatical means what people apply your regular rules of speech English. Sir, if I put English, it is not making sense. Logical. Example. Sir, vehicles are not allowed inside the park. Simple. Grammatical. Vehicles are not allowed. Logical. You try to understand what it means. Correct? Yes, sir. Why? Is cycle considered as vehicle? Is a stroller, a kit. You're carrying an infant in a stroller. Can I consider it as a vehicle? Imagine there is a person who is, differently abled. Now, can we consider this person? We are taking him in a wheelchair. Should this be considered as a, uh, the vehicle, or our Prithviraj, that movie? That can I consider as vehicle? What can be considered as vehicle? That is why we have this logical interpretation. Understood? So use your little brain and try to understand that matter. Clear? Okay. Why do we need interpretation or construction? It is because no law is perfect. We cannot blame the lawmaker and sit in the court saying that you are the reason for our system to be like this. We can't blame the lawmaker. So it is a judge's responsibility to go away from the books and try to understand what the intention was. And that's why we need something called as interpretation or construction. Remember, people, whenever we think we are not able to understand something, there is always two types of help we get. One is called as statutory help, one is called as non-statutory help. Statutory means, people, it is given in this help is given in the law. Non-statutory means it is not given anywhere. The best example for statutory help is General Clauses Act. Distance. How to measure the distance? Horizontal straight plane. It is helping you to understand something. That's why we call General Clauses Act as a statutory help. It is given by the lawmaker. It's an act. IOS is a non-statutory. It's not an act. It's an understanding. It's a rules that we have derived with time. A few authors who knew a lot. Based on that also we have derived rules. Best example, Hayden's rule. Mischief, rule of mischief. That is not something which is derived by a legislator. I mean, when I say legislator, it's not something which is written in the book. It's a rule that came in one case. Hello. Okay. Next one, sir. Rules of interpretation or construction. We have two types of rules. One is primary, one is secondary. Primary rule. First one is called rule of literal construction. I know you guys are all the best people to remember these maxims. What do you mean by rule of literal construction? Absoluta, sententia, expositor, non-indigent. Eli matte heli note panle. Aanu sentence. Again, I told you in exam, it's okay to have a spelling mistake. Sententia, you can write in different, but sententia should not be written as paragraph. That much deviation and all, my uncle is not sitting there and evaluating. Spelling mistake is okay. Now, what do you mean by absolute sententia, expositor, non-indigent? Absolute sententia means when the sentence is complete. Expositor means me, a person who helps you interpret or understand the law. That role in Greek is called as expositor. Non-indigent, not required. So when the rule is so clear, why do you need me? That's why you don't need me for understanding your songs. Now you understand why you can remember songs, but not law. Correct? Now, people, that's what is this. Whenever the rule is clear, don't use your brain. Use the rule as it is. No deviations are allowed. However, whenever we are trying to read the word as it is, we are not trying to, it is not making sense at all. Sir, give us an example. Example, people, the best example is your beetle leaf case. Huh? Assistance? Sales tax officer. Yaar assistant ಹೇಳ್ಬೇಕಲ್ಲ. Yes, sir. Now, people, beetle leaf case. What is the beetle leaf case? See, simple. What did the lawmaker say? Use the word as it is. Simple, pa. Our tax, sales tax said you should not collect any tax on sale of vegetables. The problem was, is beetle leaf considered as vegetable? See, the rule is clear. No tax on vegetable. If you go and tell it to our parents, no tax on vegetable, for them it makes sense. So what will they think? Okay, carrot on, potato on that, there is no vegetable. So less did they know that there are people in this world who are thinking beetle leaves is a vegetable. Now the question is beetle leaf a vegetable? Is it a vegetable? Is it a vegetable? ಬಂದ ಅಣ್ಣ ಅನ್ಕೊಂಡೆ why no, not even one person has come. Sir, in my home they cook. In your home they cooked. Probably in one household they will cook, or in one region they will cook. That cannot be taken as a definition by the lawmaker, noda. Tambuli ಅಂತ ಅವನು ಗೊತ್ತಿರುತ್ತೇನೋ. Tambuli is the central person in Delhi knows ada. Carrot he knows. Agreed, Now people based on that, it was derived that. Remember people, now whenever you're trying to understand a word, if a word has two meanings, one is people, a popular meaning. One is called as people, natural meaning. Or you're probably book meaning. People, if book meaning you're not able to understand, or if it is not making sense, then take the words which are popular in popular sense. If I go to 100 people, if I conduct a poll, if I conduct a research asking, is beetle leaf considered as a vegetable, I will get a no 90%, that I'm sure. Yes, sir. 10 you guys are there. 90 I know I'll get no. Correct, Popular words are to be understood in popular sense. That is what our first rule of interpretation teaches us. When you're trying to get confused, if you're getting confused between interpreting a law, exactly that's the case, beetle leaf case. When the lawmaker did not, I mean the court did not know how to understand the word vegetable because the lawmaker did not write it. Now I can't sit and blame the lawmaker for writing this law. I have to interpret, okay, what is vegetable? Now the subject matter is beetle leaf. How will the entire country understand the beetle leaf as? Versus, I will Google it. We Googled it in the class. It said Piperaceae family. What will I understand? So people, the grammatical word did not help me. Now what I will do, I will understand the word in a little popular sense. Popular sense, it's not a vegetable. Hello. And remember people, whenever there are two meanings, one gives me a narrower meaning, one gives me a wider meaning. If narrower meaning does not serve the purpose, follow the example, section 102, explanatory statement. I have to disclose interest. Interest doesn't mean here only money. It can be anything apart from money, and not only mine. Explanatory statement, if we are doing some business, if it is going to benefit, imagine my family member, my father, my wife, my children, I need to disclose that as well. I need to take it in a wider perspective, the word. Hello, that is what is this. When a word has two interpretations, one is a narrower, one is a wider. If narrower fails to achieve the object, follow the wider one. Understood? Third one, technical words are to be understood in technical sense. Example, what kind of person are you? Says our parents. According to them, person means you and me. Now people, but in reality, if we try to see the word definition, person in our class, person includes people, a human, a company, and trust, a HUF. That's a technical word. So when you're reading IT Act, you cannot take person there as a human. You need to treat the technical word in technical sense. Pakana, that shall, that's the first and cardinal rule of construction. Plain words require no explanation. Simple. That shall. Why does this much of build up for iOS? Easiest chapter. Rule of reasonable construction. Reasonable construction means what? Putras majis pulim comparet. What do you mean by that? When the plain meaning does not make sense, then people, you can construct your meaning. Example, sir, disqualification of auditor. The relatives can maximum hold securities worth how much? 1 lakh. The word used there is people relative. Now that 1 lakh, if I use literal construction, relative, one no. Relative can hold up to 1 lakh. Literal construction, one relative, one lakh. हमारा रिलेटिव्स का बहुत बड़ा टीम है, हम साथ साथ है. Correct, Noda? If I give 1 lakh to 1%, hey, full company will be mine. That is what correct, Noda. In India, you and me are relatives. Da. Pakka. Pakka. I'll tell you, da, there'll be one student of me. I'll have a mutual friend. How? World is small. We will have mutual relatives. Huh? What are no?
Yes, sir.
Believe, sir? My college. Is it?
Yes, sir.
Oh,
Not a sorry crush.
okay. I'll interpret my statutes. Okay. Now this is clear, huh? Now people see here. Now that is what they're telling you, people. When literal meaning is not making sense, people, you have to try to understand the intention. So the word relative in the Companies Act 2013, disqualification of auditor, you should not take one relative 1 lakh. The meaning and intention of the lawmaker would be all the relatives put together can be up to 1 lakh. If not, the section only will get defeated. So it's a reasonable construction that they have applied. Remember, there are high chances to ask you to write an example and explain this particular maxim. Remember that and write. Is this clear? Yes, sir. That's all. That's your second maxim. Statute must be interpreted as to lead to a sensible meaning. When the plain grammatical meaning does not give a sensible meaning, it leads to a construction. That is your reasonable construction. If code finds meaning defeats the law, it is a duty of the court to depart from dictionary and adopt construction which will suppress the mischief and advance the remedy. Clear this part? Okay. Third one, people, rule of harmonious construction. What do you mean by rule of harmonious construction? Harmony. Hum saath saath hai. Now, people, in a law, there can be a scenario, there is a conflict between two sections. It is your duty to read the law as a whole. You can't read only one part and I will only interpret that. I will ignore the second part. You cannot do it. It is your duty to read the law as a whole. Remember, people, when if at all there is conflict between two parts, I will try to go and read the sections. I will try to get some clue from the lawmaker. Lawmaker gives you a clue. Yes, lawmaker gives me a clue. How? By using certain words in the section. Like, if the word that is used is called notwithstanding, if the section starts with the word notwithstanding anything given in this act, that means lawmaker itself is telling this section is a superior section. Follow this. Forget what other sections have written. Follow this. This is superior. Who gave this hint? Lawmaker only gave this hint. Second word he can write. He might have written subject to. That means I am only telling you this section should be read subject to the other section. That means what, people? The other section is more important. This is a subordinate section. Hello? Notwithstanding and subject to are opposite. If at all a section starts with it's notwithstanding, that's a superior section. If a section has subject to, that's a subordinate section. Meaning, if at all any other section is speaking about the same subject matter, follow the other part, not this. Hello? Next one is people without prejudice. Without prejudice means people nothing but I do not intend to affect that section also. Try to read it together. Sir, what if both the sections are still contradictory? What to do? Always remember a special provision will prevail over the general provision. Again, I say special provision will prevail over the general provision. This is clear? All of you? Okay. Now, sir, see, what is the example we had seen? Article 13 we had seen? Okay. Article 13(2) of Constitution of India says people, no state, no lawmaker can bring a law which will take away your fundamental rights. No law can be introduced, can be changed, can be altered, can be amended in such a way that takes away your fundamental right. Where is it written? Article 13(2) of Constitution of India. But if you look at same Constitution of India, Article 368, it says lawmaker has every power to change any part of Constitution of India. He has not even written an exception. That means what? He has a right to change this also. 13(2) says you can't do anything. 368 says you can do everything. Even including I can change a fundamental right also. So you need to read it in such a way that it's an exception. 13(2) is only speaking about fundamental right. 368's intention is to cover the entire constitution. Probably he forgot to write that day 13(2). Can it happen? Ayo, pakka it will happen. Our lawmakers, I cannot say they are perfect. They are also humans. There will be mistakes. In class, I had showed you examples also. Companies Act only. If we sit, we can at least tell some 15 mistakes. It is still there. Yes. The best example is Section 3A of Companies Act. Each of them will interpret it in their own way until they get your, one remedy. Another example, OPC, resident in India or otherwise. Let how many? A lot of sections are there. Yes or no? Now, sir, they are telling you generic provision people, special provision will prevail over the general provision. Correct? That's the rule. When it is not possible, a specific rule will override a general rule. Hello, harmonious construction. Without prejudice, subject to notwithstanding. They can ask you in the exam, remember and go. Notwithstanding is superior. Subject to is inferior. Notwithstanding is always playing a generic role. Meaning I'm trying to give importance to the other section as well. Done. Next one, people, rule of beneficial construction or Hayden's rule, purposive construction, mischief rule. Remember and go all the rules, because if they ask you what is purposive construction, you should not feel what it is. So always remember, if a rule has two names, remember both the names and go. You should know if the question is asked in a second perspective as well. Hello. Now, what is this? The best example I'll tell you was that Smith versus Hughes. This is not there in our exam. It's not there in our syllabus, but it will help us to understand the interpretation. Very nice. What is this? There was a country in which there was a lot of prostitution that was happening, and the country wanted to take some action against it, and hence they passed one act in the country. That act was called Street Offences Act 1959. In that it was written, anyone who does these activities in the street will be considered as an offense and hence punishable. So any person who solicits people in the public places will be considered as an offense. That is what is written here. Now, what did one lady do? One lady was standing in her house, in the balcony of her house. She took one tumbler, she took a spoon, she started making sound. Now, whoever walks on the street, they look at her. And from there, she started giving signals. One day, when a police constable was walking, he noticed that and he filed a case on her and arrested. While she was arrested, there was a dispute. What? what she did, is it an offense or not? Why? Because the lawyer of this person started saying she did not do anything in public place, it was her home. As per the Street Offences Act, it is clearly written that you cannot do anything in a public place. This is not a public place. Now, people, the lawmaker wrote this, lawmaker went, Papa Judge, what should he do? Judge applied a rule called as Hayden's rule. Why is it called as Hayden's rule? It was first time applied in the case of Hayden, which happened in the year 1584. That is when the first time this rule was applied. So this was during given the kings and queens I'm talking about. Yes, sir. So, sir, they applied this Hayden's rule. Hayden's rule asks you 4 questions. After answering these 4 questions, you will have your answers. What is that 4 questions? First one, what was the law before making the act? We had no law at all. Second one, what was the mischief law did not provide? Clear, prostitution. That's why we wanted to bring this. Third one, what is the remedy the act has provided, the new act? We wanted to say no, stop it. The fourth one, what is the reason? It's bringing down the country as a picture, as the people are progressing. That's the reason we brought it. So this has nothing to do with place. It has everything to do with the intention. My intention was our citizens should not do this, irrespective of the place, but it was not written properly. And hence, in this case, it was clearly concluded that the intention of the lawmaker was not to say it's a public place, it was more to do with to stop this type of offenses. And hence, people, in this case, what the lady did was considered as an offense, and hence she was punished. One more example, Price Competition Act. In that, they have written, people, any competition, if at all you guys earn some prize money, is considered as void. Now you tell me why? Because that time it was like that, people. They used to do a lot of gamble. Now there are so many prize competitions you earn because of your skill, but that act did not write it. They said any prize competition, if you are earning prize money, is considered as what? Void. The intention of the lawmaker is not to tell every prize competition is void. His intention is to tell people anything which is earned, if you're winning based upon luck and not skill, that is void. That is his intention. That is what was discussed in Prize Competition Act. That's the example that is given here. Clear? Huh? That's there in our exam. Hello? Is this clear? Online? Okay. Next one, rule of exceptional construction, are also called as common sense rule. Why is exceptional construction? People, see, generic rule, people. Exception means what? It's an excuse. It's a different thing. But what is the generic rule? Generic rule is that in a law, even if they have written a single alphabet or even a comma, you have to read it for a reason that that particular thing will be used. You should not leave any word while you're reading the law. But at times it may so happen that if you're reading that word, it is not deriving you a sensible meaning. In that case, you are free to exclude that word while you're reading. That's why it's called as an exceptional rule. For example, there are 2 types of words. One is called as conjunctive, next one is called as disjunctive. Conjunctive means, people, a word which joins 2 statements. Example is and. Disjunctive means, people, which gives you an option, this or this. Example, small company, paid up capital of 4, turnover of 40. Disjunctive, CSR provision, 1000 crore or more, or 500 crore or more, or 5 crore or more, any one to be satisfied. That is called disjunctive provision. Now, why do we call it as an exceptional rule? Generally, and means both to be satisfied, or means any one to be satisfied. But at times, if I read and as and, it will not serve my purpose. Exceptional rule is that you can read and as or as and. The best example that I've given you in the class, people, was your what is that? PMLA, Prevention of Money Laundering Act. Correct? Now, what did we see under Prevention of Money Laundering Act? It said what do you point one it is there? Huh? 14.1 11 I've given you over section 3 somewhere towards the end. The chapter only towards the end, section 3 is there. No, it's not there. Is it? I thought I added it. Okay. So if you guys remember, people, I think you guys remember that section 3. Yeah. Now, what does section 3 say of PMLA, Prevention of Money Laundering Act? See, what does it say? Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment and projecting or claiming it as a untainted property, shall be guilty of offense of money laundering. The word used here is people and. Now, what do I mean by that? They're telling you, if anyone makes illegal money and he comes and tells to the world it is legal, then you are punishable under PMLA. Again, I repeat, they're telling you, if I earn illegal money and come and tell to the world that it is a legal money, I am punishable under PMLA. What if I earn illegal money? I will never come and tell to the world it is a legal money at all. I will just keep it with me. According to this section, I cannot be punished at all because both are to be satisfied. No, and now, if I apply this rule, common sense rule, exceptional rule, what? If I put and there, it will not make sense. I need to put it as or. If I even do illegal money, or even if I claim illegal money as legal money, if I do this or this, I am punishable under money laundering. Should be the act. In 2022, people, they changed it also. Today it is amended. Until then, it was considered as and only. Now it is or. In the recent thing, it will be or only. Understood? This is only called as what, people? Exceptional construction, or it can also be called as a common sense rule. Next one, sir. Same thing with regards to other thing also. What is that? Directory and mandatory. There are two types of words. One is called as directory, one is called as mandatory. Now, what do you mean by directory, sir? Something which says it is optional. The words used will always be may. Whenever it is, you have to do it. The words used will be shall. Exceptional rule, may can be read as shall can be read as may, to interpret the law. Next one, people, rule of existing generis. What do you mean by existing generis, people? If I know the word 1, 3, 5, comma, they have given dash, it will be considered as 7. This is only called as, people, same species. When there are enumeration of words, enumeration means what? A list of words, series of words. But that series of words should belong to a category, odd numbers. For example, cat, comma, dog, etc. Now, what do I mean by the word etc. here? Lion can come, rabbit can come, maybe. So, I'm assuming that the series of words represents a category. That is nothing but people, probably pet animals.
Inspection also for any other business.
Correct. That Anil Kumar thing. This is where we had seen that inspection, register of members. In fact, I told you also we are doing that. So, sir, that is only called as existing generis. Whenever there are series of words, specific words, enumeration, if it constitutes a category, such class or categories should not be exhausted. Meaning, I should have not written every word. Cat, dog, rabbit, donkey, everything I've written. Nothing else is left. Then you cannot apply this rule. General terms for the enumeration, general term is etc. And there is no different meaning that the legislator has prescribed. Then people, we will understand the meaning by using the maxim called as existim generis. That means nothing but, people, when there are series of words, series, and that series belong to a particular category, the general word will always take the meaning of the special word. Hello. See, arms, ammunition, gunpowder, any other goods. Any other means what? Wine? No. Can I say RDX? Yes. That's the meaning of a category. Clear? Huh? Okay. Next one, people. Secondary rule of interpretation. Now, what do I mean by that? Secondary rule, I have the first thing that is called doctrine of contemporanea exposito. What do you mean by contemporanea exposito? Contemporanea means, people, nothing but contemporary. On that day, when this rule was made, who was there on that day? For example, SEBI SCRA Act was there, 1956. SEBI Act, 1992. Now, when these acts were made, who was the regulator? Who was the authority? Is there anyone like that? Yes. Who is he? SEBI. If SEBI has given you a particular way to interpret the law, follow him. SEBI is not a lawmaker. SEBI Act was passed in the legislature by lawmakers. SEBI was a body or authority created to take care of the law. Now, he will be called as contemporary authority, like a regulator. If he is giving any interpretation, follow that. Hello? Yes, sir. So that is what they say. Optima legum interpres es constitute. What do you mean by that? The custom is the best interpreter of law, and contemporanea exposito es optima et forti senia in league. What do I mean by that, sir? The contemporary authority, whatever he has given, that is the best way to read it. And remember, to understand the meaning of a word, you can't read it sitting in today's date. Indian Contract Act, if you sit and read in WhatsApp generation, that act was made when it was a letters generation. You can't understand it. You have to read it as if today still letters are prevailing. That is the mindset you should have to understand the law. Best way to interpret a document is to read it as if it would have been read when it was made, letters. Hello? The best interpreter is that made by a contemporary authority. That day, whoever was there, if he has given a rule, follow that. Next one, people, doctrine of nociter assoces. What do you mean by nociter assoces? Nociter means, people, no, your. Assoces means associates. Example, what do you mean by red, blue, orange? What do you mean by orange here? What do you mean by orange here? Now, what do you mean by orange? Exactly is called as nociter or sources. When a word can have dual meaning, how do I have to put the, what do you mean by that meaning? How do I understand? You need to take the meaning of the word depending upon the words it is with. So I generally say, no, what? To know who you are. You are a summary of your friends. Your four friends define who you are. Correct? Huh? Know your associates. Know your friends to know you. Exactly is this point. Understood? Huh? So orange meaning will change when it is used with red and blue. It will change when I use it with apple. The word which is people don't get confused between this and agistum generis. Agistum generis, the word does not have meaning of its own, etc. Do you have a meaning? Any other goods, you have a meaning? Other, what meaning you have? Orange has a meaning, but it has more than one meaning. That's why no cite or sources will come. Agistum generis is a generic word. Hello. I hope this is clear. Okay, next one, people. There are aids to interpretation. There are two aids. One is internal, external. Internal aids, which is there in the law only. One is called as a title, short title, long title. Today's date, there is no difference, but back then it was there. Today's date, long title and preamble are almost one and the same. Because long title is nothing but people which speaks about the purpose of law. Correct? Huh? But when do we differentiate? What do you mean by short and what do you mean by long? Short title can be Companies Act. What do I understand based on that? Imagine Prevention of Money Laundering Act. It is clearly telling you what is the purpose. Prevention of sexual harassment of women at workplace. Posh. The act only is like sentence, da. Long title. Understood? Huh? Yes, sir. But here they have written it people in a way which is to understand like a preamble. Earlier old acts always had preamble. Today we don't have preambles for the acts. Best example is Constitution. You have preamble. Companies Act does not have preamble. Those days people used to write one paragraph, one page. Why did we make this law? We, the citizens of India, solemnly, you guys, it's a statement, it's a paragraph. Secular, democratic, republic. We wanted to give this to our citizens. Why? We did not have that. See, when we were under British rule, they did not allow us, they did not treat us as same. They did not allow us to follow the religion we want. That's why we had to write the words secular in our constitution. Are you getting it? So that's the preamble, that's the purpose. Today's date, we don't have it. Today's date, long title only is the purpose. Understood? Huh? Okay. Remember, the clear act can never override, the titles can never override the section. Section is clear, I will not seek the title. Same thing, preamble always tells the purpose of the act. The best example is one Christian boy and a Hindu girl got married as per Hindu Marriage Act. In Hindu Marriage Act, it is clearly written that what? Two Hindus may get married. That is what it is written now. So the Christian boy said, see the words may is written there. That means it can be Hindus or it can be anyone else also. But the preamble of Hindu Marriage Act says people, it's an act to codify the law between marriage of law between amongst two Hindus. That is what is written. So the preamble is clearly saying this act is passed for the purpose of the marriage of Hindus. And that's why people, they interpreted this law and said this marriage is invalid. Understood? Huh? The word may there is not speaking about, it can be anyone. The may there is speaking about choice. Hello? Next one, heading and title of a chapter. Example, heading and title. Accounts and auditors. Incorporation of company and incidental matters. Prospectus and allotment of securities. Companies Act has so many chapters, no, that can also help you to understand the meaning of a word. Next one, people, marginal notes. Remember, marginal notes is never an internal aid, except in a few places. Constitution of India, The lawmakers itself wrote marginal notes. What do I mean by marginal notes? If at all the book has such lengthy paragraphs, if a book has lengthy paragraphs, I will write people summary of this is this. This is called marginal notes. Marginal notes are always written by interpreters, authors, not the lawmaker. That's why we cannot consider marginal notes as an internal aid. But in a constitution of India, people, it was an internal aid. Clear? Huh? Because it was written in the lawmakers itself. It was written by lawmakers. Clear? Next one, definitional section. Simple, follow definitional section. In the definitional section, there are two types. This one is more important. What? The definitional section can be restrictive and extensive. Restrictive means people, that's all. You cannot extend. Let us imagine if they have used the word, say for example, company for, body corporate means foreign company, foreign LLP, Indian company, Indian LLP. If that is what they have said, you cannot add few more people to that. That's all. That is the meaning of the word body corporate as per Companies Act. You cannot add more to it. If the word says includes, you can add to it. For example, in your Sale of Goods Act, you said goods includes stock, shares, grass, things growing in the land, and you can add car, everything can be added. Include means like an example, you can extend the definition. Means restrictive, include extensive. Means and include, you have to take it as restrictive only. Wherever the word means comes, it's restrictive. Hello? Apply and include, again you can take it as extensive. You can add to it. Deemed to include people, extensive. Best example is your subsidiary company definition. Correct? Huh? Ambiguous definition, nothing but people. You have to read the act as a whole, not in isolation. Next one, illustration. Best example, Indian Contract Act. For every section, the lawmaker only has given you the example. It is not something your, mine, or any institute has given. It is given by the lawmaker only. It will help us to understand the act better, no? Next one, proviso. Proviso is nothing but people, an exception. Similar to your, okay, best example of proviso, private company. What is the maximum number of members in a private company? 200. Provided, that provided is called as provision. Joint shareholders should be treated as one. In a public company also will you do that? No. It's only in the case of private company. Provided the past and present employees are not counted in the number of 200. What if in a public company there are employees? Should I count them or exclude them? I have to count. It's only for private company the definition is. Hello? Getting the point? That's the meaning of proviso. Proviso is nothing but from a generic rule. There is a little deviation. Only for you, not for everyone. Good. Next one. Explanation. Associate company means a company having significant influence. Significant influence means explanation. 28 or 50%. Lawmaker only gives the this one. Schedule 3, Schedule 7. What is Schedule 7? Anything which is forming part of the act itself towards the end. Why do we have schedules? Because the act will become thick. Section 135, if I put schedule also there, it will become 5 pages. So for a person who needs it, go and refer it. We will write it. Schedule 3. If I write it in your financial statements, the format of balance sheet, it will go to 8 pages. So what do? They keep it towards the end. That's why it's called as schedules. Schedules always come towards the end. Next one, people, read the statute as a whole. Never read it in bits and pieces. The last one is called people external aids. Historical setting, meaning past, history. It will help you to understand what or why. Best example was this chief rule, no? Consolidating statutes and previous law. For example, today, if I have any confusion to understand GST, before that, what was the rule? Service tax? VAT was there. So in that, if I have a doubt, refer that. There can be some cases decided. You will understand something. Next one, usage, customs. Earlier and later acts. Pari materia. What is the earlier and later acts? Earlier and later acts means people nothing but whenever similar to harmonious construction, there is a dispute, but harmonious construction is the same act. This is people, there is a conflict between two acts. Example, take this only, minimum application money. As per Companies Act, what is the minimum application money you have to collect? 5%. But as per SEBI, then each of the act is saying two, no? But Companies Act only says follow SEBI. That's why we are following SEBI. What if that is not the case? We will follow this one. Understood? Huh? When two different statutes are there on the same subject matter, then you have to read together. But if we are not able to do it, then people, repealed act always loses its operative force. That is what? Meaning, if there is already one act which is removed, service tax is not there, VAT is not there, I will not follow it. So what if both are there? Like SEBI Act is also there, Companies Act is also there. Always remember, later act will prevail. SEBI Act 1992, Companies Act 2013, which will prevail? Technically, as per this rule, Companies Act should prevail. But in our case, Companies Act has clearly told me, follow SEBI. That's why SEBI will prevail. Hello. Next one, dictionary definition. Go outside your section 2 dictionary and now go Oxford Dictionary, Google Dictionary, Chat GPT Dictionary. Next one, use of foreign decisions. Nothing but all your past. Carlillo, Carbolic Smoke Bar Company, Salomon versus Salomon. All this will become binding on us. But remember, it is just a help. I'm not saying our Indian courts have to follow. It is just telling you that people, you try to take that as a help if you are not able to make sense. But remember, whenever there is a conflict between Indian judgments and foreign judgments, Indian judgments will prevail.
Yes,
Clear?
yes,
That's all. Okay. Let us start general. We'll taka finish it off. Okay. General. Which one? Interpretation of deeds and documentation. Correct. Interpretation of deeds and documents. Now, what does rule of interpretation of deeds and documents say, sir? First one. Remember, here one important rule is that whenever I'm trying to understand any word, what do you mean by deed? Now, two people have entered into one agreement. Let us imagine sale deed, partnership deed. Now, they have used some random words there. Now, if you are not able to understand these random words, how do we understand this particular word? They're telling you, try to understand how a common man will understand it, or try to understand the knowledge level of these people, what they might have used that word for. Don't use dictionary meaning and all. According to them, what do you think is that word? Use it in that sense. Are you getting it down? Hello. So keep that one thing in mind. Somewhere, see, in the deed, it is clearly written that delivery of a property. Now, how do I have to understand the word property? According to you guys, layman, what do you mean by property? Immovable property, asset. According to a lawyer people, in legal terms, property means ownership. You guys would have also seen it in Sale of Goods Act. So, now if two people have written it, what is their knowledge level? Do you really think they would have meant property means ownership here? No, according to them, property means immovable property. So that is how the lawmaker, if there's a conflict between people, I'll have to try to keep their layman terminologies in mind. I need to know who the parties are, not just the word.
yes,
So the document have to be read as a whole. Of course, what if there's a conflict? There's a conflict between first clause and eighth clause. Which one will prevail? Which one will prevail? 1 or 8? Remember, first clause will prevail. But in the act, it is opposite. Later clause will prevail. Hello? The circumstances in which the particular words are used. The status and training of the parties who are using the word. Property. It is an elementary rule of construction that the same word cannot have two different meanings. Sir, orange in the first paragraph means fruit. In the 8th paragraph, orange means color. That cannot happen. Property in the first paragraph means immovable property. Property in the 8th paragraph means ownership. That can never happen. That's the meaning they're telling you. Hello. If there is a conflict between two, earlier clause will prevail. Hello. Done. Associates. What is the difference? Existing generals will never come there because orange has its own meaning, no? Existing generals can only come. The word only says what? A generic word follows an enumeration of words. Now, what is generic? Anything which does not have a meaning of its own. Okay, I'll say who can come and attend the marathon? ICU students, our regular batch students, and any other person. Now, what do I mean by that? Why any other can be any student, no? Why? Any other person doesn't have a word. So any other person here can mean even if you're a past student. I'm saying you're connected with Arivu. You're getting it. So that word any other person doesn't have a meaning of its own. That is when existing members will come. Clear on? Okay, the last one is called General Clauses Act. Okay. In general clauses, which one we should do? Okay. What is the object and purpose of General Clauses Act? As I told you people clearly, why did they pass General Clauses Act? Try to understand the intention. I cannot define certain words in every act. Imagine central government is passing law. Financial year in every law means financial year only. Why should I define it in every place? If it is defined in General Clauses Act, that means it is defined in every act. So, what was the intention of the lawmakers to come up with something called as General Clauses Act? Their intention was this very simple, people, to avoid if I miss out defining any word in an act. Now, what to do? To be safe, I defined all the important words in one act and I said it is applicable for every act. Second one, by doing so, I avoided from the acts becoming thick. So we use a word called as superfluity. Superfluity means the acts were becoming voluminous, thick, because every rule I have to explain. Hey, the word distance means here. You have to read it like this. Hey, in Companies Act, I've used the word. A director will be liable for 5 lakhs. Here I mean, means people. It can be singular or plural. I've written he can hold shares up to 1 lakh. I have to write he here means she also. Look at how many clarifications should I give? In how many acts you want me to give? That's why the lawmaker said, don't worry, let us define all these rules in one place. It means it applies to all the central acts. Remember, General Clause Act we have for states also. States will pass it. Yeah. But what we are seeing is in central. Clear? Hello? Okay. That is what people, the purpose of the act was decided in the case of Mines versus Karamchand Tappar. It said it is for the purpose to place in one single statute different provision as to interpretation of words, distance, masculine, feminine, singular, plural. The purpose is to avoid tutti frutti of language in statutes. Correct? Huh? Yes, sir. Okay. Anand Behara will come back. Immovable property definition towards the end we will do. So, okay, let's start with section 5. Coming into operation of enactment. When will the law come into force? When now? The law will come into force, people, if date is specifically mentioned in the act. The law will come into force on that day. What if in the law the date of enactment is not given? If date is not specified, the day when the act has been agreed by President of India or Governor General. Forget this, remember this. President of India. So whenever President of India signs, that is the day on which the act will come into force. Hello. Next one. Effect of repeal. What do I mean by that? Now people, service tax is removed. Companies Act 1956 is removed. What if there are companies which are formed under Companies Act 1956? All those licenses will come to an end. Now Reliance and all was formed under Companies Act 1956. They're telling you, effect of repeal, people, will not take away any rights, liabilities, licenses, privileges, litigations, obligations, penalties, investigations, inspections. Nothing will go away. Everything will continue. Simple. Section 6. It will not revive anything. It will not affect any previous operations. No right, privilege, obligation, liability, penalties, punishments, inquiry, litigations, nothing will go away. Everything will continue. Hello. Okay. Next one, sir. Section 7. Revival of repealed enactments. What do you mean by people? What I've tried to do here is I've tried to put the entire section from 7 to 29 in one line. You read this is more than a page. You can actually remember everything. Some. But remember, this is only for revision. Some. Not for the first time read. One person had written on Instagram, sir, I tried to read this. I'm not understanding anything. Hey bro, how can you understand in one line? Da? You read something, you can correlate. Spoon feeding irbeko. Okay. Section 7. Revival of repealed enactments. Sir, because of any reason, we removed one section. Later, we want it back. Can I bring it back? Yes, it seems. Whether as a whole, imagine the whole act is removed. I want to bring it back. Can I? Yes. Sir, I want to bring back only one section. Can I? Yes. Just that you have to give a reason behind it. Example, section 11 of Companies Act, which spoke about commencement of business. In 2013, they said section 11 is important. In 2015, they said not important. They removed. In 2018, they were important. They added. So 10A of Companies Act came into picture like that only. Hello. Section 7. Actually, if you read in book, I would have given you cross references. When you're reading this, read the other one. Effect of repeal, section 7. Also read section 24. When we're reading section 6, what is that section 24? Come and read. Now, section 24. What does it say? Order, scheme, rules, bylaws of repealed enactment shall continue to re-enacted law unless otherwise specified. What do I mean by that? In Companies Act 1956, if at all we have passed any schemes, MSME scheme, it will continue. Just because Companies Act 1956 came to an end, that scheme will not come to an end. If in Companies Act 1956 we have passed any rules, it will continue. Everything will continue unless the law clearly says no. All that also will come to an end. If you have clearly written in Companies Act 2013, then yes, everything will come to an end. If you have not written, orders, schemes, rules, bylaws will continue even after the new act comes into picture. Hello. Okay. Next hint. What does our law say? Section 7. Read it with. We have to read one more thing, no? Reference to This only. Section 7, Section 8. Construction of references to repealed enactments. What do I mean by that? If I'm reading Income Tax Act, what do you mean by a foreign company? Income Tax Act says foreign company means as defined under Companies Act 1956. Today, Companies Act 1956 does not exist anymore. That means what? Foreign company does not have meaning. They are telling you when such act is repealed and it has been replaced by a different act, you also read it when Company IT Act is giving reference to Companies Act 1956, you read it as if it is 2013. Simple. Yes. So now my question is, can one act give a reference to another actor like that? Instead, they can only define no. Why? It becomes lengthy. Best example, securities definition in Companies Act 2013. We said follow Securities Act because it's a 1.5 page definition. We are telling whatever is the meaning of securities under Securities Act, same thing will apply here. So is it okay, na, sir, to give a reference? Yes. Where is it given? Section 28. Read. Citation of enactments. One law can give a reference to another law. Allowed. Section 28. Read it in the same order. You will understand better. Clear? Huh? Yes, sir. Okay. Now, next one, sir. Section 6A we didn't do. Section 6A says what, people? Repeal of act making textual amendment where any central act or regulation made after the commencement of this act repeals any enactment by which the text of central act was amended. Express omission, insertion or substitution of any matter unless a different intention appears, the repeal shall not affect the continuance of any amendment made by the enactment. What do you mean by that? Same thing. In Companies Act 1956, any amendments were passed. Companies Act 2013 will not replace those amendments unless you clearly said so. Amendments will also continue. Simple, huh? Okay, next one. Section 9, commencement and termination of time. I have already told you when we are doing declaration of dividends. What do you say? Whenever I'm counting time, people, they are telling me that I have to exclude the first day. Dividend was declared on 1st of Jan. Don't count 1st of Jan. Count 30 days from 2nd of Jan. Exclude the first day, include the last day. That's all. That's the rule of section 9. Hello? Sir, now imagine in any particular law, they have clearly told that, imagine in transfer and transmission of securities, if the company fails to register the transfer, I need to go to the tribunal within 30 days. What if on the 30th day the court is closed? Go whenever the court again opens next day. So the last day, if at all the authorities are closed, take a reference to the next day. Done. Section 10. If the court or office is closed on the last day, if closed, then day next to court opens will be considered as a reference. So the 31st day, if it is open, go that day. It is allowed. Hello, sir. Now, whenever it is clearly written that whenever there is a educational institutions, you are not supposed to sell tobacco in 200 meters. The 200 meters, how should I take it? Betta Atkondo, go to Mysore, come back to Kerala, come to Bangalore. Should I take it like that? Sir, it's one way, I can't come back. So it is 5 kilometers. Can I take it like that? No. Always take it in a horizontal plane and it's a straight line. I have to take it like this, not in the way the direction goes. So it's always horizontal plane, not diagonal, not vertical. Horizontal, straight line. Hello. That is what is your section 11. Done. Measurement of distance to be taken in a straight line on a horizontal plane. I hope this is clear. They'll ask you exams, question in the exam based on this only. Yes, sir. Environmental pollution says a company cannot set up a factory within 50 kilometers of a population of say 10 lakh. Now 50 kilometer, how should I take? Horizontal and clear. Now, sir, in the law it is clearly written, sir, for if I'm importing one, say for example, bottle of wine, I need to pay a import duty of 200 rupees. What if I'm importing two? What if it is three bottles if I'm importing? How much I should pay? The answer is easy. There is no A plus B whole square and all 600 only. This is a problem. Sir, something is problem. I know this is not so easy. Your mind only will be easy. That is only called as next section what? Pro rata.
Yes, sir.
If the act gives a reference to one number, if you are importing more or less, you have to take it as a proportionate one. Hello. Sir, if the act says he shall be punishable, if the act says she shall be punishable, then if the act is saying he, can I punish she?
Yes.
She, can I punish he? Masculine includes feminine, feminine includes masculine. But macha, not everywhere. Yes, sir. So, and remember, when I clearly say he shall be punishable, that means I'm giving a reference to one person. No, singular includes plural, plural includes singular, relative. Disqualification, no. Done. Correct, Amacha. Only place where we see gender equality. Correct. Section 149 of Companies Act, women director, women only. You can't go and say, sir, in that quota, give it to me. Yes, sir. Next one. Section 14, power conferred may be exercised by authority from time to time. ROC is given power. You can incorporate, you can allow registration of companies. In 2013, they gave that power. It is not applicable only for 2013. ROC can use that power from time to time. Section 14. Section 15, power to appoint may be made by name or ex officio. What do I mean by that?
For example,
Correct. Now, MCA government can pass an order. Whoever, okay, Nirmala Sitharaman is clearly appointed as a Ministry of Corporate Affairs. The first way of appointing. Second way, whoever is a Minister of Finance will be the Minister of Corporate Affairs. Second way. First way is appointment by name. Second way is appointment by ex officio. Ex officio means what? Based upon your right in one place, you are getting a right in another place. For example, whoever is the FM teacher of Arivu will become the CFO of Arivu. If FM teacher changes, CFO also changes. Hello. Done. Next one, section 16. Power to appoint include power to suspend or power to dismiss. Section 8. You guys saw central government has a power to give you license. But if you guys are violating it, I have a right to revoke also. A person who has a right to give you also has a right to. Section 17. To indicate the application of law to a person executing function of an offense, it shall be sufficient to mention the official title. Meaning what, people? For example, if I have to tell what is the power Nirmala Sitharaman has, I can say Nirmala Sitharaman Ji, you will have the following powers. Or I can say whoever is a Ministry of Finance, you will have the following power. I can clearly write it in person or I can write it in title. Whoever is the person who holds that title that day will have that right. Like for example, you and me will get a offer letter, but there it will not be offer letter, right? Tomorrow, if the minister changes, the law changes. The power will go to a different person. Next one, section 18. To indicate relation of law to successors or functionaries or corporation and personnel, express its relation to such functionaries or corporations. What do I mean by that? It's nothing but people, IEPF authorities, SEBI, bodies which have perpetual succession. So I will write it there as what? Chairman of IEPF. I will not write person. So same thing applies in the case of bodies having perpetual succession. So one is with regards to the person. One is with regards to the bodies. Bodies means what? IEPF. Tomorrow, chairman of IEPF will change. Same thing they're telling you. I can just write, whoever is the chairman of IEPF, he will be enjoying these rights. Tomorrow, chairman changes, the rights will also change. Sir, what if registrar is busy, marriage season, is going, sick leave? Who will do? Registration, incorporation, who will do? Whoever is his assistant, he will do the role of registrar that day. Now, when he is doing that role, what power will he have? Will he have the power of the superior or the inferior? Remember, whenever you are doing a role in his position, assistant registrar is carrying out the role of the main registrar. You will have all the rights and liabilities of the main registrar. In exam, they have asked this 2-3 times. Remember and go. Section 19. Hello. Section 20. Notification, order, scheme, rules shall have the same respective meaning as per the act. What do I mean by that? If I look at an amendment, people, in amendment, they again define a small company means, subsidiary company means, no. Whatever is the meaning that is applicable in the act, in the rule, amendment to notice, circular, orders, same meanings will apply. Hello. Section 21, power to issue include power to add, amend, vary, resign, notification, rule, etc. Correct? If I have given you a power to issue, I have a power to amend it also. Best example, small company, which is amended as well. Section 22, establishment of any court, appointment of judge, fees with respect to act which has not come into force, it shall not be effective until commencement of the act. What do I mean by this, sir? Remember, people, the whole act need not come into the picture on day one, or it need not come into force on one day. It can take time. Best example is Companies Act. NAFRA came into picture in 2018. NCLT came into picture in 2016. But the section of NAFRA, section of NCLT was already there in 2013 Act. On the August 2013, NAFRA was there, 132. Then when is NAFRA effective from? NAFRA is not effective from 2013. NAFRA is effective from the day the law officially passed it. That is when? 2018. That is what they're telling you. At different parts of the act can be effective from different dates. It need not mean the entire act should come into force on one day.
Yes, sir.
How to make rule? We have seen this. How? Form a committee, prepare a draft, put it in public domain, take comments, put it in Lok Sabha, Rajya Sabha. They will give you things. Take President of India approval, official gazette notification. Section 25, recovery of fines. If an act says how to recover the fine, recover like that. If the act is silent, then follow IPC and CRPC. Today it is of course replaced by BNS. Section 26, one person shall not be punished for same offense. They can ask you a question, they've asked also. What is this? For the same offense, I cannot be punished under two acts. It is also called in Constitution of India double jeopardy. A person cannot be punished twice for the same offense. Hello. Service by post deemed to be affected by. Now, what is that, sir? A court has sent a notice to anyone who is having Aadhaar card here. Everyone has. Okay. Anyone who is not staying in the address that you guys have shown in the Aadhaar card? Yes. Okay. Name. You want me to tell? It's okay. No, Sandhya is staying in address. According to the government records, Sandhya should actually stay in where? Madiwala. Where is Sandhya staying? It's a different place. Okay, different building. Now, people, you think if at all government has to issue any summon to Sandhya, what is the address that government has? Madiwala. Now, is Sandhya there? No. So she never knew that a summon is received in her name. Now, my question is, what do you think? Has the court properly given her notice or not? They have sent to Madiwala. Have they given?
Yes, sir.
They will ask only 3 questions. What is that? First one, is it a properly addressed post? Have I clearly written? Yes. Second one, is the post paid? Stamp to everything is paid? Yes. Third one, is it a registered post? Answer is yes. That's all. The court has given you the notice. Whether you received it, you are there, you are not there, irrelevant. Any liability, you will be liable. Understood? Yes, sir. Section 29, general gross existing, this one, you leave it. It's okay. Clear? Hello? Easiest way. That's a simple chapter. Yeah, the tension kaiku. Okay, there is one important definitions. Let us look over the definitions only. What are the definitions? Financial year, immovable property. Immovable property, definition people, immovable property. That means extensive or exhaustive? Extensive, we can stretch it. Hello? Land, benefits arising out of land. Mango. Mr. A sells to B right to pluck mangoes and you sell it. I sell this right for 15,000 rupees per tree. What type of contract is this? This contract is called contract of immovable property. I sell my right to take the soil from the land. What type of right is this? I'm not selling my land, I'm selling the soil on the land. What type of right? Immovable property. Why? See, any benefits arising out of land. You guys can think, what will I use the soil for? It depends. If you are a nursery, red soil, open Amazon, you will know the value where we are today. I only ordered recently. Heavy, expensive. Cocoa pit will cost you 5 kgs, around 600, 700. Then we have reached that stage. But you go to village and you say, I purchased it, they will laugh at you. Huh? You're actually, I remember people 15 or 18 years back, one of my uncle had come from village. That day we had gone out. Remember, I think 18 years back or something. We had purchased a water bottle. That day my uncle had laughed. You guys are purchasing water. You're getting where we have come water. That water only we purchased. Today we are purchasing soil. Air is already, I don't know if you guys have seen Shark Tank. Air is already there. Oxygen masks are coming. Sir, oxygen mask is there, sir. That not, it will come like a purifier, like a perfume. Generally, people going for hiking, high altitude areas, they will use that because there will be oxygen supply will not be there. Now in Delhi, they are using it. There will come a time, of course, in Delhi, technically, if you see it is in that stage, Deepavali, 20 days, it will be off. You can't see people. I mean, if Bangalore, another 10 years, same state. Nah, there also they had. I'll tell you, if you think cutting one tree is okay, then we are the next whichever state. That's the problem. We will think, hey, right in front of my home, there is one tree that is causing some disturbance. Then everyone is feeling the same. Then every tree is going down. Urban development. Come up with good road. Take away the trees. Okay. Third one, things attached to the earth. What is things attached to the earth? House, tree. Hey, is tree movable or immovable? Movable, sir. Dance ಆಡತ್ತಲ್ಲ. Bahubali, sir. Ayyo, 180 degree. Huh? Remember, if you enter into a contract to cut a tree, it becomes a movable. Until you enter into a contract to cut a tree, it is immovable. As long as it is in the land, without any agreement to cut it, it is immovable. Hello? Permanently fastened to anything attached to earth. What is attached to earth? House. Anything that is permanently attached to the house, that is nothing but door. It can be windows. Which one?
Like people who are doing farming,
Huh.
they separate land and then plant mine, they grow those plants for years.
Huh.
Then they sell it, the whole, like the land, they'll sell it
Land is immovable only. Directly immovable. No? Immovable only. It will come directly here. Okay, where in any enactment the definition of immovable clause is negative and not exhaustive, the definition as given in General Clause Act will apply. See, soil, right to build, right to grow new trees, fishery. I have a pond in my land. I'm giving that right to do fishery to someone. That is nothing but it will come here. Things, benefits arising out of land. Hello. That is one important definition. Next one, imprisonment. What do you mean by imprisonment? In the past, they have asked once, 20 September 20, Allah, May attempt. Imprisonment shall mean imprisonment of either description. By section 53, the punishment to which offenders are liable under the act are imprisonment which is of two descriptions, namely, one is rigorous and one is simple. So imprisonment can be of two types. One is called as rigorous, one is called as simple. What do you mean by rigorous imprisonment? Rigorous imprisonment means people. Best example is Sanjay Dutt. He had to put labor while for whatever he had arrested for. Correct? He was doing carpentry, or they can even tell you to hit rocks. So there will be intense labor that will be involved. That is only called as what people rigorous imprisonment. See, in our act, every place they have written just imprisonment. Noda. In imprisonment, what will you do? Go your rooms. Everyone come there and you chit chat. There should be something, no? Remember, it depends upon what is the offense you have done. A pickpocketer. What will you do to a pickpocketer? It will be simple. Imagine offense under Companies Act. Now what? Sir, I have not declared dividend. We have declared dividend. We have not paid it on time. Rigorous, sir. Hey, dividend you have not paid on time. Rigorous, sir. Put him under the train, sir. Make the trains go on his hand. Hey, in final destination, yes, sir. That's what it is. Simple is nothing but you see what he has done. Pickpocket. For that, what you want to do? Put him in jail. Teach him lesson. But in that, what you want to do? Victims are every day. Correct, Indian law, month means what? Chaitra, Vaishaka, British calendar. Official gazette is nothing but it can be Gazette of India or Gazette of State, which is technically published by who? Department of Publication, which comes under Ministry of Housing and Urban Affairs. Person includes, extensive, exhaustive. Extensive. They are saying company, association, and body of individuals. What of LLB? LLB also can come because it is includes. You can stretch this definition. It's extensive. Swear, oath, affidavit, everything same. Pinky promise. Year means British calendar year. What do you make good faith? A thing shall be deemed to be done in good faith where it is in fact done honestly, whether it is done negligently or not, is considered as what people? Good faith. But here there is one contradictory statement. See, the term good faith has been defined. This definition may be applied only if there is nothing given in the other act. Nothing is said to be done in good faith. What? Nothing is said to be done in good faith, which is done without due care. What is this then? And they're giving clarity using General Clauses Act. Yes, sir. So today that what do I have to interpret it as? You have to interpret the full thing. That means what? To call something as a good faith, I should have put my due care. Due care means what? I should not be negligent. Hello. Okay. Government battery. Enough. Then covered more major. So that's your General Clauses Act. Clear? So that is your CA inter corporate and other also marathon. I hope our knowledge level after marathon has increased at least 1%. Now, people, what is the weightage that they have given till now? Now, okay, now see here. From the definition parts, what I will do is, people, what is the minimum given? what is the maximum given? That should serve the purpose, huh? Hello? Okay. The minimum and maximum from the definitions section. The minimum peoples, there are attempts that there has been 0 also. So I will take whatever is the minimum asked. There has been minimum of 4 marks. They have gone up to 5 marks from the definition sections. I mean definition chapter. Incorporation of matter. I'm taking an average of the last 6 attempts. The minimum has been again 0 marks is also there. There has been 4 marks. There has been 5 marks. From the third chapter, they have always asked the question in the last 6 attempts. The minimum has been 5 marks. The maximum has been 10 marks. In chapter 4, there has always been a question asked. Minimum asked has been 5 marks. Maximum has gone up to 7 and 10 marks. So you can write 10 marks. Acceptance of deposits, always there has been a question. Minimum has been 3 marks. And there is one attempt which is in 2024, they have asked once 13 marks. Lottery. That day if you have letter, none. Yes, sir. Why I am saying that is, you need to know when you are taking risk. Yes, but every attempt they have asked the question. Next one, people, is chapter 6, registration of charges. There has always been a question. Here, there are been attempts where 0 marks are also there. They have not asked. Minimum, if I have to put it, they have asked 5. May attempt people, there has been 15 marks. Sir, that attempt I should have left and gone, sir. Hero. Huh? Chapter 7, always there has been a question. Minimum has been 6 marks. Maximum has gone to, remember people, if I take the last 4 only, it's been 13, 14, 15. That's the marks. So constantly for the last 4 attempts, it has been more than 10. I'm writing as 15 and I'm putting a special mark there. Remember, 15 marks. There has been dividends 0 also, but constantly it is 5 and 5. Most of the attempts. Chapter 9, last thing, if I take only the previous 6 attempts, minimum has been 8 marks. Maximum has been 13 marks that they have asked. Audit and auditors, minimum has been 3 marks. Maximum has been 9 marks. Chapter 11, minimum has been, of course, 0 is there. If I leave that, it has been 5, but they have asked 11 marks also. General Clauses Act, for people who ignore and go, I'm telling you, I'm writing the attempts also. 8, 10, 11, and 13. 4 attempts. It's going, Allah. There has been an indirect question. Case laws, Allah, there is an indirect case-based question that is being asked. For example, I just told you, the factory. It's a case-based question. If you ask me, indirect question only, no. Hello. IOS, if I have to say, minimum has been, pakka question will come down, 0 alla baralla. Maximum has been 10 marks. FEMA, minimum has been 9, maximum has been 15. Constantly for the last 3 attempts, it is 14 marks. Very important. Huh? LLP we didn't write. LLP minimum has been 5 marks, maximum has been 9 marks. Now, ABC analysis and all I'll not say, but I'll tell you which are the chapters you have to mandatorily concentrate. First thing, Dil ka Dhadkan. Why? Take only minimum. Add. Can I say 8 plus 8 plus 9? Can I say 25? Yes. Add LLP also there only. Macha, 30 done. I'm not even touching the upper. Yes. Now, what are the major chapters in upper? One, accounts of companies. Chapter 9. Very important. So, if you call these as A, these are all A chapters. Next one is management and administration. Why? I told you. See, constantly there is 13, 15, 12, 11. Remember and go. Yes, sir. And see, if I keep giving, I'll give you everything. The next thing I'll tell you is, people, give more weightage to the 3 small chapters you know. Which one is that? 1, 2, 3. Everything is having a chapter weightage of 12 pages. Dividend so is 8. That time should they technically think the 77 to 87 charges. 123 to 127 dividends. 73 to 72 sections is deposits. You should remember. That's all. 3 chapters. Weightage no count. Technically, it has put everything put together 40, 50 pages. Yes. Okay, count. How much is it? Minimum is 3. 5. 5. How much? 13. Passed. You have passed already. In rest and all is your accidental. And foreign company, actually, I tell you, it's easiest. There is nothing will come in foreign company. This is the order you have to follow. Foreign company, remember and go. Minimum C, maximum C. Online will be filling. Why, sir? Write off in 3 chapters you have left. I'm giving you an order. Meaning, that is the first differences. Hey, anyone will first come and write, share and this one they will write. They are Dilka Dhadkans. You will have chapter questions. Buyback, everything. I have not even taken. Hey, that is nothing but 150 pages in your book. Then, sir, for whom have you given this? For ranker, I'll hit you. This is only for you to align yourself and study. That's all. Hello. Done. This is your ABC analysis or whatever you call. Okay. We'll taka do of people the quick revision of the limits, or you guys will just go through this. Huh? Correct, no limits, again the same thing will repeat. I'll send this to you guys go through. I'll send that. Okay, this part, this part I'll send it to you. Fairly I've tried to include maximum whatever I could. With whatever details I can include, have included. Should be good enough. Yeah. Do let me know whether if there is anything to be changed, I'll change it. Yeah. I've tried to cover most of it. If there is a limit, I've tried to cover. No, for you it's the same. 4 and 40. Remember that. May. Yeah, that is 10 and 100.
10 and 100.
That's for May. Yesterday you told no. Yeah, I told you no. In no. Here I've not added definitions part here. For Jan students, small companies 4 and 40. For May and onwards, small companies 10 and 100. Remember and go. Capital is 10, turnover is 100. Effective December 1st, 2025. Yes, Sam. Okay, fair enough. I'll forward you. Next, we'll just look at the tricky questions.
So the dual citizenship, when it comes like India, will never be dual citizenship.
No, if you want to have Indian citizenship, you cannot have any other citizenship. We do not follow dual citizenship. So if I become some, uh, huh?
That is not done.
No, which country is that? England, UK follows. There's one more country also, which is that. One more country which follows. Dual citizenship, few countries follow. Hi, yes, people. Okay, tricky questions. Wherever it is tricky, I'll try to take something. We'll see. Articles of Association of AB Limited provides that documents may be served upon the company only through speed post. Suresh dispatches some documents to the company by courier under the certificate of posting. The company did not accept it on the ground that it is in the violation of Articles of Association. As a result, Suresh suffered from loss. Explain with reference to the provisions of Companies Act 2013 whether refusal of document by the company is valid, whether Suresh can claim damages for it.
Yes,
Now, the section that we are asking from, which section? Section 20, service of documents. Yes. Now, as per that, what are the different ways I can serve? I can send the documents. Registered post, speed post, in person, courier, electronic means. Agreed? There only I told you. Why I am saying this is tricky is when you guys would have studied that, you wouldn't have studied it so detailed to see that if some other method is followed, I will be able to give it. I can follow whatever is given in the articles. There is nothing written like that. You can serve the documents in any of the above way. So whatever the refusal of the document of the company, is it valid? The answer is no, it is not valid. Next one, whether Suresh can claim damages for it. If he has suffered any damages, yes, he can claim for it. Again, why did I add it? Because it is nothing written in the act. If you look at it, we have not written if at all a person has suffered damages, you'll be entitled for penalty. We have not written anything. Clear? So yes, see, registered speed, everything. So I can give it in the method I want. So the refusal will be considered as invalid. So there are two ways of answering a question. Then we have sub questions. First, try to write out the provision. What does section 20 say? A person is entitled to serve the documents on the company in the following methods. Now that is my provision. Next, facts of the case. In the given case, they given the name. Mr. Suresh dispatches some documents through courier to the company. The question in the particular fact is that, is this valid? That's all. Keep your facts very simple. Then go to conclusion. There are two questions. My conclusion one will be the content referring to the provisions of Companies Act and the facts referred above. It is clear that the refusal of the document, they would have given you in the question only whether refusal of document by company is valid. All right. Hence, referring to the facts and provision above, the refusal of the document by the company is invalid. Conclusion 2. If Suresh has suffered any damages, he can claim it as damages. That is allowed. Are you getting the point? So, that is one way of writing. One main provision, two conclusions. Hello? Next one. Mr. Shamlal is a BTech in computer science. He has promoted an IT startup and got it registered as a private limited company. Initially, only he and his family members are holding all the shares in the company. While drafting the articles of association of the company, it has been included that Mr. Shamlal will remain as a director of the company for lifetime. Mr. Mehra, a close friend of Mr. Shamlal, has warned him that in future, if 75% or more shares in company are held by non-family members, then by passing a special resolution, the relevant articles can be amended. And Mr. Shamlal may be removed from the post of director. Mr. Shamlal has approached you to advise him for protecting his position as a director for lifetime. Why did I take it as people? Because the way it is questioned is good. People will think I know a lot of people have answered it, keeping a provision. A director can never be appointed permanently. In which rule I have taught you that? It's not there in your provision only. From 149, director's provision will start. So it's not there in your syllabus. Why do you want to answer something that is not there in your syllabus? They're testing you the other part. So technically, in articles of association, what are they telling you? Now, this fellow, Shamlal, he wants to put a condition. What is that? In the articles, I should be the director of the company forever. Someone has advised him what? Hey, even if you put it, there is no use. Tomorrow, if others become shareholders, by a special resolution, they can alter the articles. So they will tell, we can remove you, and they can be removed. How to stop it? They're telling you, entrench the articles and say, if you want to amend the articles tomorrow, 75% Allah, you have to pass 90, 100. Entrench it. So tomorrow to get this, even your approval will be required. So someone gave him this advice. Now, is this advice valid? Answer is yes. And this only is called as what people entrenchment. Now, which type of company it is? How many people have to agree? All members have to agree. Now, one more point, people will miss writing procedure. How to entrench the articles in a private company? Everyone have to agree. Hello. That's why I say it's a good question. Getting the point? Yes. Okay. This is a beautiful question. Vishal Limited is an unlisted public company having 5 directors in its board, which includes 2 independent directors. Sam Private Limited is a subsidiary company of Vishal Limited. See, where I didn't teach you to write P and Limited. I didn't teach you. In exam, if you are of the same clarity, we know sir, private limited, I'm happy. Even if 1 second that thought comes, publica privata, welcome to the law. That's the whole purpose of asking it as P limited. Public limited will neither have P, PVT, nothing. It will have only limited. They wanted you to use that brain. Nice, no? Adiki, that's why I'm saying it's a good. Okay. It is yet to go see. Okay. Sam Private Limited is a subsidiary company of Vishal Limited, actively carrying on its business, having paid up capital of 1.5 crore with 40 members and turnover of 18 crore respectively. And the said company is not a startup. It is also provided that Sam Private Limited is not a startup company. In the context of aforesaid case scenario, please answer the following. Whether Sam Private Limited is mandatorily required to prepare cash flow statement for the financial year. See, from top to bottom, subsidiary, private, that and all is coming. From nowhere, a bomb got dropped. Cash flow statement is coming. Okay. As a part of its financial statements, provide your answer by analyzing Sam Private Limited into the following categories of companies. Assume Sam is a small company. Assume Sam is a dormant company. First of all, you tell me how you will phrase your question. Let us do the answer writing also now only. Tell me. First, you'll write definition of subsidiary company. Yeah. Okay, you'll write the definition of small company. Yeah. You'll explain what is small company. And then subsidiary company and dormant company. And hey, first, you need to write cash flow statement in which definition it will come down. 2 clause 40. That's the main definition you need to write because they're asking you the question on financial statements. So I will write financial statements includes balance sheet to P&L, income and expenditure, changes in deviation in equity, your cash flow statement. I will write that first. And I will write cash flow statement is exempted. Now tell me for whom? small company, OPC, dormant company, private company which is a startup. Correct? Yes, sir. Okay. Now they have clearly told. Is this a small startup? Clearly they have told it is not a startup. Now they are asking you, assume Sam Private Limited, assuming it into small company and dormant company. Answer. Should I should I file CFS? Small company, is it required? Hmm.
Subsidiary cannot be small.
So I'll be writing here, as per the definition of small company, a subsidiary company can never become a small company. Whether it's a subsidiary of public company, then it will be deemed to be public company. That also is correct. Subsidiary company is also correct. So first of all, Sam Private Limited can never become a small company. On that grounds, the cash flow statement exemption is not applicable for Sam Private Limited. If at all they want to enjoy, the only way is people by becoming a startup. That's why specifically it is given.
If it is subsidiary to a public company,
That is okay. You will be coming into startup.
even if it is a startup, you can exempt it from cash flow. Like,
Ah.
it is subsidiary to
Public company is that provision will come because that time will become a public company only. That is there. No, I'm saying for if there is any other category left, imagine there is a private company on the top, private company only in the bottom also. I cannot be a small company now because holding subsidiary both are. Next one, dormant company. Possible now. What is dormant company? A company which is formed for a future inactive company. So now tell me, should they file? So as per dormant company, they need not have to file cash flow statement. Now, why I am saying it tricky is people. Sam Private Limited is a subsidiary company of Vishal Limited, and hence they are telling you this cannot even be considered as dormant company. Eppadi? Nice question, no? That's why I'm telling you it is important and tricky. So this company neither can be considered a small company, neither can be considered as dormant company, and hence the company is not exempted from filing CFS. Super, no? So now how will I write this? I will write it. Provision is simple. The first provision is standing on financial statements. I will write the definition of financial statements. Section 2, clause 40 of the Companies Act 2013 defines the financial statements as balance sheet, P&L, income, expenditure, cash flow, statement of deviation, or you write on everything. After writing everything, and you write. Remember, note, cash flow statement is not required to be filed by OPC, dormant, small company, and a private company, which is a registered startup. The facts of the case is that assuming Sam Private Limited as the following below mentioned companies, is the company exempted from filing cash flow statement? Conclusion 1. Small company, as per the definition of section 2 clause 85, a private company which is a subsidiary of a public company cannot be considered as a small company. Now, why am I again not writing the whole definition of small? That means people, if at all that is the case, I'll have to write the definition of subsidiary also, small also, dormant. 20 mark question now. So directly I will write the answer to the point. Now, what is my point? The following class of companies are excluded from the category of small company, irrespective of the capital and turnover. And who are they? A company which is a subsidiary company, or a subsidiary of a public company is a deemed public company and hence cannot be considered as a small company. On the following grounds, Sam Private Limited can never fit in the definition of small company, and hence it cannot be excluded from cash flow statement. Conclusion 2. Dormant company, as the question infers, the company is actively engaged in the business and hence it cannot be categorized as a inactive company, and hence you cannot assume the company to be a dormant company. CFS mandate. Write this much. Understood? Huh? Okay. Drug software company, INC, a company incorporated in Australia, proposes to establish a place of business at Mumbai. The list of directors includes Mr. Arun, Managing Director, Mr. Ranveer, Director, Mr. Ramesh Malik, Director, Mr. Nawaz, Director, Ms. Lavina has been appointed as the Secretary of Drug Pride Software Company. It is to be noted that Mr. Ramesh Malik and Mr. Nawaz, resident in India, are the persons who have been authorized by Drug Software Company INC to accept on behalf of the company service of processes, notices, or other documents required to be served on drug software. In relation to the company's establishment, you are required to enlighten the drug company with respect to whose a declaration will required to be submitted to the registrar for not being convicted or debarred from formation of company in or outside India. What is this? Whenever in foreign company, yesterday I told you one thing. We need to file it with the registrar. There has been one amendment there that registrar is today, you need to read it as registrar CRC. That's all. Central Registration Center. Why I in short tell you. Now for incorporation, registrars they are becoming too occupied. Too much of incorporation requests are coming. So in the central level, what have they done? They have moved away all the powers of the registrar. They created one more department called as CRC, Central Registration Center. It's called. All the work of the registrar with regards to incorporation today will be carried out by CRC. You can imagine like this. Till today, Karnataka was coming to Karnataka. Tamil Nadu was coming to Tamil Nadu. Maybe manipulations might have happened. Today, everything is central, CRC. Wherever you file, the applications go to central. And the authority created, it's still registrar only, but we write it in the brackets CRC. It's a new department formed. Only amendment for previous attempt only it was there. Yes, sir. Understood what is this? When a company is coming and forming its place of business in India within 30 days, have to give declaration. No, what is that? Me and these people are not debarred from managing or convicted from formation of companies. They're asking you, who are they? Who should not be debarred? Authorized representatives are secretary, director, who? Only directors and authorized representative, secretary. I don't know. I'm asking you. I don't know. I'm asking you. So remember, this was actually a tricky part. When I was doing that part only, I stressed that point and I said, authorized, trust me. Why I'm telling you that is, in the same place, when you're establishing a place of business in India, you'll have to give the details on 3 people. Director, secretary, and authorized representative. To confuse you with that, they've asked this point. But debarred will apply only for 2 people, not for secretary. Authorized representative and directors, they should not be debarred. That's why see, and complicated way of asking, they've asked names. Photogenic memory, you will remember. Hey, I remember seeing director and secretary or director and authorized representative. Playing with mind. Yes, you guys go and see the names, but that is the names. Director and authorized representative. Hello. People, PQR Private Limited operates as a manufacturing company, generating a turnover of 150 crore and holds an outstanding loan of 75 crore from a PFI solely in the previous financial year, with a total loan availed of 110 crore, but 35 crore were repaid during the same year. The company's board has delegated the authority to CEO to designate an internal auditor to conduct internal audit. However, the CEO believes that the company is not legally obligated to have an internal auditor. Analyze the accuracy of CEO's perspective by referring to the provisions outlined in the Companies Act. What would be your response if the board of directors wanted to appoint Mr. Nagendra, an ex-employee who is qualified chartered accountant, as an internal auditor? There are two questions, sir. Are they required to form? I mean, is internal audit mandatory for them?
Yes.
First to go and see it. The name of the company, they will not give it for time pass, sir. Private company, out of 4 conditions, now only 2 conditions will apply. What are the 2 conditions? Deepika Padukone works for L&T, but Deepika Padukone does not work in a private company. So DP is not there. Only L&T is there. L is what? Loan. T is what? Turnover. Last 2 categories what? 100 of 200. 100 I told you is exceeding. Exceeding 100 crore. That's the limit. Hello. Now people, one limit here says at any given point of time in the previous year, loan or turnover. Of course, turnover chance illa. It should be loan only. So they are telling you in the previous year, 110 crore loan was there in SIMS. But during the same year, they have repaid 35 crore. So technically, the loan has now come to 75 crore by the end of the year. So if I look at 31st March 2026, they have only 75 crore. Now internal audit is applicable to them or not?
Yes.
That point C at any given point of time. That's the question. Is internal audit applicable? Answer is yes. Now how will I write? Section 138 of Companies Act defines internal audit requirement applicability as in a private company. A company having loan of exceeding 100 crore at any point of time in the preceding financial year or turnover of 200 crore as per preceding financial year, they will have to mandatorily appoint internal audit. That's my provision. Facts in the given question is the, what is that, perspective error? In the given question, there are 2 conclusions. What is that? They're asking you. CEO is of an opinion that internal audit is not applicable to us. And second thing is that, can we appoint Nagendra, our ex-employee, who is a CA? Can we appoint him as our internal auditor? Can we? Yes or no? Answer me with provision. How can you say yes? The question is not on a child accountant. The question is on the ex-employee. Okay. Remember, they are asking you. They're asking you 2 things. One is correct. That is true. So professional, yes, CA can be an internal auditor. Can ex-employee be appointed? There is no such restriction. Did I teach you? I don't know if you learned. I thought I did not teach. Why did I say it's a tricky question? It's not there in our book. You guys, I'll tell you what you will feel in the exam. Internal auditor should not be associated with the company. Oh, he's been a past auditor. Then no. Now, people, conclusion, what will I write? Don't use your brain. Rewrite the words. Analyze the accuracy of CEO's perspective. Correct? The CEO's perspective of applicability of internal audit is invalid. As at the given point of time, the company had 110 crore of loan, the applicability of internal audit will be mandatory. And hence CEO's, what is that? Accuracy, perspective is invalid. Second one, can we appoint Nagendra, who is a qualified CA, ex-employee? There is no restriction. Internal auditor can be CA, CFA, any other professional, whether an employee or a consultant or a professional. Anyone can be an internal auditor. There is no restriction. So yes, Mr. Nagendra can be appointed as an internal auditor. Right this much. Understood? ಏನು ಅಂಡರ್ಸ್ಟುಡ್ ಏನು ಅಯ್ಯಬ್ಬ NOP Private Limited, since its incorporation 2002, is engaged in the production of premium quality glass bottles. According to financial results of company as on 31st March 2023, net worth of the company was 90 crore and turnover for the financial year 22-23 was 510 crore. The company proposed to accept the deposit as on 1st Feb 2024, which would be due for repayment on September 2028 from the public for expansion and redevelopment programs of the company. Furthermore, company has accepted a loan of 1.5 crore from Mr. P. Kishore and the loan was to be repaid after 24 months. Company in its books of accounts records the receipt as a loan under non-current liabilities. At the time of advancing loan, Mr. P. Kishore affirms in writing that such amount is not being given out of the funds acquired by him by borrowing or accepting loans or deposits from others, and complete details of such loan transaction is furnished in board's report. On the basis of above, answer the following. Whether company was eligible to accept deposit from public, what is the criteria for acceptance of deposit and tenure for which deposit can be accepted, whether the tenure decided by the company was in accordance with provisions. With reference to the loan advanced by Mr. Kishore, state whether the same to be classified a deposit or not. Eligible company. What is the eligible company? Company having net worth of ಎಷ್ಟು 100 okay, net worth of 100 crore or more, or turnover of 500 crore or more. Is it or and? Or and? Pakka, zero doubt. No doubt at all. Okay, remember, for a reason they have given you a limit where one is satisfying, one is not satisfying. This is just to test you to know and or. Out of 10, 3 people won't remember. Trust me. Yes, is it eligible company? Answer is yes, it's eligible company. Can I accept deposit from public? Answer is yes. Have they done any non-compliance? No, not at all. They have done non-compliance. What is the maximum tenure of deposits? When have they issued? When is the repayment? In 24 or 28 a year, doubt illa. 4 years can they issue? So the deposit provisions is not as per the rules, as the maximum tenure of deposits cannot exceed 36 months. I'll add more to it. What are the procedures that the company should follow for accepting deposits from public? Okay, circular. Credit rating is mandatory for every year as far as the tenure is concerned. For the entire year, you have to take, okay, and newspaper advertising is mandatory, validity 6 months, okay, and what are the procedures, right? Previous resolution and 181C. Certificate, financial position, you have not, should have not defaulted, that's all. Now tell me the forms. Which are the forms that will be applicable for this entire process? Circular should be in the form. ಗೊತ್ತಾಯ್ತಾ ಇಲ್ಲೇ audio 80% voice is silent. DPT1 and I'll tell you, deposit trust deed is required, public deposit it is, DPT2, credit rating is mandatory. Depending upon section 181C, if the limits are over and above, have to file form MGT 14 because special resolution becomes mandatory. It's a secure deposit. Hence, I need to file CHG1 procedure. दिल का धड़कन रुक जाता है. Clear? Easy. Tell me, is there money given by direct deposit? Yes, clearly given a declaration. Definition is clear. What is on a deposit? Any money given by the director, which He has given me the declaration that it is own funds, not borrowed funds, and that declaration goes in board's report, does not consider as deposit. Remember, in a private company, money can be given by director and his relative also. They can question that. Simple. Children. Our next one. Yogbir Singh has a mango orchard at Manchanga village, Bilaspur. The orchard has more than 100 mango trees. Yogbir Singh has sold orchard along with all the mango trees. Explain in the light of provision of General Clause Act whether sale of trees will be considered as sale of immovable property.
It is,
Today only we saw that. That's why we are saying. People remember the word instead of tree, if they have used the word timber, timber is specifically excluded from the definition of immovable property because timber is a tree which is grown for the purpose of cutting only. Hello. So here it's nothing but what is the right term? Benefit arising out of a land, mango and its tree. It is considered as immovable property as per the definition of immovable property. Clear, huh? Mr. Yenna is caught stealing a bicycle, an offense punishable under the Indian Penal Code. According to section 379, see this, of IPC, the punishment for theft was charged against him. Elaborate how the term imprisonment levied under General Clause Act 1897 can be applied in line with the relevant law specified in the IPC. So you need to say imprisonment is defined under General Clauses Act in two categories. One is rigorous, one is simple. It depends upon the type of offense committed. That stealing, what is that? Stealing only, na? Stealing of a bicycle can be considered as a simple offense. And hence, the imprisonment may be assumed to be simple in nature, assuming the nature of offense is first time and not repetitive in nature. Bicycle, if stolen for 100 times, I cannot say it's simple. So many assumptions. That's why I said it's tricky. Nice, no? Right, you're right, right. You have to write a note. Hello. See how what they have assumed. If theft involved, they have just given stealing of bicycle. How did you steal it? Was it just parked there? You unlocked it, you took it. Someone was driving there. You hit him, you took it. They have said was committed in a violent manner. If you ask me, should I write? I'm saying no. They are giving you different perspectives. That's okay. If you are writing with an assuming that this is how it is, it is okay. Yes, sir. It's a simple imprisonment. Clear? Huh? Chicago Bricks Inc. is a company incorporated in Chicago, USA in the year 1985, engaged in the manufacture of cement and related products. On 10th April 22, it commenced manufacturing in India through its branch, engaged in the manufacture of fly ash bricks used in the construction of buildings and other infrastructure projects throughout the country. The operations of branch have been growing at a fast pace. The turnover of the branch as on 31st March 2025, solid question. 25 since its commencement are, that's the turnover for 3 years. As per the data available, the branch works based on 20% of net profit margin. Mr. Ramesh, one of the directors of Chicago Bricks Inc., has advised the branch to comply with the requirements of CSR and to form a CSR committee as well for monitoring the aforesaid activities for financial year. For my understanding, I'm writing question number 1. The branch is opposing the above view and has submitted that although the CSR provisions are applicable in the present case, but there was no requirement to constitute a CSR committee and the above CSR function can be discharged by the board or directors themselves. Considering the provision of Companies Act, whether Chicago Bricks is correct in the view to non-applicability of formation of CSR committee in this case. See, They are first thing, people. I tell you the questions. On a foreign company, CSR applicable. I don't know how many pens will stop there only. Okay, let us assume all of us know foreign company CSR is applicable. The second point, should the foreign company, should they form a CSR committee? If the threshold limit is more than 50 lakhs, CSR is applicable. Now, how do I know what is the CSR applicability? How much is the money I need to spend? Where is it written? 2% of the turnover. People, they have, so I have to take this 2%. Yes or no? No. This is turnover. They have told as per the data, the company works on 20% net margin. This is your turnover. Multiply this into 20%. How much does it come to? 7.5 into 2, 15. Here, 13. Here, 17. Correct? 20%. Now, this is my data. Now add 15 plus 13 plus 17, how much? 45 crore. Now do this into 2%, how much? 90 lakhs, 0.9 crore, then 90 lakhs only. Now, CSR amendment, what is that? CSR committee, not required. If at all the CSR expenditure is up to 50 lakh. Anything beyond is required. So the amount is 90 lakh. CSR committee hence is applicable. Hello? Now CSR committee, who will be the member of CSR committee? We very happy. They did not ask you. If I were an examiner, no, I would have asked you to frame the CSR committee. Who will be CSR committee? Three directors. One of them shall be independent director. Correct? Remember, first of all, in a foreign company, there will be no independent. In a foreign company, in a foreign company, there is no independent director at all. Okay, I give you that. Now tell me again. Two members and in two, one should be resident or 2 plus 1. I getting no? Allah no. Now, if you ask me, did I explain? I've explained. FYI, this is the question. What your all the people said the previous attempt exam was very difficult. Is a question? No. Previous attempt paper September paper. Go and see CSR provision. You have written 2 members. In that one shall be resident. Same provision is applicable to private company also. I would have told you, but it is 2 directors. 100 times I tell the same thing. A 60 page also you will not read. So, what is that I'll write end of the day? Considering the provision, whether Chicago bricks is correct in the view as to non-applicability, no. The view of Chicago bricks is incorrect. As the company is covered under CSR provision, they will have to comply with the CSR committee, which will consist of 2 members, in which one shall be a resident in India. Hello? Nice, no? Forward Troopers Limited, the public limited company, engaged the manufacturer of wearable protective gear and accessories, including helmets and shields, for supply to the armed forces in the country. It is a subsidiary of Security Troopers Limited. The financial position of Forward Troopers Limited, as per the latest audited balance sheet, is as follows. Capital is 1,145 crore, reserves and surplus 1,000, loan 120. Creditors 14. The board of directors of Forward have planned upon the following schemes of financial assistance to facilitate the purchase of its share by its employees, to create an institution in form of trust which would be responsible for the purchase of shares of Forward Troopers Limited with help of loan of 110 crore by the aforesaid company itself. The trustee therein would purchase the shares worth the above mentioned amount on behalf of the employees in accordance with the employee share scheme, to provide loan directly to employees to the maximum of their 5 months salary to enable them to buy fully paid shares. Mr. Strong, one of the directors, has although approved the first scheme but have opposed the second one, claiming that employees can be granted loan for the purchase of forward troopers but not for its holding company. Considering the provisions under Companies Act, answer the following. Validity of the decision by Board of Directors of Forward Troopers Limited to provide a loan worth 110 crore to the trust to aid the employees to buy its shares. The validity of the contention of Mr. Strong on grant of loan for purchase of shares of Security Troopers Limited. Which section now?
The company cannot give loans to it.
Section now? 68 buyback. 67. Yes, sir. Prohibition in giving financial assistance loans to anyone to buy the shares of the company or holding company. Exceptions. Ah. First one is ordinary course of business, banking company. Second one, ESOP. As a trustee, you can give it. You can even give the money to, you know what? Why I'm calling this a very good question. You guys know, but the problem is one of the director is pointing that you can give loan to the employees to buy your company shares, but you cannot give loan to your employees to buy the shares of the holding company. Is this contention valid? They can give. That is person. But can you give money to buy the shares of the holding company? Possible? Where is it written? Okay, I don't know how what page you guys answered, but if you are so sure, answer is yes, people. I can give money to buy my own company shares as well as the same place it is written. Holding company shares also can be purchased. And we can give loan up to 6 months of salary for the employees and not for directors or KMP. Ange madhya they will screw up with kalchidre, that will go. Understood? Section 67. Again, September attempt exam question. This is like people said, it's lengthy, full paper in here. The first time CQ was 1.5 page. Heavy load. Now, is it difficult? Answer is no, but you should know. Heavy Loaders Limited is a public limited company incorporated in India. See, I'll tell you in simple people. In the class also, I would have told you 100 times. On the face of it, questions are extinct. Those days are done. Mele. CSR means 1,500. Done. How many years do you expect the questions to be same? What else we can question? There's no questions it will be today. Very rare done. I cannot. It will be there. iOS chances is there. General clause chances there. But it will be less than 15 marks direct. And engaged in the manufacture of loader vehicles used for commercial construction purpose. It is planning to expand its business outside India and hence has come in contact with Mr. Fred, an American citizen working as an agent of company planning to secure business in USA. Mr. Fred has informed the directors of Heavy Loaders Limited that another Indian company engaged in the commercial construction business has requirement of 25 loader vehicles for its wholly owned American subsidiary company, Heavy Loaders Limited, supplied the required loader vehicles with an invoice value of $3,50,000 in exchange of allotment of equity capital of the same worth in the American company. Mr. Fred has asked for an export agent commission of 15% on the invoice value of the goods supplied from Heavy Loaders Limited, to which Heavy Loaders Limited has refused the payment on grounds that maximum commission that can be paid can be 10% of the invoice value of the goods supplied. Considering the provisions, decide whether the above transaction of supplying machines of equity investments can be treated as export, keeping in mind the absence of monetary factor in the transaction, whether the rate of export agent commission demanded by Mr. Fred be paid or confined to only 10% of the invoice value of the goods supplied. What will be right? Huh? Ah. So I will write. How will you write your answer? As per Schedule 1 of FEMA Act, the following current account transactions are prohibited. And that is what? I need not write the entire list because there are two sub questions. If only one, I understand. So I'll specifically write the exact pointer. For people who were in the class, the question is directly being asked upon. Which question? Remittance of commission on exports towards equity investments. Yes, sir. Tea and tobacco was what? That is rupee state credit group, no? Yes or no? So I'll keep that in mind and I'll answer. So what I'll write? If at all, if I'm taking any equity investments, I'm not allowed to take any export. I'm not allowed to make any payments related to export. That is not allowed. Whether first thing is it considered as export? Answer is yes. Whenever it is leaving your country, it is definitely considered as export.
If we give him, they gave money and we have to give commission, the percentage is still in the.
No, that is not defined. No.
What is it?
Rupee state credit, that is not defined. See, in a normal scenario, we will not define the percentage. You can pay whatever is being claimed there. There is no restriction as such there. Here you are not paying because you did not earn. Clear? Huh? So it's a prohibited transaction. Agreed? Huh? Hello. So this is one section that, yes. But I hope you guys got a fair idea. Yeah. So that's what I said. I felt it's a good sections, good questions, brain teasers. Agreed? Huh? Hello. Okay. So, yes, people, the last part, as I said, I'll try to give you some sections along with certain tricks to remember your sections. Yeah. Some can be logical, some can be illogical, but however you guys want to do it. Yes, sir. The first one we build. So I've tried to put in some places some story so that you guys can remember like a story. In some places, I've tried to do some hacks. Try to remember that. So wherever possible, I've tried to do that. So remember and go. I mean, some can be very silly, but I'm so sorry. So the first one, I've just written it as this is something which I had remembered. Same cut copy paste. I'm giving it to you. SP Balasubramaniam. SP Balasubramaniam prohibits issue of, I'm just writing it here as shares at discount as he values the sweat of technicians and he also prefers not to transfer and transmit securities. For more understanding, instead of shares and securities, if you can relate it to a ticket. Imagine SP Balasubramanian is conducting a concert. Yes, sir. So if they are telling you SP Balasubramanian prohibits issue of tickets at discount. If price is 1,000, pay 1,000 and buy the ticket. Why? Because he values the sweat of the technicians. And also, if I buy the ticket, I do not prefer giving it to someone else. Remember that, people. Securities premium account. Section 52 prohibits issue of shares at a discount. Section 53 sweat equity. Section 54 prefers not to transfer. Preference share. Section 55 transfer and transmission of securities. Section 56. That is only your SH4, SH5 and all that part. Hello? So remember, if possible, some can be very silly. Please excuse me. Yes, sir. Next one. Duty to register charge. I think this I told you in the class only. I had given section 77. So I had remember charge like your charge only. You know, like a thunder. This is how I had remembered. So the charge 77 is here. Yes, sir. If you guys have a better way, please remember. These are all the things that I did when I was a student. Next one is register of members. So members 8, section 88, no. This is how I had remembered. Members, no. This is how I had remembered. So members, according to me. Yes, sir. Ah. Couples. Yes. Next one, of course, 96. I've told you the whole dependence of section 96. Everything is 96. First, subsequent 9 to 6 AM, PM, all the entire thing will be 96. Remember and go that. Easy. 9 plus 5, 9 minus, everything will be that only. 9 plus 6 and all. Next one is, of course, EGM. There is nothing 100. Easiest way. There's nothing for me to do that. Next one, 10th one. Notice of a general meeting. So this is how I had remembered. Section 101. So 101. It will be like this. Notice. Yes, sir. Notice of a general meeting. Yes, sir. Next one is what? 11th one is few people will get confused between quorum also. 105, 103, 104. This is very far fetched, but if you guys can remember, remember and go. 103, I used to remember like this. 3, no. So I remember that as Q. So it's 0 and 3. Imagine like this. You're writing 103. This is 3. Q. Q, if you remember, I think it's quorum. Very rarely you'll get a number. Yes or no? 12th one, no. Chairman. No. Section 104. ಅದಕ್ಕೆ ಇದನ್ನ ಮಾಡ್ತಿರೋದು. Section chairman now. People. Chair is there. 4. 1 is there. 0 is there. So chairman. Yes, sir. Hey, already 13 sections we have remembered. In ಏನನ್ನ ಯಾತಕ್ಕೆ ಒಂದಕ್ಕಾರು we should use brain. Next, proxy. Proxy is section 105. So remember, this is how I remembered. 105. Me as a student, I used to put lot of proxy. So Sai sir, yes sir. Yeah, I proxy. Sai sir, proxy. For me, it was easy to remember because I said myself. I used to put lot of proxy. If you guys can remember in a better way, remember. Next one is voting by show of hands. Voting by show of hands. Section 107. Voting by show of hands. 107. So voting by show of hands. A person is voting by show of hands. Correct? Hello. Okay. 15. Show of hands is done. Next one is poll. Section 109. So remember, name itself has POL. POL. Mirror image. Yes, sir. What else was there? Next one is people. If declared dividends are unpaid within time, it shall be transferred to IEPF after 7 years. Until then, it shall be kept in abeyance. It shall be kept in abeyance failure to do so may result in punishment. Failure to do so may result in punishment. Declaration of dividend 123. Unpaid dividend or even timeline 124. IEPF 125. Abeyance 126. Punishment 127. If you see, that's not even a story, that's the whole provision. If declared dividend are unpaid within time, it shall be transferred to IEPF after 7 years. Until then, it shall be kept in abeyance. Failure to do so may result in punishment. Correct? Yes, next one. This is a little, what is that? Lengthy provision, but writing this because it is covered under your, I mean, it's relevant for you. Audit chapter. So I'm giving it to you with your reference. My appointment as an auditor, my appointment as an auditor feels like my appointment as an auditor feels like removal or resignation. Removal or resignation when my eligibility is checked. When my eligibility is checked, or when my remuneration is quoted. But remember, my powers, my powers even after not rendering certain services certain services makes me sign or makes me liable for signing audit report and attending AGM and I will be punishable if I demand any illegal costs to do my job. To do my job. Yes, sir. You know, one in the paragraph, no? I'm sharing it actually first time. This is how I used to remember. I remembered easily, I'm telling you, 80 to 90 sections. Like this only. Yes, I'll tell you how. Now, I at least I feel I got a breakthrough to remember the entire series. Now all I need to do is I need to remember that series. I'll remember. Yes, sir. Now how I'll do? Now, for example, my appointment as an auditor, first section 139. Next, removal resignation, section 140. Eligibility, section 141. Eligibility, removal resignation, appointment. Check for my remuneration. Remuneration to be paid. Once they have asked this question, section 142. Powers of the auditor. 143. Auditor not to render certain services. 144. Auditor to sign audit report. 145. Auditor to attend AGM. If he doesn't attend, what to do? Have to send someone else? No.
He also
Qualified. 147. Punishment. Cost audit. 148. Kopida. Done. So remember and go. I don't know how many. Think fair bit of sections you will be able to cover. If you guys can remember any stories, then I'll give you more. Easily I'll give you. See, that's why stories will come only in the series of sections. And if I'm saying one story, if I remember, from where to where, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 sections covered, then good or not? Yes or no? After turning on the camera, I'll tell you how to remember that also. Yes, sir. Sir, Jayashree, like first you turn off, sir. Power ಎಲ್ಲ ಯಾರಿಗೆ ಬೇಕು? Criminal and right on this. Criminal and civil liability. Criminal and civil liability are both punishable offenses for the class for personating as good students. Instead of that, write down as shareholders. So we can remember as students, good for you. Now tell me, criminal liability 34, civil law 35, punishable offense, class action suit, personating as a shareholder. Correct? And one more thing I had remembered was, what is that? Shelf prospectus. How will the shelf, what is shelf prospectus? Correct? It will be valid for a particular time. So 31, section 31 only, Huh? Correct, no? So first right one wall is there. For that wall, shelves are there. 31 only, no? ಅರ್ಥ ಆಗಿಲ್ಲ. Now, where will it help you? I'm telling you. Imagine you have a confusion. For example, you might get confused. So, red herring prospectus is 31 na, shelf prospectus is 31 na. At least in that cases, these can help you. Huh? Yes or no? Then that's what 3 is shelf. It's a shelf. 1, 31. Yes, sir. That is there. One more pair you guys will get confused is small company with section 85 subsidiary company. Now people will get confused there. Correct? Angala. It's a dictionary. Alphabetical order. SM. SU. So subsidiary will definitely come later. Small M comes first. So M comes first. So 85 will be small. 87 will be later. Hello. Subject Saku. I can give you people easily. I can give some 45, 50 seconds. I can give you. But now I think good enough. I don't know how many sections I gave you. Remember and go. Huh? 30 plus sections. Good enough, Goda. Huh? Almost 40. Good enough sections. Remember this and go. Huh? After the camera, I'll tell you how to remember that also. Yes, sir. So I think we covered a good enough part. Yeah. So I'll share you. I'll share you. Okay. Pakka. Huh? Okay, chalo. I think they have class or something. Wish you guys the best. Whoever is writing in Jan, may the best be with you. Please do practice properly. Don't become lethargic. And remember the main thing. The difference does not happen in the 1 year. It difference happens in the month that is there in front of you. And especially the day before the exam and the 3 hours in the exam. Be calm, be composed. It's okay that, if you're feeling the paper is difficult, make sure it counts. Be there for 3 hours. That itself will add a few marks to your paper. Don't walk out in between. Remember, when the paper is difficult is when you need to work more, not when the paper is easy. When the paper is difficult is when your need as a person is there, not when the paper is easy. Yeah. So put all of that. I hope we were able to recollect and revise good enough content. With this, thank you so much. Let us meet some other time. Thank you, everybody. See you. In between, no. A certain part you will not be allowed. Yes. Yes, people. Chalo. Thank you so much. See you all. Bye bye.